Tractate Yevamos discusses a bit of a unique topic in the laws of marriage. There's a concept called the Levirate marriage, or Yibum, where essentially a woman whose husband passes without leaving any children, her brother-in-law, the deceased husband's sibling, has a responsibility to marry her in his stead. If they don't want such a marriage to go through, there's an additional process called chalitza, a ceremony which annuls this bond and allows her to marry whoever she wants. Chapter 1 will begin the discussion of these laws. The first Mishnah says, in regards to the laws of Yibum, the Levirate marriage, and Chalitza, the annulment of a Levirate marriage, there are some cases where the relationships of the people involved make it so that neither Yibum or Chalitza are permitted to be done. If the deceased husband had married his brother's daughter, obviously now the brother is not allowed to perform the Levirate marriage, which would be to his own daughter. If the deceased husband had married his brother's granddaughter, either from his son or daughter, if the deceased brother had married his brother's wife's daughter or granddaughter through son or daughter, if the deceased husband had married his brother's mother-in-law, or his mother-in-law's mother, or his father-in-law's mother, or the deceased husband married his brother's maternal half-sister, or his brother's mother's sister, or his brother's wife's sister, or his brother's maternal stepbrother's wife, or the deceased husband was married, the brother did Yibum, marrying the widow, along with a co-wife, and there's a later-born brother, he's now exempt from marrying both of those women, if the older brother also passed, or if the case is that the widow is his daughter-in-law. So, in all of these cases, there's an exemption for Yibum and Chalitza for them, all the wives discussed, and their co-wives, and their co-wives' co-wives. Their co-wives would be permitted to the husband's brother if the first wife died beforehand, or they refused to marry him when they came of age, or they were divorced, or they were found to be in ailonis, a unique disorder where a woman has male characteristics, often defined as Turner syndrome or some other physical disorder, which terminates a marriage. Such a case is not possible by the mother-in-law, mother-in-law's mother, or father-in-law's mother by an ailonis, or them refusing the marriage, as those cases are where they had children. This concept is further defined in regards to the co-wives. Furthermore, with any of these cases, if the wife was able to refuse the marriage when she came of age, but decided to marry him anyways, the co-wife requires Chalitza to nullify the bond if her husband dies, but she cannot do Yibum if they want to get married. The Gemara asks, why don't they just teach the case of a wife's sister first, as that's the verse this is all derived from? We say the reason that the case of the daughter goes first as that was learned from scriptural exegesis, so it was said first because they were fond of the teaching. Actually, all of these are derived from scriptural exegesis. It's just that the actual initial prohibition against marrying your daughter is itself derived from exegesis, as it's never actually explicitly written in the Torah. The remaining order is by how closely related the individuals are, which is explained. It specifically says they exempt their co-wives, not forbid them, since the marriage is only forbidden by the laws of Yibum. Outside of that, it would be a permitted marriage. It also says they're exempt from Chalitza, and says at first, to say this is like the opinion that Chalitza is actually the preferable option. There's some further opinions, and it goes through all the verses that explain how all of those listed marriages are forbidden by the laws of Yibum. The verses are further discussed. It also discusses some verses on the laws of tzitzis and shadness, which are juxtaposed, and some unique laws from those. This goes further. It also goes through some additional verses which teach specific laws by these concepts. It goes through some additional qualifications on the laws of shatnez and tzitzis, and also explains the necessity of certain other verses. There are further these discussed. It also goes through the necessity of having several of these potential marriages excluded by the Torah based on potential derivation by several other verses and concepts. The principle is the question if a positive commandment can generally override a kares prohibition, which we try to bring from other topics, like by punishments in regards to the violation of Shabbos, but we can't, and we end up unable to explain why the Torah excluded a wife's sister from Yibum. Rather, we say it was necessary to teach for necessity of learning other concepts from its scriptural exegesis, meaning it needed to be singled out, as otherwise you might have thought that the prohibition of a brother's wife was singled out to exclude this, so we list this also to say that's not the case. Others disagree, and say that you might have mistakenly derived its permissibility by a wife's sister from the permissible case of the typical brother's wife, which is explained further based on some similar concepts. This is discussed further with even more suggestions as to why the Torah specified this concept. These are further debated in regards to the specific wording of verses and the concepts that could be implied from them. There's further discussion on what's derived from certain verses on this topic. One sage attempts to take a ruling cited by a later Mishnah that if the marriage is forbidden to one brother, it could be permitted to a different one, which would apply to a case where there's a sister who's another sister's fellow Yevama who can do either Yibum or Chalitza. This case will be discussed more in a later Mishnah, but there are many opinions as to which of the cases we discussed that this applies to. There are other suggested cases mentioned in regards to these situations, which are additionally discussed. We also try to suggest to add another case to the list, according to one of the opinions, where the deceased husband's brother did Chalitza, and then afterwards betrothed her, and then died. She and her co-wife are exempt from Yibum and Chalitza from his brother. Others answered that this wasn't listed as the co-wife's co-wife doesn't apply here, unlike by all the other cases. That's if you hold the marriage is prohibited under penalty of kares. If you hold that it's just a negative commandment, then that's the reason itself. This is debated based on verses. The debate as to this level of punishment is argued further. Another case, a co-wife and a wife who committed adultery are both forbidden to do yibum, and therefore exempt from chalitza, which is based on the verse. Others disagree, saying that this rabbinic enactment was made in the manner of a biblical law, compared to a case of a biblical sotah. This is argued on further with discussion on particular cases of remarriage after divorce in regard to the laws of Yibum, which is debated among several opinions. Besides for the situation with an adulterer, the co-wife of a wife who refused to marry the brother cannot do Yibum to marry him, the one who was refused. This was said as a precaution to avoid the similar case of a brother who was with the other's daughter who refused to marry him along with her co-wife. Both are impermissible, which is discussed. Also, the co-wife of an Ilonis, who cannot have a child, is forbidden based on a verse. This is discussed. A related point, typically, preventing conception is forbidden by Jewish law. However, there are 3 exceptions to this rule, where women can use a cloth or similar to prevent conception. The first is a minor. Now, it goes without saying that marriage or cohabitation with a minor is very strictly forbidden on many levels in Jewish law. However, it's saying that, God forbid, in the event that a minor is in such a situation, she would be halachically permitted to take any step necessary to prevent conception for the sake of her own health. Other sages say that God will have mercy on her and keep her safe. The next is a pregnant woman who can do this for the safety of her fetus, and the third is a nursing woman, as it could cause issues with her milk. There's debate as to the level of physical development in a girl that constitutes her being a minor, and it says that if a woman gives birth, legally, she's assumed to be beyond these stages, meaning it would never be necessary to check. The remaining points from the Mishnah are qualified along with verses. New Mishnah. Sex relationships by Yibum are stricter than all the ones listed earlier, as they're related paternally. A mother cannot do Yibum to marry the son's paternal brother. You can't end up marrying your father's wife, or your father's sister, or your paternal sister, or the wife of your father's brother, or the wife of your paternal brother, meaning after they had kids. So, they can't do Yibum. Beis Shammai actually allowed the co-wives of the first 15 cases to marry the wives' brothers. Beis Hillel says no. Practically, this means if they did Chalitza, Beis Shammai says this was valid, and they can no longer marry a Kohen, while Beis Hillel would say that nothing happened and they can. Or if they did Yibum, Beis Shammai would say that was valid, and they can still marry a Kohen if their husband dies, while Beis Hillel would say no. In spite of Beis Shammai and Beis Hillel's disagreement by this, they would still marry into each other's families, and similarly, in spite of the fact that they disagreed frequently by the laws of impurity, they would still eat food together using each other's utensils. The Gemara debates the verses that source these opinions. Some say Beis Shammai holds like he does, as he says a prohibition does not take effect upon another prohibition. It also discusses the necessity of the example by marrying a Kohen. It's because some instituted that co-wives should all just do chalitza to be safe, so it specifies this to say that wasn't implemented, hence the different opinions. There's an additional point on the prohibition against creating different factions in regards to the performance of mitzvahs. An exception is the reading of the Megillah, which could be done on different dates depending on the region, as further discussed earlier in Chapter 1 of Tractate Megillah. So there's a question as to how Beis Shammai and Beis Hillel could have their own practices in regards to the marriage of co-wives on this topic, which is seemingly in violation of this principle. So it's said that actually Beis Shammai just followed the law according to Beis Hillel, and there's a number of suggestions why. There's reference to the incident where a voice from heaven said that we always follow Beis Hillel. Possibly it was because Beis Hillel just had the majority in his school, which is why we hold like him. There are a number of reasons given. Others say the concern of factionalization only applies where one court rules partially like both opinions, not where there's 2 courts in a town, both of which follow the different opinions. There's further discussion on this topic. and this is all qualified further. There's additional debate based on many cases if Beis Shammai did end up holding like Beis Hillel in these laws. There are even further specific cases discussed to try to figure out this topic. In the end, we proved from the quoted case that the co-wife of a daughter was allowed to marry the brother of her deceased husband, which is the opinion of Beis Shammai, implying that they did actually hold like their own opinion. The whole case is further quoted, along with a few additional points, such as which peoples we accepted converts from. Specifically, the Talmudians are not accepted, possibly as they're descended from the slaves of King Solomon, possibly because they're descended from the women who were assaulted during the destruction of the first temple. There are related verses on this discussed, and there are some specific regions and towns mentioned on this topic. And that's the end of Chapter 1. Chapter 2 of Tractate Yevamos further discusses the laws of the Levirate marriage, the laws of a woman who either marries her brother-in-law after her husband's passing, leaving no children, or the rejection of this marriage, called chalitza. The bond that's created between her and her brother-in-law that forces her to either marry him or do the chalitza ceremony to not marry him is referred to as zika. The Mishnah says, in the case where there are two brothers and one passes childless, and then there's a third brother that's born, the second brother married the first brother's wife through Yibum, and then he also dies, the third brother is exempt from Yibum and Chalitza from both brothers' wives, as he's a non-contemporary brother. He wasn't alive when he died, and the second brother's wife was also her co-wife. If the second brother had only betrothed the first brother's wife and then died, the second brother's wife cannot do Yibum, but must do Chalitza. The Gemara clarifies points on the wording of this, saying the widow can be referred to as the widow of the first or second husband. It also brings the source for these points from verses. Some say, if a woman was waiting to go through Yibum, but then died, the man is allowed to marry her mother. Some suggest this, as this opinion holds there is no Zika bond between the widow and her brother-in-law, but he can only marry the mother after she passes, as he has the first obligation to marry the widow. Others disagree, saying there is a Zika bond, and it's debated. These opinions are challenged based off many related cases. This is debated further. Some clarify the opinion to be that the Zika bond does exist, and it doesn't vanish after the widow dies, hence the issue with marrying the mother. There are a few different opinions on this topic, but we do seem to hold that such a bond does exist. New Mishnah, if there were two brothers, the first dies childless, so the second does Yibum, marrying his widow, and then a third brother is born, and then the second brother died childless. Again, he's exempt from Yibum and Chalitza to both brothers' wives, as he's a non-contemporary brother to the first. He wasn't born yet, and the second is the other's co-wife. If the second brother had only betrothed the first brother's wife before he passed, his widow cannot have Yibum and must do Chalitza. Others disagree with this case, saying if both brothers married and died, the third brother should do Yibum or Chalitza to either of them. The Gemara explains the logic of the disagreeing opinion, saying it's due to an apparent redundancy essentially between this Mishnah and the previous. There's further discussion on this. The opinions are argued on. There's different interpretations of the disagreeing opinion as to what exactly is going on. Some say he's referring to a case where the first two brothers married sisters, and also a mother and daughter, like this. Others disagree based on a source. Alternative suggestions are brought, and it's further debated. We bring the case from a source of a few listed cases to find the one where the opinions disagree. There are several of these cases, and the last one is where a brother does Yibum, and then a third brother is born, and then the second brother dies childless. Some would say both are widows and exempt from Yibum and Chalitza, and the disagreeing opinion would say he can do Yibum or Chalitza with either widow, as the third brother and them only ever were permitted to each other, and were never in a state of impermissibility to each other. He wouldn't disagree with the first opinion if he was born before Yibum was done. There's actually a number of particular cases discussed, which are debated between the two opinions, but they can be summarized pretty concisely into this chart, so this is basically the whole discussion. They're discussed a bit further though. New Mishnah. Generally, regarding the widow, if she's forbidden to marry due to the general laws of who you can and can't marry the brother-in-law, she cannot do Yibum and is exempt from Chalitza. If they can't marry due to a mitzvah or due to sanctity, which will be explained, they can't do Yibum, but they require Chalitza. If there are two sisters who both are widowed by brothers, the third brother can do Yibum or Chalitza with one of them if it's impermissible for him to marry the other. Unable to marry due to a mitzvah is the instituted prohibition against marrying secondary relatives. and unable to marry due to sanctity is the prohibition against a widow marrying a Kohen Gadol, or a divorcee or similar to a Kohen, or a child of a forbidden union, or a Nazarite to anyone, either as the husband or wife. The Gemara says the general rule comes to include the co-wife of an Ilonis, again someone with Turner syndrome essentially, as exempt from Yibum or Chalitza, according to one opinion. Others say it's actually disagreeing with this opinion. The remaining points are for the qualified, and there are some unique exemptions discussed. It also gets into some other cases. What if a Kohen Gadol impermissibly did Yibum with his brother's widow? There's disagreement if the widow's co-wife is still connected to the widow in regards to the laws of Yibum. There's further discussion on this, some sources, and a list of all the secondary relatives as to what is considered to fall into this category that you cannot marry. Here's a chart listing basically all of the biblically prohibited marriages that are specifically written and all of the rabbinically forbidden marriages of secondary relatives. These are for the qualified, along with some specific cases, and they're all discussed further at length. Others say the chart is as follows, including all of these in addition. This is for the discussed, again with some particular cases, and some add that converts have no rabbinic prohibition from marrying these secondary relatives. On the topic of converts, it says that paternal brothers who converted can testify together, and maternal brothers, some say they can, some say they can't, but if they did, it's still valid. This is because conversion basically resets all of your relationships. You're considered like a newborn, and all prior familial relationships don't exist. Now, not everybody's aware of this, so we're still strict by marriage, that they can't marry their relatives after they convert, but a court knows these laws, so they can accept their testimony. New Mishnah. If someone has a brother of any kind, Yibum will apply, and he's considered his brother by everything, unless the brother is from a Canaanite maidservant or idolatress. If you have a son of any kind, that makes Yibum no longer necessary, and the son would be liable for wounding or cursing his father, and is his son by everything, unless he's from a Canaanite maidservant or idolatress. The Gemara says, a brother of any kind includes even a bastard, which is necessary to say based on some verses. Them being brothers for everything is to include them being impure for each other, which is also necessary from some verses, and this is further explained. A son of any kind is to, again, include a bastard. Verses are discussed, and this is all qualified further. There is additional discussion on these verses. It mentions famously, based on one of the verses, that a person is Jewish based on his mother alone, meaning if a person is born to a non-Jewish father and a Jewish mother, he's considered totally 100% Jewish, and if he's born to a Jewish father and a non-Jewish mother, he is not considered Jewish. This is further discussed. New Mishnah. If someone betrothed one of two sisters, but he's not sure which, he has to divorce both of them. If he died without divorcing them, his brother must do chalitza with both of them. If the dead brother has two brothers, one must do chalitza and the other can do yibum. If both brothers married both sisters, they don't need a divorce. If two unrelated men betrothed two sisters and neither knows which he betrothed, both of them must give a divorce document to both of them. If both men died childless without divorcing and each has a brother, both must do chalitza with both sisters. If the first dead guy had one brother and the second had two brothers, the single brother should do chalitza with both, and the first of the two brothers should do chalitza and the other can do yibum. If the two brothers marry the sisters, they don't need a divorce. If both dead guys had two brothers, one of each brother must do chalitza with one, and the others can do yibum with the sister that the opposite brother did chalitza with. If two of the brothers did chalitza with both, one must do chalitza and the other can do yibum. If they both married them, they don't need a divorce. The Gemara tries to learn from this that marriage is still valid even if you cannot legally cohabitate, but we say no, as the marriage made initially was where they could cohabitate, and it was only after that the sisters got mixed up. These points are further discussed if we can learn this from any part of the Mishnah. The explanation of the cases are further qualified. New Mishnah. The commandment is for the eldest brother to do yibum, but if the youngest did it, it's still valid. The Gemara cites and discusses sources for this. New Mishnah. If there's a rumor about someone that he cohabited with a slave woman who was later set free, or with an idolatress who later converted, he cannot then marry either of them. But if he did, they don't need a divorce. If there's rumors about someone cohabiting with a married woman, and the court rules she should divorce her husband, she cannot marry the other man. And if they do, they must divorce. The Gemara discussed these cases, and there are some additional points on these topics. New Mishnah. If an agent brings a divorce document from abroad and says that it was written and signed in his presence, he's not allowed to marry the divorced woman. If someone testifies about a man that he died, or he or we killed him, the testifier is not allowed to marry the dead man's wife. Some add that if the testifier said, I killed him, the woman cannot marry anybody now, as the witness had admitted he's a sinner, and thus disqualified his own testimony, leaving her unsure if her husband actually died. If he said, we killed him, then she may remarry. The Gemara explains these cases. Basically, it's as we rely on the testimony of these individuals, the marriage is therefore impermissible after. They're further discussed. It also explains the difference by saying we killed him. It's as he's saying, I was with somebody who killed him, which is discussed. New Mishnah. If a sage prohibited a woman to be with her husband by not nullifying a vow against her from being with her husband, the sage may not now marry the woman. If a woman refused the husband or did chalitza before a sage in court, the sage is permitted to marry her, as he was doing this as a court function. The Gemara explains points on these cases along with a debate. If they did marry by the vow case, if they actually need to get divorced or not. New Mishnah. By all of the above cases where a testimony or a court function or similar prevents someone from marrying the involved woman, this does not apply if the man was married at the time and the wife later died. Also, with all of the women, if after the incident they married somebody else and then were divorced or widowed, they can then marry the guy from the case. Also, the women are all permitted to the sons or brothers of those involved in the case. The Gemara discusses these points in regards to marrying the brother of the involved individual. That's allowed as either there's no concern of her meeting up with the guy through the relative, as men don't typically visit each other, or it's because the husband won't permit such a thing, as it'll lead to an impermissible marriage on his end. This might be a concern by a father to son, but a son has respect and awe of his father, so he won't cohabit with his wife. And that's the end of Chapter 2. Chapter 3 of Tractate Yevamos further discusses the laws of the Levirate marriage. The Mishnah says, if there were 4 brothers, 2 of which were married to 2 sisters, and they both died childless, they should do chalitza to the other brothers and cannot do yibum. If they did marry, they must divorce. Some say it's actually dispute if they need to divorce or not. If one of the sisters was forbidden to one of the other brothers as they were related, he can't marry her, but he can do yibum with her sister, and the other brother can't marry either of them. If the sister was prohibited to the other because of a mitzvah or because of sanctity, they must do chalitza, but they cannot do yibum. If both sisters are each forbidden to one of the brothers as they're related, they're allowed to marry the other one. The Gemara tries to argue based on these cases the implication of the existence of a zika bond, a connection of a sort, between the widow and her brother-in-law, but we say no. The principal issue with this case as to why the yibum is forbidden is as you can't negate the obligation to do yibum from yourself, and if you marry one and the other brother dies, this will cause this issue. It doesn't mention a case of 3 brothers, as that's obvious that he's negating the obligation by marrying one of them, and we don't mention 5 brothers, as it's very unlikely that 2 brothers would die. A similar case, if there are 3 sisters that marry 3 brothers, and all 3 brothers die, and there's 2 brothers to do yibum with, one brother does chalitza with one brother does chalitza with the other, and they both do chalitza with the third. The logic of this is further explained, and some actually disagree, saying that one brother can do chalitza for all of them. According to this latter opinion, there are a few particular cases discussed as to what he holds like and why in regards to these laws. There's further discussion if the principle of zika applies, how, and where. This is further discussed, along with the necessity of all the cases brought in the Mishnah in regards to this principle. There's further qualification on these cases. New Mishnah. There were 3 brothers, 2 of which were married to 2 sisters, or to a woman and her daughter, or even granddaughter. If they became widows, they need chalitza, but they cannot do yibum. But others exempt them even from chalitza. If one of the widows couldn't marry the brother-in-law because they were related, he may do yibum with her sister. If she couldn't marry him because of a mitzvah or sanctity, they do chalitza and cannot do yibum. The Gemara explains the necessity for this repetition to clarify the opinion that says that they're exempt from even chalitza. Still, if there are 2 sisters where one can't marry the brother-in-law due to being related, according to this, the other sister can still do yibum. This is further discussed. New Mishnah. If there's 3 brothers, 2 of which are married to 2 sisters, and the third is unmarried, if the first brother dies childless and the third brother betroths his widow, and then the second brother dies childless, Beis Shammai says the third brother remains with his betrothal and the second widow does neither Yibum or Chalitza, as she's his wife's sister. Beis Hillel would hold that he must divorce his betrothal and do Chalitza with both wives. The Gemara says that this is to dispute the opinion of a Rabbi Yehoshua, which is going to be discussed way later. There's further discussion on the opinions, how they hold betrothal affects which stage of marriage exactly, which is debated, and after a bit it's said to only affect the stage of Erusin, the earlier stage of marriage, where you give a ring or a betrothal document, and this is further discussed. New Mishnah, if there were 3 brothers, 2 of which married 2 sisters, and the third married some other woman, the second brother died, so the third brother did Yibum, marrying the second brother's wife, and then died, the first brother doesn't marry either of them, as they're his wife's sister, and her co-wife. If the third brother only betrothed the second brother's wife before dying, the first brother does Chalitza with his wife, and doesn't do Yibum. The Gemara clarifies, if the third brother didn't even betroth the second wife, the first brother could do Yibum, implying that according to this opinion, the Zika bond does not exist. New Mishnah, if it was the same situation as before, only the third brother, the one married to the unrelated woman, died first, the second brother did Yibum to marry his widow, and then he died, the first brother cannot do Yibum or Chalitza, as they're his wife's sister, and her co-wife. If the second brother betrothed the third brother's widow and then died, the first brother must do Chalitza and cannot do Yibum. The Gemara debates the necessity of this case, as it's very repetitive of the prior, so it's explained that originally this one was taught, and then they switched the rulings on the prior one, and decided to teach it first, but they decided to keep this one in here anyways. New Mishnah, if there are 3 brothers, 2 of which married 2 sisters, and the third brother was married to some other woman, and the second brother died childless, so the third brother did Yibum and then married his wife, and then the first husband's wife died, and then the third brother died childless, the first brother cannot marry the sister of his dead wife, as she was forbidden to him at one point during this. The Gemara adds an opinion that based on a verse, if at the time a woman becomes a widow, she's unable to be with her brother-in-law, she can no longer do Yibum with him forever. This is not redundant from our case, because it adds that she's still not permitted to do Yibum if it became permissible during the actual first Yibum situation. This is implied from other cases. New Mishnah, if there were 3 brothers, 2 of which were married to 2 sisters, and the third was married to some other woman, and the middle husband got divorced, and then the third brother died childless, and the second divorced brother does Yibum to marry the third brother's widow, and then he dies childless, this is the case that the co-wives are permitted to marry the remaining brothers. The Gemara clarifies the logic of this case. It's discussed further, and the different opinions argue, again, if this implies the existence of a Zika bond. New Mishnah, with all of the cases discussed in the first Mishnah of the Tractate, if they were done but within a questionable state of betrothal or divorce, their co-wives require Chalitza and cannot do Yibum. A questionable betrothal would be, for instance, if someone threw the betrothal document to her and it landed close by her, and questionable divorce is where the husband wrote the divorce document himself, but there's no witnesses, or if there are witnesses, but there's no date on the document, or if there is a date, but there's only one witness. The Gemara says that the implication is that if you throw a divorce document near a woman, it's not questionable. Some say the logic is that prior to the questionable divorce, if the husband had died, she would have been allowed to marry anyone, so it doesn't make sense to prohibit her from a questionable event. This is unlike the betrothal, as that's a stringency. Others argue with that, saying that then this stringent, questionable betrothal will be able to override someone else's proper betrothal. This is argued further. We compare it to a case where a house collapses on someone and his brother's daughter, her co-wife, does Chalitza and cannot do Yibum, as we don't know who died first. So there's a few answers as to why this is different than divorce. Some say we're more lenient by divorce, as that's a bit more common. Some say because by divorce the woman is right there and you can clearly show she's not allowed to marry the other, along with her co-wife. It's discussed further at length. There's also discussion as to why there's differences between the divorce and betrothal document. Only divorce documents require a date. According to some, it's to prevent the husband profiting off of her fruit after the divorce, and we need to know when the divorce exactly happened for that. Others say it's because you can also betroth someone with money, which you don't mark a date on, and most do that. And if it's to prevent adultery, it wouldn't help, because no matter who's holding onto the document, they could fake the numbers, either the wife to save herself, or the husband to protect his wife. New Mishnah, if there are 3 brothers who are married to 3 unrelated women, and the first brother dies childless, so the second betrothed his widow and then dies, so both of these women must do Chalitza and cannot do Yibum, as based on the verse, you cannot do Yibum if you have 2 Zika bonds to your brother-in-law. Others say he can do Yibum with one, and do Chalitza with the other. The Gemara discusses the verse which teaches this. Some add if the second brother who betrothed the widow divorced her before he died, then her co-wife, the second brother's original wife, can do Yibum with the third brother. The divorced betrothed woman cannot, as she might be confused with a case where she's receiving an unspecified divorce document where she cannot do Yibum after. Some say she is actually allowed to marry the third brother as she was properly divorced. New Mishnah: if two brothers marry two sisters and one brother dies and the other's wife dies, they cannot marry as she was forbidden to him briefly during this period. The Gemara explains that this is pretty redundant, it's just that this was actually taught first. The earlier Mishnah was cited due to its unique ruling and was then put in first, and this was not removed. In the event that the brother-in-law cohabited with his brother's widow while his own wife, her sister, was still alive, there's debate as to what he violated. Some say just as he was with his brother's wife, some say also that he was with his wife's sister. This is debated. It's argued further as to what prohibitions he violated, and this is practically relevant in regards to where he's going to be buried. There's further particular discussion as to what exactly these opinions hold, one of which does not have a more inclusive prohibition principle, and we give a few examples. The disputed points are further explained. They're explained further, and again, the practical difference as to what the violations were by the cases were in regards to where people are buried. New Mishnah: if two men betrothed two women, and at the time of entering the chuppah, they decided to cohabit with the other one's wife, they're both liable for the prohibition against cohabiting with a married woman. If they were brothers, they'd also be liable for cohabiting with your brother's wife. And if the wives were both sisters, they'd both additionally be liable for cohabiting with your wife's sister. And if the women were menstruating, making them ritually impure as a nida, you'd also violate the principle against cohabiting with a nida. Anyways, if this occurs, the women are separated from their husbands for 3 months to watch for pregnancy, and in regards to this principle, if, God forbid, a minor was cohabited with, she does not need to be concerned about watching for pregnancy over the next few months. Also, if they were the daughters of Kohanim, they'd be disqualified from eating teruma, which is basically produce tithes that can be eaten by Kohanim and their relatives. The Gemara clarifies that this exchange of wives was accidental, and it brings supporting evidence. It debates who the view of this Mishnah is like according to what different people held like by these laws. There's further qualification by this case, such as that the wives have a concern of pregnancy as they cohabited twice, as the first act of cohabitation by a woman cannot make them pregnant, according to one opinion. That's actually disputed, citing many verses in regards to the incident with Tamar, but it's a debated point. There are other particularities mentioned in regards to how and women get pregnant. The remaining points are further discussed. It clarifies the point by the minor girl is an unusual case, hence the lack of an obligation for her to wait 3 months, and there's further disputed opinions in regards to who and in what circumstances does a woman who cohabited and then wants to marry need to wait 3 months after. It also said they cannot eat teruma if they were the daughters of Kohanim, and it says this means that if they're married to Yisraelim, they cannot eat teruma from their home. And that's the end of chapter 3. Chapter 4 of Tractate Yevamos covers some additional laws of the Levirate marriage. The Mishnah says there's a law instituted in regards to the Levirate marriage that Yibum should not be done within 90 days of the husband's death to ensure that the wife is not pregnant prior to the marriage. This would mean that chalitza cannot be done within this period either. If somebody did end up doing chalitza within this period to their brother's widow, and the widow, who as it turned out was actually pregnant, gave birth, as Yibum is not done if the wife has had a child, so the chalitza is thereby retroactively invalidated, and they can now legally marry each other's relatives, and she's still allowed to marry a Kohen. If the child was stillborn or similar, the chalitza actually was valid, so now they cannot marry each other's relatives, and she cannot marry a Kohen. If they did Yibum and got married, and the woman was then found to have been pregnant and gives birth, they have to get a divorce and are liable to bring an offering in the temple. If the baby was stillborn or similar, they can stay married. If there's a question if the child was from the first brother's marriage or a premature child of the new second brother's Yibum marriage, they must divorce, bring an Asham Taloi offering, and the child is legitimate as both marriages were legally valid. The Gemara says a related point: if a brother does chalitza with his brother's pregnant widow, and she then miscarried, there's a debate if they need to redo chalitza based on if you hold the first chalitza was valid. Some say this debate is illogical as to whether we say that the retroactive non-viability of the child works, and some say it's disputed based on a verse. We try to prove from a number of related cases as to which one we hold like. There are further cases brought and disputed, however, in the end we say we hold like the ruling of Reish Lakish, who held that they need to redo chalitza. It also says in addition there are some other things we rule in accordance with the opinion of Reish Lakish, such as that when somebody is delineating their property to be given to their child and he wants to adjust the particular amounts, it's permissible if it's done as a gift and you specify that the term gift applies to both recipients. The other thing we rule like Reish Lakish is if a son has a pending inheritance from his still alive father and the son preemptively sells it and then dies while the father is still alive, Reish Lakish says this is a valid sale. Once the father dies, as he holds ownership of the rights to property, is not the same as owning the property itself. So the father did not actually own the property at the time of sale. Anyways, back to Yibum. We said if you marry somebody through Yibum, she's found to be pregnant, and the baby is stillborn, you can stay married. It says here that others disagree and require a divorce, and there are similar opinions cited. We say from a different source that if a child dies within 30 days, it's considered to have been non-viable, and this is used to discuss some related points. It also says if someone betroths a woman within 3 months of her leaving her first husband and then runs away, some say that they put a ban on him, which basically just means he's treated similar to a mourner. Some say this is sufficient to end the betrothal, which was ruled like by a case where this occurred. In the case where the child could have been born from either husband, it's where the woman gave birth at 7 months and her fetus wasn't noticeable at a third of the days of her pregnancy, so we don't rule with her like we would by majority. There are related points in regards to the uncertain status of some of these children. This is discussed along with some different inheritance disputes that can arise if a child is born within a time frame where it could have been from 2 different husbands. There are a few of such cases brought, and these are discussed further. New Mishnah. If a woman whose husband passed is waiting for her brother-in-law to do Yibum or not with her, and then she inherits property from her father, everybody agrees she can sell it or give it away. If she dies during this period, Beis Shammai says the marriage contract and the inheritance is split between the wife's family and her brother-in-law's family. Beis Hillel says everything stays with whoever owns it, so the marriage contract stays with her brother-in-law and the inheritance stays with her parents. If their brother-in-law did Yibum to marry her, they are considered married in all respects, besides that the marriage contract obligation stays on the estate of her first husband. The Gemara clarifies, according to the sage Ula, the difference between the first case, where everyone agrees that she receives her father's inheritance, is where the first brother died while she was in Arusa, the first stage of marriage, while the disputed case is where he died while she was a Nesua, the completed stage of marriage. Some disagree, specifically Rabbah, and say both cases are where she's a Nesua, having fully completed marriage, but the first case was where she's alive and has a definite claim, unlike the husband's heirs, while in the second case she died, so both claims are uncertain. This is further disputed, and the sage Abaya has his opinion, saying the first case is where she inherited the properties while pending Yibum, and the latter case is where she's still married to her first husband. These opinions argue with one another, and the remaining cases are discussed. New Mishnah. The mitzvah of Yibum falls to the oldest brother. If he's unwilling, you go to the younger brothers. If they're unwilling to do it, you go to the older brother and tell him to do Yibum or Chalitza. If it was deferred to a minor brother until he comes of age, or to an older brother until he arrives from overseas, or to a deaf, mute, or insane person, this is not allowed, and we force him to decide between Yibum or Chalitza. The Gemara cites a dispute between if it's preferable to do Yibum with a younger brother or Chalitza with the older brother. Some say Yibum with the younger brother is better, as the main obligation is with Yibum. Others say that Chalitza by the older brother is preferable, as they hold the younger brother has no obligation in doing Yibum at all. This is debated between these opinions. Others say that actually both say Yibum from a younger brother is preferable, and the dispute is actually between Chalitza of an older or younger brother as to which is preferred. Some say it's better if the older brother does it, as he has the obligation. Some say the preference of the older brother is only by Yibum. It just really doesn't matter who does it by Chalitza, and this is further discussed. There are further related points, including on the validity of certain forms of matzah on Passover. New Mishnah. If someone does Chalitza with his brother's widow in regards to inheritance, he's treated like all the other brothers. If the dead brother's father is still alive, the inheritance would go to him, unless the other brother did Yibum, in which case the inheritance would go to him. Others say it always goes to the father. The Gemara says that it stated that the brother who did Chalitza has the same inheritance as his other brothers, as you might have thought that he would have lost his inheritance as he prevented her from ever doing Yibum. We bring sources, and it says we follow the opinion that the inheritance always goes to the father, which is based on a verse which is discussed. New Mishnah. If someone does Chalitza, they can no longer marry each other's relatives. It lists several examples and says the other brothers can marry into the other family. Also, a man is allowed to marry the co-wife of the woman he did Chalitza with, but he cannot marry the co-wife of the relative of the woman he did Chalitza with. The Gemara asks if secondary relatives are also prohibited from marriage in a case where chalitza was done. There are a number of proofs brought, but in the end we say from a source that they cannot marry secondary relatives. An additional rule, it says if someone has relations with the co-wife of the woman he did chalitza with, the child born from this is illegitimate, which is based off of our discussion. Also, the difference between the woman's co-wife and her relative's co-wife is that the relatives go with the woman to court to get the chalitza, so it was ruled that they're treated similar to the woman who received chalitza herself. The woman's actual co-wife does not go to court, so they're not forbidden to marry. New Mishnah. If someone does chalitza with a widow, and his brother then married her sister, and then dies, they must do chalitza and cannot do yibum. Similarly, if someone divorces their wife and his brother marries her sister and dies childless, she's exempt from chalitza and yibum. If a woman was pending her yibum with her brother-in-law and then his brother betrothed her sister, some say we should tell them to hold off the completion of their marriage until the chalitza is done. Even if the widow dies before they could do chalitza, the siblings can still marry each other. If the brother-in-law dies, then the other brother must divorce his new wife and do chalitza with the widow. The Gemara asks, we said similarly by the first two cases, where one was pending yibum and the other was divorced. But the rulings are different. Some say it actually said however, not similarly. In fact, marrying the sister of a divorced wife is biblically prohibited, while marrying the sister of one who did chalitza is only rabbinically prohibited. It also mentions that we rule like the latter opinion of the Mishnah. There's a dispute if someone is marrying the sister of a woman who is pending yibum and his wife died, can he do yibum with the widow? Some say yes, as she's considered a woman who was permitted, then forbidden, then re-permitted, so she reverts to her original status. This logic is further debated, and others disagree. New Mishnah, a woman cannot do chalitza or yibum until after 3 months of her husband's passing to see whether she's pregnant. This also applies to all the other previously married women, virgins, non-virgins, divorcee, widows, etc. Others disagree. Rabbi Yehuda says that you don't need to make such a delay after betrothal unless you're from Judea, as there was a concern that people were actually cohabiting with their brides during betrothal. Rabbi Yossi also disagrees, saying any previously married woman can immediately remarry, besides for a widow because she needs to mourn. The Gemara asks, out of concern of pregnancy, it makes sense to not do yibum during the first 3 months, but why can't you do this after chalitza? They're not even marrying. Some suggest this is another refutation of the opinion that you can do chalitza while pregnant. Some suggest it's as the child could be born, retroactively removing the necessity for chalitza and allowing the woman to marry a Kohen, which would need to be announced, which is debated. And others say it's as the verse seems to imply, that if you cannot do yibum, you also cannot do chalitza during that period either. This is further discussed, along with a related case. A woman by yibum must wait 3 months, as she cannot get married to her brother-in-law if she was pregnant with child from the prior marriage. But what's the issue with all of the other women from marrying immediately after? So we say, based on a verse, that people shouldn't have ambiguous lineages. There are instances of this given, and some say the issue is that then people might accidentally marry their relatives if they don't know precisely who their father was. She must wait 3 months, and not less, out of concern that the pregnancy was delayed, which is described further. It also says, if you're certain the woman's pregnant, you still need to delay out of worry that if you are intimate while pregnant, it could damage the fetus. But what's the difference between normally cohabiting with your pregnant wife, which is permissible? There are a few answers given, and we say that if she becomes pregnant while nursing, it could mess up her milk, and with your own wife, the husband would pay for nursing alternatives, but there's a concern where it's not the husband's child that he won't provide an alternative, and she'll be too embarrassed to collect her funds from the prior marriage, and her nursing will be damaged and the child will die. These points are further described. It also covers some specific laws of impurity in regards to combs. In regards to waiting 3 months, several sources say you don't need to wait 3 full months, you can marry in the middle of the third. Some disagree. In the end, the ruling is that a nursing woman must wait 24 months before marriage, not including the day the child was born, or the day she enters Erusin, the first stage of marriage, and a widow must wait 3 months, not including the day her husband died, and not including the day she enters Erusin. We said a widow must wait to marry, as she's mourning, but why should that prevent marriage if she's allowed to even launder clothing, which based on another discussion by the fast of Tisha B'Av is shown to be more strict? It's discussed. We amend the Mishnah to be talking about the later final stage of marriage, so there's no comparison. This is further debated at length. There are a number of further suggestions offered as to the variance between cases. In the end, we say there's a difference between ancient mourning and current mourning, and also there's a difference between communal mourning and personal mourning, so the cases are really not comparable. New Mishnah. If 4 brothers were married to 4 women and they all died, their older brother is allowed to do Yibum with all of the wives. If one was married to 2 women and he died, doing Yibum or Chalitza with one of them releases the co-wife from this obligation. If one of the widows was qualified to marry a Kohen and the other was not, if the brother is doing Chalitza, he should do it with the disqualified one. If he's doing Yibum, he can marry whichever one he wants, obviously assuming he's not a Kohen. The Gemara clarifies the case and disputes a bit in verses which are discussed. The point on doing Chalitza with the disqualified woman is as Chalitza disqualifies a woman from marrying a Kohen, so you may as well do it to the woman that's already been disqualified, so as to not cause issues for another woman. New Mishnah. Rabbi Akiva holds that if someone remarried his divorcee after she had remarried, or if you marry a woman you did Chalitza with, or her relative, you need to divorce, and the child is illegitimate, a mamzer. The rabbis say the child is not a mamzer unless you're marrying the relative of your divorcee, in which case it is. The Gemara suggests that Rabbi Akiva actually also meant the relative of a divorcee, not the relative of a woman you did Chalitza with, which is supported based on some sources, but they're disputed, and in the end we say, no, he actually meant you're biblically forbidden to marry the relative of a woman you do Chalitza with, and there are verses brought to prove this. Some say everybody agrees that if someone marries their divorcee, their daughter cannot marry a Kohen, and this includes a later discussed opinion of Rabbi Yeshua. Similarly, it's said, according to some, that everybody agrees that if a Canaanite slave or a non-Jewish person has relations with a Jewish woman, the resulting child is a mamzer. There's some debate as to who this opinion includes, and some disagree, saying their child actually is valid. This is for the qualified along with some specific instances. There are a few more cases discussed in this regard. In the end, it says the final ruling is that if a slave or a non-Jewish person have a child with a Jewish woman, the child is still legitimate whether she's married or not. There are a few more related instances brought. There's some discussion on the process as to how a slave would convert. There's further instances on the requirements for conversion in general. Some say it's circumcision and immersion in a mikvah. Some say this immersion can be done on Shabbos, and it's further discussed. It also goes through many of the verses on this topic and further qualifies the exact process of conversion. You have to ask them why they want to and explain that being Jewish is actually extremely difficult with constant hardship and oppression, and if they still want to convert, we accept it, and we teach them the mitzvahs and their laws as to how they'll apply strictly to him now that he's Jewish, and that we don't receive abundance of good or punishment and other points, and if he still wants to convert, he's circumcised, and after he's healed, he immerses in a mikvah, and he's further taught the mitzvahs and obligations of being Jewish, and he's a Jew once he immerses. If it's a woman that's converting, she's immersed by women, and the people teaching the Torah and mitzvahs do it outside. We spend so much time discouraging potential converts, as if converts don't properly abide by the laws of Judaism, it's very problematic, so you gotta make sure people are really serious about joining first. Therefore, the points on this topic, further expounding on the sequence and the reasons. The points and sources are further discussed, and this is all qualified further. New Mishnah. Rabbi Akiva says a mamzer is defined as any child born from a cohabitation which violated a negative commandment. Rabbi Shimon HaTimni says it's a child born of cohabitation that is punishable by kares, which is what we hold like. Rabbi Yeshua says it's a child born of a cohabitation that is punishable by capital punishment from the court, and there are sources which support his view. If someone's wife died, he can marry her sister. If he divorced his wife and then she died, he can marry her sister. If she married someone else after the divorce and then died, he can marry her sister. If the woman you are going to do Yibum with died, you can marry her sister. If he did Chalitza and then she died, he can marry her sister. If after Chalitza she married somebody else and then died, you can marry her sister. The Gemara cites verses as sources for the different opinions as to what defines a mamzer. These are discussed along with some discussion as to how the prophet Yeshaya died. He was killed by Menashe, who wanted to kill him, as he felt he had prophesied falsely, so Yeshaya said God's name and was swallowed by a cedar tree, but then Menashe had the tree cut down, killing him. These verses are further spoken on. It also says, some say the last part of the Mishnah is actually redundant, and that's the end of chapter 4. Chapter 5 of Tractate Yevamos deals with some further particularities in regards to the laws of the Levirate marriage, specifically points on betrothal or divorce, which are basically less effective methods of Yibum or Chalitza in their situation. The Mishnah says, in regards to the laws of Yibum, if the marriage falls between 2 widows or 2 brothers, there's no validity to the second divorce document, or to a second betrothal, or to a second Yibum, or to a second Chalitza. The rabbis say there is actually validity to a second divorce document or to a second betrothal. If a brother-in-law betrothed the widow and then divorces her, he still needs to do Chalitza. If he betrothed her and then did Chalitza, he needs to divorce her. If he betrothed her and then did Yibum, that makes a valid marriage. If he divorced her and then betrothed her, he needs to divorce her and do chalitza. If he divorced her and did yibum, he needs to divorce her and do chalitza. If he divorced her and did chalitza, that's the end of things there. If he did chalitza and betrothed, divorced, or did yibum and then betrothed, divorced, or did chalitza, there's no validity to anything after chalitza is done. This applies by one brother-in-law and one widow, and also with one brother-in-law and two widows. If he betrothed both, they both require divorce and chalitza. If he betrothed one and divorced the other, the betrothed one must be divorced with chalitza. If he betrothed one and did yibum with the other, they both must be divorced and do chalitza. If he betrothed one and did chalitza with the other, the first must be divorced. If he divorced both, he does chalitza to them. If he divorced one and did yibum with the other, she needs divorce and chalitza. If he divorced one and betrothed the other, she needs divorce and chalitza. If he divorced one and did chalitza with the other, the chalitza ends anything further. If he did chalitza with both, or did chalitza with one and betrothed, divorced, or did yibum with the other, or he did yibum with both, or did yibum with one and betrothed, divorced, or did chalitza to the other, the rule is that there's no validity to anything after chalitza. This would apply if there's two brother-in-laws and a widow, or two widows and a brother-in-law. If the brother-in-law did chalitza with the widow and then betrothed her, divorced her, or did yibum, there's no validity to anything after chalitza, no matter when it's done in the sequence. If he did yibum and also betrothed her, divorced her, or did chalitza, if the yibum was done first, there's no validity to anything after, but if it was done in the middle or end, there is validity to things after. Rabbi Nechemiah holds that by both yibum or chalitza, no matter where they're done, there's no validity to anything done after. The Gemara discusses the logic of these points. There's further qualification discussed by these particular cases, and the more precise details are all discussed further. There's also debate as to the rabbinic punishment instituted for the violation of some of these principles. Some say lashes, and there's points on how exactly betrothal is done, with either an item worth an amount of money or with a document, the text of which is described. There are additional points. There's some unresolved discussion by particularities of certain divorce documents and further points on the remaining cases. There's also particularities. It's decided that all opinions agree that there is validity to a chalitza done with stipulation, but that's not being discussed in our case. There's further discussion on these points. It also goes through which opinions hold which statements from the Mishnah, which is explained in accordance to their particular opinions. And that's the end of chapter 5. Chapter 6 of Tractate Yevamos continues points on the practice of the Levirate marriage, now on particularities as to the actual performance of the yibum service. The Mishnah says, if someone cohabited with the woman he was to do a yibum with, whether on accident, not with this as his intent, under coercion, or willingly, no matter which of them is in any of these situations, it's valid to do yibum and they're married, and there's no particularities in regards to the manner of cohabitation. These principles of cohabitation would also apply in regards to not being with any of the forbidden listed relatives, or someone disqualified from marriage, like a widow to a Kohen Gadol, or someone who did chalitza, or to a divorcee to a Kohen, or otherwise. The Gemara says that even when the male cohabited on accident and the woman did so with improper intents, even though neither intended to do the mitzvah, it's still valid. There's a lot of debate as to what exactly it means to be coerced to cohabit with someone. Some suggest that he was forced, literally. Some say he was sleeping while it occurred. Some say the case is that he fell off a roof and landed on and in a way that resulted in him cohabiting with a woman. These are all disputed. Instead, the suggested case is where he intended to cohabit with his wife, but the other woman was there somehow instead. The case where they were both coerced is where they were literally forced by others to cohabit with each other. And sources are brought which are discussed. There's also debate if you can do yibum by cohabiting while you're asleep. It's disputed. Some say there's a difference between sleeping and dozing, which is defined. Another ruling, if somebody falls off a roof and lands on a woman cohabiting with her, he's liable to pay her for damage, pain, unemployment, and medical costs, but not for humiliation, as that's only paid if it's intentional. And also, this is not a valid form of yibum. Also, if someone intended to press themselves against a wall, but the widow somehow got in the way, this is also not a valid form of yibum. For such a circumstance to somehow work, you have to be pressing yourself against something with actual intent to cohabit with it, and the woman to somehow get in the way for this to be a valid form of yibum. There's sources listed that even the act of beginning cohabitation is sufficient to do Yibum, which is further discussed. There are more sources for this which are also qualified, and there are several other verses on this topic discussed. It also goes through some times where the Torah specifies the necessity for complete cohabitation, each of which is relevant by a particular situation. There's particular debate as to what precise physical action constitutes the legal beginning of cohabitation. In addition, we said if he cohabits with the woman to any extent, he's acquired her for Yibum. Some interpret this to mean that he's fully properly done Yibum. Others say it means that this isn't a fully proper method of Yibum, and he's acquired her in accordance to what the verse references, which is to inherit his brother's estate, and to free her from the attachment of Yibum. This is for the qualified, along with some specific cases in regards to eating teruma in regards to the laws of marriage. There's also points on the continued permissibility of a woman to her husband if she cohabits with somebody else. If it was consensual, meaning it was effectively adultery, she can no longer be with her husband. If it was not consensual, she can still be with her husband, but it implies that if the husband was a Kohen, they can no longer be married. This is further debated. New Mishnah. If a widow impermissibly married a Kohen Gadol, or a divorcee, or a woman who did Chalitza impermissibly married a Kohen from the first stage of marriage, Erosin, they cannot eat teruma, which is food tithes that can be eaten by Kohanim and their relatives. Others disagree and say that they can. If these women were then widowed or divorced from these marriages, if this occurred after the final stage of marriage, Nisuin, they are disqualified from marrying a Kohen. If it was before, by the stage of Erosin, they are still permitted to marry a Kohen. The Gemara debates the logic of the opinion that says they can eat the teruma. There's a specific case brought. If a Kohen with damaged genitals betrothed a woman, this is a dispute, as according to our opinions, who said a woman awaiting biblically forbidden cohabitation cannot eat teruma, while the others say she can. It's explained that the cases are comparable. Abaya says as she can eat teruma if he's not cohabiting with her after becoming injured, and Rava says as there are others who are now allowed to eat teruma, being their slave. Abaya did not hold like Rava here, as he says you can derive laws of matrimonial acquisition from other laws of matrimonial acquisition, and not from acquisition of slaves. Rava would disagree with Abaya, as by the case of the injury, she was eating teruma before he got injured. This is further debated. There's also a question if a maimed Kohen can marry the daughters of a convert. It's disputed who this question was asked in accordance with. It said she's allowed to marry a Kohen, but is not fully considered to be a part of the Jewish people, so could eat teruma if married to a Kohen. With all the cases where a Kohen marries someone forbidden to her, there's dispute if the chuppah, the formal entry of the bride into the husband's domain to complete the marriage, if this has any legal significance. Shmuel and Rav hold that, as discussed by a later case, if, God forbid, a Kohen marries a girl 3 years or younger, she still cannot be legally cohabited with, and cannot legally do chuppah, unlike a girl above that age where cohabitation would be considered legally significant, although it goes without saying that that's not something that should be done ever. There's further dispute on other points in regards to eating teruma by the laws of marriage. There's additional particularities discussed in another case, in the event that a Kohen Gadol betrothed a minor to wait until she became of age, a bogeres, as it's called, before finalizing the marriage. There's dispute if this is legally permissible, and it implies no, but this is not comparable to the case of a widow, as the difference between cases is that the widow does not physically change between the stages of marriage. New Mishnah. A Kohen Gadol can only marry a virgin, so he cannot marry a widow, no matter if she was widowed during the marriage stages of Erosin or Nisuin, and there's debate if he can marry a bogeres. He also may not marry a woman who is not a virgin due to being injured by a piece of wood. The Gemara cites verses that show he can't marry the widows. The dispute if she can marry a bogeres is in regards to dispute over the implication of a verse, in regards to particularities as to the level of virginity the woman must have. There's dispute if this is still permissible if the woman has had relations before, albeit not in the typical manner. There are additional points on this. It mentions if a woman was violated by an animal, this does not render her unfit to marry a Kohen, and that a Kohen Gadol cannot marry a woman that he had violated or consensually cohabited with premaritally. And some say he does need to divorce her if they marry, although he wouldn't need to pay the typical fine for consensually cohabiting with her premaritally. Others disagree, and it's discussed. This is all further qualified. There are a few specific instances. It mentions we hold like the opinion that says a Kohen can marry a woman who had converted while she was a child younger than 3, which is further discussed. There are additional points. New Mishnah. If a Kohen started marrying a woman, the first stage, Erosan, and then became a Kohen Gadol before completing the marriage, he can still marry her. It mentions an instance where this occurred. If a woman was pending Yibum with her brother-in-law, a Kohen, who then was appointed to be a Kohen Gadol. Even if he betrothed her beforehand, he cannot marry her. The Gemara cites sources for these points and discusses the instance where this occurred. New Mishnah: if a Kohen Gadol's brother died, he does chalitza with the widow, not Yibum. The Gemara said this would apply if the widow had been fully married or was still in the first stage, even though if she's only an Erosa, she hadn't cohabited yet out of concern that he might fulfill his obligation of cohabiting with her to the Yibum, and then might do it a second time, which is forbidden as she's a widow. New Mishnah: a Kohen cannot marry an Ailonis, a woman with a condition that causes her to exhibit physical male characteristics, probably Turner syndrome or something similar, unless he already had a wife or children. Others say he still can't marry her, even if he has a wife or kids, as the marriage is forbidden by the Torah, which says he can't marry a Zona, which he defines as someone who can't have kids. Others define it as a female convert, a freed slave woman, or someone who had cohabited impermissibly. The Gemara further expounds on the logic of these opinions. There are other opinions as to what exactly constitutes a Zona. Some say it's an adulteress, some say it's a woman who is willing to cohabit with any person, some say it's someone who cohabits with their husband after being accused of adultery, some say it's an Ailonis, some say it's a female convert, or a freed slave woman, or a woman who had cohabited impermissibly. Others say it's an unmarried woman who cohabited with an unmarried man without intent to marry. It also discusses the impermissibility of a Kohen to marry a minor, which is discussed, and further additional points. New Mishnah: a man is not allowed to abstain from procreation unless he already has children. Beis Shammai says he must have 2 male children. Beis Hillel says he must have a male and a female, as the verse says he created them male and female. The Gemara says if he has children, he's not obligated to procreate if he has children, but he is still obligated to be married. In such a case, some say you'd be allowed to marry a woman who can't have children, and there's a practical difference by selling a Torah scroll to marry a woman. It's only allowed if he does not yet have children. The explanation of the opinions of Beis Shammai and Beis Hillel in regards to the children you'd need to have to fulfill your obligation are discussed. Moshe abstained from procreation after having 2 sons, but that's not a viable proof, as that was one of the 3 things Moshe did based off his own logic, that he permanently separated from his wife. As he always spoke with the divine presence, he broke the 2 tablets based on the logic that an apostate can't give the paschal offering, so for sure they shouldn't be able to receive the whole Torah, which God actually commended, and he also added a day of abstinence to the Jewish people before accepting the Torah based on the verse, including the day that the command was given. This is further discussed. It mentions if a person converted, so there's a dispute if his children from before the conversion fulfill his obligation to have children. Some say yes, as he has children. Some say no, as conversion legally resets all of your familial relationships. There's a similar argument if a convert can have a firstborn son from before his conversion in regards to the laws of inheritance. We need both of these cases to be brought, as some say non-Jewish people are also obligated in this requirement to have children. This for the discussion on this topic. There's debate if 2 grandchildren from a single child is sufficient to fulfill this obligation, based on if grandchildren are regarded as children, which is a disputed point. Some say a person should never abstain from having children. Similarly, Rabbi Akiva said a person should never abstain from learning Torah and having students, no matter his age, which is seen from the fact that Rabbi Akiva had 12,000 pairs of students, and they all died from a plague of diphtheria between Passover and Shavuos, because they didn't treat each other with respect. So he only had 5 students left: Rabbi Meir, Rabbi Yehuda, Rabbi Yossi, Rabbi Shimon, and Rabbi Elazar ben Shammua, and he continued to teach them from there. A side point: the day that this plague ended, and also the day his student Rabbi Shimon Bar Yochai passed, have been instituted as a holiday, the holiday of Lag BaOmer. Anyways, we hold like this opinion that a person should never abstain from having children. There are other miscellaneous points on the high importance of being married, saying without it a man has no Torah or peace or similar, and it speaks about the conjugal obligation of a husband to his wife. There's a lot more on this, several other points on the importance of choosing a good partner, an expansion on a few verses, and good business and agricultural practices. It also speaks on a few instances of individuals whose wives would aggravate them, and related points. There's a lot more instances on marrying a good wife and examples as to what constitutes a not good one, and quotes from other texts more on the importance of marrying a good woman. There are additional points on this. New Mishnah: if a man married a woman and stayed with her for 10 years and she did not have children, he must marry a new wife. If he divorced her, she can marry someone else and try again. If she miscarried, the 10 years are recounted from the miscarriage. The Gemara discusses based on this how the forefathers Avraham and Yitzchak stayed married to their wives as they were infertile for several years. Also, it mentions that God answered Yitzchak's prayer even though both him and his wife were answered, as Yitzchak was a righteous man, the son of a righteous man. It also says that the forefathers were infertile as God desires the prayers of the righteous. Some say it was an exceptionally great miracle that Abraham and his wife Sarah had a child based on verses. Some say that both of them were tumtumim, with covered reproductive organs. Some say Sarah didn't even have a uterus. Some say the 10-year marriage limit without children is actually reduced to 2.5 years, as lifespans were shorter in later generations. Some say it's 3 years, as discussed. Some say if they don't have a child after this period, while she can remarry, she can't remarry a third time. There's further discussion. Some say she could remarry for the third time someone who already has children, and if she married someone who does not have children, she must divorce without receiving the stipulated payment from her marriage contract. There's further qualification. Some say if a woman miscarried 3 times, she must be divorced, and there's a dispute as to what to do if she miscarried twice and claims she miscarried a third time. It's ruled that we believe her, as she wouldn't want to be established as a woman who frequently miscarried. New Mishnah. It's an obligation to be fruitful and multiply, which applies to men, and some say it also applies to women. The Gemara brings and discusses the verses as source. It also says a ruling, the same way it's a mitzvah to rebuke someone if they'll accept it. It's also a mitzvah to not rebuke somebody if they won't accept it. Some say it's even a mitzvah to not tell the truth if it'll keep the peace between people, as learned from the incident with Yosef and his brothers, and Shmuel secretly anointing David. There's dispute as to who we follow in regards to if it's also a woman who has the obligation to have children. This is further discussed. It concludes that women are exempt from this obligation, and it gives an instance of a case where the rabbis forced a man to fully free his half-slave so she could marry a free man, but that was only done as she was frequently cohabiting with other men. And that's the end of chapter 6. Chapter 7 of Tractate Yevamos further goes through additional laws of the Levirate marriage. The Mishnah says if a widow is married to a Kohen Gadol, which is impermissible, or a divorcee, or a woman who did Chalitza, is married to a Kohen, the woman's property, which has the designation of either Son Barzel, an item of assessed value, which is declared to the status, and is returned to the woman in the event of the marriage's termination, or the designation of Milog, which is basically everything else, and if the marriage terminates, she gets the value of the item as is, meaning not accounting for its original amount. Anyways, if she had slaves, if they were designated as Milog, they cannot eat teruma, and if they die or go up in value, it's her loss or gain. If they're designated as Son Barzel, they can eat teruma, and if they die or go up in value, the value goes to the husband. If the daughter of a Yisrael marries a Kohen and has slaves of either sort, they can eat teruma. If the daughter of a Kohen marries a non-Kohen and had slaves of either sort, they cannot eat teruma. The Gemara debates this point from a source which implies that the slave of the wife of a Kohen can also eat teruma, regardless of the status of the wife, but this is different here as it's a widow who can't eat teruma herself, so therefore can't allow others to, which is a bit of a general rule. Others disagree and say that actually they can eat teruma. The point is that they want to cause issues, so the widow divorces him, therefore, as it's a forbidden marriage. Others say it's forbidden out of concern that she'll continue giving them teruma after the husband had died, and this applies by all widows married to a Kohen Gadol. It further defines the different property statuses of Milog and Son Barzel, which are further discussed, and there are some additional points on this. New Mishnah. Rabbi Yossi says, if a Yisrael's daughter marries a Kohen and the Kohen dies, leaving her pregnant, her Son Barzel slaves can't eat teruma due to the fetus in the womb, which disqualifies them from eating the teruma. The rabbis say by that logic that would also apply to a Kohen's daughter too. The Gemara asks why exactly the fetus disqualifies them from eating teruma, possibly as it's a non-Kohen while it's a fetus, so there's no Kohen to make the teruma permissible. Possibly because an unborn Kohen can't entitle others to eat teruma. There's a practical difference if the fetus is a girl. There's debate as to which one is the issue. Some say if there are other children besides for the fetus, slaves can eat teruma in their account, or possibly from the father's brothers, or even his other relatives. This topic is further discussed. Some say a daughter entitles others to eat teruma along with a son, unlike by just a son in a case where it's a meager estate, which is qualified. New Mishnah. A fetus, somebody requiring yibum, somebody going through betrothal, a deaf-mute, and a boy 9 years and a day old disqualify others from eating teruma, but cannot entitle others to eat teruma on their account. This would also apply if there's a doubt if the boy is 9 years and a day old, or if there's a doubt if the betrothed boy has fully reached the necessary stage of physical development. If a house fell on him and his brother's daughter, and you don't know which died first, her co-wife does chalitza and cannot do yibum. The Gemara qualifies points on these laws. The explanation is provided for these instances, and specifics on these situations are discussed. It also speaks on sources for these points from Scripture. There's further discussion on other prohibited unions which prohibit a woman, and disputes on second-generation Egyptians or Edomites and similar. New Mishnah: someone who violates or seduces a woman or is deranged, they do not disqualify the woman they cohabited with from eating truma, and they do not get to eat truma themselves. If they are unfit to marry a Jewish person, they would disqualify her. It gives specific instances of several of these cases. The Gemara further discusses these points, and it brings verses as sources, and it goes through some of the specific case instances and qualifies them. And that's the end of chapter 7. Chapter 8 of Tractate Yevamos covers additional laws on the Levirate marriage, and also on the permissibility of people connected to Kohanim eating truma, which is produce tithes that are given to Kohanim. The Mishnah says an uncircumcised person and someone ritually impure cannot eat truma, but their wives and slaves can. If a Kohen had injured genitals, his slaves can eat truma, but his wife cannot. If he had not cohabited with his wife after his genitals had gotten injured, his wife can eat truma. It gives definition as to what exactly constitutes a genital injury. The Gemara cites the scriptural source for these rulings, which are discussed as to how this is derived from their words. It also is learned from a comparison to a verse about the Paschal offering, which is further qualified in regards to how we know an uncircumcised individual cannot eat truma. There are further verses on this topic discussed. It also speaks on specific cases of a lack of circumcision disqualifying individuals from the Paschal offering, and also some say that they can still be purified from ritual impurity. There are other particular verses mentioned on specifics with the practice of circumcision. Some say the Jewish people born in the desert were not circumcised until they crossed the Jordan River and entered Israel, as they were tired from the journey, or because the north wind didn't blow for them, possibly as God was rebuking them, possibly so the clouds of glory wouldn't disperse. Based on this, some say not to circumcise or draw blood on a cloudy or extremely windy day, but it says now that everybody does it, so God will protect them. There are issues cited with someone who is circumcised, but his skin is in a way that he looks uncircumcised, with such an individual eating truma. Some say he can't, others dispute this, and sources are cited. This is further discussed, and it also debates if an uncircumcised person is allowed to perform the water sprinkling for ritual impurity on somebody else. It's disputed. This is discussed. It's debated if an uncircumcised person can eat Ma'aser Sheni tithes based on how it's compared to the Paschal offering. There's also a dispute if a mourner is permitted to eat Ma'aser Sheni tithes or Bikurim, the first fruit tithes, and the opinions that say you can or can't cite verses which imply like their opinions, and this whole thing is further discussed. This whole topic in regards to a lack of circumcision or a lack of proper circumcision as to who can eat Ma'aser Sheni tithes is further qualified with several proofs from a bunch of different sources brought. It also brings the verse sources that an impure person cannot eat truma. These verses are further discussed. This is all explained further, and it also argues over who the source is for the point against a Kohen with injured genitals from his wife eating truma, and it further qualifies what exactly constitutes an injured genital. There are several possible different forms of injuries listed in detail, be they punctures or cuts, and how severe the wounds need to be, etc. There are a few other particularities that constitute a genital injury. It also says we don't hold like the opinion that if somebody urinates from two places, he's unfit to marry, and it also says if a person and a woman cohabit without intent to marry, this constitutes the woman as a zona. But if the woman had relations with another woman, this does not legally constitute as cohabitation, so they're not rendered a zona, but it says it's still generally improper. New Mishnah: somebody with injured genitals can still marry a convert or a freed slave woman, but they can't marry a regular Jewish woman. This is based on the verse, one with wounded or crushed testicles or whose member is severed may not enter the congregation of God. The Gemara debates by this if a Kohen is allowed to marry these women, as he normally cannot, but perhaps now he can due to his unique injured state. We bring a proof that he would be allowed to, as his state of sanctity is removed after this injury. It also debates if the prohibition against intermarriage applies by a legally binding marriage, which is debated based on some verses on King Shlomo with the Pharaoh's daughter who he married. There's further discussion by these points. New Mishnah: an Ammonite or a Moabite convert and their descendants are not permitted to marry Jewish people. Female Ammonite and Moabite converts can. An Egyptian and Edomite convert can't marry in for 3 generations, both for male and female. Rabbi Shimon allows the marriage immediately, which is based on a comparison to the others, which some doubt, but he says it's also just a law passed on from tradition. The Gemara cites verses as a source for these rulings, and it discusses some related verses about David and King Shaul. There are several other verses on this discussed and expounded on about King David, and further points in the source for the prohibition of the daughter of Ammonite converts from marrying a Cohen, which is compared to a Cohen Gadol cohabiting with a widow, along with other related points, and these topics are all discussed further. There are also related verses brought, and some other rulings, like if a second-generation Egyptian convert married a first-generation female Egyptian convert, their son is classified as a third-generation Egyptian convert, which implies we go according to the father, but other sources imply we go like the mother, but that source is an exception, as it's where the mother was a slave woman, which had unique laws. This is further debated, and there are sources that say it does actually go in accordance with the mother. There are other opinions on this discussed. Some say if they've converted, you follow the more blemished of the two, meaning if a male Ammonite convert married a female Egyptian convert, if the child is male, he goes after his Ammonite father. If it's a female, she goes after her Egyptian mother. New Mishnah. A mamzer, a child born from a forbidden cohabitation, and the Chivite inhabitants of Gibeon that tricked Yeshua into being converted during the conquering of Israel as described in the books of prophets, are forever not allowed to marry into the Jewish people, both men and women. The Gemara says a dissenting opinion that a female mamzer is allowed to marry into the Jewish people after 10 generations, and it brings a source. Some say this is not even an issue, as mamzerim are said to not have their line continue for any generations if they're not publicly known about. If only some know about their status, it's said that their line will continue for 3 generations. There's an incident mentioned where a sage publicly declared a man as a mamzer so that way God would allow him to live. The verses regarding the Gibeonites are all discussed, and there are several other verses related. It also says, eventually the sages decided to release those people from the servitude they had sworn to from the times of Yeshua, which they did, and also the altar in the temple had no ownership over them, as this was after the destruction of the temple. New Mishnah. A saris, a sterile man, either from castration or a disorder, is said to be allowed to do chalitza and have chalitza performed after his death, but then they also say that they can't, which is seemingly contradictory, so there are some explanations. Some say this means that a saris adam, a sterile male from castration, is allowed to do chalitza, as there was a period where he was viable. A saris chama, a sterile male from birth from a disorder, would not be allowed to do chalitza because he was never viable. Others say it's the exact opposite. A saris chama can do chalitza as he has the possibility of a cure, unlike by a saris adam, as he's castrated. There's an incident which implies like the first opinion. Anyways, a saris, or an ilonis, a woman who does not physically mature in a typical manner, do not do chalitza or yibum. If a saris did do chalitza or yibum, he hasn't really done anything, so the woman can still marry a Cohen. If he cohabited with her, she cannot marry a Cohen, as this is an illicit relation. Or if brothers did chalitza or yibum with an ilonis, it doesn't do anything, and she's not disqualified from marrying a Cohen, unless they cohabited with her, in which case that's illicit relations. The Gemara says that actually the first opinion would allow the saris adam to do chalitza and yibum, based on his other logics of the case, and we bring sources. It also gives definition as to these saris deformities, and say that they can be caused by the mother drinking beer while he's a fetus, and other points. These particularities are further discussed. It also further qualifies as to what exactly constitutes these unique disorders, and this is all further discussed. New Mishnah. A saris chama, a sterile male who was born that way, who is a Cohen, who was married to the daughter of a Yisrael, she can still eat teruma. Some say a tumtum, a person with a genital condition that causes him to be of indeterminate gender due to excess flesh covering the region, his wife can eat teruma. Some say if the flesh is torn and he's found to be a male, he should not do chalitza because he is now considered a saris. An androgynous, somebody with both male and female genitals, can marry a woman, but not a man. Some say that if a man cohabits with an androgynous, the same punishment applies as a man cohabiting with another man. The Gemara explains that it needed to say a saris chama Cohen's wife is allowed to eat teruma, even though he cannot have children. It says an androgynous Cohen's wife can eat teruma, but some say she can't eat the breast and thigh of a kache kalim offering, which are offerings of greater holiness. Others disagree and say she could. It's disputed, and this is all further discussed. It's spoken on a bit further and debated as to who exactly we hold like. It also disputes as to what exactly an androgynous constitutes. Some say they're considered a male, some disagree. It's debated if their marriage is a fully legally acceptable one. This is discussed along with some related points. It also goes through some points on grafting, what the gender of a tumtum whose flesh covering is torn open is considered, which is debated, and particularities as to the prohibition against a man cohabiting with an androgynous, where it brings verses as a source. It also says the opinion that holds that a man cohabiting with an androgynous is the same as a male cohabiting with another male, does not necessarily hold that an androgynous is always considered to be legally a male, which is relevant by several other laws. It also mentions an incident where they taught the teaching that a male can't cohabit with an androgynous. And that's the end of chapter 8. Chapter 9 of Tractate Yevamos continues discussing the various laws of the Levirate marriage. The first Mishnah says there are some women who fall into a category where they're permitted to be with their husbands, but forbidden to do Yibum, the Levirate marriage. Things like a Kohen married to a widow whose brother is a Kohen Gadol, a regular couple where the husband's brother is a mamzer, an illegitimate person, a female mamzer married to a mamzer whose brother is a regular person, and others. There are also women who can be permitted to do Yibum, but not to be with their husband. A Kohen Gadol betrothed to a widow, where the brother is a regular Kohen, a regular man who married a female mamzer, and his brother is also a mamzer, and that kind of thing. There are some cases where the marriage and the Yibum is forbidden. A Kohen Gadol married to a widow, and the brother is also a Kohen Gadol, or a Kohen. A regular husband marrying a female mamzer, and his brother is also a regular male, etc. And there are also more typical cases where both would be permitted. If the woman is rabbinically forbidden to be with the husband due to being a secondary relative, but not his brother, she can't be with the husband, but can do Yibum with the brother. Or if she's rabbinically forbidden to the brother with Yibum, but not to her husband, she can be with the husband, but not do Yibum. If she's rabbinically forbidden to both, she can be with neither. If such a rabbinically impermissible marriage occurs, she doesn't get the rights to the marriage contract, produce, sustenance, or old garments, which are all things that a husband is obligated to sustain his wife with. Their child is legitimate, and they must still divorce. If it was a biblically forbidden marriage, a widow marrying a Kohen Gadol, a divorcee marrying a Kohen, a mamzer marrying a regular person, there is a valid marriage contract. The Gemara asks, it says the case of a Kohen who's married to a widow, and his brother is a Kohen Gadol. It says married, not betrothed. There are a few answers proposed why. Some say if it's just betrothal, it'll be a positive commandment to do Yibum, and only one negative commandment. But that doesn't work, as we already know the positive commandment does not override the single negative commandment from all the other cases discussed. We try to suggest it because it says married by the later case, but that doesn't work because the other later case also says betrothed. So we say it's actually because the very next case of the Mishnah says married, which is necessary for its case. So does this one. Another question on the wording of this case, it says he married a widow. Why does it need to be a widow if she'll become a widow once her husband dies anyways? Again, similar answers are suggested and rejected, and we say it's because the later part of the Mishnah said the case by a widow, so it said it by this one also. It also rediscusses some points from an earlier chapter on marrying the descendants of Egyptian converts and clarifies some points. This is discussed and mentions that the daughters of Kohanim are allowed to marry disqualified men, like a Chalol, the child of a Kohen who married a divorcee. Sources are discussed. There's a question, if a woman is a rabbinically forbidden secondary relative to the husband, but not to his brother, if there's a valid marriage contract with the brother, if they end up doing Yibum, the Levirate marriage, and we say no. Although, generally, if she doesn't have a marriage contract from her husband and he dies, she gets one from her new husband if she does Yibum. We said a biblically forbidden marriage, like a widow to a Kohen Gadol, she still does get a marriage contract. Some say she nevertheless doesn't have the rights to sustenance until after the husband's death. A different source says in such a marriage, she gets the marriage contract, produce, sustenance, and old garments, but she and her child are disqualified and they're obligated to divorce. This is unlike a rabbinically forbidden marriage by secondary relatives, where you don't get the marriage contract or any of the other provisions, but she and her child are still legitimate, although they do still have to divorce. The reason the marriage contract and all the other provisions are given by the biblically forbidden marriage is because there they'll end it, as it's more strictly forbidden, but they need encouragement to divorce by the rabbinically forbidden marriage, so those provisions are all not allowed. Some say it's because there the laws themselves are rabbinic, which need additional support to be enforced. Others say by the biblically forbidden marriage, the man is persuading the woman to marry him, but but by the rabbinically forbidden one, it's the woman persuading the man, so she's penalized. The sources for these teachings are clarified. It also brings a few practical differences that would result between these different opinions. For instance, a confirmed Sotah, a woman who definitely committed adultery, the one who says the marriage contract is given if she's biblically forbidden, but the one who says if the woman convinces the husband to be with her is not given the contract, that would not be given here. New Mishnah, if the daughter of a Yisrael is betrothed to a Kohen, or is pregnant from a Kohen, or is pending Yibum to a Kohen, or these by the daughter of a Kohen to a Yisrael, she may not eat Terumah. If it was with a Levi, she may not eat Meiser. If it was the daughter of a Levi betrothed, pregnant, or pending Yibum by a Kohen, or the daughter of a Kohen to a Levi, she cannot eat Terumah or Meiser. The Gemara says this is like the minority opinion that holds Ma'aser Rishon cannot be eaten by Yisraelim, hence why it's forbidden in the first case. His sources for this are brought and discussed, however, the explanation is actually rejected, as the third case says the Ma'aser is forbidden to a Levite woman betrothed to a Kohen. Some say this just means that we don't distribute the Meiser to her at the granary out of concern that she'll be in seclusion with another man. Some say it's because she's a divorcee and might keep renewing Meiser there after the divorce. But that's difficult, as a divorced female Levite can still eat Meiser, but we say it's just done as a precautionary measure, as it's not allowed by Yisrael, who divorced a Kohen. It also specified betrothed, even though this would still apply while it's married, because the first part of the Mishnah said betrothed. It further argues many opinions in regards to Kohanim or Leviim eating Meiser. Verses are also cited. New Mishnah. If the daughter of Yisrael marries a Kohen, she can eat Terumah. If the Kohen dies, but she has a son, she can eat Terumah. If she then marries a Levi, she can eat Meiser, but not Terumah. If the Levi dies and she has a son from him, she can eat just Meiser. If she marries a Yisrael, she can't eat Terumah or Meiser. If the Yisrael dies and she has a son, she can't eat Terumah or Meiser. If the Yisrael son dies, she can eat Meiser from the Levi son. If the Levi son dies, she cannot eat Terumah again. If the Kohen son dies, she can't eat Terumah or Meiser. If the daughter of a Kohen married a Yisrael, she can't eat Terumah. If he dies, leaving a son, she still can't eat Terumah. If she marries a Levi, she can eat Meiser. If he dies, leaving a son, she can eat Meiser. If she marries a Kohen, she can again eat Terumah. If he dies, leaving a son, she can still eat Terumah. If the Kohen son dies, she can now only eat the Meiser. If the Levi son dies, she cannot eat Meiser. And if her Yisrael son dies, then she goes back to her father's house. As the verse says, she shall return to her father's house as in her youth. She may eat from the bread of her father. The Gemara clarifies additional points on several of these rulings. Some say when she returns to her father's house, while she can go back to eating Terumah, she cannot eat from the portions of the Shalomim offering, and sources are brought and discussed, and the remaining points are also qualified. And there's some additional clarification on some unique cases that are brought, and additional discussion and questions. And that's the end of Chapter 9. Chapter 10 of Tractate Yevamos continues discussing the laws of marriage. The first Mishnah says a woman whose husband went overseas and she was told that he died, so she remarried, and then the husband, as it turns out, had not actually died and returns. She needs to divorce both husbands and has no claim to the marriage contract, to the rights of produce, sustenance, or old garments from either husband. If she did take such payments, she needs to return them. Any child born from either husband is a mamzer, an illegitimate child, and if they are kohanim, they are not permitted to become ritually impure from contact with her corpse. Neither husband is entitled to her earnings, nor are they authorized to annul her vows. If she's not a Kohen or a Levi, she can no longer marry a Kohen. If she's a Levi, she can't eat Meiser. If she's a Kohen, she cannot eat Terumah. Neither husband's heirs inherit her marriage contract, and if either die childless, their brothers do chalitza, not yibum. Some have particular disagreement. Reb Yossi says her marriage contract is valid with her first husband. Reb Eliezer says the first husband is entitled to her earnings and can annul her vows. Rabbi Shimon says the first husband can do yibum or chalitza and exempt her co-wife from doing either. And also their child is not a mamzer, so the child is legitimate. Now, all of this was if a single witness reported the husband's death, which is a special exception to allow women to remarry easier. If there were two witnesses that testified to the husband's death and she remarries, she's allowed to continue to be with her first husband if he reappears. If she had remarried from one witness, she needs to divorce both, and she's exempt from bringing a chatas offering due to the power of the court. If she had remarried from two witnesses, she needs to divorce her new husband and is liable to a chatas offering. If she was told that her husband died based on one witness, and then she just went and immorally cohabited with another man, and then found out that her husband was actually alive, she's liable to bring a chatas offering, as she was only allowed to remarry. The Gemara says, although the wording in the first case says they testified, it refers to a single person's testimony based on the later part of the Mishnah, referring specifically to two witnesses in comparison to this part. Normally, we basically always require 2 witnesses for everything, according to Jewish law. One of the only exceptions is in a case like this, where a woman's husband vanishes. It leaves her in stasis, essentially, without her husband, but unable to remarry, as she's not certain if he's dead or not. So in such a situation, there's a leniency to believe a single witness who testifies that her husband died, to allow her to therefore remarry. This is also learned from other sources too. Another thing, a single witness is said to be believed by if a single witness tells a person that that individual inadvertently ate chalev, forbidden fats. If that man doesn't dispute it, then he's liable to bring a chatas offering, and we bring sources which are disputed. There's further argument on these sources, and in the end it concedes that a single witness is actually not believed by an established prohibition. However, by the woman remarrying, that's permissible as it's a rabbinic institution. If she remarried from the testimony of one witness and the husband comes back, we said she needs to divorce both of them. Some say if there were 2 witnesses, she doesn't need to divorce her husband, but that's only where she cannot recognize the old husband and the witnesses also testify that it's the same man. It's still debated as to how she's allowed to remain married to the second husband. Some say it's where there were 2 arguing sets of witnesses who came as to whether her husband died, and then after she remarried, wherein this ruling was stated to disagree with an opinion that says she would need to leave her husband. Or some say it's where she remarried and then the second witnesses came, that she can stay married, and if she married after both witnesses came, she can't remarry, which actually means she's agreeing with the second opinion. This is for the disputed. Some say that actually it just means she can just stay with her first original husband. Regarding the case of a single witness, some say she only needs to leave the second husband if she recognizes that the returning husband was her original husband. If she says that's not actually him, she wouldn't need to divorce her new husband. The case is clarified to be dealing with 2 witnesses who say it was the original husband, but they would be normally disqualified, which is further discussed. She needs to divorce also the second husband, even though, as it turns out, her first husband was still alive. So it was effectively just adultery. However, it's a rabbinic institution, so that way people watching who don't know the situation won't think that she just left her husband without a valid marriage contract, and this is for discuss. There's qualification by some related cases. Anyways, we said in the case that she doesn't get her marriage contract. This is because she did adultery effectively and must be divorced, and the whole purpose of a marriage contract is to discourage divorce. The other rights listed have the same status as the marriage contract, and the remaining points are also clarified. It also brings sources for many of these points, and there are additional proofs cited and discussed also for some additional points, like in regards to certain services in the temple. This is all discussed further, along with points on the source for her Kohen children not being allowed to become impure for her corpse. We also said her husbands aren't entitled to her property or earnings, or to revoke her vows, which is something normally given to promote a happier relationship, but here we want them to divorce, so we don't allow such things. The remaining prohibitions are also explained. We also said there were 3 opinions who disagree with particular parts of the prohibitions. Some say that each later opinion agrees with the prior one, but the initial opinions disagree with the later ones due to their opinions on the severity of the prohibition. The last actually allowing cohabitation with Yibum, the second allowing monetary earnings, and the first allows only the marriage contract, which is collected even as the marriage ends. Others say it's the exact opposite. The initial opinions agree with the later ones, and the later opinions disagree with the initial ones. The marriage contract is taken from the husband and is the most strict. The second is more lenient, where it's the wife's earnings to the husband, and the third is cohabitation with Yibum, which would apply even after the husband's death. We also said that if she remarried on the basis of 2 witnesses, she can return to her original husband if he's found, and it's disputed if we hold like this. This opinion is argued on further from several different sources. It remains unresolved, and practically in a case, we go like the strict opinion. So if a woman remarries based on a testimony and her husband returns, no matter if it was with 1 or 2 witnesses, she has all of those listed penalties apply. If she remarries and there's just a rumor that the husband was still alive, she's not penalized. This means that the rumor is considered to be as if it came about after she married. Some disagree with the Mishnah's statement that she needs to divorce both husbands after the testimony of a single witness. There are sources brought. At the end, we discussed immoral cohabitation. Some say this refers to cohabitation outside of marriage. Some say this refers to a widow marrying a Kohen Gadol, or a divorcee marrying a Kohen, or similar. The first opinion would agree with the second, but not vice versa. Sources are brought. New Mishnah: if a woman's husband and child went overseas, and she was informed that first her husband died and then her son, so she married somebody else, and then after was told it was the inverse, that her son died first, thus requiring her to actually have done Yibum, she now needs to leave her new husband, and the child, either conceived before or after this occurred, is a mamzer. If they informed her that her husband had died first, so she did Yibum, and then she's informed that actually her husband had passed first, she needs to divorce, and the child, either conceived before or after this occurred, is a mamzer. If she was informed that her husband died, so she remarried, and was then told that your husband was actually alive when you had remarried, but died after, she must divorce, and the child conceived before this occurred is a mamzer, and if it's after, it's legitimate. If she was told that her husband died, so she betrothed somebody else, and then her husband came back, she can go back to him. If the second husband gave her a divorce document, she'd still be allowed to marry a Cohen. This is learned from the verse, and nor shall they take in marriage a woman divorced from her husband, meaning it had to be her actual husband. The Gemara clarifies points on the wording of the Mishnah. It says the child is born either first or last, which, as said here, refers to the child being conceived either before or after them being informed of the information, which is particularly relevant in the last case. Also, it says the first case, that the children of a woman who had actually required Yibum and accidentally she had married somebody else, her children are mamzerim, illegitimate. Some people actually disagree with this, as they hold that it's only a violation of a negative commandment involving marrying a relative that can produce a mamzer. There's a dispute between opinions if it's a valid act of betrothal when a woman who required Yibum accepts the betrothal from another different man. It's held that this is not a valid betrothal and she still requires a divorce document. Some say based on this, if such a thing occurs and her brother-in-law was a Cohen, if he does chalitza, she can then stay with the husband, as if she was divorced, she wouldn't be able to marry her Cohen brother-in-law anyways. Others say no, as then you're rewarding the husband for a wrongdoing. So actually it says that if her brother-in-law is a non-Cohen, her current husband can divorce her, allowing her to do Yibum with her brother-in-law. We said a woman in this situation's betrothal won't work, but there's a debate if Nisuin, the final stage of marriage, is effective. The final ruling is that betrothal is not valid for a woman who requires Yibum with somebody else. This is discussed along with a related debate if a person can legally do a business transfer on something that doesn't yet exist. It's further debated between several opinions based on several sources. It's further proven from related discussion that a single witness's testimony, if uncontested by any later testimony, is believed in order to allow a woman to marry through Yibum. This is further discussed with additional proofs brought. It also says from the quoted verse, and nor shall they take in marriage a woman divorced from her husband, that even more you can learn from this that a Cohen cannot marry a woman who is divorced from her husband under the stipulation that she couldn't marry anybody else later after she's widowed. She's still not allowed to marry a Cohen. New Mishnah. If someone's wife traveled abroad and he was informed that his wife had passed, so he married her sister, which is only now permitted, but then the wife came back, he can return to his wife, and he and the sister can still marry into each other's families. And if his first wife does actually die, he can go back and marry the sister. If this case occurred, but he had children, and he was informed that his wife was alive during the marriage but died after, the children conceived before his wife's death are a mamzer. If conceived after, they're legitimate. Others disagree with this principle, saying that anyone who disqualifies others is himself disqualified, and if he doesn't, then he isn't disqualified. The Gemara says in the first case, where his wife vanishes overseas and he marries her sister, if his brother-in-law, the husband of the woman he wants to marry, also vanished overseas, and they then return, the sister and her husband, the brother-in-law, can't be married, but he can still be with his wife. Other people dispute the whole principle from the Mishnah as to whose view it accords with, and it's discussed. He's also allowed to remain with his wife in this case, as he's only violated a rabbinic decree. The sources for this are brought and discussed, and there are related cases spoken on. It also clarifies the ending point of the opinion that says if someone disqualifies others, he disqualifies himself, which means he holds that if he disqualified his brother-in-law from his wife, he's also disqualified from his own wife. And when it said if he does not disqualify others, he's not disqualified, that refers to an earlier case where a woman remarried based on two witnesses and her first husband returns. She's allowed to remarry her old husband, and the sister can remain married to the brother-in-law. There are other similar explanations given on this unique ruling. It also says in opinion that this is the ruling we hold like, but it's disputed. New Mishnah. In the event that a man was informed that his wife had passed, so he married her paternal sister, and then he was informed that she had died, so he married her maternal sister, and he was then told that she died, so he married her paternal sister, and he was then told that she died, so he married her maternal sister, and then he found out that they were all actually still alive. He's permitted to stay with the first, third, and fifth wives, and two of them would be exempt in the event of Yibum or Chalitza done with the third. He cannot stay married with wives 2 or 4, and if he dies, if Yibum is done with one, the other is not exempt. If by this case the first wife actually had died, and then he married his second wife and so on, he can stay married with wives 2 and 4, and the other would be exempt from Yibum, and he can't stay with wives 3 and 5, and if Yibum is done with one, the other is not exempt. A new topic, if there's a boy 9 years old and a day, if he does Yibum to marry his dead brother's wife, his older brothers can't do Yibum either, and vice versa. However, he can only disqualify his older brothers by doing Yibum, while they can disqualify him by doing Yibum, betrothing her, divorcing her, or by doing Chalitza. The Gemara clarifies the first cases, as was stated. It also discusses further points on the disqualification between such brothers by Yibum. New Mishnah: if a boy is 9 years and a day old and he did Yibum, marrying the woman, if his older brother of the same age also marries her, the second brother has disqualified the first. Others disagree. If a boy of such an age does Yibum and then also does Yibum to her co-wife, he's disqualified himself from both. Others disagree. The Gemara explains the logic of the disagreeing opinions, that only one of the Yibums could be legally valid, so one would always be permissible. With all of the above cases, it implies that the betrothals would be permissible, but others would disagree with the second case, with the co-wives saying that's not allowed. New Mishnah: if a boy of 9 years and a day does Yibum and then dies, his older brother does Chalitza and can't do Yibum. Generally, if a minor boy has married a woman and then died, he's exempt from Yibum and Chalitza. If a 9-year-old and a day boy does Yibum, becomes an adult, marries another woman and then dies, if the boy hadn't cohabited with the first wife after he became an adult, she does Chalitza with his brother and not Yibum, and the second wife can do Yibum or Chalitza. Others disagree, saying the brother can do Yibum with whichever he wants and Chalitza with the other. This all applies by either a boy of 9 years and a day or a 20-year-old boy that doesn't have the necessary signs of physical development. The Gemara discusses these points. It's qualified further, and it also mentions in regard to the non-physically developed 20-year-olds, other similar discussions refer to a saris, a man with an actual disorder, while ours does not. If such a thing occurs, meaning he's not a saris, but he's also never physically developed, he's considered a minor until majority of his years have passed, which is said to be 36 years. Also, it says as general advice, if such a thing occurs, meaning there's a boy who reaches an adult age without having physically developed, it was said to either gain or lose weight, depending on where it's necessary. And that's the end of chapter 10. Chapter 11 of Tractate Yevamos goes through some additional general points in the laws of marriage. The first Mishnah says it's legally permissible for a man to marry the relatives of a woman he had violated or seduced, but he is liable if he does these acts to the relatives of his wife. A man is permitted to marry a woman who was violated or seduced by his father or son, but Rabbi Yehuda says it's impermissible if done by his father. The Gemara says this is a biblical permissibility. Rabbinically, there are stringencies by related situations, and a person is rabbinically only allowed to marry the relative of a woman he had violated or seduced after she passed. Sources are brought and discussed. It also lists a lengthy number of popular riddle-like questions from those times of complex relative possibilities and how they're theoretically possible based on various odd marriage combinations. New Mishnah: if a female convert had sons who converted with her, and one of the sons marry and pass, his brothers don't do Yibum or Chalitza. This would also apply if the son was conceived prior to conversion and born after, while the brother's conception and birth were after they converted. This also applies by a slave woman whose sons were freed with her. The Gemara discusses some related disputes. This is all discussed further along with some additional points. New Mishnah: if there are 5 women whose children all got mixed up with each other and then grew up, marry, and die childless, in regards to Yibum, their 4 brothers can do Chalitza with 1, and the remaining can do Yibum for each widow. The Gemara says the Chalitza needs to always be done first to prevent the possibility of a woman needing Yibum marrying a random other man. Furthermore, the specific case of the Mishnah has to show that it's more preferable that one brother does Yibum with all of the widows to give everybody at least a chance of marrying their brother's widow and fulfill the obligation of Yibum. There are several other variations of this case discussed, and this goes further. New Mishnah: if a woman's child got mixed up at birth with her daughter-in-law's child, and they grow up, marry, and die childless, the sons of the daughter-in-law do Chalitza and not Yibum with both widows, because it could possibly be their brother's wife, who they can marry, or their father's brother's wife, who they cannot marry. The sons of the older woman can do Chalitza or Yibum with both, as they could be their brother's wife or brother's son's wife, which are both permissible to them. If the sons whose identities are known die childless, the mixed-up sons of the older woman both do Chalitza, but not Yibum, as one could be their father's brother's wife, and the daughter-in-law's sons, one does Chalitza, and the other can then do Yibum. If the child of a Kohen got mixed up with the child of her slave woman, both can eat Truma, but they can only get one portion. Neither can impurify themselves from the dead, and neither is allowed to get married to anyone. If they grow up and free each other, they can marry women fit to marry a Kohen, and they cannot touch dead impurity. Although if they did, they don't get the penalty of lashes. They cannot eat Truma, but if they did, they aren't required to do the full reimbursement, which is plus a fifth. They don't get a portion of teruma, but they can sell their own teruma produce and keep the proceeds. They don't receive a portion of consecrated temple items or kudshim, holy offering meats, but they can keep their own. They don't need to give the select animal portions to a Kohen, and their firstborn animals should be left to graze until they develop a blemish, and they have the stringencies of a Kohen and of a Yisrael. The Gemara further qualifies all these points, and this is all discussed further. New Mishnah: if a woman remarried without waiting 3 months from her previous marriage and gave birth, and they don't know if it's a child from the prior marriage or a premature child from the current one, and she also has other sons from both husbands, the other sons can do chalitza, but not yibum with the questionable son's wife. He does the same to their wives. If the son has brothers from both husbands, but the ones from the other husbands aren't from that mother, and they die, he can do yibum or chalitza with their widows, and if he dies, they can do only chalitza. If one husband was a Yisrael and the other was a Kohen, all the stringencies from the last Mishnah also apply here. If both husbands were Kohanim, he would observe the laws of a mourner for them, and them for him. They can't become impure for each other if they die. He does not inherit from them, but they do from him. He is not liable for hitting or cursing them. He can go up to the temple as a part of the Mishmar group of either one, but does not receive a portion of the sacrificial meat unless both husbands were a part of the same Mishmar group. The Gemara discusses these points. There's related discussion. Some say if he hits or curses both fathers, he's liable. Some say if it's done one after the other, which is discussed. It also clarifies the other points, like to establish by the sacrificial meats, it works if the fathers are a part of the same Mishmar group and base of, and he gets one portion. And that's the end of chapter 11. Chapter 12 of Tractate Yevamos starts discussing some of the actual laws of the Chalitza ceremony. The first Mishnah says, the ceremony of Chalitza, wherein the Yibum marriage of a widow and her brother-in-law is refused, essentially consists of the reading of several verses from the Torah, the widow removing the brother-in-law's right shoe, and then spitting towards him, which is all brought from verses in the Torah. There's lengthy explanation elsewhere as to why this ceremony is done in such a manner. Anyways, this ceremony must be done before a panel of 3 judges, although they can even be 3 regular people. This ceremony can be done with a minal, a type of soft leather shoe, but not with a sock. It can be done with a sandal, only if it has a sole. It's a valid shoe if it's worn from the knee and down, not from the knee and up. It is a valid chalitza if the shoe is not the brother-in-law's, or if it's a wooden sandal, or if it's a left shoe on his right foot. He could also use a shoe that's too large if he can walk in it, or a shoe that's too small if it covers most of his foot. The Gemara explains, it says judges, even though they can be laymen, to say that they must be able to dictate the necessary verses that are read, as judges do. Others say you need a panel of 5 men, which is a dispute based on a verse. It's argued further, but we say we do chalitza before 3 judges, as the opinion that said it must be 5 eventually retracted his opinion, unlike by the judges of Mion, by the refusal of an arranged marriage where there's 2. Based on a verse, the location of the chalitza must be arranged beforehand. There was also a time when chalitza was done before 5, but 2 of those weren't judges. Those were there just to publicize the event, and there are related points mentioned. It also says, based on the verse, that a convert can only judge another convert by such laws. It further qualifies which types of shoes are and are not permissible to be used. There are related points. It says, if a woman grew up along with the person she eventually does chalitza with, we're not worried that she ever happened to remove his shoe for whatever reason, thus technically doing chalitza, and if we saw such a thing occur, there's no worry that that was her intent. There are other points on which types of shoes are and are not permitted, along with sources. It also discusses an instance wherein a heretic tried to compare the Jewish people and God to a woman who did chalitza, but it was disputed based on the wording, saying that although the Jewish people have done wrong, our bond is still there. Furthermore, it says that a sock is not considered a shoe, which has relevancy by other laws and has variation depending on the type of sock. This is for the discussed. It also mentions that while doing chalitza, your foot must be pressed to the ground, and some say that if your foot is deformed in such a way that you walk on the upper part of your foot, you're not allowed to do chalitza. The remaining points are discussed along with sources. This goes further along with additional clarification on exactly which types of shoes are usable. New Mishnah, there's debate if chalitza is valid if done at night, and also debate if it's valid if done on the left foot. The Gemara debates why these opinions argue. It said to be that they argue if this is compared to the beginning or end of a monetary trial, depending on if it can be done at night. It also mentions an instance where a sage did a chalitza case with a felt shoe by himself and at night, the permissibility of which is disputed. The argument on the permissibility of using your left foot for chalitza is based on the explanation of a verse. New Mishnah, if the shoe was removed and she spat, but she didn't say the verses, it's a valid chalitza. If she said the verses and spat but didn't remove the shoe, it's an invalid chalitza. If she removed the shoe and said the verses but didn't spit, the validity of the chalitza is debated based on the interpretation of a verse. If either the woman or man are a deaf mute or the male is a minor, it's not a valid chalitza. If a minor girl did chalitza, which means she's rejecting the marriage, she must redo it later as an adult. If she didn't, her earlier one is invalid. If the chalitza was done before 2 judges, or 3, and one was found to be disqualified, it's disputed if her chalitza was invalid. Once there was a widow and brother-in-law in prison, and they did chalitza by themselves, and it was ruled to be valid. The Gemara says that we said the verses aren't necessary, however the deaf mute still can't do chalitza, as they aren't legally considered to be mentally competent. A regular mute also cannot, as they need to be fit to speak. It also says, if the widow spat at one of the brothers, she then needs to do chalitza, as we're concerned that was her intent. This is debated. This is all discussed further, along with several related points. It also says if the widow spits blood, she then still needs to do chalitza, as there was definitely spittle included. It's further debated if it's legally accepted if a minor does chalitza, and it cites a related incident. It says that the oldest a girl can do chalitza, the rejection of a Levirate marriage, is when she's older, having reached certain stages of physical development. The other points are further discussed. The case of the chalitza in the prison cell was said to have a witness outside, which was how they knew about this whole thing. It was also said that the entire incident and the ruling of the case took place in the prison. Therefore, there are additional cases discussed, and a few additional qualifications, such as an argument if the judges need to be able to recognize the man and woman doing chalitza. New Mishnah. In regards to the exact order of chalitza, it's that they first go to court, and as the verse says, and the elders of the city shall summon him, and they shall speak to him. This means that they're advised, for instance, if there's a large age gap, they're advised to not marry, and that they should do chalitza instead. They cite the relevant quotes from the verses. My Yevamos refuses to establish a name for his brother in Israel. He is not willing to take me in Yibum, and the other says, I do not want to marry her, and this is all said in Hebrew. The verse then states, Then his Yevamos shall approach him before the eyes of the elders, and she shall remove his shoe from upon his foot and spit before him. And this means that the spittle should be visible to the judges. Then the verse says, And she shall declare and say, So shall be done to the man who will not build the house of his brother. Although some have said that they would read the entire chapter, and that's what the custom was established to be. The verses then finish, and his name shall be called in Israel, the house of the one whose shoe was removed, which is what he's then referred to, although his students don't have to, and others say that everyone there must say that. The Gemara clarifies these points, and further says exactly what they need to say with which words. It also describes the chalitza document, and says that the scriptural verses can be written on it. The spittle must be at least level with his face before it blows away. If that occurs, she must spit on her own without chewing stuff beforehand to help. The judges must see the spittle. The remaining points are clarified, and that's the end of chapter 12. Chapter 13 of Tractate Yevamos discusses the laws of miyun, which is that in the event that a family arranged for their minor girl to marry somebody, it's instituted that the girl, when she becomes of age and the marriage is about to go into effect, she can refuse this marriage if she wants, nullifying it completely in a process known as miyun. The first Mishnah says, Beis Shammai holds that you can only do miyun for an arusa, someone in the first stage of marriage, while Beis Hillel says you can do it while in any stage of marriage. Beis Shammai says it could be done towards a husband, while Beis Hillel says it could be done towards a husband or for yibum, the Levirate marriage. Beis Shammai says it has to be done in the husband's presence. Beis Hillel says it could be done without him. Beis Shammai says it must be done in court. Beis Hillel says it does not. Beis Hillel says she can do miyun, refusing to marry as many times as she wants. Beis Shammai says she just should do it once and then must wait until adulthood to marry. The Gemara debates the logics and sources behind these opinions, and they're all discussed further. New Mishnah. Now, all of this applies if the girl was being married off by her mother or brothers, that she can decide to refuse the marriage if it was done with her consent. If it was done without her consent, it's just not considered a legal permissible marriage in the first place. Some say that if she's not capable of safeguarding her betrothal article, it's not permitted to marry her off. Rabbi Eliezer says, if, God forbid, somebody tries to marry a minor, this is not legally binding. He has accomplished nothing. For instance, if a Yisrael's daughter is with a Kohen, she may not eat Truma, and if vice versa, she may still eat Truma, basically meaning, as stated, that the marriage is not legally acceptable or permissible, really, so nothing is accomplished legally. Some are of the opinion that if the restraint is due to him, they are considered married, and if the restraint is not due to him, they are not considered married, and it's going to explain soon what that means. The Gemara describes the exact text that's written in this Miyun document of refusing such a marriage, and there are further particular cases discussed. It also describes how if a man tries to marry such a minor, as described, it's considered completely illegal and not legally binding, explaining how all of the typical laws of marriage do not apply. The opinion in regards to if it was due to restraint, which what exactly that means is debated. Some say it could mean that if someone gave her a divorce document, that's called restraint due to a man, and she's not allowed to marry his relatives or a Kohen, but if she refused him, this is restraint not due to a man, as mentioned, and she would be allowed to marry his relatives in theory, or a Kohen. This is further described. New Mishnah, if the minor refuses the husband, they're still legally allowed to marry each other's relatives, and she can still legally marry a Kohen, unlike by if he gives a divorce document. If he gives her a divorce document, asks her to remarry afterwards, and then she refuses him, then eventually marries somebody else and is widowed or divorced, she's legally allowed to marry the first husband. If she refused the first husband and then later married him, and then divorced and then married somebody else, and was then widowed or divorced, she's forbidden to remarry the first husband. Generally, if a divorce document is given at a point after Miyun was done, they cannot eventually remarry, and if it's vice versa, they can. If the girl refused to marry the man and then later married somebody else and then divorced and then went to somebody else, refused him also, and then eventually married somebody, got divorced, and then refused somebody else, she's legally allowed to remarry anyone she left via Miyun, but not via divorce. The Gemara discusses these points. New Mishnah, if someone divorces a woman, remarries her, and then dies childless, there's disagreement if she can do Yibum with his brother. There's also disagreement if this is done by an orphan girl. If a father marries off his daughter, and she's then divorced, she is considered like an orphan, so if she's remarried by him, she cannot do Yibum. The Gemara further qualifies these points, along with the logic behind the differing opinions. New Mishnah, in the event that two brothers have married two minor sisters or two deaf mutes, which are all non-biblically recognized or permitted marriages, and one of them dies, the other one cannot do Yibum or Chalitza. If one sister was an adult and the other husband died childless, the younger sister does not do Yibum or Chalitza. If the other husband dies, some say we tell the minor to refuse to marry the husband, so that way he can do Yibum. Some say she can just wait until she becomes an adult, at which point the marriage will now be recognized biblically and permitted, and the other sister won't need to do Yibum anymore as she's now a wife's sister. Others say he needs to divorce his wife and also do Chalitza. The Gemara says here it's allowed to encourage her to do Miyun to allow the fulfillment of a mitzvah. This is related to an opinion which says you should cleave to Chalitza, making peace between people, and revoking vows, while staying away from Miyun, accepting deposits for safekeeping, and acting as a guarantor for a loan. These points are all further expounded on. It also talks about the importance of judging properly. If somebody's a judge, and if he is, he should always view himself as if there's a sword resting between his thighs with Gehenna open beneath him, which is based on a verse. The other opinions are also discussed. This is all qualified further, and it decides we rule like the opinion that in the above case, we encourage a minor to refuse the husband, so that way they don't marry, so that way they'll separate and he can just do Yibum. New Mishnah, in the event that somebody was married to two orphaned female minors or two deaf mutes, a marriage, again, not legally recognized by biblical law or permitted, and he dies, Yibum or Chalitza with one releases the other from the requirements of Yibum and Chalitza. If he was married to one and one of those, Yibum with one does not release the other from Yibum. If he was married to a mentally competent individual and also a deaf mute, Yibum with the mentally competent woman releases the deaf mute, but not vice versa. If he was married to an adult and an orphaned minor, again, only the adult marriage being biblically recognized, Yibum with the adult releases the minor, but not vice versa. The Gemara further debates these cases. This is all discussed further, and there are additional points on these brought. New Mishnah, again, by a biblically non-recognized marriage, if somebody married two female minor orphans or two deaf mutes and died childless, and one does Yibum and then one of the brothers does Yibum also with the other one, the first one is still valid. This wouldn't apply if one was the orphan and one was the deaf mute. If one wife was mentally competent and the other was a deaf mute, if the first did Yibum and then one of the brothers did Yibum on the second, the first is still valid. With an adult woman and a minor, if they do Yibum with the adult and then the minor, the adult's Yibum is still valid. If they do Yibum with the minor and then the adult, the minor cannot be married through Yibum. Some say we instruct the minor to just refuse the marriage. The Gemara says, again, we follow the latter opinion that we instruct the minor to refuse the marriage, and this needs to be repeated as here Yibum was actually already done. New Mishnah, if a minor did Yibum with a minor, we wait until they both become adults. If a minor boy does Yibum with an adult, we also wait until he becomes an adult. If a woman, after doing Yibum, says she didn't cohabit within 30 days of them living together, we compel him to do Chalitza. If this was after, we request that he does Chalitza. If he admits he didn't cohabit, even if it's way after, we compel him to do Chalitza. If, while her husband was alive, a woman took a vow to not benefit from her brother-in-law and then finds she needs to do Yibum with him, we compel him to do Chalitza. If this vow was made after her husband died, we only request that he does Chalitza. If her intent was to avoid Yibum, then we only request for him to do Chalitza, even if it was made during her husband's life. The Gemara further clarifies these points and discusses some related ones. This goes further along with bringing some specific cases which are discussed, and there's additional qualifications on all of this. And that's the end of Chapter 13. Chapter 14 of Tractate Yevamos continues discussing the law in situations of various different types of marriage. The first Mishnah says, if a deaf mute marries a mentally competent individual, as the deaf mute can't speak, when they marry or divorce, they can do so through gesturing. If a woman became a deaf mute after the marriage, they can still be married or divorced. If the woman became mentally insane after the marriage, he's not allowed to divorce her. And if the husband became a deaf mute after the marriage, he can never divorce his wife. It says a woman is different than a man here by a deaf mute, as a woman can be divorced with or without her consent, while a man can only be divorced with his consent. It also says that a woman who became a deaf mute after marriage is similar to a deaf mute girl whose father married her off, that she also can be divorced. If two deaf mute brothers are married to two deaf mute sisters, or two regular sisters, or to one sister who's a deaf mute and the other's mentally competent, or to two deaf mute sisters married to two regular brothers, or to one deaf mute brother and one mentally competent brother, in all these cases, if these became a widow, they're exempt from Chalitza or Yibum. If they aren't related, then the other should do Yibum. They're able to also divorce. If there are two brothers, one is a deaf mute and one is mentally competent, who are married to two competent sisters, and the deaf mute brother dies childless, the widow does not do Yibum as she's a wife's sister. If the competent brother died childless, the other must divorce his wife and can never marry anybody ever again, as he's stuck, unable to do Yibum or Chalitza. If there are two competent brothers married to one sister who's a deaf mute and one who's competent, if the deaf mute's husband dies childless, the other brother doesn't need to do Yibum, as the widow is his wife's sister. If the competent wife's brother died, the other must divorce his wife and do Chalitza. If there are two brothers, one deaf mute and the other competent, married to two sisters, one deaf mute, the other competent, and the deaf mute brother died, the competent brother doesn't do Yibum, as he'd be marrying his wife's sister. If the competent brother died, he must divorce his wife and can never marry for the same reasons as before. If there are two brothers, one deaf mute and one competent, married to two unrelated competent women, if the deaf mute brother dies, the other can do Yibum or Chalitza. If the competent brother dies, he must marry the widow and is never allowed to divorce her. If there are two competent brothers, one is married to a competent woman, the other to an unrelated deaf-mute woman, and the deaf-mute's husband died childless, the other should do Yibum and is allowed to divorce her later if he wants. If the other brother died, the other could do Yevamos or Chalitza. If there's a deaf-mute and a competent brother married to an unrelated deaf-mute and competent woman, if the deaf-mute brother died, the other should do Yibum and is allowed to later divorce her. If the competent brother died, the other must do Yibum and can never divorce her. The Gemara says there was a rabbinically instituted category of marriage for a deaf-mute maid, as they can have normal lasting marriages, but not for an insane person, as their marriages can't function. We also said we don't institute a category of marriage for a minor boy, as unlike a deaf-mute, the boy will eventually become allowed to marry as an adult. The institutions for a girl that she can be married off by her family in the event that her father dies, with the clause that she can refuse it if she wants to, was something instituted as protection for the girl, as back in those days, at least, without her father to protect her, there was a concern that people would take advantage of her. Therefore, it was instituted that if her family consents and she doesn't refuse it, she can be married, to be put into the care of another individual. Definite women don't have miyun apply to them, as men would be deterred and don't want to marry them in the first place. There are other practical differences mentioned between the two, and there are additional cases discussed. There's also discussion if you're obligated to stop a minor from committing a sin, like if you see a child about to violate Shabbos, if you need to stop them, which is debated, and there are several proofs brought, and is further discussed. And that's the end of chapter 14. Chapter 15 of Tractate Yevamos discusses further points in the laws of a widow whose husband vanished overseas. The first Mishnah says if a woman went with her husband overseas and they weren't having any marriage issues and she came back and reported that her husband had died, she can do Yibum. If they weren't having marriage issues, but the world was very chaotic at the time with wars, or they were having marriage issues and there was peace in the world, she's not believed if she says her husband died. Rabbi Yehuda says we only ever believe her if she comes back crying with her garments torn. The rabbis say we believe her even if she doesn't show signs of mourning. The Gemara clarifies points on the wording and says the issue by wartime is that she might have seen her husband injured when he actually survived. It's also said that famine is even stricter than wartime, that a woman is only believed here if she says she actually buried him. A building collapse, snakes and scorpions, and some say a plague are similar to wartime by these laws. This is discussed. There's further debate along with some specific cases where a fire burnt down a couple's house and the woman escaped, saying her husband was inside. Even if you find a burnt corpse in the house, that's insufficient to assume it's the husband, as he also could have escaped, and that corpse could have been somebody else. And there's further debate on these laws, and there are additional unique cases brought. It also defines what constitutes argument between a couple by these laws. Some say it's at the point where the woman says that she was divorced before a witness, although the witness denies this, and this is further debated. New Mishnah. Beis Hillel says we only believe a woman that her husband died to allow her to remarry if she comes from the grain harvest and in the same country. Beis Shammai says she can come from any harvest or any country. A grain harvest was mentioned as that's what the discussed case was dealing with. Beis Hillel retracted his ruling to rule like Beis Shammai. The Gemara qualifies these opinions and cites the full case about the grain harvest, that some people went to harvest wheat and a snake bit one of them, and the wife testified about it, and there are related cases brought. New Mishnah. Beis Shammai says when we say a woman can remarry from her own testimony that her husband died, she can also get her marriage contract. Beis Hillel says she does not. They argued on this. Beis Hillel retracted his opinion. The Gemara further debates these points. New Mishnah. Everyone is believed to testify for a woman that her husband died, besides for her mother-in-law's daughter, her co-wife, her husband's brother's wife, and her stepdaughter. They would be trusted to testify on her husband giving her a divorce document, as that's a written document. The Gemara says these women can't testify as they'd be hostile to the wife for various reasons, which are further explained. New Mishnah. If one witness says her husband died and she remarried, and then another witness says he did not die, she can stay with her new husband. If two witnesses testify that her husband is alive, she must leave her new husband. If two witnesses say he died and one says he did not, she can remarry even after this testimony. The Gemara clarifies points on these laws. New Mishnah. If two co-wives went overseas with their husband, and one says he died and the other says he did not, the one that said he died can remarry and collect her marriage contract, and the other one cannot. If they give different testimonies as to how he died, one saying he died naturally, the other saying he was killed, some say they can't remarry, some say they can. If one witness says he died and one says he did not, be they man or woman, she cannot remarry. The Gemara explains the logic of these cases. New Mishnah. If a woman went with her husband overseas, returns and says her husband died, she can marry and get her marriage contract, but her co-wife cannot remarry based on this. If the husband who vanished was a Cohen and the co-wife was a Yisrael, she'd still be allowed to eat teruma. Others disagree. If a woman went overseas with relatives and testifies that her husband and father-in-law died, she can remarry and get her marriage contract, and her mother-in-law cannot. Again, there's debate if she can still eat teruma in that circumstance. The Gemara explains the necessity of both cases, as there's variation based on the hatred between relatives. It also says we hold up the opinion that they can eat teruma, which is sourced. New Mishnah. If someone betrothed one of 5 women and he's not sure which, and they all say it was them, he divorces all of them and drops the marriage contract between them and just lets them figure it out. Others say he must give each of them the marriage contract. There's a similar argument if someone stole something from one of 5 people. Some say he just drops it off between them. Others say he must give one of it to each person. The Gemara again clarifies further points. New Mishnah. If a woman went overseas with her husband along with a child and then comes back alone saying the father died first and then the child, she's believed. If she said the son died first, thus requiring her to now do Yibum, she is not believed. To be safe, however, she must still do Chalitza. If she says that she had her child born while overseas, she's believed if she says the son died first, but not if she says the father died first, in which case she'd still require Chalitza to be safe. If she went overseas with her husband and says he had a brother born there and says both died in either order, she's believed. If the brother went with her overseas, she's not believed if she says both died in either order. This is explained. The Gemara cites some related discussion. It also says if someone gives a divorce document to his wife through a third party and there's conflict, we assume the woman would have preferred to stay married. Similarly, it says a husband who is extremely short or has an undignified profession, like combing wool, or has flawed lineage, will all remain married, although there's a concern the wives will be unfaithful. And that's the end of chapter 15. Chapter 16, the final chapter of Tractate Yevamos, discusses some final laws on a widow whose husband vanishes overseas. The first Mishnah says if a woman's childless husband and her co-wife went overseas and she's later informed that her husband died, she cannot get remarried or do yibum until she figures out if her co-wife was pregnant. If a woman's mother-in-law went overseas, there's no concern she has a child, requiring her not to do yibum, unless the mother-in-law left while pregnant. Others say it's still not a concern. The Gemara further qualifies these points and opinions and debates their logic, and this is discussed further. New Mishnah: if the wives of two brothers return from overseas and they both say their husbands died, neither is allowed to marry somebody else out of concern their brother-in-laws are still alive. If one has witnesses, she can't remarry while the other one can. If one had children, she can remarry, unlike the other. If they did yibum with their other brothers and those also die, there's debate if they're allowed to remarry. The Gemara discusses further similar cases, and they're additionally qualified. New Mishnah: in regards to testifying the identity of a dead man to allow his wife to remarry, they must have seen the form of the face, including the nose. Without this, they can't even testify based on identifying marks or the body or clothes. They can only testify if they see him actually die, not if he's just badly injured or even mid-hanging from a gallows or being eaten by an animal. They can only testify on the corpse if they saw it within 3 days of him dying. Others say the time frame is variable as it depends on the corpse or location. The Gemara further describes the necessity of which facial parts must be identifiable. It also says how you can't identify based on a body mark like a mole, which is debated. There are further specific points discussed, and it describes how a person in theory could survive a serious wound after being presumed dead through cauterization and similar. It also says you can testify that person died if you saw him being eaten by an animal at a vital part of his body, which is described as parts of his throat. This is further discussed. New Mishnah: if somebody falls into a body of water and is not seen to emerge, no matter the size of the body of water, he's not presumed to be dead. An incident is cited where somebody fell into a large water cistern and came out 3 days later alive. Some say based on an incident, if you see somebody submerged in water and you watch the bank for long enough for him to drown and he doesn't emerge, you can assume he died. There's also an incident where somebody was lowered into a sea and they retrieved only his leg, and it was said that he was only assumed dead if it was severed above the knee. The Gemara defines these bodies of water and cites some related incidents. It also mentions some other lethal events, disagreement if somebody falls into a pit of snakes if they're considered dead. It says somebody's considered dead if they fell into a pot of boiling wine and similar points. It also cites an incident where the daughter of a ditch digger fell into a cistern, so they kept going to the sage Rabbi Hanina ben Dosa for help, and he kept saying it was fine, and then the third time he said she had emerged, and she had, claiming that an old man with a ram had let her out. They asked Rabbi Hanina if he was a prophet, and he said, no, it just doesn't make sense that a righteous man should have his child punished through the good things he had done. This ditch digger's son, nevertheless, still died of thirst one time, as God is extremely exacting still, based on verses. New Mishnah: if a person hears somebody else saying that somebody died, he can testify that the man died. Some say even if he heard his kids saying that they were going to eulogize and bury him, it's allowed. These words are accepted whether they were intended as testimony or not. Some say we only believe an idol worshipper if they didn't intend to testify. The Gemara further clarifies these points along with citing some related cases, and this is discussed further. In New Mishnah: witnesses can testify that somebody died whether they saw him by lamp or by moonlight. You can also allow a woman to remarry if they just heard but didn't see somebody testifying to her husband's death, and it cites some particular incidents. The Gemara discusses these points, and it asks, what if the person that she heard was a demon? And it says that, in that case, it must be where she saw at least the man's shadow of a shadow, which it said that demons cannot fake. New Mishnah, it gives the list of all of the sages who argued whether we believe a single witness's testimony that a husband died, and all of the opinions on this. And the Gemara further discusses these opinions. New Mishnah: Rabbi Akiva said we don't allow the testimony of a woman, slave, or maidservant by these laws. It cites an incident which seems to imply otherwise, but Rabbi Akiva said that was where the witnesses brought many identifying possessions of the individual. The Gemara further discusses this incident with a few particular points and ends by quoting a verse which says that Torah scholars increase peace in the world. And that's the end of chapter 16 and the entire Tractate Yevamos. Alright, that was a lot of information. So here's a rough summary of a lot of the practical takeaways from this tractate. The Levirate marriage is a very unique form of marriage. Essentially, if a wife is left widowed without any children, her remaining brother-in-law is obligated to marry and take care of her in a process called Yibum. In the event that they don't want to go through with this marriage, they don't have to and perform a ceremony known as chalitza. There are various types of marriage which are forbidden, either biblically or rabbinically for various reasons. Forbidden people to marry include relatives, secondary relatives, a Kohen Gadol marrying a widow, a Kohen marrying a divorcee, various converts from specific nations, an illegitimate individual, people with reproductive issues, people lacking the necessary mental capabilities, like a minor or insane individual, and many others. There are unique leniencies to allow a potential widow to remarry easier. Typically, almost everything in Jewish law requires 2 witnesses. One of the exceptions to this is that if a woman's husband vanishes and is thought to be dead, she'll be allowed to remarry and not be stuck questioning if her husband's actually alive or not through the testimony on the death of her husband by a single witness. Tractate Kesubos discusses the laws of the marriage contract, referred to as a Kesubah, and also the general obligations of the marriage agreement. Chapter 1 will begin discussing some points on the general laws of marriage. The first Mishnah says, "It's instituted that a virgin marries on a Wednesday while a widow marries on a Thursday." This is because courts were in session on Mondays and Thursdays back in those days, and if somebody wanted to go to court after a marriage to dispute the claim of his wife's virginity, he'd be able to go the next morning. The Gemara says, she's married on a Wednesday, not a Sunday, which is discussed. It explains that we want to give 3 days for the husband to prepare for the marriage feast, Sunday, Monday, and Tuesday, and also the husband is only obligated to provide her with food by Wednesday. There's debate if, based on this, the wedding was delayed, if the husband is obligated to provide her food at this time. It's explained, based on a different discussion, that if the wedding was unavoidably delayed, the husband is not obligated to provide her food, while if it was voluntarily delayed by the husband, he would be obligated. Some also add that this notion of unavoidable delay would not affect a divorce document. It's debated what the source for this is. A number of options are suggested and all rejected, and it's explained that it's just a logical conclusion. Essentially, it could either be that this notion of the impermissibility of delaying bringing a divorce document could either be a situation of a modest woman, so the husband just decides to delay here voluntarily, and she'll assume it was involuntarily and then just wait, unable to remarry. Or alternatively, it could be an immodest, bold woman where the husband is actually unavoidably delayed, but she assumes he's just stalling voluntarily, so she'll remarry impermissibly and father illegitimate children. So because of this, it's deemed that there's no notion of delaying a divorce document. The permissibility of the court to enforce such a document is that as they're allowed to betroth a woman, they can also retroactively remove a betrothal, whether it was done with money or through cohabitation, in which case they could just retroactively rule that it was an illicit cohabitation, thereby nullifying the entire marriage. Others say it's actually the exact inverse of all of this, that we do apply the principle of an unavoidable circumstance delaying a divorce document. Again, various sources are suggested and debated. Anyways, we said earlier that marriages tend to be on Wednesdays. This was instituted after the enactment that courts would convene on Mondays and Thursdays. Before that, people would just marry whenever. And they could also still do that now if the court also convenes whenever, obviously assuming you took care of the wedding preparations before Shabbos. This is discussed. At some times, it became dangerous to marry on Wednesday, as it was instituted at some point in this time historically that anybody married on a Wednesday had to go to the local governor and cohabit with them first, and many modest women would treat this as a life-threatening matter, among other issues. So anyways, people started marrying on Tuesday, which was fine, but to marry on Monday was only done due to an unavoidable circumstance, such as a general and an army coming to town during the week and a while after, and there's a worry they'll cause issues with the wedding if it's done any later than this date. Alternatively, the unavoidable circumstance is the sudden death of a relative while they're finishing the wedding preparations, so they can just marry earlier, have the wedding, and then do the burial without delaying it. This applies if it's the father of the groom that passed, or the mother of the bride, as if they delay the wedding then no one will re-prepare it. It further says that the wedding must have been prepared to the point where the food has all been prepared, as if it could just be resold and rebought later. They can just delay the wedding until afterwards. We bring sources. It clarifies some further laws in regards to a mourner getting married. We also say that in the event that a marriage occurs towards the end of the week, You shouldn't cohabit with your wife for the first time on a Friday night, as you could cause bleeding, creating a wound of a sort, and you can't create a wound on Shabbos. And it also shouldn't be done on the night after Shabbos, and there's debate why that's not allowed then exactly. There are a few suggestions. It said to be impermissible out of concern that he might slaughter a bird to prepare as a wedding meal after Shabbos ends, which would also be an issue for cohabiting on a Friday night. There's also debate generally as to when the act of cohabitation takes place by marriage. By a Wednesday, it said that by marrying a widow, it's done on Friday, either as there's blessings there, or so that way we make the husband spend time with his wife for the next 3 days, Thursday, Friday, and Shabbos. There are some practical differences, either if the man doesn't work or a holiday fell on a Friday, where we know he'll be spending time with his wife either way. It cites some related verses on this as a side point. It says your fingers are shaped in a point based on a verse, so you can plug your ears if you hear someone saying something improper, like gossip, for instance, which is a very negative thing to listen to, which is also why you have earlobes. Anyways, it further debates if cohabiting for the first time with someone legally constitutes as the creation of a wound, which would make such an act for the first time impermissible on a Shabbos, depending on what type of blood you hold that wound creates, and whether or not this is considered to be a destructive or a constructive act. There are several opinions who disagree on this matter. We cite a number of sources which seem to imply that it would be permissible to do such a thing. There are several different opinions listed ruling as to whether it is or is not permissible. The final ruling is that it is permissible to cohabit with a woman for the very first time on a Shabbos. It also speaks on some of the blessings said by a wedding. These are further discussed. There are 7 blessings called the Sheva Brachos said in the house of the groom, although in Judea they would sometimes say it in the house where they did a rusin, the final stages of marriage. It also lists the text of the blessings. It says they're said before 10 people, all 7 days of rejoicing, although others say only when new people come to the meal, and it further lists all the text of these blessings. These and further variations as to how the blessings were read are discussed further. There are some particular related incidents mentioned, and further phrasing on other blessings, like by a mourner and similar. By the Sheva Brachos of a wedding, there are also several cups of wine that are drunk before eating, during eating, after eating, by the after blessing, and others, which were instituted, one of which is drunk in honor of the sage Rabban Gamliel, who set the practice, starting with himself when he passed, that he should be buried in very cheap garments to allow burial to be easier on poor people, as now everybody also used cheap clothing. Anyways, in regards to actual testimony that somebody would make that the wife he married was not actually a virgin, we believe him, and they can no longer be together. This is clarified to apply either if he's a Cohen, meaning she'd be forbidden to him even if she was violated anyways, or it was a case where a father accepted betrothal on his minor daughter under 3 years and a day old to eventually one day have this marriage go through when she becomes an adult, when she's actually legally allowed to marry, in which case the cohabitation must have occurred way later after this, as you're not allowed to cohabit with somebody that young. This case is further discussed. There's debate if this is a valid ruling based on other sources. Some also say in such a situation she doesn't get her marriage contract, although this is similarly debated if it requires actual evidence of an absence of blood or not. It also disputes if the notion of a Kesubos, the marriage contract, is of biblical origin or not. It also cites some specific cases of people who came to sages claiming their wives were not actually virgins when they married. One was actually admonished for this, as the only way he could have been an expert in such things was if he was frequenting harlots, and the other was said that perhaps his act of cohabitation was done at a slight angle, so it didn't appear to him like she was a virgin. There was another incident where a couple came before a sage, one saying she hadn't bled, the other saying she was a virgin, so he soaked the sheets in water and found some blood. There are several other similar incidents mentioned. New Mishnah. The Kesubos, the document given at the start of a marriage, contains the stipulation for an agreed-upon sum of money to be given to the wife upon the termination of the marriage, either through divorce or widowship. For a virgin, it was typically in those days done at a minimum of 200 zuz, which was an old form of coin, and for a widow was lower than that, 100. A virgin who was widowed, divorced, or had done chalitza while in erusin, the final stages of marriage, her kesubos is still the full 200 zuz, although the husband can make a claim against her if he finds she's not a virgin. The Gemara cites a few verses which source some of this terminology. It also speaks a bit on the health benefits of dates, and some other points on etymology. New Mishnah. A convert, a captive, and slave girl, if they were a child under 3 years and a day when they were ransomed, converted, or emancipated, Eventually, when they get older and marry, their Kesubos dowry is still the full 200 zuz for that of a virgin, although a claim could be made against them. The Gemara debates if a minor is allowed to be converted by a court. If a minor had been converted, there's discussion on if she needs to reconvert when she becomes an adult. New Mishnah. In the event, God forbid, that somebody had cohabited with a minor girl, or in the case that a minor boy had cohabited with an adult female, or if a woman became no longer physically a virgin by an injury from a piece of wood or something, their Kesubos, when they eventually do marry, is still the full 200 zuz as if they were still a virgin, meaning they are not held responsible for any of these events occurring to them. Some say by the injury, however, it is actually reduced to 100. A virgin widow, divorcee, or somebody who had done chalitza from nisuin, the first stage of marriage, their Kesubos dowry is 100 zuz, and they can't have a claim made against their virginity. A convert, captive, or slave woman who were ransomed, converted, or emancipated when they were older than a child, meaning over 3 years and a day, when they eventually get married, their Kesubos dowry is 100 zuz, and they can't have a claim made against their virginity. The Gemara says, as a minor boy cannot legally cohabit with anybody in a circumstance where he had, it's considered the same as if the woman was injured by a piece of wood, and she has her dowry paid in full, according to some. Similarly, if, God forbid, a man had cohabited with a minor girl, that does no damage to her dowry when she eventually grows up, and she'll still be given the full 200 zuz when she one day gets married, as she's not in any way held responsible for that thing which occurred to her earlier on in her life. These points are for the discussion. There's debate based on this if the standard amount given to a woman who was said to be a virgin and was then found to not be one is only 100 zuz. Some say it's actually nothing. This was just unique, as the woman in question was already married before, so the husband should have at least suspected she was no longer a virgin. There's variation on this discussion which is qualified. New Mishnah, if somebody eats in his father-in-law's house in Judea without witnesses that he didn't seclude himself with his betrothed, he cannot make a claim against her virginity after they marry, as they would typically have secluded themselves. The Gemara says that even within Judea, there was some variation between customs in different places, and this is discussed. New Mishnah, a widow, whether she's a Kohen or not, has a Kesubos dowry of 100 zuz. The Kohanim would typically give 400 zuz as a Kesubos if their wife was a virgin, which was permitted. The Gemara says for Kohanim, by widows, it was initially 100 zuz, but then people started treating the marriages lightly, so they raised it to 200, but then people stopped marrying widows, so they brought it back down to 100. It also says an eminent family, not just Kohanim, could set the contract to 400 zuz. New Mishnah, if somebody marries a woman and finds she's not a virgin, but she says, I was actually violated by somebody after you betrothed me, so it shouldn't affect the contract, while he claims it occurred before the betrothal, there's a debate as to who we believe. The Gemara says, generally, if somebody says to a person that you owe me money, and the person says, I don't know, there's a debate if he needs to pay it. Some say he does, that's a definite argument against an uncertain one. Others say he doesn't need to pay it, as the money should stay with who currently has it. Anyways, it suggests that possibly that's the same logic as the arguments by this case. Some say no, as there's a principle known as migoi by the case of the betrothal, which essentially states that as she had a much better claim, which wouldn't have been able to be disputed at all, like that she lost her virginity from an injury, for instance. So there's an additional reason to believe the woman by that case, as she chose to not make a much better and easier believed argument, while such a thing doesn't apply by the situation where somebody claims that the other person owes them money, as no such principle applies there in that situation. We say we follow the opinion that a definite statement doesn't override an unsure one. However, by our Mishnah, due to the difference between the cases and the additional reason to believe the woman that was described, we do believe her. New Mishnah, if a woman says she was no longer a virgin from an injury and the husband says it was from a prior person, actually, it's debated who we believe. Some say the woman, some say only if she brings proof. The Gemara debates if the situation is where it's between paying 200 zuz and 100 or 100 and nothing, based on what you hold the payments are. It also lists the case in addition to the prior to teach the extent of the differing opinions. The first says she's not believed in spite of the migoi claim. The second, which says she's believed in spite of the lack of a migoi claim. New Mishnah, if the court saw a woman speaking to somebody and they ask what his status is to see if it'd affect her marriageability, and she says he's a Kohen, meaning not an illegitimate person, there's a debate if she's believed or if she needs proof. Similarly, if a woman is pregnant and she says the father was a Kohen, and not somebody illegitimate. Some say she's believed, some say she needs proof of this. The Gemara says that when it says that she was speaking to somebody, that either means that they were in seclusion or it's just a euphemism for cohabitation. This is further discussed. The logic of these cases is further qualified. It also debates if such a woman's daughter is considered legitimate or not. It's debated as to who we hold like and further discussed. It's additionally debated. New Mishnah. There was an incident recorded where a girl was violated by a man from a town. It was ruled that if majority of the members of the town were fit to have their children marry a Cohen, this girl's child should be allowed to marry a Cohen legally. The Gemara further discusses this. There are further points on different majorities that create a presumption that a child is eventually allowed to marry a Cohen, and there are some particular instances discussed and some additional qualification on these laws. And that's the end of chapter 1. Chapter 2 of Tractate Kesubos discusses further laws of marriage and the marriage contract. The first Mishnah says if a woman was widowed or divorced, meaning she collects her marriage contract at that point, and she claims she was married as a virgin, meaning she should receive the full 200 coins, while those paying claim she was married as a widow, meaning she'd only be paid 100. If we have witnesses that by her wedding she was sent out with a hinuma, which will be defined, or with her hair down, and some say if parched grain was given out, as was the custom if the woman was a virgin, meaning there are proofs that at the time of the wedding she was a virgin, she's now paid the full 200 zuz. Another point, if somebody goes to a man and says he bought a field from his father, he's believed, as this guy was unaware of the field in the first place, so the only proof it was ever owned by somebody else is from the person who owns it. However, if there are other witnesses that it was owned by the other person's father, he's not automatically believed if he says he bought it from him. The Gemara debates the logic of the first case. The implication seems to be, as the woman has witnesses, that if there were no witnesses, she wouldn't be believed. This would be different from a case from the prior chapter where the woman was believed, according to the opinion that it was a definite claim, which overrides an uncertain claim, as our case is a definite claim versus a definite claim, essentially, as most women marry when they're a virgin. Based on this, there's also a question as to what the other opinion, which references the concept of migoi, the notion that somebody would be more likely to be believed if they have the option of giving a more easily believable testimony and instead chose to bring the one they brought, is exactly referring to in the earlier chapter. There are several suggested cases brought. It also suggests that although majority of women marry as a virgin, this wouldn't help here, as typically it's also public knowledge, unlike by this case. It also says there's no concern of the woman reusing the Kesubos contract in different courts, as possibly we write a receipt, possibly because this is a situation where the contract isn't written. This is further discussed. It also mentions several different practices that were done by the weddings of virgins, such as passing a cup of teruma wine, a barrel of wine, and also singing and dancing was done. There's also debate between Beis Hillel and Beis Shammai if we praise a bride on her beauty at her wedding, even if she's not actually beautiful. It lists a few others of such blessings, and it talks about the importance of dancing before the bride and groom at their wedding. It also says we hold it's not allowed for people to gaze at the bride during the 7 days of celebration. It also says if there's an entourage carrying a corpse, they're diverted for a bride and a corpse, and a bride is diverted for a king. A king, Agrippas, once diverted himself for a bride, and it's debated if this was proper. It's said that it was at a crossroads, so it was fine. It mentions other obligations by a wedding or funeral. It says many shofars were blown to honor the dead. The amounts are debated. Also, the definition of a hinuma is either a myrtle canopy or a veil. It discusses other things done at weddings if the bride was a virgin. The next point was by the field case. It said a case where the man claimed he purchased the field from the other man's father and not from the man himself, unbeknownst to him, as that case doesn't really work for listed reasons. This is discussed. It also discusses the effectiveness of a legal protest not lodged in the occupant's presence, if this is effective, which is debated. It also proposes other cases it could have discussed, but rejects them based off of individual issues, and it's further qualified. New Mishnah, if witnesses certifying a document say this was our handwriting, but we were coerced to sign, or we were minors when we signed it, or we were otherwise unfit to testify, they're believed, as the only person suggesting that it was legitimate was also themselves. If, however, there there were witnesses that it was signed by them or otherwise verified, they're not believed if they try to disqualify their own testimony. The Gemara suggests that if they say that they signed the document under threat of death, they'd still be believed even if their signatures had been verified by a third party. This is rejected as witnesses who testified cannot re-testify to retract their prior testimony. Rather, what it means to say is that if the witnesses testify that they falsified their testimony because of a threat to their finances, they're not believed, as there's a rule that a person cannot establish themselves in court as a criminal. There are related points. It quotes an opinion that says witnesses who authenticate their signatures on a document are not believed to invalidate it. This is because the document is valid even without their certification, as the individual conceded that he had drafted it. It also holds that if somebody has a debt document that he said was written on trust, he's not believed. There's debate as to what kind of document exactly he's referring to, and there are related cases discussed. Furthermore, if witnesses have signed a document and died, new witnesses can't appear to contradict the validity of the original testimony, as it's the two witnesses versus each other now. So the current status just remains as it is. We bring sources. In regards to certifying the validity of a document, some say you can only compare it to a document that was challenged and verified. But some say you can also compare it to two Kesubos marriage contracts or bills of sale of two fields, provided that the owners used the fields peacefully for 3 years after, and this is assuming the documents were procured by somebody other than the person whose document is actually being questioned. And there are further points on the laws of written testimony. It also discusses some laws of impurity, which we use to teach that a witness can testify on something he saw up to 60 years ago. Others say it should be more, as people will take care to remember something that they need to testify on. New Mishnah: if two witnesses verify their handwriting and their fellows, it's valid. If each person can only validate their own handwriting, some say they need to get another person to verify their handwriting, others say their testimony is sufficient. The Gemara debates exactly what this case is referring to. It also cites an opinion that if two people are witnesses and one of them dies, two new people must authenticate the signatures and one can't be the original witness. If there's one new witness, then the surviving witness should just write his signature on a shard, so that way it can't be used afterwards for forgery by others, and it will then be used to verify his original signature. It's said that we rule that the two witnesses can just verify themselves. It lists a few unique related cases. Furthermore, some say a witness and the judge can combine to authenticate signatures, but this is rejected. There are other specific cases brought, and these are qualified further. New Mishnah: if a woman says, "I was married and got divorced," she's believed, as she's the only source of this information. If there are witnesses, however, that testify that she was married, she's not automatically believed that she was divorced. Similarly, if a woman says she was held captive but remains pure, she's believed because she's the only source of this information. If there are witnesses that say she was held captive, we don't automatically believe her if she says that she's pure. If these witnesses came after she married, she nevertheless doesn't need to leave her husband. The Gemara cites sources for these rulings, and it also cites some particular cases. There are further particular cases brought. Some say if two witnesses say a man died and two witnesses say he did not, the man's wife cannot remarry. If she did, she can stay married. If two witnesses say a woman was divorced and two say she was not, she cannot remarry, and if she did, now she would actually need to divorce. There are a few suggested differences between these cases. The first is that it was actually one witness testifying by both cases, where there's a special exception to believe that the husband died, or it's that there's a stricter opinion accepted by divorce, as she can contradict the husband's claim if he says he didn't divorce her, so long as there are no witnesses, or it's that the witnesses testify that the death or divorce happened today, which can't be verified by the dead husband, but it can just be verified by the divorce, as they could just have her show the divorce document that she should have received. And there are further particular cases discussed. The other points are further qualified, along with bringing some instances of a few actual cases. New Mishnah: if two women were held captive and they testify about themselves that they're pure, they're not believed. They are believed if they testify about each other. The Gemara discusses some related particular instances. If a woman testifies about herself, saying she was made captive and violated, she's believed. If she says she's pure, she's believed, so long as there aren't other witnesses to testify to her captivity. If a woman testifies that another captive was violated, she's not believed, unless witnesses testify to their captivity and there are no witnesses that say she wasn't violated. If a woman testifies that another captive is pure, she's believed, regardless as to what the other witnesses testify. New Mishnah: if two men testify about themselves that they are Kohanim, they are not believed. They are believed if they testify about each other. Some say we can't make somebody a Kohen based on one witness. Others say that's only if it's contested. Others say we can, even if it's based on one witness. The Gemara explains the necessity of these cases, and they're further discussed. It also debates
the evidence level required to elevate somebody to be a Kohen. It's debated if you can use documents or if it's just based on the fact that he at some point said the priestly blessing. It tries to bring many further proofs for the latter point, which are further discussed. There are additional suggestions brought, attempted proofs from having seen the individual reading from the Kohen portion of the Torah and similar. It also says that casual speech could work to establish somebody as being a Kohen. It gives an instance of a man who casually mentions that his father would give him teruma, a tithe, which can only be eaten if you're a Kohen, when he was younger, and he was therefore established to be a Kohen based on that. And there are further similar points brought, and it debates of having received Ma'aser Rishon tithes, if that's sufficient proof, and that's further discussed. New Mishnah: if a woman is imprisoned by people who worshipped idols, if it was for monetary matters, she can be with her husband after her release. If it was for capital punishment, she can't be with her husband if she gets freed. The Gemara clarifies, if the Jewish people are actually ruled over by these people, then she's not allowed to be with her husband in either case. And there are some other instances discussed, along with some additional points. New Mishnah: if a city fell to a siege, all wives of Kohanim within can no longer be with their husbands, unless they have witnesses that they weren't attacked. We'd even believe a slave or slave woman's testimony here. We don't, however, believe somebody's testimony on themselves. The Gemara says that, unlike by the woman, there's no concern that they used wine barrels for idolatrous libations, as there'd be no time. It also clarifies that this is a city besieged by a different kingdom, not by a city besieged by its own same kingdom. And there's no concern of somebody slipping past the army into the city, as it's sufficiently guarded in this case. Some say if there's even a single hiding spot in the whole city, all of the women within are presumed to not have been attacked and violated. There are related points discussed. It also argues that if a woman says, although there was a valid hiding spot, she didn't use it, but she still wasn't attacked, she's in that case believed. It further clarifies which testimony is accepted by such a situation. New Mishnah: there was a sage who survived the Roman siege of Jerusalem, and he swore that he had stayed with his wife the entire time, and she was not attacked. But he was told that a person still can't testify on his behalf. The Gemara discusses related points, and there are further related laws here discussed. New Mishnah: the following are believed in their testimony of something they saw back when they were a minor. Somebody who testifies on the handwriting of his father, teacher, or brother, the fact that a wedding occurred in a manner typically done for a virgin bride, that somebody did things that implied he was a Kohen, or that a location is a plowed-over graveyard in regards to the laws of impurity. He is not trusted by monetary claims, like that somebody had a path through a region, or a designated eulogizing spot or similar. The Gemara says that all of this applies if there's also an adult testifying along with him. The remaining points are qualified, and it explains why these testimonies are believed, such as that generally most women marry as virgins anyways, whether a person was a slave or not, and the points on eating teruma to verify that he's a Kohen. The remaining points are also further discussed. And that's the end of Chapter 2. Chapter 3 of Tractate Kesubos continues discussing various laws of marriage. The first Mishnah says, if a Na'ara, a girl in a middle stage of adulthood, is illegitimate, or a Gibeonite, or a Kuthian, and is violated, God forbid, she's paid a fine. If a convert, captive, or slave girl who were ransomed, converted, or emancipated as a child were violated, they're also paid a fine. If somebody violates his own relative, his sister, aunt, sister-in-law, father's brother's wife, or a nida, a menstruating woman, they're paid a fine. This is although the violator is also subject to the punishment of kares. The Gemara further clarifies these points. It also discusses the verses which source these laws, and it qualifies which opinions on these laws these statements seem to reject. There's also some additional points on the different forms of capital punishment that used to be administered when there was a Sanhedrin. There are related points discussed, and this is all qualified further. It also mentions other forms of reimbursement for such crimes. There's an apparent contradiction. Our Mishnah says a person who violates his sister is liable to pay a fine, while a later source says he's liable for lashes. The difference between these cases is disputed. The other one could be where he was warned beforehand, possibly, but this is discussed, and it cites some sources. It quotes additional verses as sources for several of these laws and similar, such as for financial reimbursement after injuring somebody, and these sources are further qualified. It also discusses the various punishments for the violation of various other prohibitions. It's on things like particular violations of the Shabbos and similar. Further, some would hold by that later source that the punishment for somebody violating their sister is both lashes and a fine. And this is further debated as to why some hold like this and others disagree. There's further discussion on this and some similar related points. It cites further rulings on these fines by additional particular unique cases, and these are all discussed further. New Mishnah, the Na'aras who aren't entitled to a fine are as follows: a convert, captive, or a slave girl who were ransomed, converted, or emancipated after they were a child. Some say a captive who was ransomed is presumed to not have been violated, even if they're older than a child. Also, there's no fine if the violator is liable for the death penalty, such as someone who's with their daughter or granddaughter or stepdaughter. The Gemara discusses related opinions. It further debates, based off sources, if captives are suspected of having been cohabited with. It also discusses the first source for the point that somebody who was liable for capital punishment does not have to pay fines. These verses are further discussed, and there's some additional qualification. New Mishnah, if a Na'ara was betrothed, divorced, and then violated by somebody, there's debate if she's entitled to a fine. The Gemara explains that this is based on the interpretation of various verses on this subject, and the differing opinions are discussed and additionally qualified. New Mishnah, a seducer pays for humiliation, deprecation, and a fine, while a violator also pays for the pain he caused. Further differences, a violator pays the fine immediately, while a seducer pays it when he sends her away. Also, a violator can be forced to marry the woman and take care of her financially for the rest of his life, even if she's extremely undesirable, unlike by a seducer. The exceptions to this marriage by a violator are if she's found to have committed adultery prior, or she's illegitimate, which is based on verses. The Gemara debates which pain exactly it is that the violator is being fined for. The other points and the differences between a violator and a seducer are further qualified. New Mishnah, if an orphan was betrothed and divorced, a person is liable for violating her and exempt for seducing her. The Gemara argues on the source for this ruling. New Mishnah, payment for humiliation is determined based on both parties involved. Deprecation is calculated by assessing how much the woman would have been sold as a slave in theory before and now, based on the difference between the two sums, similar to the whole concept as to when a person pledges their worth to be given to the temple, and the fine is a fixed amount. This notion of fixed fines applies by all monetary liability in Torah. The Gemara debates that the set 50 shekel fine does not include within it the fines for humiliation and deprecation. It also debates who receives these fines based on sources. It's debated if it goes to the woman or to her father. It says there's no biblical source for this, but logically it should go to the father, as he generally got to make decisions for his daughter. It further describes how the deprecation value is calculated. New Mishnah, in some places it was done that a father would sell his daughter as a maidservant to serve for several years, and then would marry her master or his son. There's either permissibility for such a law or punishment for violation or seduction. A minor could be sold by her father as a maidservant, but wouldn't be subject to such a penalty. A na'ara would be subject to the penalty, but can't be sold. A bogeres, an adult woman, can't be sold or entitled to the penalty. The Gemara further qualifies points in these laws. If someone had admitted that they seduced somebody, they pay for humiliation and deprecation, but not for a fine. If somebody admitted that they stole, he pays the principal, but not extra. If somebody admits his ox killed somebody or an animal, he repays the amount, but not if he says it killed a Canaanite slave. Generally, if somebody would have had to pay more than what he damaged, he doesn't pay based off of his own admission. The Gemara says it doesn't mention a case of violation, as that's obvious compared to the seduction case, as there he discredits the woman. Others disagree with many of these points. It cites several sources which imply that half damages are considered compensation, not a penalty. These are further discussed. It's ruled that half damages are actually considered a penalty, and this has relevance by several particular cases. And that's the end of chapter 3. Chapter 4 of Tractate Kesubos continues discussing the laws of marriage, here particularly in regards to the fines of a violator or seducer. The first Mishnah says, a na'ara, a girl in the middle stage before adulthood that was seduced, the payments for her humiliation, deprecation, and fine all go to her father, as does the payment for pain by a violator. If she sued the man in court before her father died, the payment goes to her father. If the father died before all of this, the payments go to her brothers. If she sued after her father died, it goes to her. If she sued before she became an adult, the payments go to her father, and if he dies, her brothers. If she sued after she became an adult, it goes to her. Some say if she sued while her father was alive, but he died before she could collect the actual payment, the money goes to her. Generally, any of the girl's earnings or fines, if they're uncollected, if the father dies, they go to the brothers. The Gemara explains this is very repetitive of the last Mishnah, but it's to teach that the money goes to her father, and also to teach the dispute between opinions as to where the money goes if she sued the seducer while her father was still alive. It cites a later case that if an accused man denies having seduced or violated somebody and then later admits that it was him, there's a dispute if he pays the fine based on if you hold you can make yourself pay a fine based off of your own admission, although he definitely still would need to pay for the humiliation and deprecation. It said that if he denied having been sued and having to pay the fine, that is considered a denial of monetary obligation, and he'll be liable to bring an oath offering. The logic of this case is further debated. A related point, if a daughter is being supported by her brothers from the estate of their father, there's a question if her earnings go to the brothers in place of the father, or if that's not a valid comparison. And we try to compare it to a related case involving a widow saying that it should go to the brothers, but this is debated. It's said, based off of a different case, that actually the earnings stay with her, not the brothers, and we bring opinions which corroborate this and sources. This is the final ruling. New Mishnah, if somebody gives his daughter to be married and the groom divorced her prior to the completion of the marriage, and then they restarted the marriage process again, and then he died before they could complete it, both marriage contracts go to the father. If the same case happened for both times the marriages ended after the final stages of marriage, some say the marriage contracts go to her, some say only for the second marriage. The Gemara says an opinion that she's still allowed to remarry after this, but she wouldn't if she had been widowed 2 times in a row, according to the opinion that such a presumption of reoccurrence is established after 2 occurrences. The logic of the contracts going to the father is that they were written while she's still under her father's jurisdiction. There's debate as to when exactly the base marriage contract of 200 or 100 zuz becomes applicable. Some say it's in the initial stage of marriage, some say it's only after the completion of the entire marriage, and this is debated. The logics are further explained, and it's ruled that all of the contract amounts are collectible after the final stage of marriage. New Mishnah, in regards to a female convert who converted along with her daughter, and the daughter did adultery, the daughter is liable to capital punishment, which back then was strangulation. She's not subject that this occurs at her father's house, and if it turned out that her husband had defamed her, she's not entitled to a fine. If her conception was prior to conversion, but her birth was after, she's instead liable for stoning, and the other 2 points also don't apply. If she's conceived and born after conversion, she's like a Jewish woman in all other respects by these laws. If she has a father but doesn't have a house, or she has her father's house but no father, she's still liable for stoning. The point being that it should be by her father's house, as mentioned in a verse, is just an additional obligation. The Gemara brings sources for these points. It also says regarding the fine for defaming an orphan girl, the verse says you give it to her father. So if she has none, some say it's just not given, assuming the cohabitation happened while she had no father. This is further debated along with if it's required to pay the fine if somebody defamed a minor girl. This is further debated, and there's additional discussion on this point. It also debates based on other sources whether the term for lashes can be used in reference to a monetary loss, and it discusses the punishment for a defamer being lashes, which we bring sources for. It also debates if this still has applicability if the defamed in question and the woman did not ever actually cohabit, which is based on the interpretation of the verses. Uniquely, there's not typically difference drawn by these laws of cohabitation in regards to either the natural or atypical forms of cohabitation. The ruling is usually the same, except by a defamer, where this only applies if the husband is accusing his wife of having done adultery in a natural manner, and also they had cohabited themselves in a natural manner. New Mishnah, a father legally has the right to betroth his daughter, receive the money, accept the betrothal document, or give to be betrothed through cohabitation. He's entitled to her fines and earnings, he can annul her vows, and he can accept her bill of divorce, although he doesn't get to eat the produce of her field. Once his daughter is married, the husband overrides all of the father's rights, although he also gets to eat her produce, although the husband is now also obligated to give his wife sustenance, ransom her if necessary, and pay for her burial. Others say even the poorest man in Israel must hire at least 2 flutes to mourn for his wife at her funeral. The Gemara cites sources for all of these rulings going through all of the applicable verses. These are further discussed going through all the sources for these points, and it additionally discusses the husband's obligations to support his wife. It also discusses the points on the obligation to have flutes by your wife's wedding. Some say that what it's referring to is specifically the opinion which holds that it's an obligation where it's the custom of the man's family to do so. It said we follow this opinion. It's also said if somebody went insane, the court goes through his property and supports his wife and children, and some say also gives adornments for his wife, and some say charity. The logic is debated. If a man is overseas and his wife dies, the court goes through their property to bury the wife according to her status, or at the very least according to his status. This teaches that a woman rises to her husband's status but does not descend to his status even after her death. Another ruling, if somebody says that if he dies, he shouldn't be buried from his own property, we don't listen to him, as people shouldn't be able to make their families richer off of the public wealth. New Mishnah, a girl is under the domain of her father until she's in her husband's domain in a completed marriage. If the husband gives the daughter to the husband's messengers who will deliver her to him, she's considered in the husband's domain at that point. If the father or his agents went with them, she's still considered to be in her father's domain. She's in the husband's domain once the father's messengers have given her to the husband's messengers. The Gemara says this disputes the opinion that a girl can't eat teruma during her betrothal to a Kohen, and it further debates the legitimacy of using messengers to deliver a daughter to a husband. This is further discussed. There are further points that says that once a woman enters her husband's household, if somebody does adultery with her, they're liable to the capital punishment of strangulation. New Mishnah, a father is not obligated to provide his daughter's sustenance. Based on the wording of the marriage contract, it's implied that the same way sons inherit after their father's death, a daughter is sustained after her father's death. The Gemara clarifies based off this wording that a father is still obligated to provide sustenance for his sons, and he does have a mitzvah to do so also for his daughter, and it debates whose opinion this holds like. This is further discussed, and some are of the opinion that a father must sustain his minor sons and daughters, although we bring a few sources that the court can't force a person to do this unless he's wealthy. It also debates if somebody wrote off all of his possessions to his children, he and his wife are still sustained from them, and it said we don't rule like this. Generally, it's proper to give a tenth of all of your income to charity. If you want to give more, it said you shouldn't give more than a fifth, and it brings sources. There are also other points. It also says how and when to discipline a child who won't learn, and some medicinal treatments for a sick child. There are further related points and expansion on a few verses on the importance of charity, and likewise, it further qualifies which property should be given to support children as to whether or not you can use movable property, and this is further debated. New Mishnah, if a groom did not write a marriage contract, if he married a virgin, she gets 200 zuz. If she's a widow, she gets 100 as stipulated by the court. There are particularities by promising land. If he didn't stipulate that he'd ransom her, if necessary, in the marriage contract or similar, he's still obligated to do so as it's stipulated by the court. If such a thing does occur, he's not allowed to divorce her to just get out of it. If his wife gets sick, he's obligated to heal her, but here he's allowed to divorce her to exempt himself. The Gemara debates the author of this Mishnah. This is further discussed, along with if a Kohen's wife was violated, there's debate if she's allowed to remain with her husband after, out of concern that to some degree she'll have reconciled to the attack and the full act won't be legally considered entirely unconsensual. There's debate if this is held, others disagree with this point, and there are related points discussed. It also says that if a woman is held captive by a king, if it's of a major monarchy, the act of cohabitation is deemed non-consensual, and she'd be allowed to be with her husband after. If it was with a minor, irrelevant king, there might be a concern of her trying to marry the king, so she wouldn't be allowed to be with her husband after, and there's a similar point by bandits. This is all further discussed, and there's additional qualification. New Mishnah, if the marriage contract didn't say that the marriage contract would be inherited by their sons, that's still done anyways as a court stipulation. If it didn't say that their daughters will be supported by him until marriage, that's also still done, again, as a court stipulation. If it didn't say that after his death, his estate and house would still support her, that's still done as a court stipulation. The last point was done in Jerusalem and Galilee. In Judea, the heirs could just give the widow her contract payment and be no longer obligated to support her. The Gemara says that it established that part of the marriage contract goes to their children, so that way they'll give large dowries for their daughters, which will help marry them off. A dowry would be a tenth of a person's possessions. And there's further particular discussion on this. There's further qualification and points on what exactly a woman gives up if she waives her right to a marriage contract. Some saying she no longer needs to be given sustenance. There are particular instances of similar things given. There are related points on supporting a daughter, and there are a few other unresolved questions on these laws. A widow is supported by her husband's estate. However, it says not if she remarried, or even if she turned down a marriage offer from somebody if she felt that he was unworthy of her, or if she cohabits illicitly, and some say even if she dresses in a manner to try and attract other men, although it said we disagree with all of this, and it's held that her support ends when she demands the payment of her marriage contract. The remaining points are further qualified, and that's the end of chapter 4. Chapter 5 of Tractate Kesubos further discusses laws of marriage and the marriage contract. The Mishnah says, although the general principle is that a virgin receives a marriage contract of 200 zuz while a widow gets 100, you can add to this if you want. This amount is collected by her upon her becoming a widow or a divorcee, no matter what stage of marriage she's in. Some say she only gets any extra more than the default minimum 200 or 100 if they separated after she was fully married. If they agree, they can write the contract as the legal minimums, 200 or 100, and then afterwards have her give him back some of the money. Some say if the Kesubah amounts are beneath the minimums, cohabitation between them is considered non-marital and impermissible. The Gemara says, it had to state that you're allowed to increase your Kesubah contract more than the minimum to say that there's not a principle of a set amount here to reduce the embarrassment of poor people. Further, a stipulation to add to the Kesubah is considered like the Kesubah contract itself, which has relevancy for several things, be it the woman selling her Kesubah, waiving it, impairing it, demanding it, and others. Further, it said that the Kesubah given to male children is not collected from encumbered properties. It's also ruled that non-intact movable property and designated land with one border can be collected from the Kesubah without an oath. It's also held that if somebody wrote a document of transfer, gave it to witnesses without legally acquiring it prior, they don't need to consult the donor prior to giving it. It's debated if we hold that it's only after the final stage of marriage that the woman collects any additions to the marriage contract, and this is further debated. It's said that we do hold like that. There are further unresolved questions on this. In regards to the method of reducing the Kesubah past its minimum by stipulating the full amount and then separately writing that she's giving money back to him, it's said that this only works if it's actually written. This is because it's a rabbinic decree regarding a certain matter which are treated stricter, so they'll be actually followed. Some hold that the Kesubah, however, is actually of biblical origin, and this is further discussed. It's a lengthy debate as to the legitimacy of orally reducing a Kesubah during select periods, be it at the beginning of the chuppah wedding ceremony, after that, but before cohabitation, and if it can be done after cohabitation. There are a few opinions within that as to when it would and wouldn't be permissible. New Mishnah. After the betrothal, if either party says they want to go to the actual marriage, the other can request time to prepare. A virgin or the groom are given 12 months to prepare. A widow is given 30 days. If the set time passes without them being married, the woman can eat of the husband's food or terumah if he's a Kohen. Some say all of his terumah should be given to her. Some say half her food should be terumah. A woman who does Yevamos, the Levirate marriage, until the actual marriage, she can't eat terumah. There are some particularities on this mentioned. It was later ruled that a woman can only start eating terumah once she enters the chuppah. The Gemara cites sources for these rulings from verses. It's forbidden and not allowed to set a wedding date for a minor that has her be married off while she's still a minor, particularly as it's rabbinically forbidden to have a minor daughter be betrothed anyways in the first place. However, it would be permissible to set a wedding date for such a daughter to be married once she becomes an adult, and there are related points on this discussed. It also discusses opinions as to how much terumah exactly must be given to a wife. There are sources for the other points also mentioned. New Mishnah. If somebody consecrated his wife's earnings, she can still support herself from them. If he consecrated the excess, it's a debate if it's still considered consecrated. The Gemara says some hold that a woman can tell her husband that he is obligated to support her, and she's not going to give her his income. The legitimacy of such a statement is debated. In regards to consecration of the wife's excess earnings, according to those that say it is consecrated, it's debated if it takes effect when the wife dies or if it takes effect immediately. The logic is debated. This for the discussion, it said we hold that if somebody tries to consecrate his wife's future earnings, it doesn't take effect, and the particularities of this are debated. This is discussed further. New Mishnah. The obligations of a woman to her husband are to grind grain for flour, to bake bread, launder clothes, cook, nurse her children, make his bed, and work with wool. If she brought one maidservant into the marriage, she doesn't need to grind, bake, or launder. If she brought 2 maidservants, she doesn't need to cook or nurse. If she brought 3, she doesn't need to make his bed or to work with wool. If she brought 4, she can just do nothing if she wants. Some say no matter how many maidservants she brings, she should still work with wool, as idleness brings to unchastity. Others say that if a husband takes a vow prohibiting his wife from working, they must divorce, as idleness brings to insanity. The Gemara says as grinding grain is typically done with a water mill, either she's just tending to the grinding or it refers to a hand mill. There's disagreement on the other points. It's said from a different source that if a couple gets divorced but the child refuses to nurse from anybody but with the mother, the ex-wife must still nurse the child and is paid. There's debate as to how old such a child is. It's held to be 50 days. There's further discussion on this and on how and when a child nurses. There's also related rulings on these laws in regards to nursing discussed. It also mentions many actions by a woman which could lead to unhealthy or unique children depending on what they do or eat or similar. It further discusses the wife's obligations to nurse, and it brings sources. It goes through the points on maidservants and also says that if she has 4, meaning she can do nothing in theory, some say she should still prepare her husband's wine, make his bed, and wash him. These are the only actions a nida, a menstruating woman, cannot do for her husband, although she can make his bed when he's not there, and you can mix the wine if it's done in some specific manners, like not placing it directly before him and otherwise, and there are related points discussed. There's further discussion, and we said that there was an argument if idleness brings to infidelity or to insanity, and there's a practical difference if the woman is occupied with playing with puppies or with chess. New Mishnah. If a man takes a vow that his wife can't cohabit with him, Beis Shammai says if it was for 2 weeks, it's fine. Beis Hillel says if it's for 1 week, it's fine. Longer than that, they must divorce. Students can leave their wives to study Torah without permission for 30 days. Laborers can leave for a week. The conjugal rights to a woman are as follows. Tayelin, which will be defined, are obligated every day. Laborers are obligated twice a week. Donkey drivers once a week. Camel drivers once every 30 days, and sailors once every 6 months, according to Rabbi Eliezer. The Gemara gives sources for these points. There are related points on this discussed. It also argues what a tayelin is. Some say it's a person who's totally self-sustaining and is not required to pay taxes. Some say it's a very healthy person, and it gives instances of individuals of great health. Laborers, conjugal rights, were twice a week if they work in their town, and it's once a week if they work in a different town. There are related points. It says that a husband shouldn't change his job that'll keep him away from his wife for longer. It also says that this is the opinion we hold like in regards to Rabbi Eliezer's list of mandated conjugal obligations. It also mentions an incident of a sage who was so engrossed in learning he forgot to go home to be with his wife, and his wife was so sad she cried and the floor that the sage was sitting on collapsed and he died. It says Torah scholars should be with their wives on Shabbos Eves, which is based on a verse. There are a few related instances discussed. There's a very famous story on the life of Rabbi Akiva. He started as an illiterate shepherd of a man named Ben Kalba Savua, whose daughter, Rachel, saw that Akiva was a good man and offered to marry him on the condition that he one day became a Torah sage. He agreed, but Rachel's father was very upset with all this, and he disowned her and took a vow against giving them his possessions. Akiva spent 12 years studying Torah and returned as one of the greatest sages of his time, with 12,000 students accompanying him. When he reached his house, he overheard a man criticizing Rachel for having his wife leave him for so long, and he heard her say, if he was here right now, I'd have him learn for another 12 years. So Rabbi Akiva took this and went immediately back and learned for another 12 years, and then returned with 24,000 students. So Rachel's neighbors tried to have her borrow expensive clothes to dress and greet him, but she wore what she had, and she approached him to greet him, and Rabbi Akiva's students started pushing her away, not knowing who she was, and Rabbi Akiva stopped them, saying both his and all of your portions of Torah belong to her. Anyways, Rachel's father, Ben Kalba Savua, heard that a great sage had come to town, not knowing that it was his son-in-law, so he wanted to annul his vow to support his daughter. He spoke to the sage, again not knowing it was Rabbi Akiva himself, and Rabbi Akiva asked him if he would have made his vow if he knew his son-in-law would have become a great sage, and Ben Kalba Savua said he wouldn't have if he knew his son-in-law would have learnt even a single chapter or law. So Rabbi Akiva revealed who he was, and Ben Kalba Savua gave him half his possessions. Rabbi Akiva and Rachel's daughter ended up doing a very similar thing to her husband, Ben Azai, sending him away for a long while to learn Torah. And there are a few other related incidents. New Mishnah: if a woman refuses to fulfill her marital obligations, you deduct 7 dinars a week from her marriage contract. Others say 7 trapaks, which was a different type of coin. Some say he stops when the Kesubos has nothing left. Others say you just keep going and deduct the amount from any inheritance she gets. If a man refuses to fulfill his marital obligations, he adds 3 dinars a week to the Kesubos, and others say 3 trapaks. The Gemara argues that the situation is that the woman is refusing to cohabit with her husband or to do work. This is further debated. The method of this instance is described, and there's further discussion on these laws, and it debates exactly what the trapeak currency was. Some say it was worth half a zuz, and it brings sources. It also says that a woman is charged more for refusing her marital obligations, as men typically are much more desiring of women in a more noticeable manner. New Mishnah: if somebody provides to his wife through a third party, he cannot give her less than 2 kav, a measurement of wheat, or 4 kav of barley per week. There's debate if she's given a barley stipend. He also gives half a kav of beans and oil, a kav of dried figs, an amount of pressed figs, and if he has none, he gives from a different fruit. He must also give her a bed, a soft and hard mat, a hair kerchief, a belt, and shoes from holiday to holiday. Also clothes worth 50 zuz from year to year, being new clothes in the winter, and she wears them in the summer and she gets to keep each year's old clothes. He also gives a silver ma'ah a week from her other needs, and she eats with him on Friday nights. If he doesn't give the silver ma'ah, she gets to keep her own earnings. The woman's obligations are to spin the weight of 5 sala'im of warp thread in Judea, or the weight of 10 sala'im of weft thread in Judea, which are the equivalent of 20 sala'im in Galilee. If she's nursing, her earning amounts are reduced in exchange for food. These amounts have all been minimums for the poor. If you're any wealthier than this, it goes according to what you make. The Gemara debates the author of this Mishnah based on differing opinions on these laws. It's further discussed in regard to the barley. Those that paid double the barley amount, that was because theirs was of poor quality. It also says that there's no wine stipend, and it cites verses, although some say we do give it if she's accustomed to drinking wine. Some say if a woman is accustomed to drink 2 cups of wine when her husband's there, she's given 1 cup when her husband's not there, and if a woman is accustomed to drink 1 cup by her husband, she's not given any cups at all when he's not there. This for the discussion. Some say, the other opinions say if a woman is accustomed to drinking, we give her wine for cooking, and there are related points on it not being good to drink in general. The mats the husband must give her are for her bed, to make it comfortable. The constant need for shoes was because this was authored in a mountainous region, and also we want the woman to be happy by the holidays. It further discusses the different worth of the clothes. When it says she eats with him on Friday nights, some say this means literally they eat together, some say this is a reference to relations. This is debated based on sources, and it also says that by a nursing woman that you add wine, which helps nursing. And that's the end of chapter 5. Chapter 6 of Tractate Kesubos goes through additional laws of marital obligations and the Kesubah, the marriage contract. The first Mishnah says, a wife's fines and earnings go to her husband. If she inherits property, the husband can take from it while she's alive. If she's being financially reimbursed for being hurt, for humiliation and devaluation, it goes to the woman. Others say if it's a concealed injury, 1/3 goes to the husband, and if it's revealed, he gets 2/3. His share is given immediately, and her share is used to purchase land, which he can benefit from. The Gemara says most of this is obvious, as we've said most of these in regards to her father's ownership also, and that her husband's ownership then overrides her father. So, rather, all of this was to bring the dispute by the injury reimbursement. There are further points, and it says a wife is unique in regards to being repaid for humiliation, as a man suffers disgrace when his wife is assaulted, as your wife is legally considered part of your own body. New Mishnah. If somebody pledges an amount of money to his son-in-law as a dowry, and the son-in-law dies, it's said he can choose to not give the dowry to the Yibum Levirate marriage brother. If a woman brings money or goods into a marriage, the husband must reimburse them upon a divorce. He pays a 50% increase by pledged cash, and by appraised goods he pays a 1/5 less than their value, unless they were appraised and worth a set amount. If the groom accepted appraised goods of a mana, she must give goods worth 1¼ mana. If he accepted appraised goods worth 400 dinars, she must give goods worth 500, meaning there's a difference of about a 1/5. The Gemara says by the promised dowry to a dead son-in-law, he can even refuse to give it if the second is objectively a far better son-in-law, like being a Torah scholar as opposed to the original who was an ignoramus. It also says that it teaches all the types of appraisals above, large, small, and by the husband and by the wife. New Mishnah. If the bride pledged to bring money as a dowry, it's increased by 50%. The groom accepts to pay 10 dinars for her cosmetics for every money she brings in. Rabban Shimon ben Gamliel says, simply everything is done just according to the local custom. The Gemara further discusses these points and related incidents, which are discussed further. New Mishnah. The minimum for an unspecified dowry is 50 zuz. If they agree to not have a dowry, the husband shouldn't say he'll only start supporting the woman once she's in his house. If a charity is marrying off an orphan girl, the dowry minimum is 50 zuz, although if there's enough money, they should give as befits her honor. The Gemara gives the definition as to the zuz coin. There are related points brought on the importance of giving charity to orphans. It also describes how to give charity and more points on its importance. There's a story where the sage Mar Ukva would secretly give coins to one poor man from his town, so the poor man wanted to uncover who was giving him charity. So he went out to catch this person, who, as it turns out, was Mar Ukva and his wife. But before they were seen, they quickly ran away and jumped into a large oven. Mar Ukva's feet started to burn, but his wife didn't, and she said it was because
she stayed at their house, so gave charity more often, and also that she gave prepared food, which benefits people immediately. It says they jumped into an oven, as it's better to jump into a fiery furnace than to embarrass another person. There are other points on the massive amounts of charity Mar Ukva gave, and that he gave half of all of his assets to charity before he passed away. Normally, you shouldn't give more than a fifth of your assets, but it's fine there as he was about to pass away. And there are further of such points, and they're discussed a bit further. New Mishnah, if an orphan was married off by her mother or brothers, and she consented to this marriage, the dowry is 150 zuz, and she can get her full inheritance when she becomes an adult, once the marriage actually fully goes through. Some say if the father married his first daughter and then died, the second daughter's dowry should be the same as the first. Others disagree, saying people's financial situation changes, so it goes according to the estate at the time. The Gemara has an opinion that to determine the dowry of an orphan, you look at the character of the father when he was alive, if you can. Otherwise, it's a tenth of his estate, and this is for the debated, and others support this. It's for the debated as to who we hold like, and there's additional particularities in these laws discussed. It's decided we collect such payments from real property, not movables, whether for sustenance or for a dowry. New Mishnah, if somebody deposits money with a trustee for his daughter, there's debate if the daughter can tell him to give it to her husband. This applies by an adult. The Gemara describes these cases, which are qualified further. And that's the end of chapter 6. Chapter 7 of Tractate Kesubos further discusses various laws of marriage and related concepts. The first Mishnah says, if a man takes a vow against his wife benefiting from him for up to 30 days, he must set up somebody to support her. If it was longer than this, they must divorce, and he pays the marriage contract. Some say that's by Yisrael. By a Kohen, it's a 2-month minimum. If a husband confirms activating a vow for his wife, such as that she won't eat a certain type of fruit, they must then divorce. Some say this is if the vow was for more than 1 day. By Yisrael. By a Kohen, it should be 2 days. If somebody confirms and activates a vow for his wife that she won't wear a type of perfume, they must divorce. Others specify if it was a poor woman, they divorce if there's no specified limit, and if it's a wealthy woman, then it's a 30-day minimum. The Gemara further clarifies where the husband vows against supporting his wife. It's where he says she should take her earnings instead of his food provisions, and she needs support as her earnings aren't also enough to pay for her small items that she was accustomed to getting from her father's house. That's why there's a 30-day minimum, because that's when people will hear about this and embarrass her. There are other answers given. The way he can have somebody else support his wife without it being through him, as he vowed against this in this case, is he says if somebody does so, they're just not going to lose out. It further debates if this is considered to be legally his agent, and the remaining points are for the qualified and additionally discussed. New Mishnah, if somebody vows for his wife that she should not go to her father's house if they live in the same city, if it's for under a month, it's fine. If it's for more, they must divorce. If the father was in a different city, then it's fine if it's for just 1 holiday. Not so if it's for 3, where they must divorce. If somebody vows for his wife that she shouldn't go to a house of mourning or feasting, they must divorce, as he's locking her inside. There's an exception to this, which will be explained. If the husband says he'll annul a vow on condition that she tells him something that somebody else said, or that she tells somebody something, or to take care of the garbage, which will be defined, they must divorce. The Gemara discusses this and brings sources which show a daughter wants to visit her father, hence the above ruling. There's further discussion the exception to the husband being allowed to vow her away from a mourning or feasting house is if there's an established factual concern of promiscuity. The things the husband can't force his wife to say are shameful things, and some say taking care of the garbage is a euphemism for preventing conception. Others say it means to dump pitchers of water in a garbage, which looks insane. There are further examples of impermissible vows. New Mishnah, the grounds for divorce without paying a Kesubos marriage contract are for violating Torah law, secretly feeding the husband untithed produce, cohabiting as a menstruating nida, not separating the chalatayv, or not fulfilling the accepted vows, and also for violating general Jewish practice like wearing her hair uncovered, spinning in the marketplace, speaking with many other men. Some say cursing his parents in his presence. Some say being noisy enough that her neighbors hear her. The Gemara further qualifies these points, and they're additionally discussed as to how these different acts are considered forms of promiscuity. New Mishnah, if a man betrothed a woman on condition that she's not taken any vows or that she's not blemished, and then discovers that she had vows or blemishes, this is not a valid betrothal. If this was not stipulated and they marry, and then he finds out that she had vows or blemishes, this is grounds for divorce without paying the marriage contract. All bodily defects that disqualify a Kohen from service in the temple are considered legally defects by marriage. The Gemara says this is all also cited in a later tractate, Tractate Kiddushin, as it involves betrothal and also marriage contracts. The types of vows that invalidate such a marriage are vows against meat, wine, or colored clothes, and we bring sources which are further qualified. There's additional discussion on these points,
And for the particularities in these details, it said if a woman then annuls her vows, she's back to being betrothed. But if a woman goes to a doctor to remove her blemish, she's not back to being betrothed. This is because a vow is annulled retroactively, unlike a blemish. Others disagree with this principle. As for the discussion, it lists blemishes that qualify here as legally a blemish, which are discussed. New Mishnah, if a blemish was found on the woman after betrothal, but while she's still in her father's house, the father must prove the blemish appeared after betrothal so that it's the husband's loss. If the woman was in the husband's domain, it's the husband's responsibility to prove the blemishes were there prior. Some say this is only by concealed blemishes, and he can't make a claim by exposed ones as he would have just seen them. If there's a bathhouse, he can't even complain about concealed blemishes, as his female relatives in theory would have told him if there were blemishes. The Gemara further discusses these opinions, which are further qualified along with many additional points. New Mishnah, if a man develops physical defects after marriage, he's not forced to divorce his wife, although some say we do if they're major defects. The Gemara says some of this applies even if the defects were there prior to the marriage, and she could demand a divorce by a major defect, saying she thought she'd be fine with it, but as it turns out, she just couldn't deal with it. It defines major defects, blindness, a severed limb, and similar. It debates who we hold like as to if a woman is allowed to demand divorce after a major defect. New Mishnah, physical defects on a man that can force a divorce are things like boils, polypus, also somebody who works with excrement, a copper refiner, and a tanner can have a divorce demanded from them, and all these apply if these were the case before or after marriage, and the wife can say that she thought she could deal with it, but as it turns out, she couldn't. Others say she must still be with him, besides for by boils, as his flesh falls apart. And there was an incident where a woman was married to a tanner, her husband died, and she refused to marry his brother, who was also a tanner, saying she just couldn't tolerate him. The Gemara defines these illnesses and forms of work. We also force a man to divorce if he refuses to feed or provide for his wife. Some say we only force a divorce if a man is married to a woman disqualified to him, and there are instances of this given. It further defines these diseases, along with several others, and medicinal cures for some of them. There's an instance where the sage Rabbi Yeshua ben Levi was about to pass away, and the angel of death was told to fulfill his request. So Rabbi Yeshua ben Levi asked to see his portion in the Garden of Eden, and also asked to hold on to the angel of death's blade. And when they got to the Garden of Eden, the sage jumped in with the blade and swore not to leave. It was a whole issue, and it was said that he didn't need to leave, as he'd never had an oath annulled during his entire life, but he did have to return the blade. Anyways, it describes the sage entering the Garden of Eden, and he was asked if there was ever a rainbow seen during his time, which is a negative sign, and he said yes, but that wasn't true, he was just being humble. Another sage, Reb Chanina bar Papa, also met the angel of death as he was about to pass, and he made the exact same requests to have some time to review his studies, and to see his portion in the Garden of Eden. And then he asked for the angel's blade, but the angel of death refused, saying he was not going to fall for that one again. It also says that when this sage passed, a column of fire appeared to separate him, which traditionally only happens for 1 or 2 people per generation. And there are a few other points on the mentioned diseases, and that's the end of chapter 7. Chapter 8 of Tractate Kesubos covers further additional laws of the marriage contract, the Kesubos between husband and wife when they marry. The first Mishnah says if a woman inherited properties before the initial stage of marriage, she's then allowed to sell or give them away, and it's a valid transfer. If she inherited the property after the initial stage of marriage, Beis Shammai says she can sell them, Beis Hillel says she cannot. It's agreed that if she did, though, it's still a valid transfer. It's questioned why, and it's said that they really do not actually understand the logic of the established principle that after marriage the husband can undo a sale with his wife's inherited properties, so they're not about to institute this also with properties inherited prior to the completion of the marriage. Anyways, if she inherited the properties after the completed final stage of marriage, the husband has the right to take them away back from the buyers. If she inherited the properties before the final stage of marriage and became fully married then, some say this is a lasting transfer. The same logic as above applies. Some distinguish between types of property, saying property known to the husband the wife cannot sell, and it's a void transfer, and if they're not known to the husband, she can't sell them, but if she did, it's a valid sale. The Gemara says the difference between before and after betrothal is that the properties are under her jurisdiction prior. After the first stage of marriage, it could be under hers or under his, so she can't sell it, but if she did, it's a valid sale. There's further discussion on this. It speaks on some specific cases. Others say if the woman acquired properties before or after the first stage of marriage, if she then gets fully married, her husband can revoke any later sale of them. This is disagreed with by a few others. Everyone agrees if she inherited the properties after the final stage of marriage during her life, the husband can revoke their sale. The definition of known and unknown properties are: known properties are land, unknown properties are movable. Others disagree, saying that both of those are known, and unknown property is property that the woman acquired that's currently overseas. We bring proofs for that definition. Once a woman didn't want her property to go to her husband, so she signed it all away to her daughter beforehand, and then later divorced her husband, but a sage invalidated this. It's debated if this was valid. There's a bit of an argument. It said the property is considered like unknown property to the husband, in accordance with the opinion that says that such property is actually retained by the wife. New Mishnah: if a married woman inherits money or detached produce, it should be used to buy land, and the husband can eat of its produce. If she inherited produce attached to the land, some say they calculate how much more the land is worth with the produce, and that amount is used to buy land which the husband can eat from. Others say that the attached produce belongs to the husband, while detached produce should be used to buy land. As a general principle, wherever the husband has the advantage by marriage, he has a disadvantage by divorce, and vice versa. For instance, when he marries, the husband gets attached produce, and if he divorces, she gets the attached produce. With detached produce, by marriage, she gets it, by divorce, he gets it. The Gemara says, in regards to land purchases, land is always purchased over a house. Houses are always purchased over date palms are always purchased over other fruit trees, and fruit trees are purchased over grapevines. Regarding sorb trees or a fish pond, there's debate if those qualify as land or as principal. Generally, if a trunk regrows, it's considered to be produce, otherwise it's considered to be principal legally. There's further qualification on these points. New Mishnah: if a woman inherits old slaves or maidservants or old olive trees and grapevines, they should be sold and used to buy land which the husband can use. Others say they're not sold, as they represent the prestige of her father's house. The Gemara says the dispute on the use of trees is only if she didn't also inherit the field. If she did, it's agreed that she does not need to sell them. New Mishnah: if somebody spent money on his wife's property and then divorces her, no matter what he spent, he can't demand compensation from his wife unless he only spent and didn't consume, in which case he swears what he spent and can take compensation. The Gemara says it said he can't demand compensation if he consumed even a little bit of the produce. Some say this is even a single dried fig, assuming he didn't eat it quickly. Others say it's even if it's as small as a case of pressed dates, and it's unresolved if he benefited from a cake of squeezed out dates. If he ate the produce quickly, it's debated as to how much he needed to eat. There are a few other particular incidents mentioned of such cases, and for the discussion, which all goes further. New Mishnah: if somebody pending Yibum inherited property, it's agreed that she can sell them or give them away, and it's a valid transfer. If she died while pending Yibum, Beis Shammai says her marriage contract and properties are divided between her husband's heirs and her father's heirs. Beis Hillel says that everything stays with whoever has it, so the marriage contract would be with her husband's heirs, and her property would stay with her father's heirs. If the dead husband left money or detached produce, it should be used to buy land that his brother can eat from. If he left attached produce, some say an appraisal is made, and the extra money the land is worth from the produce is used to buy land. Others say attached produce goes to the brothers, and detached produce goes to whoever acquired it first, and if it went to the wife, it should be used to buy land. If they marry, they are considered husband and wife in all respects, besides that his marriage contract obligation is on the estate of the first husband. The husband can't designate part of his brother's property as the marriage contract to be able to access the rest of the property. Actually, all of the first husband's property is pledged as her marriage contract. This also applies by a typical marriage. If the Yibum couple divorce, she gets her original actual marriage contract. If they remarry, she's like a typical remarried divorcee and is entitled only to the original marriage contract. The Gemara says, if a woman pending Yibum dies, it's debated who has to bury her. It said it's the Yibum brother's responsibility. We bring sources, although it's debated based on the logic of some related cases. Therefore, there are particular cases discussed, and it goes further through what rights exactly the brother that's doing Yibum has to the original husband's estate. There are further points. It says by the Yibum marriage, the marriage contract goes to the estate of the first husband, as the new husband isn't really fully choosing this marriage. If there is not a marriage contract from the first marriage, they have to make a new one to decrease the possibility of divorce. The remaining points are also discussed, and that's the end of chapter 8. Chapter 9 of Tractate Kesubos continues on the laws of the marriage contract. The first Mishnah says, if somebody writes to his wife that he's relinquishing all of his rights to her property, he's still allowed to consume her produce, and he still inherits from her if she dies first. However, if she decides to sell her property, it's a valid transaction. If he relinquished all of his rights to her produce, he can't eat her produce, but he still inherits from her. Some say he always can eat some of her produce unless he specifies he's relinquishing his rights to the produce of her produce infinitely. If he relinquished the rights to her property and produce, or produce of her produce, during her life and after, he can't eat of her produce or inherit from her. Others say he does still inherit, as such a stipulation goes against the Torah, which makes it void. The Gemara says such a relinquishment can also be done orally. It brings proofs that a husband actually does have the ability to waive his rights to his wife's property or produce like this. Some say this is only effective during the initial stage of marriage, as during the later actual final completed stage of marriage, they actually equally share the property. Some hold that he actually has a greater share of the property, so there'd be a practical difference by a woman who's pending Yibum. There are related points discussed by property ownership. There's more on this. It asks why he needs to say the produce from the produce until infinity to give up his wife's produce, and it's unresolved as to why you need each part of that phrase. There's further discussion, and it's ruled like the opinion that a husband can't relinquish his inheritance from his wife, but due to a different reason. And it's debated as to what exactly this reason is. Then, according to this opinion, a husband inheriting from his wife is actually rabbinic. It's just that he says rabbinic laws are very strict, so they still can't be violated. And this is further discussed. New Mishnah: if somebody dies leaving a wife, creditor, and heir, and he had a deposit or loan with others, some say it's given to the weakest of them, others say it's given to the heirs, as those don't require an oath to collect. If the dead man left detached produce, whoever gets it first gets it. If the wife or creditor took excess, more than what they're owed, some say it should be given to the weakest, others say to the heirs, as they don't require an oath to collect. The Gemara says the case has him leaving a loan and a deposit, as we need both. A loan is given to be spent, while a deposit is given to be held. This would create variation between the opinions if both weren't mentioned. The weakest of them, some say this means this would be the one with the weakest proof. Some say it means to give it to the woman for her marriage contract, so that way it'll function easier and women will marry more. There are similar points regarding the excess detached produce. The second opinion that says it goes to the heirs would say actually all of the produce does. He just mentioned excess here, as the first opinion did that also. It's debated where the produce goes, if it's kept in a recessed area near a public road. There are related points discussed and a few particular incidents regarding creditors of a deceased individual. These cases are discussed further, and there are further particular relevant incidents listed. Another point: if a man owes money to a creditor and for his wife's marriage contract, and he has land and money, the creditor gets the money and his wife gets land. If he only has land to give one, it's given to the creditor, as we're not concerned about women just not marrying anymore because of this one particular situation. There was a case where a man didn't have money to pay a creditor, but he did have land, and he was told to sell his land to pay the creditor, but that was only because he had lied and said he had no money, so the court decided to act stricter with him. According to the opinion that says repaying a creditor is the fulfillment of a mitzvah, it would be a positive commandment, which you're allowed to force somebody to do. There are further particularities by cases of a divorce document. New Mishnah: if one has his wife as a storekeeper or his business administrator, he can make her take an oath that she was honest with the business dealings if he wants. Some say he can even make her swear he didn't take his stuff outside of work. The Gemara says, according to this latter opinion, it's debated based on if the husband can be so imposing. Even if she's also sworn by the business, according to this opinion, the oath outside of business can be made even before the oath within business. New Mishnah: if a husband writes to his wife that he won't make her vow or oaths, he can't do that with his wife, but he can with her heirs and successors. If he wrote that he won't vow or oath with her or her heirs and successors, he can't impose an oath on any of them, although his heirs can. If he wrote such an oath, and also specified that his heirs can't impose such an oath, he and his heirs can't impose oaths on her or her heirs or successors. However, if the husband died and the wife went back to being the administrator of her husband's business, his heirs can make her take an oath about future events, but not about past ones. There's debate about what type of oath is exactly being referred to. Some say it's over the administrative position, others say it's over her trying to impair her marriage contract. This is for the discuss. It goes through various different phraseology of the husband to free his wife from oaths, as to which are considered to be legally effective and which are not, and for what. It said we hold out the opinion that he and his heirs cannot impose oaths, whether he wrote without oath, clean of oath, without vow, clean of vow, or my possessions, or these possessions. New Mishnah: if a woman impairs her Kesubos marriage contract, admitting it was partially paid, or there's one witness that her marriage contract was paid, she must take an oath to collect the remainder. She'd also need an oath to collect her marriage contract from the property of orphans, from encumbered property, or if she's doing this not in her husband's presence. A woman impairing her marriage contract, for instance, it was for 1,000 zuz, and the husband said, I already paid it, and she says, no, you only paid 100 zuz. She collects the remainder with an oath. The case of a single witness: is if the marriage contract was for 1,000 zuz, her husband says he paid it, she says, no you didn't, and a single witness says, yes he did. She'd need an oath to collect the payment. Collecting her money from encumbered property is where the husband sold his property and she's collecting her contract from the purchasers. It must be done with an oath. Collecting from orphans' property is where the husband died and left his property to orphans. She's collecting from them with an oath. Him not being in her presence is where he's overseas, so she, again, must collect with an oath. Others say, whenever she claims her Kesubos contract, the heirs can impose an oath on her, and if she doesn't, they cannot, and this will be explained. The Gemara suggests that by the impaired contract, it's a biblical oath, as she's admitted to part of the claim. This is rejected, as it's only biblical if she's not paying, and here she's taking payment, and also it's not biblical to swear on the denial of land lien. Rather, it's said that this is a rabbinic oath to make her pay attention when she's paid. It's unresolved if we assume it's true if the woman impaired her contract while there were witnesses there. It's also unresolved what if the impaired amounts are in very small numbers, such as under a peruta currency. There's no oath imposed on a woman who devalues her currency, and there's a presumption of trust between the husband and wife, as the original contract is now admitted to be void. There's the same debate if the oath by a single witness is biblical or rabbinic. It's said to be rabbinic, and it's done to put the husband's mind at ease. If the husband wants, he can make the woman take a biblical oath by re-giving the woman the contract payment before the first witness and the second one, and then establish the original payment as a loan, thereby forcing her to now take a biblical oath. This only works if he tells the witness what's going on beforehand, so she can't claim there were just two marriage contracts. There are related cases discussed. It also debates exactly which cases the last opinion was referring to, which was on the earlier Mishnah back on 86b and others. New Mishnah, if a woman brought out a divorce document but no Kesubos marriage contract, she can still collect her Kesubos. If she had just the Kesubos but no divorce document, meaning she says she lost the divorce document and the husband says that he had paid it and lost his receipt, or similarly, if a creditor brings a loan document but no document authorizing the court to collect his debts, neither the woman nor this creditor can collect their payments. If it's a dangerous time, it's that they can collect such payments without those other typically necessary documents. The Gemara further discusses these points, which are qualified further at length. New Mishnah, if a woman produces two divorce documents and two Kesubos marriage contracts, or two Kesubos and one divorce document, or two divorce documents and one Kesubos, or a Kesubos, a divorce document, and proof of her husband's death, she gets one Kesubos payment, as if somebody divorces and remarries his wife, he does so based on the first Kesubos without rewriting one. The Gemara discusses this further. New Mishnah, if a minor was married off by his father, which is not legally allowed, however the marriage does go into effect when this person becomes of age. The Kesubos that was written while he was a minor stays in effect. This also applies by a convert who converted with his wife. Their marriage contract stays in place from before the conversion. The Gemara debates if this contract is just the base minimum of 200 zuz, or if it also includes any extra sums added. It said no, it only refers to the principal minimum of the Kesubos. And that's the end of chapter 9. Chapter 10 of Tractate Kesubos covers additional laws of the marriage contract. The Mishnah says if somebody was married to two wives and he died, and there's not enough money to pay for both Kesubos, the marriage contracts, the first wife has priority for payment, and the heirs of the first wife have priority over the heirs of the second wife. If he married the first wife, she died, he remarried, and then he died, the second wife and her heirs have priority over the heirs of the first wife. The Gemara suggests, based on the wording, that if the second wife takes her contract first, she would be allowed to keep it, which would mean that if a person had two creditors he owed money to, and the second creditor comes first, he can collect his money, seemingly. This is rejected based on similar uses of this wording. Some say the entire argument happened in the inverse, actually. Further, from the Mishnah, it can be learned that if a man's two wives die, one during his life and one after, the heirs of the first wife have priority to the marriage contract for the male children, and there's no concern of this causing argument. Also, we can learn that a Kesubos can become surplus to another Kesubos. We can also learn that the Kesubos towards sons cannot be collected from encumbered property. The logic of these conclusions is described, and the validity of these statements are debated from several sources. It's further debated and ruled that if a man's two wives die, one before his death and one after, the heirs of the first wife have rights to the Kesubos for sons. Also, it's ruled that a Kesubos can become surplus for a counterpart Kesubos. It explains the necessity for both of these statements according to various opinions. New Mishnah, if somebody married two wives and both of them died, and then he died and there's only enough money to pay for the Kesubos, the money is split equally between them, and if there's any surplus money, the Kesubos are paid as written and the surplus is split between them. The property is appraised by a court, so no party can inflate the value. If there are prospective assets in the estate, they are not treated as owned. Some say even movable property is not counted. The excess money split only occurs if there's enough actual property to pay the Kesubos in full and a dinner or more. The Gemara discusses these points. There are a number of relevant cases cited and discussed in regards to property collection and similar, which are further discussed. There are a few additional rulings mentioned, such as if a person sold a field to another with a guarantee and the creditor comes to collect money from the first person, so he goes to the field he sold to the second man. The first man can argue on behalf of the second person to not take the field, as he is going to have that amount of money taken away from him by the second guy. Some say this applies even if there's no guarantee, as the first person is considered to be a concerned party, as he doesn't want the second man to get upset at him. Additionally, some rule that if one man sold a second man a field without a guarantee and then protesters claimed it was never the first guy's field to sell, so long as the second guy hasn't made a proprietary act to claim the field, he can retract from it without paying. A proprietary act is like walking along the border of the field. Some say this applies even if a guarantee was made. New Mishnah: if somebody marries 3 wives and then died, and the Kesubos were 100, 200, and 300 zuz respectively, and he only has 100 zuz, it's divided equally. If he has 200 zuz, the first one takes 50, and the second and third take 75 each. If there were 300 zuz, the first takes 50, the second takes 100, and the third takes 150. The system also applies if people deposited money in a fund, and they had a loss or a profit. It's divided like above. The Gemara explains by the middle case, the first woman got 50 zuz, as the second woman removed herself from the claim to the first 100 zuz, so it's being split between the first and third woman. However, the second woman still gets her amount because she didn't totally remove herself from her necessary payment. Similarly, by the third case, the third wife removed herself from the claim to the first 100 zuz. Others suggest these cases deal with 2 different seizures of property by the wives, which is described. This is further discussed. New Mishnah: if somebody married 4 wives and died, the priority goes in order of marriage, and each must swear to the next that they haven't yet been paid, although the fourth does not need to do this. Others say the fourth actually must collect with an oath. If the Kesubos were all written on the same day, it goes by order still of who was written first, by the hour, which was recorded on these documents in Jerusalem. If they were all written within the same hour, and there's under 100 zuz in the estate, it's divided equally. The logic of the dispute is debated along with related points. These are further discussed along with further cases of conflicting deeds which have the same date. New Mishnah: if somebody married 2 wives, sold his field, and the first wife wrote to the field buyer that she has no claim over this field. When the husband dies, the second wife can collect the field from the buyer, and the first wife can take it from the second, and the buyer can take it from the first, and they can just keep on going around in circles until they reach a compromise. This also applies by a creditor and a wife who is her husband's creditor. The Gemara says the case is where the buyer did an act of acquisition with the field with the wife, so when the woman rejected the field, that has legal validity. Others disagree, and some suggest this is dealing with a divorced woman to make the case work like everybody. There's further debate on this. It's discussed and it's ruled that if free property becomes ruined, a creditor can collect from encumbered property, and there's further discussion on these points. And that's the end of chapter 10. Chapter 11 of Tractate Kesubos continues discussing the laws of a marriage contract. The first Mishnah says, a widow is supported from the property of the orphans. Her earnings belong to them, and if she dies, they are not obligated to finance her burial. That her heirs, those who inherit her marriage contract's responsibility. The Gemara debates based on the practice of regions. If a widow is actually supported from the orphans. Further, it's said that all the things a woman is obligated to do for her husband, a widow must do for her heirs, besides for mixing his wine, making his bed, and washing him. Similarly, all tasks that a slave does for his master, a student does for his teacher, besides for untying his sandals, if he won't be recognized as a student. If he's wearing tefillin, he's always allowed to, as he won't be mistaken as a servant. It speaks on the importance of a student serving his teacher. If a widow took movable property as payment for her support, that's allowed, and we bring sources. This isn't allowed if it's taken for her marriage contract payment. It's also said regarding retroactive sustenance, if a woman waits 2 or 3 years without claiming support, she has forfeited her rights to it. If the orphans claim they gave support and she denies it, it argues who has the responsibility to bring proof. It's debated from a number of sources. In regards to a widow selling her husband's property to get support, some say she sells property every 12 months, and she's provided for every 30 days. Others say she sells every 6 months and is provided every 30 days. And we bring sources which are debated. This was a discussion and says it's only from leftover land that a woman can use to collect of her marriage contract. There are related points by general laws of sales, such as debate if a person sold land because he needed money and then found out he didn't need money as to whether or not the land sale is now considered void. It's argued from a number of sources, and it's ruled that yes, the sale is now revoked. New Mishnah: a widow from either the first or final stages of marriage can sell her husband's property without consulting a court. Others disagree, saying if she was widowed from the first stage of marriage, she must consult a court, as such a woman has no legal right to sustenance, so therefore requires the court's approval. These points are debated on. New Mishnah: if a widow sold all or part of her kesubah, or pledged it as security for a loan, or gave it as a gift, the remainder can only be sold with the court's approval. Others say she can sell her kesubah in portions if she wants, and sell the entire estate for her support without the court's approval. When she sells property for sustenance, she should specify so on the sale document. A divorcee cannot sell her dead husband's property without the court's approval. The Gemara debates the author of this Mishnah based on the logic of different opinions. It debates a seeming contradicting alternative source, but it's based on the interpretation of the definition of a few words in regards to these laws. Based on a case, it seems to be held that if a woman gets part of her kesubah, she still retains the right to her sustenance. If a widow sells her dead husband's estate without asking the court, it's debated if she also needs to do this with an oath. They would hold that there isn't a public announcement required, which is debated, but we do hold that, and she does require an oath. New Mishnah: if a woman's kesubah was for 200 zuz, and she sold property worth 100 zuz for 200 zuz, or property worth 200 zuz for 100, it's ruled that she's relieved of her kesubah. If the kesubah was worth 100 zuz, and she sold property worth 100 zuz and a dinar, meaning more than what she's owed, for 100 zuz, it's void, even if she tries to return the extra dinar. Others say the sales always stand unless there's enough to leave over a 9 kav area in a field, or a half kav area in a vegetable garden, although some say even a quarter of a kav. If her kesubah was worth 400 zuz and the woman sold 3 pieces of property to 3 people worth 100 zuz each, and then to a last person she sold property worth 100 zuz and a dinar, the last sale is void and the first 3 are still valid. The Gemara says the issue in the first case, where she overcharged, is where the widow sold land which doesn't have a fixed price at double its worth. So according to this opinion, they would hold that all of the excess goes to the heirs. It's ruled that if an item has a fixed price, the excess is split between the principal and the agent. If there's no set price, the excess goes to the owner of the purchase money. There are related cases discussed. The validity of these points are further debated, citing a few other relevant discussions. It further discusses related laws of an agent by sale and whether such an individual maintains his status even if he does something that was not requested. Some say that a sale is valid if the error was made by the principal seller, but if the agent made a mistake and was overcharged, the sender of the agent can say, "You did not have my consent to do that," making the sale therefore invalid. It brings sources for this point, and there's further discussion on this. New Mishnah: if a property was sold after being appraised by judges, but they undervalued or overvalued it by a sixth, the sale is then void. Others say the sale does stand due to the authority of the court. If there's a letter of inspection written, even if they were way off, the sale still stands. The Gemara debates based on this if an agent is like a widow's sale, whose sale is invalidated if it's off by any amount, or like a court sale, whose sale is invalidated if it's off by a sixth. It's debated and said to be like the sale of a widow, meaning if it's even a bit off, it's invalidated. There can be variation by an agent buying teruma, as people can separate it in different amounts. It's ruled that a court sale of being off by a sixth is invalid by such a case. This is discussed with variation by particular cases. It's further ruled that if a widow sells her dead husband's estate, the sale's guarantee falls on the orphans as it would if it was sold by the court. This is stated to show that property purchased from the court will be guaranteed. According to the opinion that we don't invalidate a court sale, even if they're off by a sixth due to the authority of the court, the sale would still be revoked if it was off by half the property's value. This for the discussion on these points and a few related incidents. New Mishnah: a minor girl who refused to marry a husband, a secondary rabbinically forbidden relative, and an Ilonis, an underdeveloped woman, sometimes defined as someone with Turner syndrome, do not receive a kesubah payment, and they do not get the benefit from each other's property, nor do they receive support or old clothes. Regarding the Ilonis, if the husband married her knowing she was an Ilonis, she does receive a marriage contract. If there's another forbidden marriage, a widow marrying a Kohen Gadol, a divorcee marrying a Kohen, a mamzer, an illegitimate person marrying a regular Jew, they all still receive a kesubah payment. The Gemara debates if a minor who was preemptively divorced, if she still receives a kesubah payment or not. Further, some say an individual must wait at least 3 months before remarrying. It's discussed as to if there's any notion of validity to the marriage of a minor girl whatsoever. Rabbi Eliezer says there's none at all, it's completely forbidden, and not legally binding, meaning there would be no Kesubos. Others disagree, but it's explained that the logic is that they too hold it's not a legal marriage and forbidden. However, there was a specific case in those times by an orphan girl where there was a significant concern that people would take advantage of her if she wasn't protected, as here she has no father, so she can be legally temporarily put in the care of an individual, with the caveat that she'll be properly married to him once she becomes an adult, although this is a marriage that she could refuse if she wants, all done just to protect her from any exploitation by others. So according to this latter opinion that says she can be given by her family to another person, this is only done as long as she consents to this, and there wouldn't either be a marriage contract written. This for the discussion on the property entitlements of the different marriages from the Mishnah. There's more on the case of the marriage to the Ailonis, where the husband is aware of this prior, and it's compared to the case of a widow marrying a Kohen Gadol, where she does receive a Kesubos, and it's explained that's only if the Kohen Gadol was aware of her widow status prior to the marriage, and if he wasn't aware of this, there would be no Kesubos. And that's the end of chapter 11. Chapter 12 of Tractate Kesubos discusses some additional laws on the marriage contract and the obligations between a husband and wife. The first Mishnah says if somebody marries a woman and they agree that the husband will feed her daughter from her last marriage for 5 years, he must do so. If they divorce and she marries somebody else and they remake the same deal, the first husband must still feed the daughter for 5 years and must bring it to her. The two husbands also can't split the cost of the food. Each must fully supply the food in full. If the girl eventually marries, the husband provides her with food, and each of the stepfathers must also continue giving her food. If they die, their daughters are fed from unencumbered property, while this stepdaughter is fed from encumbered property, as she's legally considered to be similar to a creditor. It was advised that when originally making such a deal to agree to feed the daughter, so long as they're still married, to prevent some situations like this. The Gemara discusses a related case. If somebody tells another that he owes him money, there's debate if he must pay. If he did this through an unsigned note, as it's debated if such a note is sufficient to create indebtedness. It tries to prove from our Mishnah that such a person would be liable, as the case would be with a similarly unsigned document, but we say no, our case is with documents of allotment, which are legally valid, so can't be used as a proof. And for the debates, the argument from other sources, and the remaining points are discussed. It also cites some relevant cases. New Mishnah, if a widow said to her husband's heirs that she couldn't bear to leave her husband's house, they can't tell her to leave, and that they'll support her. They must support her there and give lodging in accordance with her status. If the woman said she couldn't bear to leave her father's house, the heirs can say she'll be supported only if she lives with them. If she argues that it's inappropriate for her to stay with them, as she's a young woman and they're young men, they must support her where she is, even if it's her father's house. The Gemara further qualifies these points and discusses other things on the passing of the sage Rebbe, that he requested not to be eulogized in the towns, and many other points which are related. This for the discussion on a number of other sages. There are additional points on the passing of the sage Rebbe. He was extremely ill, but the sages kept praying for him so he wouldn't pass, and his maidservant, feeling bad for him, threw a vessel off the roof, causing the praying sages to stop for a moment and allowing Rebbe to pass on. There's further discussion on this. New Mishnah, if the widow is staying at her father's house, she collects her Kesubos whenever she wants. If she's at her husband's house, she can only collect it until 25 years, during which she'll have done many favors to the heirs, thereby repaying her Kesubos. Others say it's the inverse. She can collect her Kesubos whenever she wants from her husband's house and within 25 years from her father's house. If she dies, her heirs must bring up her Kesubos within 25 years, otherwise they forfeit their rights to it. The Gemara says that the 25 years are adjusted depending on the wealth of the widow. Further, the debt is considered legally forgiven right at sunset on the 25th, which is how many of such concepts work. It's also said the woman can collect her Kesubos whenever she wants, if she has the actual document, but others disagree, keeping the 25-year limit anyways. It's debated. This is further discussed along with some related incidents, and that's the end of chapter 12. Chapter 13, the final chapter of Tractate Kesubos, covers some final additional laws of the marriage contract. The first Mishnah says there were 2 judges of decrees in Jerusalem. The first made 2 rulings which were contested, the first of which were that if somebody went overseas and his wife demands support, she needs to swear to claim her marriage contract, but not to claim this support. Others disagreed, saying she needs to swear by both, but it's debated between sages. The Gemara defines who these judges were, and what their jobs were, and how they were paid. It also speaks on how wrong it is to accept bribes and related verses. These points are discussed. It says a judge who borrows things without having anything to lend cannot be a judge. It said a judge shouldn't judge a person he likes or dislikes, and there are related points. It says you shouldn't even accept a bribe of words, which is somebody speaking politely to you or doing a small favor for you, and there are instances of sages who are judges having small favors done for them and then choosing to not judge those people out of concern of being biased. and examples of them not accepting gifts from individuals for the same reason. There's further discussion on this topic. It also discusses uses of the excess temple funds, different opinions as to where the different funds were spent, which was more lengthily discussed in Tractate Shkolem. There's further points on the above discussion. The original topic is debated, and it's ruled that we do give support to the wife of an absent husband. It's also ruled that a woman is legally allowed to refuse to work and still be supported by her husband. It also rules that by purging earthenware vessels to make them kosher, it can be done by black and white earthenware vessels, but not by green ones, which have absorbing qualities due to their high alum content, and if the vessels have cracks, they're all forbidden. New Mishnah, the second of the contested ruling from the first judge, was that if somebody went overseas and somebody else supported his wife, the second man is not reimbursed. Others disagree and say he swears how much he spent and he collects it back. It's debated between sages. The Gemara further debates this point. New Mishnah, the other judge made 7 contested rulings. The first was if somebody dies leaving behind sons and daughters, if he has lots of property, his sons and daughters are supported. If he doesn't, then he supports only his daughters. Others disagreed. The Gemara says they argue, saying if men inherit when there's a lot of property, why should they not when there's less? New Mishnah, the second contested ruling, if somebody claims jugs of oil from somebody, and the man said he owed empty jugs, as he admitted he owed something, he must swear this. Others disagree, saying the partial admission is not considered to be a full claim. The Gemara explains the debate is based off the wording, if he's including the actual jugs along with the oil, which is qualified. New Mishnah, the third contested ruling, if somebody promised his son-in-law money in his dowry and then refuses, the bride can tell the groom to either marry her or not, and to not make her wait based on her father. The Gemara explains this case and says by these 2 contested rulings of the first judge, we hold like him, and by the first 3 contested rulings of the second judge, that's what we hold like, and not by the last 4 rulings. New Mishnah, the fourth contested ruling, if somebody challenges the ownership of a field but is signed as a witness on the deed that records the sale, he can still argue that he only signed the sale as a witness between those 2. However, he actually owned the property, and he did the sale because the first man who owned it was tough, and it would be difficult to get his land back from him, so he had it sold to somebody else so that way he could now get it from this guy. Others say he's lost it now that he's signed its sale as a witness. Also, if he used this field as a boundary mark in the sale of a neighboring field, he's lost his rights to the field. The Gemara further discusses the point and qualifies it. New Mishnah, the fifth contested ruling, if somebody returns from overseas and he finds the path to his field is lost, he can take the shortest path. Others say he should either buy a path at whatever its cost, or he should just fly across to his field or something. The Gemara further explains the logic of these cases and some related ones. New Mishnah, the sixth contested ruling, if somebody brings out a note of indebtedness against somebody and the other man brings out a deed of sale of a field and can claim, if I was in your debt, you should have taken it out of this field sale. Others disagree, saying maybe he sold him the field so he could collect it from the loan. The Gemara explains that the argument is where they write the deed first and then give the money in that location. So the first opinion says if the field was sold as security, he should have said so before. The others would disagree, as they say the purchaser would have eventually found out about it from other people anyways. We mentioned the last of the 7 contested rulings. If 2 people produce notes of indebtedness against each other, the second could say, how am I in your debt if you borrowed from me? Others say that they must collect the debt from each other. The Gemara says if you do this, they can just keep the money as they have it, if it'll fill out each other's debts. If it's a seizure of land property, if they own average and inferior land, it's debated if they swap the land, as they judge the land in relation to what they have, so they'll end up collecting different land. While others say they collect in relation to what the world considers to be good land, so they'll just end up swapping the same land, so they just keep what they have. Those are the discussion on these points. New Mishnah, in regards to marriage, there are 3 regions: Judea, Transjordan, and Galilee. You can't require your wife to move with you to a town or city in between regions, but you can if it's within a region. You can't have her move from a town to a city or a city to a town. You can have her move from a bad dwelling to a good one, but not vice versa. Others say you can't even make her move to the good dwelling, as it could be bad for her health. The Gemara says the issue with moving from city to town is as towns have less commodities, and the issue with moving to a city is based on a verse. It discusses the illness from moving to a good dwelling. Some say it's from a change of routine. It's discussed. New Mishnah, a person can require his household to move to Israel, but he can't make them leave. He can force them to move to Jerusalem, but he can't make them leave. This applies by men and women. If somebody marries and divorces a woman in Israel, he pays the Kesubos in coins of Israel. If he married her in Israel and divorced her in Cappadocia, he pays her in coins of Israel. If he married her in Cappadocia and divorced her in Israel, some say you pay with Israel coins, some say with Cappadocia coins. If you marry and divorce in Cappadocia, you pay with Cappadocia coins. The Gemara says even the servants can be made to move to Israel. Others say you can even move there from a good dwelling to a bad one. Those points are further discussed along with similarly related topics. The debates based on verses if we're allowed to immigrate from Babylonia back to Israel. There are related points on this, and it talks about how great the men of Israel are and how great the land is in regards to a number of topics, like in regards to the resurrection of the dead, and it says that those in Israel will rise and everybody else will have to roll there through tunnels before being resurrected in Israel, which is why Yaakov, the forefather, wanted to be buried specifically in Israel. And further discusses many of the great miracles of Mashiach's coming, on the great produce of the land then, which is described in related points. It further brings points on the great fruitfulness of the land of Israel, which are discussed. It also speaks on the love of the sages towards Israel, more on the great blessings of Mashiach's coming, and it ends by saying that in the generation that Mashiach will arrive, there will be great vilification and criticism of Torah scholars, and there will be harsh decrees against the Jewish people, which will increase. It ends by citing a verse which teaches that all the barren trees of Israel will one day bear fruit. And that's the end of chapter 13 and the entire Tractate Kesubos. Alright, that was a lot of information, so here's a rough summary of a lot of the practical takeaways from this tractate. When a husband and wife marry, they sign a marriage contract called a Kesubah. This contract outlines the sum given to the wife upon the termination of the marriage, a dowry, the delineation of finances and property between the two of them, and the marital obligations and responsibilities between the husband and wife.
There are severe penalties and fines for the violation or premarital seduction of a woman. These include a minimum set fine in addition to a variable fine for humiliation, deprecation, pain, and others. In the case of a violator, he can be forced to legally marry the woman, essentially to make him financially responsible to take care of her for the rest of his life.
Tractate Nedarim discusses the laws of vows, referred to as a neder, essentially a verbal declaration, usually to make something forbidden to you, which has legal significance. Chapter 1 will begin the discussion on the laws of taking vows upon yourself. The first Mishnah says, any other equivalent terminology for a vow functions the same as a typical vow. Any other equivalent terminology for a cherem, a type of vow, functions the same as a typical cherem. Any other equivalent terminology for an oath functions the same as a typical oath, and any other equivalent terminology for a Nazarite vow functions the same as a typical Nazarite vow. For instance, if somebody says, I am vowed from you, or I am separated from you, or I am distanced from you in that which I eat of yours, or that which I taste of yours, despite the slightly unique wording in these cases, it still functions as a valid vow. If somebody says, I am detached from you, Rabbi Akiva had a doubt as to if this is a valid vow, but he ruled stringently. The Gemara says, it taught all the different types of vows and oaths, as vows and oaths are taught about together in the Torah, so it also taught about all the other types of vows here too. And I mentioned Charamim first, as that, similar to vows, is a vow where you prohibit an item to yourself, unlike by an oath where you prohibit yourself to an item. Further, oddly, the Mishnah said it would list equivalent terminologies of vows, but those that it listed aren't equivalent terminologies. Those are brought later. The ones it brought here are partial declarations, so it's explained that it actually meant to say also partial declarations, and it taught those first here, as they were mentioned last by the preface, which is something done in many Mishnahs, and it gives several examples. It also gives some examples of Mishnahs where the first clause of the preface is actually spoken on first, but those are explained to be Mishnahs with many different clauses, so by those it explains the first one first. However, it cites more examples to prove that's not true, so it actually suggests that sometimes it just decides to discuss the first clause first, and sometimes, like by our Mishnah, it decides to discuss the second clause first. Alternatively, it said that when listing the preface, it said the actual biblical concept first, and then in the discussion it discussed the concept of partial declarations first, as those are derived from scriptural exposition. However, others disagree and say that the equivalent terms aren't even of biblical origin at all, so in the end it says, when we said to slot in the preface of partial declarations, it actually meant that we should slot them in first. It also describes the scriptural exposition that sources the laws of partial declarations, which are discussed. This is further described, and it also says a source, which states that if somebody who took a Nazarite vow, swearing off wine, grapes, and other things, if he violates his vow, he's done 2 transgressions, for violating his vow and for consuming wine. There's also a prohibition against delaying the fulfillment of a vow, which can apply to a Nazir if he vows to become a Nazir before dying, at which point he's immediately obligated to become a Nazir from that point onward. It cites proofs from related cases. Another Another instance of one who takes a Nazarite vow violating the principle to not delay, a Nazir cannot become impure, in addition to not drinking wine. So he violates the principle of not delaying if he takes his Nazarite vow while he's inside of a graveyard. Even if you say his vow doesn't take effect immediately, he's delaying it by staying in an impure place. By the way, this also teaches that if an actual Nazir intentionally becomes impure, he transgresses the prohibition against delaying. Another way a Nazir can delay, on top of not becoming impure or drinking wine, a Nazir is required to cut his hair and bring some offerings when the time of his Nazarite vow is over. So he can also delay doing either of those. This was the discussion on this point. In regards to the partial declarations mentioned, if somebody says, I am vowed from you, or separated from you, some say if he adds the ending part of, in that which I eat of yours, he's forbidden to benefit from the other guy, but the other guy can benefit from him. If he just said the first part, neither of them can benefit from each other. This is debated from other sources where such specificity of wording is not recognized. Instead, it suggests that he needs the second part of the statement about food for it to be an effective vow, as these partial declarations are vague, and when he says, I am vowed from you, that could just mean I won't speak to you, or when he says, I am separated from you, that could just mean I won't do business with you, that kind of thing. This would mean this opinion holds that inconclusive partial declarations are invalid in accordance with other opinions, and we bring sources. Whether inconclusive partial declarations are valid is actually debated by others, although some would actually hold that they are effective, besides for by a divorce document, which is debated over. The validity of these points is debated from other sources. It also debates if a partial declaration is valid by a betrothal, or peya, a type of field charity, based on its comparisons to other cases. They're left unresolved. It asks if there's validity to partial declaration by charity, or to nullify your ownership of something, which is debated if it's different than charity, legally, at least. Also, if there's validity to a partial declaration of designating an area as a restroom, and these are also left unresolved. In regards to Rabbi Akiva's doubt regarding the I am detached from you, he ruled stringently on the doubt, so there wouldn't be a punishment of lashes if you violated such a vow. Others debate this point, and it mentions some laws of excommunication. If excommunication is done in somebody's presence, it must be annulled in their presence. If it wasn't done in their presence, it can be annulled with or without his presence. Some say if somebody hears a man say God's name in vain, they must excommunicate that man, and if he doesn't, then he himself should be excommunicated. This is because saying God's name in vain leads to poverty. There are instances of this brought. It also says the sage can excommunicate himself, and he's allowed to annul his own excommunication. There's an instance of this by a sage who would always excommunicate himself before excommunicating somebody else, and then he would nullify both the excommunications. There are other teachings that says you're allowed to swear to perform a mitzvah. It says a person who says he will get up early to study a chapter, or that he will study a tractate, has vowed a great vow. You can fulfill the oath from Mount Sinai to study Torah by saying the Shema prayer every morning and night. It also says if a person tells a person they should arise early and study a chapter, then he must do the same also. Further, if somebody had a dream that he was excommunicated, he must have it annulled before 10 people who at least study Gemara. And if he can't find 10 of such people, he should at least get 10 people who study Mishnah. And if he can't find those, he should wait until he gets 10 who can study Gemara. And in the meanwhile, he should sit at a crossroads and greet people who will respond, "Peace be with you," to keep himself safe. You must still do all of this even if he knows who excommunicated him in the dream, as while that man he dreamed about was an agent to excommunicate him, perhaps that man wasn't an agent to annul his excommunication. If in the dream the excommunication was also annulled, you can't rely on that, as serious dreams do also have some nonsense mixed in. There are examples of such instances occurring. It also says a single expert sage can annul excommunication, and it lists points on the importance of not saying God's name in vain. New Mishnah. Further examples of partial declarations: if somebody says, like the vows of the wicked, meaning like a casual vow, whether to become a Nazir, or to bring an offering, or for an oath, that's an effective vow. If he says, like the vows of the virtuous, it's not a valid vow. If he said, like the Nedava of the virtuous, which is a specific type of vow, this is valid, be it to become a Nazir or to bring an offering. The Gemara says, regarding if he says, like the vows of the wicked, he needs to add am I, as long as there's an actual Nazir there right in front of him. Upon me, to bring an offering, or from it I shall not eat, for an oath, for it to be valid for those vows. There are further points. It gives the difference between a vow, which is said by some to just not be done at all, and in a dava, which is a proper thing, either as that's done to vow the consecration for an animal specifically right before it's offered, so that way it won't be misused, or by a Nazarite vow taken with full sincerity, like by an instance where it says a man was extremely handsome, so he took a Nazarite vow to remove his hair so that way he wouldn't come to sin. There are further points on this list, and there's additional discussion on this. New Mishnah, if a person takes a vow to bring an offering, a karban, it's still valid if he says equivalent definitions, like the word konam, konach, or konas instead of the word karban. That's a valid substitute for the word. Similarly, if he says cherek, cherech, or cheref, this is valid instead of the word cherem. If he says nazik, naziach, or paziach, these are valid instead of the Nazarite vow. If he says shavusa, shekuka, or the vow of Mohi, which is a way of saying Moshe, this is valid instead of an oath. The Gemara disputes the sources for all these terminologies, and it discusses the validity of various other specific terminologies. New Mishnah, if somebody vows in reference to a person's food that to him it's not unconsecrated, not kosher, not clean or pure, impure, leftovers of an offering, or rejected food from an offering, he's invalidated himself from eating the food. If he says the food should be like a designated lamb, an animal kept in a temple enclosure, like an animal designated for the temple fire, like on the altar, like from the heichal in the temple, like offerings in Jerusalem, or referencing any of the altar accessories, even if he didn't mention a specific offering, it's considered a vow to designate something as an offering. Others say if he says it should be like in Jerusalem, he hasn't said anything. The Gemara further debates these points as to the authorship of this Mishnah. This is further discussed, along with some additional points. It goes through other terminology which encompasses broader concepts in regards to vows, like the inclusion of teruma from certain phrases and similar, and the other terminologies are also qualified. New Mishnah, saying karban, or any of the specific types of temple offerings, ola, mincha, chatas, toda, or shlomim, and then he says, that which I eat of yours, he can't eat the food, but others say he can, as he needed to say, like a karban specifically. If somebody says the karban, or like a karban, or just karban, and then that which I eat of yours, he can't eat the person's food. If he said to a karban, I shall not eat of yours, some say he can't eat of their food. The Gemara further qualifies these points. New Mishnah, if somebody says konam, my mouth speaking to you, or my hand working with you, or my foot walking with you, that's a valid vow of prohibition. The Gemara says, as vows are only really applicable by things which have substance, he must be vowing against the person's mouth, hands, or feet which have substance, and it brings sources. And that's the end of chapter 1. Chapter 2 of Tractate Nedarim discusses some additional specific terminology in regards to their validity as vows. The first Mishnah says, if somebody vows that somebody's food should be to them unconsecrated, like pork, like an idol, like skin perforated at the heart, like types of improperly slaughtered animals, like types of bugs or crawling creatures, like the challah tithe or teruma, the vower can still eat the food. If somebody vows to his wife that she should be to him like his mother, he must have the vow annulled, so that way he takes such things more seriously. The Gemara suggests if he said the food should be like not unconsecrated food, some say this means it should be like a karban, a temple offering, thereby disallowing it. This is debated. Others say that such an implication can't be derived. The general point of the Mishnah is that if somebody associates a permissible item with an inherently forbidden item, that's not a valid vow. It cites sources for these points in regards to somebody vowing his wife should be like his mother. Biblically, he's done nothing, but rabbinically, he must still have the vow annulled. Others say this is only if he's a Torah scholar. He must actually have it annulled if he's ignorant, and it brings sources. This is for the discussed. New Mishnah, if somebody says konam, my sleeping, or speaking, or walking, or cohabiting with his wife, he cannot desecrate this vow. The Gemara says, if somebody vows against sleeping today on condition that he sleeps the following day, it's a debate. Some say he might sleep the next day, so he can't sleep today. Others say that's not a concern, so he can just sleep on the first day. If somebody says he's vowing against sleeping tomorrow, if he sleeps today, that's valid, as the vow is conditional on what he does today. Further, again, as a vow must be on something of substance, the case of the Mishnah must be that his eyes are konam from sleep specifically. This, however, cannot refer to a permanent vow against sleep, as it says if somebody vows against sleeping for 3 days, as that's basically impossible, he immediately receives lashes for swearing in vain, and then he's just allowed to sleep. So, the case must refer to where he vowed that against his eyes sleeping today, if he sleeps tomorrow, meaning that the first part is a possible vow and the second part is a stipulation, as he can't sleep at all on the first day in case he sleeps on the second day. Others say that simply the vow is a rabbinic one, which can't be desecrated, and we bring sources. This is further debated. There's additional discussion on this point. New Mishnah, if somebody vows against sleeping, speaking, or walking, he can't do those things. If somebody says, Korban, I shall not eat of yours, ha korban, that which I eat of yours, or la korban, I shall not eat of yours, he's not allowed to eat the other person's food. The Gemara says, this is the opinion of the one who holds that there's a difference between saying korban, that which I eat of yours, which would be valid, and ha korban, that which I eat of yours, which would not be valid. Also here he said la korban as two words, which means not to korban, which is not a valid oath, unlike saying la korban, which means to a korban. New Mishnah. If somebody says, an oath I will not eat of yours, or behold an oath that I eat of yours, or not an oath I shall not eat of yours, he can't eat the other guy's food. The Gemara explains that saying, behold an oath that I eat of yours, meaning he's vowing against eating the man's food, as the specific word used can be in reference to not eating, sometimes depending on the context. Others say it used the wrong word in the Mishnah, and it should have wrote differently that I will not eat, which is about a letter off in its original language, and still would be a valid oath, even if he misspoke. Others say simply the wording must be amended to say that he did not eat, as stated. New Mishnah. Oaths can be stronger than vows, and vows can be stronger than oaths. For instance, if somebody vowed against doing a mitzvah, against making a sukkah, shaking a lulav, putting on tefillin or similar, that's a valid vow, but he can't take an oath against doing a mitzvah. The Gemara explains that the way oaths are stricter than vows is by the earlier case. If somebody vows against sleeping, speaking, or walking, that vow goes into effect rabbinically, but if it was an oath, it would go into effect biblically. It also brings sources for these points, which are discussed. New Mishnah, there is validity to a vow within a vow, but not to an oath within an oath. For instance, if somebody vows to become a Nazir, if he eats bread and says that vow twice and eats it, he must now become a Nazir for 2 terms. But if he takes an oath not to eat bread and then he repeats that and then eats the bread, he's only liable once. The Gemara clarifies the double Nazarite vow only works twice if he vowed for 2 different periods. If he vowed that both Nazarite vows should be within the same time period, he'd still only do one. Others disagree and say that he must do a second term after the first, and these opinions are debated from various sources, and there's additional discussion on them. New Mishnah. Indeterminate vows are treated stringently, but if they're clarified afterwards, they're believed, even if it's lenient. For instance, if somebody declares an object to be, to him, like salted meat or a wine libation, if he specified he meant like a temple offering, it would be forbidden to him. But if he specified it should be like an idolatrous offering, he'd be allowed to eat it, and if he didn't specify, he can't eat it. There are a few other examples given. Some say if he vows that his food should be like teruma in Judea, it's forbidden. In Galilee, it would be permitted, as the forbidden type of truma would be a half shekel tax, which the people in Galilee just weren't very familiar with. Others make a similar distinction by cherem, items vowed to be temple property. In Judea, they'd be permitted, and in Galilee, they would be forbidden, as they don't know about the cherem of Kohanim, which can be used. The Gemara disputes based off of similar cases if you can actually rule stringently by an indeterminate vow, as a different source says a Nazarite vow, if indeterminate, is treated leniently. It's debated further as to which differing opinions were the authors of these statements, and the other points are also qualified. New Mishnah. In regards to somebody who makes a vague vow and then clarifies it to be lenient, there are a few examples. If he vowed an item to be cherem and then said he was referring to fishing nets, if he vowed regarding an offering and then said he meant an offering for kings, if he vowed against his wife benefiting from him, and then clarified he meant an earlier divorced wife, and others. With all these vows, they don't need to go before a sage to have them annulled. If they did, then it must be held strictly. Others say we find a basis to annul the vow and tell them to keep it, so that way they'll take vows seriously. The Gemara clarifies it means a Torah scholar doesn't need to have his vow annulled, but an ignorant person is treated strictly. Such a person is punished that he must keep the vow for the same number of days that he violated it before it's annulled. Others say a court just shouldn't get involved if the person transgresses such a vow. Others say we excommunicate a court that doesn't impose this penalty. It also similarly cites points on generally refraining from vows to prevent these issues and other things that lead to sin, like staring at women and similar. It also speaks on the importance of being modest while being intimate and similar points. There's further on this, there's a dispute if there are particularities as to the manner of cohabitation. It cites verses which source the fact that a man should never think of another woman during cohabitation, and similar improper actions or people that will result in the individual's children ending up improper. And that's the end of chapter 2. Chapter 3 of Tractate Nedarim continues going through the laws of vows. The first Mishnah says there are 4 types of vows which are permitted by the sages, which just means that these following types of vows are null. Motivational vows, exaggerated vows, unwitting vows, and vows of circumstances beyond your control. A motivational vow, for instance, is a vow taken during a business deal that you won't go higher than a certain amount, even though you would be willing to. The Gemara disputes the author of this Mishnah based on a related case. There's further debate as to what exactly this means that the sages allowed these vows. Some suggest it means a sage must annul them. Others say it means that they're automatically null. Others say it means that a sage can only nullify vows similar to these, meaning regret is not a valid method of nullifying the vow. There are instances of this brought. It further gives cases of instances of invalidating vows, and it also speaks on how negative it is to be an angry person, how there's severe punishment for such, and it also mentions an incident where a sage was traveling with others and one of them got angry and killed the other, and then the person turned to the sage and asked if he had done the right thing, and the sage, fearing for his life, said yes, and you should open the wound up so that way the man will die faster and not suffer. Later the sage was upset by this whole event, but he was told he had done the right thing in saving his own life. It further speaks on how terrible it is to get angry. There are further particular instances of annulment of vows, and it's ruled that we do find a way to annul a vow out of the man's regret of the vow, and we do also deal with one who vows on God's name. There are further similar instances discussed, and these are all described further. New Mishnah: if somebody wants to vow to make his friend eat with him, he should earlier say that any vow he makes should be null, and this works as long as he remembers he did this when he makes the vow. The Gemara asks how this would work if the other guy knows he's preemptively nullified this vow that he's gonna make. Some say to amend the wording to be that this works if he doesn't remember the nullification when he made the vow. Others say it's where he made the nullification stipulation earlier, but he forgot what he had said, so he says he's making his vow in accordance with his original intent to nullify it. It's debated if this type of vow constitutes as the above-mentioned type of motivational vow, which is debated from several sources. It's said that others do disagree, but it's held that this case does constitute a motivational vow. New Mishnah: the next mentioned type of vow was an exaggerated vow. For instance, if somebody vows not to eat something if he didn't see as many people on a road as there were people by the exodus from Egypt, or that he saw a snake as thick as the beam from an olive press. The Gemara says exaggerated vows are permissible, but not exaggerated oaths. For instance, taking an oath against all the fruit of the world as he didn't see an amount of people as great as the Exodus. It also clarifies he can't say when he took this oath that he was referencing an anthill, actually, as that's not the way people typically speak. Judges still do clarify the literal meaning of an oath, but that's only because there was a famous case where a man owed coins to somebody and told him that he had already paid it, so it was brought to court, and the judge told the borrower to swear that he had given the man the coins back, so the borrower handed the other guy his cane, and he took this oath that he had returned the coins, and the other guy got so mad he smashed the cane, and all the coins rolled out. So that meant technically the guy had not made a false oath, as he had literally returned the coins. It further clarifies the necessity for specific wording in an oath, and it says that he can't be referring to other concepts when he uses particular words. In regards to exaggerating that you saw a massive snake, but it says there actually was such a massive snake in the days of King Shapur, which swallowed 13 stablesfuls of hay. So rather, when somebody is exaggerating a vow that a snake was like an olive press, it means that the snake's back is rigid. This also informs us that the back of an olive press is rigid, which has relevancy in regards to whether or not it needs this factor in regards to the laws of sale. New Mishnah: an unwitting vow, as mentioned, is if somebody vowed against something if he had eaten or drunk earlier in that day, and then he remembered that he had actually eaten or drank earlier that day. Or if it's somebody who vows against something if he will eat or drink, and then he forgets about this vow, and then he ends up eating or drinking. There are other instances given. The Gemara says, along with an unwitting vow being allowed, an unwitting oath is also permitted. For instance, if two people take an oath that somebody said something, and they both believe themselves to be correct. It discusses the above cases, and these are all qualified further along with some additional points. New Mishnah: a vow of circumstance beyond their control is a vow, for instance, against somebody that they must eat with him, and then the other person becomes sick or otherwise unavoidably delayed. The vow does not take effect. The Gemara cites a relevant case of such a thing occurring. Some ruled in that case the person's vow was null. Others disagree, as they say it was by a foreseeable constraint. The other says it was null, as the case was what's referred to as an asmachta, which means a commitment that the person made not thinking he'd have to honor, which this opinion holds is not legally binding. The law is that such a commitment in asmachta is legally binding, so long as he wasn't constrained by circumstances beyond his control, and it was made through a formal act of acquisition through a prestigious court. New Mishnah: you are legally allowed to vow to a murderer, a plunderer, or an unlawful tax collector that the produce that they're trying to steal from you is teruma, or it belongs to royalty, even though that's not true, just so that way they won't eat it. Beis Shammai says you can make any type of vow for this, but not an oath. Beis Hillel says you can also make an oath. Beis Shammai says you can't initiate such a vow. Beis Hillel says you can. Beis Shammai says the vow is only allowed on the demanded parts of the vow. Beis Hillel says it's on any part of the vow, he said. Examples are given. The Gemara clarifies when it says the tax collector, obviously as there's an obligation to abide by the laws of the country you live in, you have to pay your taxes. So clearly this must refer to an unlawful tax collector, either one who made no set limit or a self-appointed tax collector. It further describes the method of making such vows. There's an apparent dissenting source which implies that an oath can be made according to Beis Shammai, but this is disputed. New Mishnah, if somebody vows that saplings should be consecrated if they're not felled, or a talus should be consecrated if it's not burnt, they will be considered consecrated and must be redeemed. If somebody vowed that saplings should be consecrated until they're felled, or a talus should be consecrated until it's burned, they are consecrated but not redeemed. The Gemara says, it said they're also redeemed by the first one to parallel the wording of the latter part. It further describes the method of such a consecration vow. The reason the consecrated produce can't be redeemed is because they'd automatically just be reconsecrated over and over until they're felled or burnt. Others say it's because once they're felled, they don't need to be redeemed, they're just automatically deconsecrated. This is further debated. It brings other cases to dispute the opinion that physical sanctity can't leave by itself, and there's further discussion on these points by relevant cases which are qualified further. New Mishnah. If somebody vows against benefiting from seafarers, he can benefit from land dwellers. If he vowed against benefiting from land dwellers, he can't even benefit from seafarers, as they're also land dwellers. This doesn't apply by travelers of a short distance, but rather to a large distance. This last point, it's debated if it refers to the first or last part. Some say the first part, someone who vows against benefiting from seafarers can benefit from seafarers of a short distance, but not of a long one, while others say it's on the last part, someone who vows against benefiting from land dwellers still can't benefit from any types of sea dwellers. New Mishnah, somebody who vows against benefiting from those who can see the sun can't benefit from the blind, as he meant those that the sun sees. The Gemara says, if he wanted to not benefit from the non-blind, he would have said against the sighted. This vow he made, vows against those the sun sees, excludes specifically fish or fetuses. New Mishnah, if somebody vows against benefiting from dark-headed people, he still can't benefit from bald or old people, but he can benefit from women or children, as dark-headed is an expression to refer to men specifically. The Gemara says, he didn't say not to benefit from those without hair. Dark-headed refers to men, as women always cover their hair, and children always uncover their hair. New Mishnah, if somebody vows against benefiting from the Yoldim, those who were born, he can benefit from those who will be born. If he vowed against benefiting from Noladim, those who will be born, he can't benefit even from those who are already born, but others disagree, and others say he's referring to anything that can be born. The Gemara clarifies the logic of these terminologies. The last opinion includes only mammals. New Mishnah, one who vowed against benefiting from those who rest on Shabbos can't benefit from Jewish people or Kuthians. If he vowed against benefiting from people who eat garlic, this includes Jewish people and Kuthians. If he vowed against those who go up to Jerusalem, that includes only Jewish people. The Gemara explains, he said those who rest on Shabbos, which Kuthians also did. He should have said those who are commanded to keep Shabbos. By going up to Jerusalem, Jewish people and Kuthians were commanded to do this, but only the Jewish people did this. New Mishnah, if somebody vowed against benefiting from the descendants of Noah, he cannot benefit only from non-Jewish people. The Gemara explains that although everybody's included as a descendant of Noah, Jewish people aren't referred to as such. They're called descendants of Abraham. New Mishnah, if somebody vows to not benefit from the descendants of Abraham, he can't benefit only from Jewish people. The Gemara explains based on verses that this excludes Yishmael and Esav, even though they are technically also his descendants. New Mishnah, if somebody vows against benefiting from Israel, he can do business with them at a loss. If he vows that Israel can't benefit from him, he can do business with them at a gain, although people probably won't do business with him. If somebody vows against the benefit to or from Israel, he can do business with idol worshippers. The Gemara cites some related points, and these are discussed further. If somebody vows against benefiting from the uncircumcised, he can still even benefit from uncircumcised Jewish people, and not from circumcised non-Jewish people. If he vowed to not benefit from the circumcised, this still includes circumcised Jewish people and excludes circumcised non-Jewish people based on verses. It lists several teachings from several sages on the great importance of circumcision. The Gemara describes how Moshe was punished for delaying the circumcision of his son as he traveled back to Egypt even a little bit. It says, as he traveled, 2 angels of destruction came and swallowed Moshe up to the legs, so Moshe's wife quickly performed the circumcision. It cites several other teachings on the great importance of circumcision, that it's equivalent to all of the other commandments of the Torah, and similar. It also criticizes people who try to divine the future, and says God will help those who don't do such things, which is based on verses. There are further points on the forefather Abraham. It says he recognized God when he was 3 years old. It also says he had total mastery of his body, which again is all based on verses, and the priesthood was taken from the descendants of Shem to be with Abraham's descendants. And that's the end of chapter 3. Chapter 4 of Tractate Nedarim continues discussing the laws of vows. The first Mishnah says, there is no legal difference between somebody who vows against benefiting from another person and somebody who vows against letting his food be used to benefit somebody, besides for entering the other person's property or using utensils which aren't used for food, both of which would be disallowed by the first vow. If somebody is subject to a vow that forbids him from receiving food from somebody, he can't use that man's flour sieve, grain sieve, mill, or oven, but he can use the man's shirt, ring, cloak, or earring. The Gemara cites an opinion that holds that forbidding somebody to benefit from you includes your property also. Further, by the vow against receiving food, it also includes all those listed utensils, as the vow in this case was a benefit that brings to the consumption of your food is forbidden to me. It lists several other utensils that would be included in such a vow: a fruit sack, a donkey used to carry fruit, and a basket. It debates about other particular entities if they're included in such a vow. New Mishnah, continuing the last vow, any utensil which is not used to prepare food, if the region rents out similar of such items, it's prohibited. The Gemara says, based on this, the prior Mishnah would disallow the usage of utensils used to prepare food, even if they're not rented, and it says the source for this opinion. New Mishnah, if somebody vows against generally benefiting from somebody, that other person can still pay the individual's half shekel tax for him, repay his debt for him, and return his lost article to him. If the custom in the location is for the finder of the lost object to take compensation, then that, in this case, should be given to the temple treasury. The Gemara explains the logic, as it's similar to driving a lion off of somebody's property, meaning it's preventing a loss, essentially, and it cites the sages who hold this. Some say that alternatively, it's like everybody, and it's a case where the debt in question doesn't have a set repayment date, and it further cites these opinions, which are debated. Regarding the lost object, some would argue if the case of benefiting from the property of the guy with the lost object is forbidden, the finder would not be allowed to return the object, as there's a principle that if you're taking care of somebody's lost object, that's a mitzvah, and you're exempt from any other mitzvah while you do it. So that's technically speaking a form of benefit. Others disagree and say that's just uncommon, and this is further debated. There are related points on similar cases. It additionally discusses some laws of me'ilah, impermissibly benefiting from consecrated property, and similar. New Mishnah, the person who is prohibited to give benefit to another due to a vow, he can still separate the other person's terumah or tithes without the other person knowing, or bring bird offerings for various impurities on his behalf, or sin offerings, or others, and he can teach the man midrash, halacha, law, and agados, but not scripture, although he can teach the man sons and daughters scripture. The Gemara asks a relevant general question, which is, do the Kohanim in the temple act as agents of the public, or as agents for heaven? This is practically relevant if somebody vowed against benefiting from a certain Kohen. This is debated from several sources. It's discussed further. It asks a related point from above: if a person removes tithes from his own produce to cover it for somebody else, does he need that man's consent? It tries to resolve that based on our case, where the terumah removal from the other guy's pile is permissible, even though he couldn't give benefit to the guy. But it's explained that the Mishnah's case was where the man said, whoever wants to remove terumah from my produce should do so, which means that when the other man removed his terumah, it's not regarded as a prohibited benefit. So it asks, if a person separated terumah from his own produce to fix the produce of somebody else, who gets to decide which Kohen receives the terumah? It's debated further, and it says that the decision goes to the separator here. The reason why teaching midrash and similar was permissible, but not scripture, some say it was because it's a place where it was only customary to be paid for teaching scripture. Others disagree and say that teachers aren't paid for the teaching of scripture either. They're paid, according to some, for safeguarding the students, and others say it's for teaching the cantillation, the singing method, essentially, of the verses. According to the opinion that the payment of teaching is for safeguarding the students, our case must be where he's teaching a child, and the part of the Mishnah that says he could teach his children refers to a separate point in general on an adult. But there's a further question. It cites a different case where there's a prohibition against school children from learning new material on Shabbos. So if this teacher's job is safeguarding the students, then he wouldn't be permitted to do so no matter what's being taught, which actually has issues with both opinions. Whether the issue with teaching children new material on Shabbos is either because we want fathers to spend time with their children, or it's because they eat and drink more on Shabbos and they won't be able to study properly. The opinion that says the payment of students is for teaching cantillation, they disagree that it's done for safeguarding, as daughters don't need safeguarding. The one that says it's for safeguarding and not cantillation, that's because he holds cantillation is of biblical origin, so you can't be paid to teach this, and it brings a source for this. Further, it mentions that the vowelization of words, stylistic words, and words which are read but aren't written, or vice versa, are traditions from Mount Sinai, and it gives several examples of these. It further discusses examples of these verses. It mentions Moshe's great wealth, and it says that the divine spirit only rests on one who is mighty, wealthy, wise, and humble, which were all exemplified by Moshe, and it cites sources for each of these, and sources for the wealth of several other prophets. New Mishnah, further in regards to a vow against benefiting somebody, he can still support his wife and kids, even though they're the other guy's responsibility, although he can't feed any of his animals, as that makes them go up in value. Some say he can only feed his non-kosher animals. Further, this opinion says a kosher animal's spirit belongs to heaven, while its body belongs to its owner, while a non-kosher animal's spirit and body are God's. Others disagree, saying a non-kosher animal's spirit also belongs to heaven, and its body also belongs to its owner, as while he can't eat it, he can sell it to a non-Jewish person, for instance, or feed it to his animals. The Gemara says an opinion that if somebody vows against benefiting from somebody, that man can still marry his daughter to him. This case is explained to be where the property of the bride's father is prohibited to the groom, but the daughter is a legal adult, meaning she marries with her own consent. It describes other permissible, smaller benefits that are permitted. New Mishnah, if somebody has been vowed against benefiting from somebody and then goes to visit the man, he can stand but not sit, and can heal his soul but not his money, which will be explained. The Gemara explains this case is where the possessions of the visitor are prohibited to the sick man, and the locale is where they take payment for sitting with a sick man, but not for standing. The generalization of the Mishnah teaches that you are never allowed to take payment for standing with the sick, and therefore cannot derive benefit from doing such a thing. Others say the issue of him sitting is that sitting is forbidden rabbinically in case he sits for too long. Others say the case is the inverse, where the possessions of the sick man are forbidden to the visitor, and the vow didn't include doing things for the man's health within his vow, which can only be done while standing. This is discussed. It digresses to cite many verses and points on the immense importance of visiting the sick, and also verses regarding Korach, who challenged Moshe's leadership during the Jewish people's wandering the desert, during which it says that the sun and moon ascended to the higher heavens and demanded God support Moshe on this, so God responded by asking why they're getting involved in Moshe's honor when every day people worship the sun and moon instead of God. So the sun and moon thought to stop illuminating the world because of this, but God forces them to continue. It further brings points on the great importance of visiting the sick, which has no limit, and it says it takes away a 60th of the sick man's suffering to an extent. There are more such points in this, and instances where certain sages became sick and people visited them, causing them to get better. It says those who visit the sick are spared from Gehenna and will also be rewarded in this world, and further such points. These are discussed. There are further points on the sick. It says once a person has reached the end of his life, any creature can end him, and it gives examples and it describes other illnesses and their causes. These are discussed, and it says that healing the soul, as mentioned, is healing the man's body, and healing his money means healing his livestock. New Mishnah. The person subject to the vow against benefit is allowed to bathe in a large pool with the man, but not a small one, and they can share a bed. Others say they can't share a bed in the winter, as he benefits from his warmth. He may recline with him on a bed, eat with him at the same table, but not from the same bowl, unless there's enough for both to have leftovers. The Gemara cites sources which say similar points. New Mishnah. A person who was vowed against benefiting from somebody should not eat with the vower from the same food trough for laborers, and not work with him in the same row of a vineyard. Others say they can work in the same row as long as they're far apart. The Gemara says that actually both agree that a close spot is disallowed, and they dispute a far spot. The first opinion is saying they can't work even far apart, as the vower makes the ground softer for the other, while the others say that's just not an issue. New Mishnah. If somebody vowed against benefiting from another person, he can't enter the man's field or eat fruit from branches that extend out of his field. If the vow was made on a sabbatical year when farming is prohibited, he can't enter the man's field, but he can eat of the extending trees. If the vow was against specifically food-related benefit, he can enter the field by both cases and to not eat the fruit accordingly, depending if it was a sabbatical year. The Gemara cites related opinions in these cases. It explains the issue with entering the field on a sabbatical year. It's because you might delay there, which isn't allowed. New Mishnah. Somebody who vowed against benefiting from another person, he can't be lent items, can't borrow items, can't lend or borrow money, and can't sell to him or buy from him. The Gemara says the issue of benefiting while borrowing from somebody is either the cases where both men vowed against benefiting from each other, or it's because there's a concern that borrowing will lead to lending, so it's a rabbinic decree. New Mishnah. If somebody asked a man to lend him his cow, and he said it's not available, so the other man vowed against ever plowing his fields with the cow, and then later the man lent him the cow. If it was the vower's habit to plow his field himself, then only he can't use the cow to plow. If his habit was for others to plow his field, then he and everybody can't use the cow to plow the field. If somebody vowed against benefiting from somebody, and he has no food. The other man can go to the store and tell the shopkeeper that he wants to help this guy out, but the guy took a vow against me from benefiting from him, hinting to the shopkeeper to help the guy. So the shopkeeper can help the vower, and then the other guy can pay the shopkeeper. This applies in various cases. If there was no shopkeeper, if they were traveling together, the man can give the food as a gift to somebody else to then give to the vower. If it's just the two of them, he can leave the food on a rock and declare it ownerless, and the vower can eat it. Others forbid this. The Gemara says the opinion that forbids the last one, it's because he holds making something ownerless is like making it a gift, so he still technically partially owns it. This is debated. It further discusses points on the effectiveness of making an item ownerless. This is discussed further, and there's additional points on these laws. And that's the end of chapter 4. Chapter 5 of Tractate Nedarim continues discussing the laws of vows. If two partners who share ownership of a courtyard both took vows against benefiting from each other, both of them are not allowed to enter the courtyard. Others say they can both enter into their own portion of the courtyard. Both of the partners are forbidden to install a mill or oven or to raise chickens in the courtyard. If only one of the partners vowed against benefiting from the other, he can't enter the courtyard. Others say he can enter only in his portion, and we compel the man who took this vow to sell his courtyard share. If some other third guy took a vow against benefiting from one of the courtyard owners, he's not allowed to enter the courtyard. Others say he's allowed to only enter the other's courtyard portion. If somebody took a vow against benefiting from somebody, and that man has a bathhouse or olive press in the city that's leased to others, if he still has a holding on the bathhouse or olive press, the vower can't use it. If he doesn't have a holding on it, the vower can use it. If a man vowed against entering a man's house or purchasing a man's field, and the owner dies or sells it to another, the vower can now enter the house or purchase the field. If he vowed against entering this house or buying this field, even if the owner dies or sells it, he can't enter or purchase them. The Gemara says the Mishnah first case of the dual vows on the shared courtyard, the cases where the partners vowed against themselves using the other's portion. But what if they vowed against the other partner using their portion? Would that create variance in the opinions? It's debated and it's unresolved. Further, some argue that the disputed case as to whether or not they are banned from using the courtyard or they can just use their portions is if the courtyard is large enough to be divided. If it's too small for that, both would permit using it. This is disputed. As we see from a related case by a synagogue, which is jointly owned by a town, it cannot be entered due to a vow from benefit, even though it's not divisible. So rather it's said the argument between the opinions is where the courtyard is too small to be divided. Both would agree it's forbidden to enter if it's large enough to be split. It says we follow the opinion that allows each to enter their courtyard portion. In regards to the case of a vow against benefiting from someone who owns a bathhouse where he can't use it if the owner still has a holding over it, a holding, according to some, is the owner still retaining the right to at least a quarter of the income. Others define it as the owner having a fixed annual rental fee. A related case, if somebody vows against somebody else entering his house and he then dies or sells the house, it's learned from a different case that someone is allowed to prohibit something of his to somebody and have that continue to apply even after it leaves his possession. There are similar cases discussed, and they're qualified further. New Mishnah. If somebody said, I am chayrim to you, chayrim being property vowed to the temple treasury, he's essentially vowing that the other guy can't benefit from him. If somebody vowed, you are chayrim to me, the vower can no longer benefit from that man. If somebody said, I am chayrim to you, and you are chayrim to me, they cannot benefit from each other. Both of such people can benefit from a public use faculty in Israel for those who came from Babylon, places such as the Temple Mount, the courtyards, and the pilgrimage festival path water cisterns. They can't benefit from a faculty in the town they live in, like the town square, the bathhouse, the town synagogue, and its ark and books. If they want to allow the other to use these faculties, they can give up their share of the faculty by writing it over to the Nazir, the leader of the Jewish people of that time. Some say you can write it to the Nazir or to anyone else, but if you write it to the Nazir, nobody needs to acquire it on your behalf. Well, this would be necessary if it was written to anybody else. Others say even the Nazir needs to have some acquire it on his behalf, and it just mentioned the Nazir here as that's what was typically done. Some rule that the people of Galilee don't need to write over the shares of communal faculties to the Nazir, as this was already done by the earlier generations. The Gemara further describes the process in regards to the people of Galilee. It said that they kept on making vows against benefiting from each other, so they had their shares of the communal properties written over to the Nazir. New Mishnah. If somebody vowed against benefiting from somebody and he has no food, the other man can give his food to somebody else as a gift and have that man give it to the vower. It says an incident of this where a father vowed against benefiting his son, so the son wanted his father to attend his child's wedding feast, so he gave it as a gift to somebody else.
so that his father could attend, and that man that he had gifted the feast to just decided to consecrate the whole thing to the temple, which the son was not okay with, and it was ruled that it wasn't a valid gift anyway. So the Gemara further qualifies these points. There are related incidents brought and discussed, and further in regards to the validity of the wedding gift, consecration case, and similar, and that's the end of chapter 5. Chapter 6 of Tractate Nedarim discusses further laws of vows, further on specific terminology that can be used in a vow. The first Mishnah says, someone who takes a vow against partaking in that which is cooked, he's still allowed to eat or benefit from roasted or undercooked food. If somebody vows against tasting a cooked food, he can't eat liquidy food from a pot, but he can eat solid foods and also a specific type of egg or gourd, which will be described. If somebody vows against a preparation of a pot, he can't eat food that's been boiled extensively. If somebody vows against tasting any food that goes into a pot, he can't eat any foods that are cooked in a pot. The Gemara says, some say if somebody vows against cooked foods, that actually does include roasted food, which was based on the unique wording of their locale. And also, secondarily, from a verse, which seems to imply that roasted foods are referred to as cooked. In regards to the vow against tasting cooked foods, where it said that it forbids liquidy foods, that's because the specific use of terminology refers to foods which are eaten with bread, and sources are provided. It also discusses which types or parts of a squash are good for a sick person. It also says the Mishnah goes against the practice of the Babylonians who eat thick porridge with bread, as that's excluded. It discusses additional points on the proper manner of eating porridge. It also mentions one sage whose face shone, and it's attributed either to his great wisdom or to his personal healthy practices. It also discusses the beginnings of the great sage Rabbi Akiva, who started as an illiterate shepherd, and his employer's daughter, Rachel, saw that he was a good man with great potential, and offered to marry him so long as he would study Torah. Rachel's father was very upset by this, and disowned her, but they married anyways, and they were extremely poor. It says they would sleep in a straw shed, and Akiva would pick straw out of his wife's hair, and say if he had the means he would give her a golden tiara instead. Eliyahu the prophet appeared as a poor man begging for a little straw, and Akiva told his wife, see, at least we even have straw. Anyways, Akiva eventually went to study at the academy and did so for 12 years. He then returned and overheard a wicked man criticizing his wife, saying, firstly, your station was far higher than your husband, and secondly, he's abandoned you for the past 12 years. Rachel responded to the man, if Akiva was here, she would tell him to go and study for an additional 12 years. So Rabbi Akiva turned and went back to study for another 12 years, and then returned as a great sage with 24,000 pairs of students. Everybody in the town went out to greet him, including his wife, who still wore her poor clothes, so Rabbi Akiva's students, who didn't know who she was, pushed her away, but Rabbi Akiva said to stop, as his Torah and all of theirs belonged to her. Anyways, Rachel's father, who had disowned her a while earlier, heard a great sage had come to town and came to him to release himself from the vow he had made against providing for his daughter. Rabbi Akiva revealed who he was and received great wealth from his father-in-law. It also says Rabbi Akiva became very wealthy as the figurehead of a ship broke off and was found by Rabbi Akiva, and also that he received a treasure chest as he gave a few coins to some sailors to give him anything, and they had found a chest which happened to have been filled with gold coins from a sunken trader ship. He also received a lot of wealth from a Roman noblewoman, from the wife of the Roman governor Turnus Rufus, who would eventually execute Rabbi Akiva, and also from a man named Kitia Bar Shalom, another Roman nobleman who was kind to the Jewish people. A different sage also gave some sailors some coins in exchange for anything, so they gave him a monkey, which ran away into a hole, leading him to find a cache of pearls. It also says a story that the daughter of one of the Caesars was chatting with the sage Rabbi Yeshua ben Hananiah, and she said that he had such beautiful Torah knowledge, but he was extremely physically unattractive. So he responded by asking where her father kept their best wines, and she said in earthenware vessels. So the sage said they should be kept in fancy gold and silver vessels instead. So she did that, swapping them all into gold and silver vessels, and all the wine went bad. So the sage explained it's the same way with learning Torah. She asked, but there are also extremely handsome Torah scholars, and he said they'd be even more learned if they weren't. It also speaks of a time that there was a different woman who insulted the teacher of a sage during a court case, so the sage excommunicated her and she died. It also describes the special mentioned egg, which was a specially prepared egg that was used for medical diagnostics. There are other further points spoken on. It also describes the preparation of the special gourd dish mentioned. New Mishnah, somebody vowed against the preserved food. He can only not eat preserved vegetables. If he vowed against tasting preserved food, he can't eat any preserved food.
The Gemara says it's unresolved what he's banned from if he vows against that which is preserved, that which is undercooked, that which is roasted, etc. A new Mishnah. If somebody vows against the roast, he can't eat roast meat. If he vowed against tasting roast, he can't eat any roast food. If somebody vows against the salted food, he can't eat salted fish. If somebody vowed against tasting salted food, he can't eat any salted food. If somebody vows against eating fish or fishes, he can't eat any fish, be they large or small, salted or unsalted, or raw or cooked, but he can eat a specific type of chopped fish and brine. If somebody vows against eating a specific type of mixture of small salted fish, he can't eat chopped fish, but he can eat brine. If somebody vows against eating chopped fish, he can still eat brine. The Gemara describes which words refer to which types of fish. New Mishnah. If somebody vows against milk, it's debated if they can have whey. If somebody vows against whey, he can have milk. If somebody vows against cheese, he cannot eat any type of cheese, salted or unsalted. If somebody vows against eating meat, it's debated if he can eat gravy or meat shreds. There was a ruling which implies not, but the case was possibly by a specific vow against a specific piece of meat, wherein he couldn't eat the meat or anything its flavor mixed with. If somebody vows against having wine, he can eat a cooked dish that tastes of wine. If somebody vows against tasting wine, he can't eat a dish with wine where the wine can be tasted. The Gemara explains the dispute if you can eat whey, if somebody vowed against milk, is that in some locations they refer to whey as whey of milk. New Mishnah, somebody who vows against grapes can have wine. Somebody who vows against olives can have oil. Somebody who vows against tasting grapes or olives cannot have wine or oil. The Gemara further debates these points. New Mishnah, somebody who vowed against dates can have date honey. Somebody who vowed against winter grapes can have winter grape vinegar. There's a debate on if generally somebody vows against a food, if a derivative of that food is still permissible, if it shares the same name as the food. The Gemara explains that it needs to clarify date honey and vinegar to say what we hold by edible foods, where their derivative is edible and where it's not edible. New Mishnah, somebody who vows against wine can have apple wine. Somebody who vows against oil can have sesame oil. Somebody who vows against honey can have date honey. Somebody who vows against vinegar can have vinegar of winter grapes. Somebody who vows against leeks can have a leek with a head. Somebody who vows against greens can have wild greens. This is all because it goes in accordance with the specific used terms. The Gemara says, the point on oil applies in Israel. In Babylon, if somebody vows against oil, they also can't have sesame oil, but they can have olive oil. If both oils are used, he can't eat either as a stringency. By eating greens, it's similarly reversed that you can only eat the wild greens during a sabbatical year when farming is forbidden. This applies only if greens are not brought from out of Israel inside. Some don't allow doing that at all, out of concern that dirt will be stuck on the produce and violate some laws of impurity. New Mishnah, if somebody vowed against eating cabbage, he can't eat asparagus, a specific type of cabbage, and vice versa. If somebody vows against grits, it's debated if he can have pottage. If somebody vows against pottage, he can't have grits. If somebody vows against pottage, there's debate if he can have garlic. If someone vows against garlic, he can have pottage. If somebody vows against lentils, it's debated if he can have honey-fried lentils. If somebody vowed against having honey-fried lentils, he can have regular lentils. If somebody vowed against tasting wheat grain or grains, he can't have them in flour or bread. If somebody vowed against tasting grit or grits, he can't eat them raw or cooked. Some say if somebody vowed against tasting grit or wheat grain, he can still chew them raw. The Gemara further qualifies these rulings, and that's the end of chapter 6. Chapter 7 of Tractate Nedarim continues discussing the laws of vows in regards to particular vows against types of food. The first Mishnah says, if somebody vows to abstain from eating grains, he's allowed to still eat gourds, but Rabbi Akiva says he can't. It's disputed based on if when people say they're purchasing greens, whether that includes gourds or not. If the person vowed against partaking in fresh Egyptian beans, he's still allowed to eat dried ones. The Gemara says the vow against greens, which potentially included gourds, is as the vow was against greens that are cooked in a pot. The argument, if that includes gourds, is based on whether they hold if a man sends an agent to get vegetables, if the agent consults with the sender, if this includes gourds, whether or not this implies that gourds are included in this category or not. Rabbi Akiva does concede that if he eats gourds in this situation, he wouldn't receive lashes. It cites related cases. It further discusses particular food terminologies which encompass other similar types of foods. New Mishnah, if somebody vows to abstain from piled grain, he also can't have dried Egyptian grain, which are piled in a similar manner. Others say he's only prohibited from the 5 species of grain. Others say one who vows to abstain from Tavua, which refers to the 5 grains, abstains only from the 5 grains. If somebody vows to abstain from the piled grain, he can't have anything that's similarly piled in a granary, but he can have fruit trees or grains. The Gemara argues that the term which refers to piled grain includes everything piled in a granary, and what the term tevua encompasses in regards to the 5 grains, which is a different term than tevua of the field. It brings relevant incidents. It also mentions the connotation of other similar terminology. New Mishnah, somebody vows to abstain from clothing. He can still wear sackcloth, a sheet, or a chamila, which is a type of coarse material. If somebody vowed against wearing wool, he can cover himself with wool shearings. If somebody vowed against wearing flax, he can still cover himself with stalks of flax. Other states dependent on the vower. For instance, if someone's carrying heavy stuff and he starts sweating and vows against wool and flax, he's allowed to wear them still. He's not allowed to carry such loads on his back. The Gemara lists many types of unique clothing included in a vow against wearing clothing. It discusses related points. New Mishnah. If somebody vows against entering a particular house, it's debated if he can still enter the upper story. If somebody vows against entering the upper story of a house, he's allowed to enter the lower story. The Gemara explains the source of these distinctions, which apply by particular laws of impurity, and as to what exactly is referenced by the term house in a house in regards to laws of sales. New Mishnah. Somebody who vows to abstain from using a bed can still use a dargash, which is something similar to a bed. Others disagree, saying it would be forbidden to use. Someone who vows against using a dargash can still use a bed. The Gemara debates as to what exactly a dargash is. Some say it's a bed of fortune, which was a bed that some had the custom to designate for a guardian angel. Others disagree, describing it as a bed frame with leather tied within, which is described. Typically, a bed is meant to be overturned by a mourner, and it's held that by the leather mat bed, the holding straps can just be untied to fulfill this obligation. New Mishnah. Somebody who vows against entering a city can enter the Tichun boundary, a concept from Tractate Eruvin, and he can enter its extension. Somebody who vows not to enter a house cannot enter from the doorframe inwards. The Gemara cites sources for these points. It debates whether by a vow against entering a house, you can still enter from the doorframe outward. New Mishnah. If somebody vows that fruits will be forbidden to him, or upon his mouth, or to his mouth, he can't benefit from things in exchange for them, or from things grown from them. If he vowed against fruits in regards to his eating, or in regards to his tasting, he can eat or taste things received in exchange for them, and things that grow from them. This applies to the produce's seeds decompose. If they don't, he can't benefit from things grown from them. Another point, if somebody vowed to his wife against the work of her hands, or vows them against his mouth, he's forbidden to benefit from things received in exchange for them, or that grow from them. If he vowed that her work should be forbidden to him eating or to him tasting, he's allowed to benefit from things received in exchange for them and things that grow from them. This applies if the seeds of the produce decompose. If they don't, things that grow from them is forbidden. If somebody vows against eating from things his wife makes until Passover, or vows against wearing what she makes until Passover, then if she makes something before Passover, he can eat or wear it after Passover. If he vows against eating or wearing things she makes until Passover, if the thing is made before Passover, he can't eat or wear it after Passover. If somebody vows against his wife benefiting from him until Passover, so long as she goes to her father's house before the holiday of Sukkot, if she went before Passover, she can't benefit from him until Passover. If she went after Passover, she's violated the vow. If he said to his wife, vowing against her benefiting from him, if she went to her father's house before Passover. If she went before Passover, she can't benefit from him until the holiday of Sukkot. She can, however, go to her father's house after Passover. The Gemara discusses similar points. These are further qualified. It discusses various points on laws of produce in the sabbatical year. It also goes through points on Truma tithes and similar. These are discussed further, and there are some additional points. And that's the end of chapter 7. Chapter 8 of Tractate Nedarim continues discussing the laws of vows. The first Mishnah says, if somebody vows against tasting wine today, he's forbidden to have wine until nightfall. If somebody vows against wine for this week, he's forbidden wine from then to the rest of the week, including Shabbos. If somebody vows against wine this month, he's forbidden wine during the rest of the month, excluding the next Rosh Chodesh. If somebody vows against wine this year, it includes the rest of the year, but not the next Rosh Chodesh. If somebody vows against wine during this 7-year cycle until the sabbatical year, he's forbidden it the rest of the years until and including the coming sabbatical year. If somebody vowed against wine for 1 day, 1 week, 1 month, 1 year, or 1 7-year cycle, he's forbidden wine from that day until the day of the completion of this period. If somebody vows against wine until Passover, he's forbidden wine until Passover starts. If somebody vows against wine until it is Passover, he's forbidden wine until Passover ends. If somebody vows against wine until before Passover, it's debated whether or not this includes Passover. The Gemara says an opinion that regarding the vow against wine today, which ends at nightfall, he still needs to get the vow annulled at nightfall. This is because there's variation if he said the vow was for 1 day as opposed to today. So, to be safe, the vow must be annulled at nightfall. Such a mistake could be made from today to 1 day, but not vice versa. This is further discussed. It specifies that a vow for a week includes Shabbos, as you might have thought it's just weekdays. A vow against the month excludes even a 2-day Rosh Chodesh, meaning even the last day of a leap month is not included. If somebody vows against something for a day, it's debated if this is akin to a vow for 2 day or for 1 day. It's further debated from several sources. Further debate the remaining points. New Mishnah, if somebody vows against wine until the time of the grain reaping, until the grain harvest, or until the olive harvest, you can't drink wine until the start of that harvest. As a general rule, if somebody vows against something until a set time arrives, you can't do that thing until the set time starts. If he vows against the thing until it is the set time is included in this prohibition. If the specified event does not have a set time, whichever he said, the prohibition is only until the event arrives. For instance, if somebody made a vow until the fig harvest or until it is the fig harvest, the vow lasts until the fig harvest starts, meaning when people start gathering fruits in baskets. If the vow is said until the fig harvest passes, the fig harvest ends when the harvesters start folding up their knives. The Gemara says it's in reference to baskets of figs specifically, not baskets of grapes, as they're picked by hand. Others say it includes grapes as they're picked by hand once their stem is dry. With the knives being put away, that's if most of the townspeople put away their knives. It discusses incidents of this harvest and mentions a story where the sage Rav Tarfon was eating figs after the harvest, and somebody saw him and decided to shove him into a sack and toss him into a river. So Rav Tarfon said who he was, and the man realized it was a great sage and ran off. Then, for the rest of his life, Rav Tarfon regretted this, as he had felt he had used the Torah for his personal benefit, which is a very wrong thing to do. It says the man tried to drown the sage, as there had been a person stealing his grapes, and he thought it was the sage. Rav Tarfon thought he should have just paid the guy money instead of using his title. It cites many more points on the impermissibility of using Torah to benefit yourself, and they are for the related points. New Mishnah: if somebody vowed against an item until the grain harvest, it's forbidden until most people start the wheat harvest, not the barley one, although it's really dependent on the regional dialect. If he made this vow on a mountain or a valley, it goes dependent on the harvest time of that mountain or valley. If somebody vowed against an item until the rains or until it is the rains, he's forbidden until the second rainfall. Others say it's until the time of the second rainfall, meaning even if the rain hasn't yet fallen. If he vowed against an item until the rain ceases, some say the item is forbidden until the month of Nisan ends, some say it's until Passover ends. The Gemara says, if somebody made a vow against something until the harvest while in Galilee, and then moves somewhere else, the timing is still dependent on Galilee. If somebody said specifically until the coming of the rain, everyone agrees that refers to the time of the rain. Others dispute this, although it's said that that was a true statement. However, people do dispute it if he said until the coming of the rains, plural. New Mishnah: if somebody vowed against tasting wine for the year, and it was announced to make the year a leap year, he's forbidden wine during the year and the extra month of the leap year. If somebody vowed against wine until the beginning of the Hebrew month of Adar, and it was a leap year which adds a second month of Adar, his vow lasts until the end of the first month. If his vow was until the end of Adar, it lasts until the end of the first Adar. The Gemara says this implies that this was said by the opinion that holds the word Adar refers to the first month. Others disagree and say that this was like the opinion that says typically by documents Adar refers to the second Adar, assuming you know it's a leap year. Our case refers to where he doesn't know the year was extended, so it refers to the first month. It brings sources. New Mishnah: if somebody vows that he won't taste wine until Passover, he can have wine on the first night of Passover if the guy intended to have his vow go until the time when everybody drinks wine. If someone vowed to not taste meat until the fast, his vow lasts until the night of the fast, as that's when people eat meat. If somebody vows against tasting garlic until Shabbos, he can't eat garlic until Friday night, as the intent was for it to be until people eat garlic. If somebody vows against benefiting from somebody, if they don't take from him for his son 1 core of wheat and 2 barrels of wine, the vower can annul his vow without a sage, as the intent was to give the food to honor his friend, so he can refuse this gift to honor it further. If somebody vows against having his friend benefit from him unless he gives his son 1 core of wheat and 2 barrels of wine, some say the vow prohibits the man from benefiting from him until he gives over the food. Others say the vower can annul it without a sage, saying he could just say it's as if he received the gift he demanded. If somebody was being pressured to marry a woman and he vowed against benefiting from her forever, or if somebody divorced his wife and vowed against her benefiting from him, these women can still benefit from him, as he clearly meant marital benefit. If somebody was pressured into eating a meal with somebody and he vowed against entering his house or drinking a drop of cold water, he can still enter his house and drink his cold water, as his vow was only against eating or drinking by his friend in large quantities. And that's the end of chapter 8. Chapter 9 of Tractate Nedarim continues discussing the laws of vows, now on the topic of the nullification of vows. The first Mishnah says, some say we find an opening to annul a vow for the sake of honoring the man's parents. Others disagree, but they concede the point. Some say you can find an opening to annul a vow based on the honor of God. Others disagree, as then there would be no more vows. It's also disputed if you can find an opening to release a vow based on a new development. For instance, if somebody vowed against benefiting from somebody and that person becomes a Torah scholar or married off his son, or similar, and then the vower said he wouldn't have made the vow if this had been the case before, or if somebody vows against entering a house and then it becomes a synagogue and he said he wouldn't have made the vow if that was the case beforehand. So in all those cases, it's disputed. The Gemara says,
When it says a vow that couldn't be annulled because of God's honor would end up preventing vows, that means that no more vows could be annulled properly. Others disagree and say it means vows will no longer be annulled before sages. It's debated and says this latter concern doesn't apply by annulling vows due to the honor of your parents, as if people are typically annulling vows before sages, they'll do it there too anyways. It also cites the sources for the logics behind the dispute as to whether you can annul a vow based on new data. These are further discussed, and there are additional points on this new Mishnah. Some say, in regards to new developments, there are some occurrences which don't constitute as a new occurrence, and others disagree. For instance, if a man vows against marrying a woman as her father is wicked, and the father either dies or repents, or if he vows against entering a house as there is an evil dog within or a snake, and he's told the dog or snake died, these are like new developments, but also not, so it's disputed if this nullifies the vow. The Gemara says the father dying is actually a new development, so either the cases where the vow is dependent on the father's death, so it's just automatically annulled without there needing to be any new developments. Others say that he was told that the father died before the oath was made. Others dispute this new Mishnah. We also find an opening to annul vows based on the Torah, so we ask, would he have vowed if he knew the verses about not taking revenge, bearing a grudge, loving your fellow as yourself, etc.? And the man says he wouldn't have made the vow if he knew this. In that case, the vow can be annulled. The Gemara discusses related points on charity. New Mishnah, we find an opening to annul a vow based on the obligation to pay a marriage contract. It gives an instance if a man vowed against benefiting from his wife, so he had to divorce her and realized he didn't have enough to pay the marriage contract, so he was asked if he would have made the vow if he had realized this, and the man said no. The vow can be annulled. The Gemara clarifies that this was dealing with land, not with movable items. It also says from this case that we do actually make an assessment to a debtor to leave him enough for his own basic requirements. It's just that the woman holds onto her Kesubos until the husband gets more funds. New Mishnah, we find an opening to annul a vow based on Shabbos and holidays. Some said this would nullify the vows only on the Shabbos and holidays, but not on the rest of the year. But it was later instituted that if part of a vow is annulled, the whole vow is annulled. For instance, if somebody vowed not to benefit from a group of people and the vow is nullified with one of the individuals, it's nullified with all of them. A similar rule, if somebody vowed not to benefit from several people, one after the other, if the vow on the first person becomes nullified, all of them do. If the last one becomes nullified, just that one does. If the middle one becomes nullified, all the vows after him are nullified, but not the ones before. However, if he was specific with each individual, saying, I will not benefit from you, like an offering, and then to another, I will not benefit from you, like an offering, he must have both of these vows annulled separately. Another example, if somebody vowed against having wine for health reasons, and was then told that aged wine is good for you, he can now have aged wine, and therefore the whole vow against wine is annulled. It gives further instances of this concept. The Gemara says the source for this opinion, and also for that aged wine and the other examples it brought that have health benefits. New Mishnah, an opening to annul a vow can be made for the sake of the man's own honor or for the honor of his children. It gives an instance if somebody made a vow and had to divorce his wife and it ended up causing a bad name for him or for his children, the vow can be annulled. A vow can also be nullified, for instance, if somebody vows to not marry somebody for a specific reason, like that they look a certain way, and it turns out that it's just not true. The vow is annulled as it was mistaken from the outset. It gives an instance of somebody who vowed against marrying a woman, but then they spent some time making the woman prettier, and the man was then willing to marry her, and so the vow was annulled. It also said some verses that the daughters of Israel are beautiful, but poverty has taken this away. The Gemara gives further instances of similar cases. It says many related points on such issues occurring in regards to vows and their later modification and similar. And that's the end of chapter 9. Chapter 10 of Tractate Nedarim continues discussing the laws of vows and their nullification. First, the Mishnah says, by a betrothed young woman, her father and husband together nullify her vows. If only one of them nullified the vow, it's not sufficient, and obviously goes into effect if one of them certified the vow. The Gemara clarifies these points, saying, both are required to nullify the vow, and if one nullified it and another certified it, and then the one who certified it removes his certification, it's insufficient, and he also needs to properly nullify it. It cites sources for the further points. These sources and the related verses are further discussed. Others dispute the source and cite another one. Another question, if just one of the two, the husband, nullifies the vow but not the father, does this make no change to the vow or does it weaken it? This has practical ramifications in regards to the punishment for its violation. It cites related lengthy sources to prove this point. It comes out from this that it's a dispute between Beis Shammai, who says he just cuts his half of the vow out, and Beis Hillel, who says it weakens the entire vow. If other asks, if you're able to dissolve the certification of your wife's vow so you can nullify it, and also can you remove the nullification in such a vow so that you can certify it? Some rule that a certification can be dissolved, but not a nullification. Another point, if somebody certified a vow twice and then had the first certification nullified, similar to an oath, the second certification still stands.
It also asks, what if somebody certified a vow and then nullified it, and said the certification will only take effect if the nullification takes effect. Based on a similar point by animal offering pledges, it says that you can both certify and nullify a vow and have the second part, the nullification, take effect. It does, however, say that you cannot certify and nullify a vow at the same time, as they can't typically be done sequentially anyways. It's similar debate the validity of saying your vow is certified for you today. It's further discussed. New Mishnah, if the father of a betrothed young woman dies, his authority does not transfer to the husband. If the husband dies, his authority does transfer to the father, so here the father has more power. The husband has more power, as in the woman's adulthood once they fully marry then. The father has no authority, the heir, while the husband fully gets to nullify the vows. The Gemara cites verses as sources for these points. The verses are discussed, and it also says the case where the husband has full jurisdiction over the vow nullification is where the betrothal also happened when she was an adult. This would make it somewhat redundant to a different source, though, so some posit this is actually the source of the law. Some say it's just repeating the latter clause as it cited the first clause. In Mishnah, if somebody took a vow when betrothed and was immediately divorced the same day and then re-betrothed to somebody else, and this could happen repeatedly, her father and her last husband nullify the vows. Generally, any young woman who hasn't yet entered her own legal jurisdiction can have her vows nullified by her father and her last betrothed husband. The Gemara cites verses as a source for these points. These opinions are discussed. It asks, is a husband's divorce considered like nothing or like the certification of a vow? There's a practical difference if a man divorced his wife and then remarried her as to whether he can now nullify the vow. It debates this point from several different sources, but it remains unresolved. New Mishnah. It was generally a practice to make sure a woman had no standing vows when she went into marriage. So when a woman was about to be married, the father would nullify any and all of her vows, and the husband would do the same during the betrothal. This is necessary to do then, as once they marry, he can't nullify her vows she had made prior to the marriage. The Gemara debates based off this whether a husband can nullify vows of his wife that he's never heard. It's debated from a number of related cases. It's left unresolved. It also asks if a deaf person can nullify his wife's vows. It brings a source which shows that he cannot. It also asks if a husband can nullify the vows of two of his wives simultaneously. Based on a verse in regards to the Sotah offering, it implies that it's not allowed. New Mishnah, the typical maximum time from betrothal to marriage was 12 months, and for a widow marrying, it was 30 days. Some say if this time passes, as the husband is now obligated to support the betrothed woman with sustenance, he would also be able to nullify her oaths. Others disagree. The Gemara cites a similar case regarding the Levirate marriage. They try to figure out what we hold, like it's debated. New Mishnah. A woman pending a Levirate marriage, the brother-in-law, even if there are multiple, can nullify her vows during this period. Some say this is only if there's one pending Yevam brother. Others say it's not allowed at all, as either there are multiple people doing Yevam, so nobody has sole authority, or one person does, but they're just not married yet, so he just has no jurisdiction. The Gemara explains the logic of the last opinion, that they actually either hold that there is no Zika bond, there's no actual legal connection between a widow and her brother-in-law by Yevam. The others would either disagree or say that there was a Levirate betrothal, which does affect a Levirate bond. The legitimacy of these points are further debated. This is further discussed. New Mishnah. If a husband says to his wife, until I arrive, any vow you make is certified, this is invalid. It's debated if he can do this by nullification. Some say yes, as he can nullify vows that have taken effect, he can nullify these. Others say no, as based on a verse, it implies a person can only nullify a vow if he's able to certify that vow. The Gemara says, according to the opinion that you can establish a blanket period of vow nullification for a wife, do these vows take effect for one instant and then immediately get nullified, or do they just not take effect at all? This has practical relevance if somebody hearing the vow said he wants to partake in the vow, meaning if it was valid for just one moment, his vow would take effect, but if it never took effect, neither would the other guys. It debates this question from several sources. It questions it even further, and it derives from a point on ritual impurity laws that he would seemingly hold that the vow doesn't even take effect at all. The opposing opinion would still disagree, again, based on their verse. New Mishnah. The nullification of a vow can be done all day that the vow was taken. This could result in a leniency. For instance, if somebody took a vow Friday night, they'd be able to have it annulled all the way up to Shabbos night, and it can also create a stringency. If somebody took a vow right before nightfall, they have until nightfall to annul the vow. The Gemara says some say the vow can be annulled for the rest of the day. Others hold it can be annulled within a 24-hour period after it's said. They cite verses and debate them. It also cites a later source which allows nullifying vows on Shabbos, but it asks, can you nullify vows related to Shabbos on Shabbos, or even all vows? It's said that according to the opinion that vow nullification can be for the rest of the day on Shabbos, you can nullify any vow as that would be your only opportunity to do so. According to the opinion that it's within 24 hours after, you can only nullify Shabbos-related vows, as other vows can just be nullified after Shabbos. In regards to asking an authority to dissolve your vow on Shabbos, it's questioned if this is permissible if you had time to do it before Shabbos started. Some say yes, some say only with a single expert, not with a panel of 3, which resembles a court, which isn't allowed to convene on Shabbos. Others disagree, saying 3 men annulling the vow does not resemble a court, so it would be allowed on Shabbos. It's also said that you can request a vow nullification even at nightfall. It's discussed as to who agrees with this. Some even say that a vow can be requested to be nullified when the judge is standing or alone at night on Shabbos by his relatives, and even when it was possible for the vow to have been nullified before Shabbos. The sage Rabbi Gamliel would not stand when nullifying vows, but that's because he held differently than this opinion that the nullification of a vow requires that it be from a level of regret, so he had to sit to examine the case. In fact, further based on the verse, taking vows is generally considered such an improper thing to do. It's considered to be like a sin, even if you end up fulfilling it. If somebody tries to annul a vow with some vague wording, like, I do not want you to vow, or this is not a vow, that's not valid to nullify a vow. If somebody instead said, you have done well, or I would have taken that vow myself, or something similar, that's a valid certification for the vow. By nullifying a wife's vow on Shabbos, it says you shouldn't just verbally nullify it, you should actually have the person violate the vow and then mentally nullify it. Some say it also works to mentally nullify a vow the rest of the week. A husband cannot nullify his wife's vow with the terminology of a course nullification, and the same applies vice versa. It cites verses and for the discussion of these points. It's also said that if a husband refuses to nullify his wife's vow to annoy her, he's still allowed to nullify it days later. It's further discussed, and it says that silence by mistake is considered like silence to annoy by these laws. And that's the end of chapter 10. Chapter 11, the final chapter of Tractate Nedarim, finishes some final laws on vows and their nullification. The first mission says the vows that a husband or father can nullify are vows of affliction, for instance a vow against bathing or against adorning yourself. Others say that doesn't constitute a vow of affliction. A vow of affliction would be a vow against all the produce in the world, and would not include a vow against produce from a single country or shopkeeper, for instance. However, if the shopkeeper is the only person she can get the produce from, that is a vow he can nullify. The Gemara says a husband can also nullify vows that affect his relationship with his wife, along with vows of affliction. The difference is that nullifying vows of affliction is permanent, while nullifying vows involving the relationship, the nullification only lasts as long as the marriage does. However, a different source seems to say that even vows of the relationship, if nullified, they're nullified permanently, so it says actually yes, that is the case. However, the vows in the relationship can be permanently nullified to the current husband, but not to her future husbands, unlike vows of affliction, which can be permanently nullified for everybody. It explains the debate on vows against bathing. The opinions that say this is a vow of affliction say she's vowed against the benefit of bathing, which means she can't bathe, and also will now cause physical issues since she can't. The opinion that says this is not a vow of affliction says that this is a reference to not bathing for one day, and there's no concern of physical issues for not bathing for one day. Some say it's that this opinion would say that she made a vow and an oath combined to not bathe, and explains that this could work with the wording, as sometimes an oath is referred to as a vow. A different source, that the latter opinion, that not bathing for a period isn't a serious affliction, would actually say that not doing laundry is a severe affliction, and cite sources. There's further discussion on these points. It also debates, according to this latter opinion, that those vows aren't vows of affliction. However, they could be a vow affecting the relationship between husband and wife, which can be nullified. It's debated if this is the case. It further discusses particular vows that constitute ones which would affect the relationship between husband and wife. These are discussed further. There are additional specific cases brought. It says if a woman vows against eating 2 loaves, one of which, if not eaten, will cause her to deprive herself, and the other one will not, there's debate if the husband can nullify just the vow against the first loaf, or even both of them. It also discusses the nullification of vows on her taking a Nazarite vow. This is further discussed. New Mishnah: if a woman vowed against benefiting from the property of other people, her husband can't nullify this vow, although if she's poor, she can still benefit from the field charity obligations. If a person vowed against letting Levium or Kohanim benefiting from him, they can still take the tithes from him against his will. If he vowed against specific Kohanim or Levium from benefiting from him, he can still give it to others. The Gemara debates in the first vow if the husband is included in her vow against benefiting from people, from several opinions. This is further discussed, and it also is debated if such a poor woman, in addition to the field charities, can benefit from the poor man's tithe, which is Meiser Ani. It's debated along with the remaining points. It's also questioned as to how the Kohanim and Levium can eat the tithes that they took from somebody that vowed against giving the tithes to them. Some say that the tithes are considered ownerless to everybody, as he can't use them, so therefore the Kohanim could just now take them. New Mishnah: if a woman vows against producing things for her father, brother, or brother-in-law, the husband can't nullify them, as they don't affect the relationship.
If the wife vows against producing things for her husband, this is automatically void, as she is obligated to help her husband, although some say he should still nullify the vow in case she helps him more than her required minimum, which would be in violation of this vow. Others say he should nullify the vow, as if they divorce, the vow will take effect, and they won't be able to remarry. The Gemara says some hold like this last opinion, and it debates based off this if you can vow against an entity that doesn't yet exist based on comparison to similar cases. It's debated further. Some say the issue is with such vows against prohibition. They have a stricter status and cannot be permitted, and this prohibits the husband from taking the produce as is. There's also the issue of them divorcing and being unable to marry. New Mishnah. If the husband mixed up the vow nullification, meaning if the wife took it and he thought his daughter took it, or vice versa, or she took a Nazarite vow and he thought she took a vow to bring an offering, or vice versa, or she took a vow against grapes and he thought it was against figs, or vice versa, he needs to redo the vow nullification. The Gemara discusses sources of these points. It additionally states, as a general rule for the retraction of speech, a person can legally retract a statement if he does so within the period of time it would take to speak a short phrase. This applies basically by all laws. The only exceptions that you can't retract the statements, even if immediately after, are if somebody blasphemes, or if they worship idols, or betroths, or divorces a wife. New Mishnah. If a woman vows against figs and grapes, if the husband certifies the part on figs, both are certified. If he nullifies the part on figs, it only is nullified if he also nullifies grapes. If the woman vowed against tasting grapes and against tasting figs, that's considered to be two separate vows. The Gemara cites sources. These are discussed further. New Mishnah. Somebody didn't nullify his wife's vows on the day she took it, and later found out that he was allowed to nullify her vows. He can nullify it on the day that he found out he was allowed to. If he knew that, but he didn't realize she had taken the vow, it's debated if he can nullify it. The Gemara cites some related disputes on lacking information in regards to certain prohibitions. New Mishnah. If somebody vows against benefiting from his son-in-law, he's allowed to give his daughter money as a gift, as long as her husband has no rights to it, and it includes whatever she picks up and puts in her mouth. The Gemara debates by these laws if the hand of a woman is legally considered to be the same as the hand of her husband from several sources, including by the laws of an Erev. No Mishnah. If a widowed or divorced woman takes a vow, such as a Nazarite vow, if she remarries right after, even within 30 days, her new husband cannot annul the vow. If a married woman took a Nazarite vow to last for 30 days, and her husband nullifies it and then dies or divorces her, the vow is still nullified after. If she took the vow, divorced on the same day, and then immediately remarried, he cannot nullify the vow. Generally, if she was under her own jurisdiction with the vow for any period of time, he can no longer nullify it. The Gemara cites sources and discusses these points. New Mishnah. There are 9 possible young women whose vows cannot be nullified. If she's an orphan grown woman, if an orphan took the vow as a young woman and then became an adult, if she's an orphan who took a vow as a young woman and still is a young woman, if she took her vow as an adult and her father died, if she took the vow as a young woman, became an adult, and then her father died, if she took the vow as a young woman and her father died, if she took the vow as a young woman, her father died, and then she became an adult, if she took the vow as an adult and her father is alive, and if she took the vow as a young woman, became an adult, and her father is still alive. Some say, in the event that a father betrothed his minor daughter to somebody to be married later, and she's widowed or divorced during that period, returning to the father, he can no longer annul her vows. The Gemara discusses the author of this. New Mishnah. If a woman vowed against having benefit from her father or father-in-law, if she prepares anything for her husband, or vowed against benefiting from her husband, if she prepares anything for her father or father-in-law, the husband can nullify this vow. The Gemara discusses additional such vows that the husband can nullify for his wife. There are some particular instances brought in. They're discussed further. New Mishnah. Originally, it was instituted that 3 types of women would automatically be divorced and collect their marriage contracts. The wife of a Kohen who says she is impure to him, meaning that she was violated by somebody else, a woman who claims her husband is impotent, or a woman who vows against having intimacy with any other Jewish person. It was later changed to make it so that if a woman wanted to remarry, they couldn't just do one of these things. So the first case requires proof, the second must request her divorce, and the third just has her vow annulled in that she can still be with him, but no other Jewish person besides for him. The Gemara debates, if a woman who is married to a Kohen who claims she was violated, whether or not she's still allowed to eat teruma. There's an issue of it casting doubt on the legitimacy of her children, so some say it's only forbidden if she becomes widowed. It also debates if she was violated, whether she received her marriage contract, as she can no longer be with her Kohen husband, but she could legally remain with him if he was anyone but a Kohen. It cites similar discussions and says she does receive her marriage contract. It also debates if a woman claims to her husband that he had divorced her, whether there's legitimacy to this claim. It's largely based on if we think a person would be brazen enough to claim such a thing lying. It tries to bring a proof from the case of our Mishnah, where a woman claims of her husband's physical impotence, but that's not a valid proof, as a husband
could be unaware of that. Well, he would definitely be aware if he had divorced her, so he would actually believe a woman who claims she was divorced. It says a particular incident, a woman who acted as if she had just cohabited, but her husband told her that they hadn't, so she said it might have accidentally been with a non-Jewish merchant there, so it was brought to court, and it was ruled that they could stay married, as she could have been lying to try and get divorced to marry somebody else. It says some similar cases. There was also a case where an adulterer went into a woman's house and the husband walked in, so the adulterer hid and saw a snake bite into a vegetable, and then the husband went to eat the vegetable, so the adulterer jumped out and stopped the husband from eating it, saving his life. It was brought to court and ruled that the adulterer hadn't actually cohabited with the woman, as then he would have just let the husband die. This is based off the verse, for they have committed adultery and blood is on their hands. This is brought to remove the presumption that they could have actually been adulterous, and the adulterer saved the husband's life anyways. And that's the end of chapter 11 and the entire Tractate Nedarim. Alright, that was a lot of information, so here's a rough summary of a lot of the practical takeaways of the Tractate. Vows can be taken, for whatever reason, to do or not do something, and must be followed. It's a severe prohibition to violate a vow, a neder, and it's a complex process to have it annulled, so as a general rule, it's simply said to be preferable to never take a vow.
Tractate Nazir discusses the laws of the Nazarite vow. It's a bit of an extension of the prior tractate, the one dealing with the general laws of vows, and now discussing the Nazarite vow, a specific type of vow, which essentially vows against the consumption of wine, grapes, or any other derivatives, against cutting hair, and against becoming ritually impure from a corpse. This vow can be taken for different period lengths, different terms, or for multiple terms, or as a permanent Nazir, and similar. It also discusses the wording of the vow to take upon yourself these prohibitions, and the ceremony that concludes somebody's Nazarite period. The first chapter begins by discussing the terminology to take upon yourself a Nazarite vow. The first Mishnah says, when taking this Nazarite vow, all equivalent terms for a Nazir can be used effectively in this vow. If somebody says, I shall be, without specifying anything after, that's a valid Nazarite oath. If somebody says, I shall be handsome, clearly referencing growing out his hair to be a Nazir, that's a valid Nazarite vow. Anyways, some equivalent terminologies for the term Nazir you can use instead. Someone could validly vow to be a nazik, a naziach, a paziach. He could vow to be like this, to be misalsil, to be mechalkel, to grow tresses, and if he vows to do the bird obligation, it's debated if this is valid. The Gemara asks a bit of a broad question, which is that the Gemara is sorted by topic. The third topic, Tractate Yevamos until Tractate Kiddushin, and those in between encompasses the order of Nashim, women, essentially dealing with the laws of marriage and similar. The question is asked, why is Tractate Nazir in the middle of the section? So it's explained that it's because there's also a discussion on the laws of marriage, particularly in the following tractate, of the laws of the Sotah, an adulterous woman, and it's explained that people only do adultery when intoxicated. So it's said that people who see an adulterous woman during the temple ceremony should take upon themselves a Nazarite vow against wine, as they just saw the negative effects that intoxication can have on a person. So that's the context of the discussion being placed right over here. Another point, it has a similar discussion to the beginning of Tractate Nedarim, which is that the preface of the Mishnah was that it would be discussing equivalent terms of the vow, and then it mentioned partial declarations, and then after equivalent terms. Some say that you should just slot in a preface about partial declarations, and then it fully discusses those first, as they were most recently mentioned, which is something the Mishnah occasionally does, and it gives a number of examples. There are instances of the opposite occurring, but it says it really just could do either way. Others say it brings the basic formula first in the preface, and then it discusses the partial declarations first, as they're a scriptural exposition and not obvious, so they're stated before everything else. Anyways, one of the partial declarations was I shall be, which was said to be a valid Nazarite vow. According to some, this is explained to refer specifically to the fact that it works if there's an actual Nazir in front of him, as he's probably not referring to anything else, versus if he just said the phrase without any context, where it could refer to other types of vows also. It also teaches that this oral declaration is sufficient in this case. Additionally, the phrase I shall be handsome is said to be referring to where he's also touching his hair as he says this, so it's not in reference to anything else. It also asks how a Nazir can be referred to as handsome, as some refer to a Nazir as a sinner for taking such an oath, but that's explained to only be if they became impure and violate their Nazarite vow. When we said it's valid for him to say, I am hereby like this, again, this refers to where there's a Nazir in front of him. The terms misalsel and mechalkel are in reference to hair, and the source for the definitions are explained, and the cases, again, are where he's touching his hair as he makes the vow. It also explains the source for the definition of the word for tresses. The debate as to whether the vow with the obligation of the birds is based on if we think a person would vow by reference to something related to the thing he intends to vow to, in this case the Nazarite offering, which there's a reference towards hair and birds together in a verse from scripture. Others explain that it's whether he's vowing to bring the bird offering of an impure Nazir, and it's where a pure Nazir passed before him as he made this vow. There's a practical difference between these two opinions. If he said, an obligation of birds which are mentioned in relation to hair is upon me, according to the latter opinion, he'd still require an actual Nazir to pass in front of him while he says this for it to be valid. It further debates from several sources as to whether a vow using a word that relates to a different concept in scripture that he has in mind, if that has validity as a vow. New Mishnah. If somebody says, I am hereby a Nazir from grape seeds, or from grape skins, or from hair cutting, or from impurity, he is a full Nazir encompassing all of the prohibitions. The Gemara says, some actually disagree, saying he needs to vow against every one of the prohibitions for it to be a valid Nazarite vow, and it's debated based on verses. This is for the discussed. New Mishnah. If somebody vows to be like Samson, or like the son of Manoah, or like the husband of Delilah, or like him who tore out the gates of Gaza, or like him who the Philistines gouged his eyes out, he's a Samsonian Nazir, which is a special lifelong type of Nazarite vow. The Gemara says the point on mentioning all of these different ways of saying Samson is that in addition to vowing to be like Samson, the son of Manoah, that could in theory be in reference to somebody else, so you would need to say another of the identifying markers. New Mishnah. The difference between a permanent Nazir and a Samsonian Nazir is that a permanent Nazir can still lightly trim his hair if it grows too heavy, and he brings 3 animals as offerings when he does. If he becomes impure, he brings the same offering as a standard Nazir. A Samsonian Nazir can never even trim his hair, and if he becomes impure, he does not bring an offering. The Gemara says it should slot in an introductory preface as to the vow of a permanent Nazir. It also says that it's like the opinion that a Samsonian Nazir can become impure. It just says if he becomes impure here, as that's the context of the wording. It further disputes the source between opinions as to whether a Samsonian Nazir can become impure from several sources, including verses about Samson's killing of all the Philistines, as to whether he did so in a manner that he didn't contract ritual impurity or not. It says it's a tradition that he became impure, meaning it was permitted. It also says sources that a permanent Nazir is allowed to trim his hair, as it says Avshalom, King David's son, was a permanent Nazir and he trimmed his hair, based on verses. It debates how often he cut his hair, which is based on different discussions. New Mishnah. The standard Nazarite period is 30 days. The Gemara cites sources for this from verses. Some count based on the verse that the Nazarite period is actually 29 days, and they'd say it says 30 here as he brings his offering and cuts his hair on the 30th day. This is further debated. The opinion is questioned based on further sources, and it's additionally discussed. New Mishnah. If somebody vows to be a Nazir for a large term, for a small term, or from now until the end of the world, his Nazarite period is for 30 days. The Gemara debates how this last term could only refer to 30 days. Some say it means he's saying it's for the 30-day period, but it's as long to him as if it were until the end of the world. It debates this point from a similar case where somebody vowed to be a Nazir until he reaches a location where it's a 30-day minimum and longer. It goes according to the distance of travel, it being the length of a single Nazarite vow, and not in reference to several consecutive 30-day terms. This is further discussed. Some simply say that the vow of the Mishnah was for one term, from here until the end of the world, hence it being only for 30 days. New Mishnah. If somebody says, I am a Nazir and 1 day, or a Nazir and 1 hour, or a Nazir 1.5, he is a Nazir for 2 terms. The Gemara explains that it needs all of these instances to show that in each of these cases the ruling is the same. New Mishnah. If somebody vows to be a Nazir for 30 days and an hour, he's a Nazir for 31 days, as there's no extension of a Nazarite vow by hours. The Gemara says, but if he said he's a Nazir for 30 days and 1 day, he would be a Nazir for 2 terms. It cites sources for this concept. If somebody says he's a Nazir as much as the hair on his head, or as the dust on the earth, or the sand by the sea, he's a permanent Nazir, and he cuts his hair once every 30 days. Others say a perpetual Nazir doesn't do that, it's only somebody who makes those types of vows. If somebody says he's a Nazir, a houseful, or a boxful, we ask his intent. If he said he meant one large Nazir period, he gets a 30-day period. If he said it was an unspecified amount, we treat the boxful he mentioned as if it was full of little seeds, and he's now a Nazir for the rest of his life. If somebody says he's a Nazir from here until a specific location, we calculate how long it would take to travel, and he's a Nazir for that number of days with a 30-day minimum. If somebody vows to be a Nazir as much as the number of days in the solar year, he has a Nazir term for each day of the solar year, so about 30 years. Somebody once did this, and they died. The Gemara says, in regards to viewing the voxel as if it's filled with small things, that's one side of an argument. Others say we treat it more leniently, which is discussed. Therefore, the point I mentioned some rule differently if the word number is mentioned in the vow, along with a few miscellaneous points. It says if somebody says he's a permanent Nazir or similar, he's a permanent Nazir. But if he limits it, even saying he's a Nazir for 1,000 years, he's just a regular Nazir for that period. If somebody says he's a Nazir and 1, that's 2 Nazir periods. If he adds and more, that's 3. And if he adds and again, that's 4. Although it doesn't double with that one. It mentions some other terminologies you can add to lengthen your Nazarite period. And that's the end of chapter 1. Chapter 2 of Tractate Nazir continues discussing the laws of the Nazarite vow. The first Mishnah says, if somebody says he's a Nazir from dried figs or from pressed figs, Beis Shammai says he is a Nazir, Beis Hillel says he's not. Some say Beis Shammai says it's not actually a valid Nazarite vow, it's just a valid vow against eating figs. The Gemara explains the logic that Beis Shammai says the first part of the vow to be a Nazir is valid and accepted, and the ending part, from dried figs, is viewed like he's trying to rescind the vow, which is not legally permitted. Beis Hillel would disagree, saying it would be allowed. There are further variations of this argument which are discussed. There's additional conversation on other various types of vows. According to others, this vow, Beis Shammai and Beis Hillel would both agree, it's not a valid Nazarite vow, and the dispute is whether it's valid for disallowing the figs. There are further points. In Mishnah, if somebody says, this cow said, I am hereby a Nazir if I stand, or this door says, I am hereby a Nazir if I open it, Beis Shammai says he is a Nazir, Beis Hillel says he is not. Some clarify Beis Shammai to only mean that the cow or door become prohibited to him, not that he's a Nazir. Gemara asks, what does it mean that the cow or door said? Cows and doors cannot talk. So it's explained that what's happening is that there's a cow in front of this guy, and the man, thinking the cow cannot stand, says he's taking this vow if it stands up, and then the cow gets up. The opinions follow the same as prior Mishnah, so this is pretty redundant, especially with the door case. Rather, some say it means that he's vowing against benefit from the cow if it does not stand, and it stands. Beis Shammai would say he means if he helps the cow up with his hands, which he didn't, so he's a Nazir. Beis Hillel would say it got up, so he's not a Nazir. New Mishnah. If a man was poured a cup of wine and he said he's a Nazir from it, he's a Nazir. There was a case where a woman was drunk and said she was a Nazir from wine, but that was said to mean she was just forbidding that wine from herself. The Gemara explains the logic of the instance is as she's drunk and is making an extreme statement so as to not be given any more wine. New Mishnah, somebody vows to become a Nazir on condition that he can still drink wine or still become impure from the dead. He's a full Nazir and he cannot drink wine or touch the dead. If somebody becomes a Nazir and then says he didn't realize a Nazir couldn't drink wine, it's debated if he can still have wine. If somebody becomes a Nazir and says he knew a Nazir couldn't drink wine, but he thought he'd be given an exception as he really needs wine, it's still an argument, although the opinions are reversed. The Gemara explains the logic of these opinions, and it says possibly reverse the answers of the final opinions in the final case, so they're consistent. Others say don't. The difference between the cases is where somebody vowed to become a part Nazir or a full Nazir. Some say the first is invalid, and there's debate if a full Nazir can become a part Nazir, which is the second case. Alternatively, the last case is regarded as an unavoidable vow, which was described in Tractate Nedarim, and the differing opinions here hold like the differing opinions as to whether you need to go before a sage to get such a vow nullified. New Mishnah. If a man vows to become a Nazir and also to provide for a Nazir the offerings he brings when he completes the Nazarite period, and his friend said he'll take the same vow, it would be a good idea for them to provide each other with the completion offerings. Otherwise, they'll need to bring the offerings for themselves and also for some other Nazir. The Gemara says, based on this, if the other only says the words "and I" after hearing the vow, he only takes part of the vow on, specifically the first part. It discusses proofs for this point. It's debated further from other sources, and there's additional discussion. New Mishnah. If somebody vows to bring the completion ceremony of half a Nazir, and another says he'd do the same, there's debate if they both bring a full sacrifice or only half of one. The Gemara says it's agreed that if somebody says he'd bring half the sacrifice for the completion ceremony, he brings half the sacrifices. And if he says he'd bring the sacrifices for half a Nazir, he brings all of the sacrifices, as there's no such thing as half a Nazir. The debate in the case where he said he'd bring half for the completion ceremony of half a Nazir, as the first part of the vow obligates him, and they argue over if the second part works to nullify the vow. New Mishnah. If somebody said he's a Nazir when he has a son, and he has a son, he is a Nazir. If he had a daughter, a child of indeterminate gender, a tumtum, or a child with both male and female genitals, an androgynous, he is not a Nazir. If he said he'd be a Nazir if he had a child, then he is a Nazir in all these cases. If the child passes right after birth, he is not a Nazir. Some say he's a doubtful Nazir, so he should say, if that was a viable child, I am a Nazir, and if it wasn't, I am a Nazir voluntarily. If his wife then gives birth again to a viable child, he would be a Nazir. Again, the other opinion would disagree, saying he's a doubtful Nazir, and he should say, if the first child was viable, I'm a Nazir, and from this new child, I'm being a voluntary Nazir. And if the first child was not viable, the first Nazir period was voluntary, and this one is mandatory. The Gemara explains that when he says, if I have a son, that refers to a son, not if I will be built up, where the words are similar. Regarding the vow, if he has a child, it gives the list of possible children to teach. Those are all considered to be having a child. There are further particular questions which remain unresolved. New Mishnah. If somebody vows to become a Nazir, and then again, if he has a son, and he has a son during his Nazir term, he finishes his first term and then does another for his son. If he says he'll become a Nazir if he has a son, and also that he is a Nazir, he's a Nazir, and if he has a son, he does the term for his son and then resumes his original term, finishing it off afterwards. The Gemara asks, if somebody says he's a Nazir to take effect after 20 days, and he's a Nazir for 100 days, what's the law? When does his Nazir term start? It explains that it asks with 100 days and not a small amount like 30 days, as presumably he'd start his vow, and at the 20-day mark, he'd switch to the other one, and after, he'd complete the initial vow term. If it was for only 30 days, he'd be doing only 10 days after, which wouldn't be sufficient for him to take upon himself in that manner. There are several other questions posed. What if he said he's a Nazir to take effect after 20 days, and from now, he's a permanent Nazir? It asks, what if the after a 20-day period was a vow to be a Samsonian Nazir, which can't be removed, and also vowed from now to have a standard Nazir period. It even asks, what if someone vows to be like Moshe on the 7th of Adar, that's the date of his passing and birth, so does it refer to taking a Nazarite vow or something else? We do say that if somebody says he's a Nazir to take effect after 20 days, and from now, 100 days, he's a Nazir for 20 days, then a 30-day period, and then he finishes the first term with an 80-day period. In regards to the case where the father interrupts his own term to do the term for his son, and he becomes impure during it, it's debated if this forfeits both the current term and the completion of the next one, or just the current term, based on if you hold it's a consecutive Nazir term or separate ones. There's a similar debate as if a Nazir becomes a leper, contracting tzara'as impurity, he suspends his Nazarite service until after. So it debates if he becomes impure during this period, if he also discontinues his Nazarite period after, and this is different than the prior discussion, as the Nazir period and the tzara'as impurity are distinct. There is an additional point that if a Nazir's hair is cut within the last 30 days of his term, he must extend his term until he has 30 days worth of hair growth. It similarly debates if during this period he becomes impure, whether this causes the man to forfeit his Nazirite period. Similarly, if he became impure during the concluding ceremony of his Nazirite period, some say he's no longer allowed to do the hair cutting ceremony. Some rule if he violated the Nazir prohibitions after completing his obligatory Nazirite term, but before doing the completion ceremony, he'd get lashes for becoming impure, but not for shaving his head or drinking wine. It's debated based on verses. This opinion is refuted from a source which says he gets lashes for violating any of those before his concluding ceremony. New Mishnah. If somebody vows to be a Nazir when he has a son, and that he is a Nazir for 100 days, he's a Nazir, and if his son is born within the first 70 days of his term, he can do both terms at the same time. After 70 days, he stops his current term, does the term for his son, and then completes his first term, as a Nazarite term can't be less than 30 days. The Gemara says, some say the 70th day can count as both the father's term and the first day of the son's term. The sources for this are disputed, and as for the debate on this opinion, it gives some similar related date calculations by other laws of impurity, and that's the end of chapter 2. Chapter 3 of Tractate Nazir goes through further laws on the Nazarite vow. The first Mishnah says, if somebody vows to be a Nazir, he cuts his hair on the 31st day after, but it's still valid if he cuts his hair on the 30th day. If somebody says he's a Nazir for 30 days, it's not valid to cut his hair on the 30th day. If somebody vowed for 2 consecutive Nazarite terms, he cuts his hair on the 31st and 61st day. If he cuts his hair on day 30, he must cut his hair again on day 60. If he cuts his hair on day 59, that's valid, as the 30th day of the first term can also count as a part of the second term. If somebody vowed to be a Nazir and becomes impure on the 30th day, some say the whole term is forfeit, some say he forfeits only 7 days. If somebody says he's a Nazir for 30 days and becomes impure on the 30th day, it's agreed that his whole term is forfeit. If somebody vowed to become a Nazir for 100 days and becomes impure on day 100, some say he forfeits his entire period, some say only 30 days. If he becomes impure on day 101, some say he forfeits 30 days, some say only 7. The Gemara explains, in the case where he says he's a Nazir and becomes impure on day 30, the opinion that says he forfeits 7 days, it's because he holds it occurs after the completion of his term. When he specifies 30 days, that meant 30 whole days, so he'd need to redo the whole term. This is relevant in regards to the earlier debate if the minimum Nazarite period is 30 or 29 days. In Mishnah, somebody who declares himself a Nazir while in a cemetery, even if he's there for 30 days, they don't count towards his Nazarite term, and he doesn't bring the offering for becoming impure. If he left and went back in, it is a part of his term, and he would bring an offering for impurity. Others say that this won't apply on the first day, as based on the verse, there's no forfeiting a Nazarite vow until you've done a few days. The Gemara says, it's actually debated if somebody takes a Nazarite vow in a cemetery, if it takes effect based on whether the vow could be held in stasis until after he leaves the cemetery or not. It's debated. We bring a source which proves you actually can become a Nazir while impure. So rather, both opinions agree that a Nazarite vow while impure takes effect immediately. The dispute is whether they receive lashes for this violation, which is debated. We bring a source which clearly says he would receive lashes. There are additional unresolved questions on some specific cases. Further, if somebody becomes a Nazir while in a cemetery, it's debated if he needs to cut his hair based on whether the hair cutting is only required on a pure Nazir who becomes impure, or even on a Nazir who started impure. This is further discussed. We bring a source which says he would not need to cut his hair in such a situation, although it depends on the opinion held by these points. There's additional discussion on these cases. Essentially, there are a number of opinions as to what to do if the Nazarite term was interrupted with impurity. Some say the count is restarted right after he repurifies himself with immersion and sprinkling on the 7th day of purity. Some say the count is restarted after the 8th day, even without sacrifices being offered. Some say the count is renewed on the 8th day, but requires the bringing of the Chattas offering. And some say on the 8th day, and after he brings both the Chattas and Asham offerings. We bring a source which appears to differentiate between a Chattas sin offering and an Olah offering, and that's explained to be like the opinion that a Nazir must always bring a Chattas offering after, whether he's pure or impure, as he's considered to be a sinner. In the case where he left the cemetery and came back in, some explain this to mean that he left sprinkled on the 3rd day, re-sprinkled, and immersed on the 7th day, and even if he re-enters the cemetery after on the 7th, it's included in the count. The other opinions are also qualified. They're discussed further along with sources. New Mishnah. If somebody vowed to become a Nazir for a long while outside of Israel and completed it and then went into Israel, the Beis Shammai says he must become a Nazir for 30 days. The Beis Hillel says he must redo his full term. There's an incident where the Queen Helena of Adiabene, a convert to Judaism whose son went to war, so she vowed to become a Nazir for 7 years if he returned safely, and he did, but she did her Nazarite term outside of Israel, and when she arrived in Israel, Hillel ruled she had to redo her whole period. So she did, and at the very end, she became impure, so it was ruled that she had to do it again, meaning she did 21 years total. Some say she was only a Nazir for 14 years, though. The Gemara explains the dispute if the person outside of Israel needs to redo their Nazarite period fully, that they both agree that the land outside of Israel is impure, not the air. The debate is in regards to the penalty, if it's a 30-day term or a redoing of the full term. In regards to the opinion that the Queen Helena was a Nazir for 14 years, the implication is that this version disagrees that she became impure, as if she had, and it was like the opinion that she would only need to redo 30 days, it would have said she had done a total of 14 years and 30 days. New Mishnah. If there are 2 sets of witnesses on somebody's Nazir vow, one set said he declared 2 Nazarite terms and the other said he declared 5 terms. Beis Shammai says they're contradicting each other, so there is no Nazarite vow. Beis Hillel says the testimony of the 2 terms is included in the 5 terms, so he must do the 2 terms. The Gemara says, others say that actually the dispute is that they agree in this case that 2 is included in 5. What they debate over is if there's only 1 witness for both. Beis Shammai says there's no Nazir period. Beis Hillel says 2 is included in 5. Some say if 1 witness testifies that he said 1 and 2, and the other says 3, 4, 5, their testimony is split, and he has no Nazarite period. Others disagree. And that's the end of chapter 3. Chapter 4 of Tractate Nazir continues discussing the laws of the Nazarite vow. The first Mishnah says, if somebody says that he's a Nazir, and another person says, and I, and a third person says, and I, they all become a Nazir. If the first one is released of his vow, they all are released of their vows. If the last one is released of his vow, it's only him. If somebody declared himself as a Nazir and a second person says, my mouth is like his mouth, or my hair is like his hair, the second person is also a Nazir. If somebody declared himself as a Nazir and his wife says, and I, the husband can revoke her vow while leaving his still in place. If she said that she's a Nazir and he said, and I, he can't revoke her vow. If a man said, I am a Nazir and you, and his wife said, Amen, he can revoke her vow while leaving his own in place. If she said, I am a Nazir and you, and he said, Amen, he can't revoke her vow. The Gemara says, an opinion that the only way saying and I to include yourself in a Nazarite vow that this works is if it's said within the time it takes to make an utterance, which is defined as the length of time it takes for a student to greet his teacher. Others disagree and they debate proofs. When a sequence of people said and I, it debates if their and I refers to the prior guy or to the original guy. This is practically relevant, as if it's to the prior guy, they can keep making new links, and if it's to the original guy, they can only make their vows within the time period of the first guy. This is debated from a number of sources. We bring a source which says if the first person is released from his vow, all of the others are also. If the last one is released from his vow, it's only him, and if the middle one is released from his vow, all the ones coming after are released from their vows, which proves that it does function in a chain language. Some clarify the case where he said about his mouth or hair to be where he said, let my mouth be like his mouth in regards to refraining from wine, or like his hair in regards to not cutting it. In regards to the husband vowing to be a Nazir and his wife saying, and I, and the husband revoking the vow, it debates if it fully retroactively nullifies the vow, or if it just stops it right there. This is practically relevant if somebody else said, and I, to the wife's vow. A number of proofs are suggested and disproven. After additional cases, we bring one which says, in that practically brought case, the second woman's vow stays, implying the wife's vow is only ended right there. Some say, if the second woman had said, I am like you, her vow would also be revoked. There's additional discussion. It asks, what if the second woman had said, I am a Nazir in your footsteps, or I am in your footsteps, or similar, whether their vows are now linked. So if the wife's vow is revoked, hers would also be. It's debated. In regards to the wife saying amen to his saying if she's partaking in it, there's a different source which seems to imply he can't nullify her vow, unlike what we said. So some amend the text to say that he can annul her vow. Some say that actually the case is where he said, I am a Nazir and you, as a statement, not a question, as our case was. New Mishnah. If a woman vowed to be a Nazir and then intentionally drinks wine or becomes impure, she receives the penalty of 40 lashes. If her husband revoked her vow, even if she didn't realize, she doesn't receive the lashes. Some say she does for rebelliousness. The Gemara cites verses as sources for these points. It also generally discusses some further points on how the intent behind an action changes how it's perceived. As an example, two people who bring a paschal offering, one to eat in a gluttonous manner, and others to fulfill the commandment, exemplifying the verse, for the roads of God are straight, the righteous walk in them, while the transgressors stumble in them. Others say it's more accurately exemplified with other instances, the point on Lot and his daughters after surviving Sodom and Gomorrah cohabiting, the daughters doing so to try and do a right thing to restart the human race, Lot doing so as a sin, as he allowed it to happen twice. There are further points on Lot and discussion on other similar instances of scriptural immoral relations, for instance Tamar, who did so but with good intent, so kings and prophets were descended from her, unlike Zimri, who did so for improper intents and tens of thousands died due to him. Some even say a transgression performed for the sake of heaven is greater than a good deed done for ulterior motives, and it brings related verses. Famously, it says, a person should still learn Torah and do mitzvahs even if it's done with the wrong motives, as through this you'll eventually come to do it for the right reasons. It discusses additional points on the incident with Lot. New Mishnah. If a woman made a Nazarite vow and consecrated an animal for the sacrifice at the end of her term, and then the husband revoked the vow, if the animal belonged to the husband, it goes back to being unconsecrated. If the animal was the woman's, if it was consecrated as a chatas offering, it's left to die. If it was consecrated as an olah offering, it's offered as a voluntary olah. If it's a shlamim, it's offered as a voluntary shlamim, which can be eaten for one day, and it does not require the bread offering like it typically does with the Nazir's shlamim offering. If there was money set aside for the offering, but it was unspecified, it goes for the voluntary communal offering. If she had specified funds, the money for a chatas offering is thrown into the Dead Sea. It can't be benefited from, but it is not me'ilah, the prohibition against benefiting from consecrated property, which won't apply here. If the money is for an olah offering, they use it to bring a voluntary olah, and it is forbidden with me'ilah to use it. With the money being for a shlamim offering, it's used to bring a voluntary shlamim, which is eaten for one day and does not require the typical bread offerings. The Gemara says, this was cited like the opinion that holds a husband is not obligated to supply the offerings for his wife's Nazarite service, which is a debated point. It also asks where the wife has her own property that's not shared by the husband, which is suggested that she either saved up for it with leftovers of her allotted food, or they were given to her as a gift on condition that her husband doesn't have rights to them. There are further points on the offerings. The points on specific funds are discussed further. There are additional points on this. It also defines as to what sort of declarations of your funds towards offerings constitute the
creation of a specified fund. These phrases are qualified, and they list some things that can't be treated as an unspecified fund as they aren't considered to be money, such as an ingot of metal. Others say it is legally money, but a stack of building bills would not be one. The logic of these opinions are debated. Some state that a blemished animal can constitute an unblemished fund as its value is of money, which is discussed. It cites a lengthy source which seems to disagree with the opinion that blemished animals are considered as unspecified funds by these laws. After citing the whole source, it again essentially explains that it's referring to blemished animals whose value is that of money, hence why they fall into the category of unspecified funds. New Mishnah. If during the wife's conclusion of her Nazarite term ceremony the blood of her offering was being sprinkled on the altar, the husband can no longer revoke her Nazarite vow. Some say he can't if one of the animals was slaughtered and they haven't yet sprinkled the blood on the temple altar. This applies if she was pure at the end of her Nazarite service. If she was not, he can revoke her vow after the offerings have been brought, as he can say he doesn't want her Nazarite service to have to restart, which it will. Others say he can revoke her vow even if she's pure during the service, as he can say he doesn't want his wife to cut her hair. The Gemara explains that this disagrees with the opinion that the woman's Nazarite service ends only when she's done every single concluding service, including cutting her hair, as the husband wouldn't be able to revoke her vow then at that point. Our Mishnah holds that her service is completed once the blood is sprinkled. The opinion which says he can't if they've even sacrificed the animal says this because it would be a waste of consecrated items. This would apply to the Chata's sin offering being done first, as the other offerings' blood can still be used. The dispute as to if you can revoke the vow because you don't want her hair to be cut is based on if people are okay with wigs or not. New Mishnah. A man can declare his son a Nazir, but a woman cannot declare her son to be a Nazir. If the son refused his father's declaration by cutting his hair or verbally protesting, or his relatives had done this and the father had consecrated animals for the service, the Chata's offering would be left to die, the Ola is brought as a voluntary Ola, and the Shalomim is brought as a voluntary Shalomim, which can be eaten for one night without the bread offering. If it was an unspecified fund that was set aside, it goes to voluntary offerings. If it was specified towards offerings, the Chata's money gets thrown into the Dead Sea. It can't be benefited from, but Me'ilah, the prohibition against using consecrated temple property, does not apply. The Ola fund would be used to buy a voluntary Ola offering, and there's Me'ilah for its misuse, and the Shlomim funds are used to buy a voluntary Shlomim offering, which can be eaten for one day, and it is not brought with the bread offering. The Gemara says the reason a mother cannot designate her son as a Nazir is either it's just a tradition passed down from Mount Sinai, or because it was enacted to help her father teach his son the observation of the Torah law, which is an obligation only for the father to a son. It's explained that this would apply to vows or even the Nazarite vow. The issue with the relatives, according to this, is that if the relatives don't approve, presumably the child wouldn't either. According to this opinion that it's not a tradition and it's only rabbinic, it's able to override the prohibition against shaving your whole head, as he holds that that's also a rabbinic institution. Furthermore, as this is basically being done for education, according to this, he's allowed to bring unconsecrated animals into the temple courtyard, as he holds the prohibition against that is not scriptural, and neither is there a scriptural law for the slaughtering requirement for birds, which is why the bird offerings are allowed here, even though they aren't slaughtered typically. There are further points. These opinions are debated in regards to the ages of the sons as to where such a vow would be permissible based on related discussions. There are additional points. New Mishnah. If a father and his child are both a Nazir, but the father sets aside unspecified funds for the offerings, and then he dies, his Nazir son can use them for his offerings, but his daughter cannot. Others say the funds must go to voluntary offerings, and a son can use his father's funds if he became a Nazir only on condition that he can use his father's funds for the conclusion offerings. The Gemara says that a daughter can't use her father's funds. That's a tradition, again, passed down from Mount Sinai, and is relevant when he only has a daughter, so there's no son to inherit before her. It's explained that the two opinions of the Mishnah argue. The first saying the son can use the funds even if it wasn't conditional, and he was a Nazir from before. It also asks, what if there are two sons, whether it goes to the first one who finishes, or if they split it, or what if one was a firstborn, does he get priority like by typical inheritance laws? It also asks if there's variation if the father and son were different types of Nazirs, one being permanent, and the other being a typical Nazir, and others, and they all go unresolved. And that's the end of chapter 4. Chapter 5 of Tractate Nazir continues going through the laws of the Nazarite vow. The first Mishnah says, Beis Shammai holds that accidental consecration is still valid consecration. Beis Hillel disagrees. For instance, they'd argue if somebody said, referring to his black ox, that the first thing that comes out of his house will be consecrated, and his white ox walks out first, or in reference to a gold dinar, he said he'd consecrate the first coin he draws out of his hand, and he draws out a silver one, or he said, in reference to a barrel of wine, the first of which comes to my hand will be consecrated, and he gets a barrel of oil first. Beis Shammai would say all of those
cause the item to still be consecrated, Beis Hillel would say it's not. The Gemara explains the logic of these opinions. Beis Shammai says an accidental consecration is valid, as these laws of primary consecrations are learnt from derivative consecration, which take effect even when done accidentally. Beis Hillel would disagree. The validity of this comparison is debated from a few sources. Some, based on these laws, adjust the case, for instance with the ox, to be where he only found out about the mistaken consecration on the incorrect animal after the fact, in the afternoon, and it says he wouldn't have made the consecration if he knew it would apply to that animal. The grammar of the Mishnah is therefore adjusted accordingly. It also debates the preference of different colored oxen for different tasks. In the Mishnah, if somebody vowed to be a Nazir and he violated this by drinking wine, and then he asked the sage to revoke his vow, and the sage said it was legally binding, he counts from the time that he vowed. If the sage had released the vow, if he had designated an animal for the offering, it's no longer consecrated. Beis Hillel argues with Beis Shammai over this, saying that this is a case of accidental consecration. Beis Shammai cites a case of miscounting animal tithes, where all the animals are still consecrated in spite of being counted incorrectly. Beis Hillel rejects this, as he says they're consecrated by scriptural decree, not based on his counting. The Gemara cites the opinion source for this Mishnah and further explains the dispute between Beis Hillel and Beis Shammai in regards to this and by miscounting tithes. New Mishnah: if somebody vowed to be a Nazir, he went to bring his animal and he found it was stolen. If he declared himself to be a Nazir before it was stolen, he is a Nazir. If it was after, he is not. It cites an instance of something like this occurring where a sage had declared himself a Nazir unknowing that the temple had been destroyed. He found out and it was annulled, but some said the annulment was based on whether he had vowed before or after the temple was destroyed. The Gemara clarifies these opinions and says the latter opinion would allow the annulment of the vow based on an unexpected occurrence. The destruction of the temple is deemed to be unexpected, in spite of there being pretty clear scriptural reference to it occurring, even down to referencing the exact year that it would happen, but they didn't know the exact day it would be destroyed, so it was said to be unexpected. New Mishnah: if there were 6 people walking, and they see somebody walking, and the first one says, "I'm a Nazir," if it's a particular person. The second man says, "I'm a Nazir," if it's not that particular person. The third says, "I'm a Nazir," if one of you are a Nazir. The fourth says, "I'm a Nazir," if one of you are not a Nazir. The fifth says, "I'm a Nazir," if the first 2 are both Nazirim, which isn't really possible. And the 6th man says he's a Nazir if all 5 people are a Nazir. Beis Shammai says they're all Nazirim, as it's similar to accidental consecration. Beis Hillel says the one whose condition is not fulfilled is a Nazir, which will be explained. Rav Tarfon says that none of them are a Nazir. If the approaching man turns around and they never find out who it was, some say none of them are a Nazir, others say the vower should say, "If I was correct, I'm a Nazir. If I was not correct, I'm a voluntary Nazir anyways, to be safe." The Gemara says, Beis Hillel says the one whose condition is not fulfilled is a Nazir. Some say this is a mistake, and it should read the one whose condition is fulfilled is a Nazir. Some say it means he's a Nazir if his later words are fulfilled. In the event that they did see the man, it debates his opinion by these laws. It would imply that he's definitely not a Nazir, unlike the last opinion, who says that he's a Nazir out of doubt. New Mishnah: if somebody sees a specific animal that there's a question if it's a wild or domesticated animal, and one person said he's a Nazir if that's a wild animal, person 2 says he's a Nazir if it's not a wild animal, person 3 said he's a Nazir if it's a domestic animal, person 4 says he's a Nazir that it's not a domestic animal, person 5 says he's a Nazir if it's a wild and domestic animal, person 6 says he's a Nazir if it's neither a wild or domestic animal, person 7 said to person 1 through 6 that he's a Nazir if one of you is a Nazir, person 8 said to 1 through 6 that he's a Nazir if none of them are a Nazir, and person 9 said to people 1 through 6 that he's a Nazir if all of them are a Nazir. Then in this case, all of them would be a Nazir. The Gemara cites a source where someone could take upon himself 9 terms of Naziris by a 10th person seeing this whole thing, saying he's a Nazir, and taking upon the Naziris of all of them. And that's the end of chapter 5. Chapter 6 of Tractate Nazir continues on the laws of the Nazarite vow. The first Mishnah says there are 3 things forbidden to a person who took a Nazarite vow, a Nazir: impurity, cutting his hair, and grapevine products. All types of grape products can be combined to form the minimum forbidden amount, which is an olive volume. Some say it's until he drinks a quarter lug, an old form of measurement of wine. Some say even if there's an olive volume of wine that was soaked into bread, he can't eat it. He is liable for eating wine, grapes, grape seeds, and grape skins. Some say he's only liable for having 2 grape seeds and a grape skin together. It gives the definition of grape skin and grape seeds. The Gemara says there's an implication, as it said grapevine products, meaning the vine itself should be permissible, although others debate this. The dispute is dependent on the manner of interpretation of certain verses which are listed. It also expounds on the methods of exposition from verses that have the opinion hold a Nazir is only liable for eating 2 grape seeds and a skin. The points on these methods of derivation are further described.
Anyways, one of the opinions said that if the bread and wine combine to form the minimum amount, he's liable. Now, typically by all prohibitions in Torah, the prohibited object cannot combine with a permitted object to create the minimum prohibited amount. The exception would be by the Nazir's prohibition, as the Torah said, he may not eat anything infused with grapes. Some would include in this concept also combinations of leaven being burnt on the altar, which is not allowed if it's over an olive's volume, unlike other opinions, and also the general prohibition against eating chametz, leavened bread, on Passover. It debates the application of this concept by a few related cases in regards to laws of teruma and similar. It also asks, how exactly do we know that the word infused in the verse teaches that permissible and impermissible foods can combine? Perhaps it just means that flavor is equivalent to substance in regards to these prohibitions. It brings sources which show that this is a concept, but others do still disagree and use it as a reference to the combination of permissible and impermissible amounts to form a minimum prohibition. This opinion would possibly instead learn the rule that flavor is equivalent to substance in regards to prohibition from the laws of not mixing meat and milk, where there is a prohibition even if only flavor of one gets absorbed into the other. However, the laws of meat and milk can't really be used to teach such general laws, as they are a novelty, and that meat soaked in milk is technically permitted. The prohibition is only if they're actually cooked together. Rather, it's learned from the prohibition against using the utensils of a non-Jewish person, as flavor absorbed from the pot can be exuded into the cooked food. So we see that even flavor is an actual issue in regards to these laws. It's debated between the opinions if such a utensil was only impermissible on the day it was used for non-kosher food, as afterwards the absorbed taste is considered to be spoiled and won't be prohibited, while others say that it is even considered to be spoiled a little bit on the day it was used. However, in spite of all this, the word infused, whether it teaches that flavor is forbidden or that impermissible combines with permissible to make prohibited minimums, can't be used to teach rulings by other laws, as there's a unique concept that, as this principle is specified in 2 scriptural verses in the Torah, meaning the concept spoken on applies specifically here and can't be used to imply the application of its laws by anywhere else. Others debate this as they hold both verses were individually necessary. It's further disputed. There are further interpretation of verses. Some say the combination principle applies by the Nazir, but only specifically to drinks. It mentions many instances by drinks that this would not apply. It further goes through the remaining parts of the Mishnah. Some say if he eats the minimum of grape seeds, he gets 2 sets of lashes for the prohibition against grape seeds and also against anything from the grapevine. Similarly, he'd get 2 sets of lashes for eating the grape skins and 3 sets for eating grape seeds and skins. But others disagree, saying you'd only violate 1 prohibition for eating a grape seed, as he'd hold there's no additional lashes for violating general prohibitions. It further debates this concept. It also defines the definition as to grape seeds and grape skins, according to the wording. New Mishnah. The standard Nazarite term is 30 days. If he or somebody else cuts his hair, he must redo up to 30 days, as he needs at least 30 days of hair growth when he finally cuts it. A Nazir who cuts his hair, whether with scissors or a razor or even by hand, any amount at all, is liable for lashes. The Gemara debates if hair grows from the base of the head or from the tip of the hair. This is practically relevant. If it grows from the bottom, the actual hair growth during the Nazarite period has been removed. If it comes from the tip of the hair, then the remaining hair left over is still from the Nazarite period. It debates this from the movement of a lice and from how hair braids loosen at the bottom, but it doesn't reach a conclusion there. Rather, it proves from the fact that if a man dyes his beard, the dyed part grows outward, and new hair is at the base, proving that hair grows from the base. There's a case where if a Nazir's hair is cut in half, it says he doesn't need to redo days of his hair, but that's explained to be a case where his hair was cut after his Nazarite period, but before he did his conclusion ceremony, in accordance with the opinion that somebody who does that needs to redo 7 days, but he redoes nothing, as there's still 7 days of growth left on his head. It brings verses as a source that a Nazir can't pull his hair out by hand or use a depilatory or similar. Some would hold that the cutting of 1 hair is sufficient to be liable for lashes, and that 2 hairs is sufficient for the concluding hair ceremony, and half the hair being cut is required to need to redo days, and this all applies by a razor and things similar. A source is brought. Generally, there are 3 people who are obligated to cut all of their hair: a Nazir, somebody with tzara'as, leprosy, impurity, and the Leviim during Moshe's inauguration, all of which must specifically be done with a razor, and we cite scriptural sources, although they are argued on. It also discusses the scriptural sources which imply that when somebody with tzara'as leprosy needs to shave, he uses specifically a razor. It debates how comparable this is to the verses regarding a Nazir. It cites other opinions on the necessity of specific wording and verses to imply the obligation to use specifically a razor when cutting the leper's hair. These points are additionally clarified. Additionally, it says by these 3 people who are obligated to cut their hair, they must cut literally all of their hair, and if they don't, it was invalid, And based on the fact that this is specified, some say that it implies by other laws that if somebody does most of something, it is considered as if he did the entire thing, which is relevant by many other concepts. It's also asked if a Nazir shaved all of his hair besides for 2 hairs, so he hasn't completed his obligation, and then all of his hair grows back, and then he cuts the 2 hairs. Has he fulfilled his obligation? It also asked if he shaved all of his hair leaving 2, and then 1 fell out, and then he cut the last one, whether he's fulfilled the obligation, and by there it said that he has not. New Mishnah. A Nazir can shampoo his hair and move them by hand, but he can't use a comb. The Gemara says this is like the opinion that says something unintended is permitted, but the comb is still not allowed, as he would intend to remove dangling hairs. New Mishnah. Some say a Nazir can't shampoo his hair with earth, as this causes hair to fall out. The Gemara asks if this applies to all earth or just a specific type, and it's left unresolved. New Mishnah. A Nazir who was warned against drinking wine and he kept drinking all day, he gets 1 set of lashes. If he was issued several warnings and he kept drinking, he gets lashes for each set of warnings. The same applies to a Nazir who was cutting his hair all day or becoming impure from a corpse and was being warned or repeatedly warned. The Gemara says there are different methods of becoming impure from a corpse, either touching one, carrying one, being in the same roofed building as one. Based on the specific implication of verses, some would say that if a Nazir becomes impure from a corpse with the first 2 methods and then entered under the same roof of a corpse, the last method, he would be liable for 2 prohibitions, although not vice versa. Others disagree with this notion, and they debate it by citing relevant sources. We further discuss in regards to their views by particular cases of people coming in contact with forms of impurity through various manners. Also, a Kohen can't typically come in contact with a corpse, but there are exceptions by a close relative, or if he finds an unattended corpse that needs burial. It states additional particular laws on that topic. For instance, there are sources that say, based on the wording of the verse, the Kohen's father's body must be full, without any parts missing for the Kohen to be able to bury him. New Mishnah. There are 3 things forbidden to a Nazir: impurity, cutting hair, and grape product. Impurity and hair cutting are stricter than grapes in that the violation for those cause you to need to redo days of your period. The prohibition to eat grapes can be stricter than the others, as there are no exceptions to that, unlike by hair cutting, where there's an exception if it's obligatory, or by impurity, where there's an exception if there's an unattended corpse. The prohibition from impurity can be stricter than hair cutting, as becoming impure makes you redo your entire term, and you must bring an offering, while hair cutting makes you redo a maximum of 30 days, and you don't need to bring an offering. The Gemara has verses for the exceptions by laws of impurity and hair cutting, and then for the lack thereof by consuming wine. These are further discussed. New Mishnah. If a Nazir becomes impure, he must cut his hair. On the 3rd and 7th day of his impurity, he is sprinkled with the ash water of the red heifer, cut his hair on the 7th day, and he brings his offerings on the 8th. If he cuts his hair on the 8th day, he can also bring the offering on the same day, as he becomes pure based on the amount of past days, not by the actual hair cutting, like by somebody with Surah's leprosy. The Gemara debates whether others disagree with this last point. It also goes through some points on the prohibitions of certain people with types of impurity from entering into the temple. Some suggest that an impure Nazir can enter the Levites' camp by the gates of Nicanor, based on some verses. New Mishnah. When a Nazir validly completes his Nazarite period, he brings 3 offerings: a chatos, an olah, and a shalomim offering. And it's debated if he cuts his hair after the shalomim or after the chatos, as to which is brought first. Although everybody agrees it's fine no matter which of them he offered before. If a Nazir brought the 3 animals to the temple, and he didn't specify what each should be used for, the animals that could be used as a chatos should be used as a chatos, the animal that could be used as an olah should be used as an olah, and the animal that could be used as a shalomim should be used as a shalomim. The Gemara cites sources for the opinion that hair cutting is done after the shalomim offering. These are discussed. New Mishnah. After the Nazir's hair was cut, he would throw it into a fire that was cooking the shalomim offering. He would not do this if he was doing this outside of Jerusalem or if he was impure. Others say that the only one who doesn't burn the hair by the shalomim offering is an impure Nazir, who is also outside of Jerusalem. The Gemara cites additional points on this ceremony, such as that some of the shalomim offering was put on the hair before it was burnt, and the sources for this. It cites the debate as to in which situations a Nazir would do this ceremony. New Mishnah. The shalomim offering would be cooked or overcooked. The Kohen takes the foreleg, an unleavened loaf, and wafer. He hands them to the Nazir, and he waves them, and then the Nazir's term is over, and he's allowed to drink wine and become impure. Some say his term is over once the blood of one of the offerings is thrown on the altar. The Gemara cites a similar debate. It also argues whether the waving of the offering is strictly required to end the Nazir's term, as to whether it's an essential obligation. Some say it is. Others disagree. There's a version of this argument, and it debates if a bald Nazir can be released from his term, as he can't get his hair cut.
New Mishnah. If his hair was cut after the first offering and the offering was found to be invalid, the hair cutting and the later offerings are invalid. If his hair was cut after the Chattas offering and it was offered with incorrect intents, and then the other offerings were brought properly, the hair cutting and the offerings are invalid. If his hair was cut after the Olah offering was brought with incorrect intents, and the other offering was brought properly afterwards, his hair offering is invalid, and it's debated if the other offerings count. If his hair was cut after all three offerings and only one was valid, his hair cutting was valid, and the invalid offerings must be re-brought. The Gemara says an opinion that if somebody had his hair cut after a voluntary shlamim offering, the hair cutting was valid, as he holds that the verse implies it can be done after any shlamim offering. New Mishnah. If a Nazir had the blood of one of his offerings thrown onto the altar and then he became impure, some say he must restart, some say he should bring the rest of the offering and purify himself. There was an incident that implies like the first opinion. The Gemara says the first opinion just holds that all of his offerings are invalid, and that's where he needs to restart, and we bring support for this. And that's the end of chapter 6. Chapter 7 of Tractate Nazir continues going through the laws of the Nazarite vow, now on some particularities in regards to the laws of impurity. The first Mishnah says a Kohen Gadol and Nazir cannot become impure for their dead relatives, but they can become impure for an unattended corpse. Rabbi Eliezer says between the two of them, it's better if the Kohen Gadol becomes impure. The rabbis say that a Nazir should become impure more than even a regular Kohen. The debate is that a Nazir brings offerings for his impurity, so that's seemingly stricter than a Kohen, but his prohibition towards impurity is not permanent, so that's seemingly less strict than a Kohen. The Gemara clarifies, if it's between a Kohen Gadol and a Nazir, the rabbis say that the sanctity level of a Kohen Gadol is greater, while Rabbi Eliezer says the Nazir is greater. Some further delineate a Kohen Gadol who was appointed with the anointing oil, as opposed to just through the wearing of the priestly garments, has greater sanctity as he brings a specific bull offering. A Kohen Gadol who came into office through wearing the additional priestly garments and is currently in office is greater than a Kohen Gadol who was anointed, who left office and isn't performing any services. A Kohen Gadol who is impure from an emission has a greater level of sanctity than a Kohen Gadol who developed a blemish, as the one with the emission can resume his service the following day. Between a Kohen anointed before a battle and the deputy Kohen Gadol, the battle Kohen has priority of sustenance as he's needed by the public, and the deputy Kohen Gadol has priority in regards to sanctity. Typically, if the Kohen Gadol or Nazir are on their own, they must bury an unattended corpse. The scriptural source for this is given. It also expounds on points of the Nazir becoming impure for their direct relatives if they have leprosy, impurity, or similar, and also gives the scriptural source that a Nazir can contaminate himself with an unattended corpse, which is discussed. It disputes the necessity of particular wording in these verses and which concepts on this subject they teach. This is further discussed. New Mishnah. A Nazir becomes impure and must go through the impure Nazir requirements from being contaminated from a corpse, an olive's volume piece of a corpse, an olive's volume of decomposed corpse fluid, a ladleful of corpse dust, the spine or skull, a limb of a corpse or living body, if there's enough flesh on it that it could regenerate if attached to a person. Half a kav, a measurement of bones, half a lug, a measurement of blood, and the Nazir will become impure by touching these, carrying these, or for being under the same roof as them. If it's a bone the size of a barley grain, the Nazir becomes impure for touching or carrying it. Anyways, the Nazir will need to sprinkle with ash water from the red heifer on the 3rd and 7th days and cut his hair, and he needs to redo his whole Nazarite term once he becomes pure and has brought the offerings. The Gemara cites an incident on the discussion of these laws. It debates the necessity of mentioning a complete corpse causing impurity, if that could be obviously derived from the fact that a limb of a corpse causes impurity. So some explain it to teach that an aborted, underdeveloped fetus transmits impurity. Some say it's to teach that the greater part of the skeleton or majority of the actual number of bones in a corpse can cause impurity, even if they don't amount to a quarter kav. It defines what exactly is this decomposed corpse fluid and what this encompasses. It discusses some related points on fluid dynamics in regards to kosher, for instance, whether a melted or poured fluid in a stream, as whether this constitutes a connection between the pouring object into a lower container, as there are thicker substances which spring back when poured. It debates this from a few sources. It also questions whether a ladleful constitutes a palmful or a handful. It also clarifies what exactly constitutes corpse dust. Some define it only as if it comes from the flesh, sinew, and bones, although this is debated. Some rule if two corpses are buried together, they become a mixture of a sort, and their dust does not contaminate with impurity. If the corpses were buried separately, decomposed, and then the dust was mixed together, that would generate impurity. Some even rule that if you cut the hair off a corpse and bury it with the corpse, their
decomposed dust is a mixture and does not contaminate. It also debates the validity of impurity from corpse dust of hair, teeth, nails, and similar. It also questions if a buried pregnant woman is impure as to whether her fetus is considered a separate mixed entity or not. It cites some further related discussion on these laws as to how this applies to decayed limbs and similar. There are further points, and it also debates from a number of separate discussions as to whether the impurity is caused by a spine and a skull, or a spine or a skull. This is debated from several other sources based on the implication of particular wording on these discussions. There are additional points, and it clarifies that a bone the size of a barley grain contaminates only through touching or carrying, not through being under the same roof, and not even if they're under the same overhanging stone. The barley-sized bone would still contaminate even if it's a powder. It also debates whether a Nazir becomes impure from touching a limb without remaining flesh sufficient to regrow on it if it's still attached to the body, which is discussed further. There are also sources which seem to imply that a person becomes impure for stepping over a grave, and it's agreed that the limb in question would cause impurity if there's a bone inside, at least the size of a barley grain, although it debates if it applies without it. It also says in regards to counting days until the Nazir is repurified, based on the wording, this implies the opinion that he restarts his now pure Nazarite term on the 8th day of purification. New Mishnah. Impurity transmitted by branchy canopies or stony protrusions, or from a grave in a plowed over field, or from countries outside of Israel, or from the coffin cover or walls, or from a quarter lug of blood, or from being under the same roof as a quarter calf of bones, or from utensils that touch the corpse, or during the days of counting, or during the confirmed days of Sarah's leprosy. For all of these, a Nazir does not become impure so that he needs to cut his hair and restart, but he does still need to sprinkle with ash water on the 3rd and 7th day. He does not need to redo any of his term, and he resumes it right when he's purified, and he doesn't even need to bring any offerings. They even said the days of impurity from a Zav or Zava emissions, or the days counted before confirming somebody with Sarah's leprosy, they count as a part of his Nazarite term. The Gemara defines branchy canopies as an overhanging tree, and protrusions are things that stick out of a wall. It asks, in regards to the impurity of the countries outside of Israel, it asks if this applies to its soil or airspace, based on the wording of our Mishnah. It says it's on the airspace, and it's debated if somebody can enter other countries without becoming impure while inside a carriage, trunk, or a closet, as to whether that'll still cause ritual impurity or if it's just too uncommon to be a concern. In regards to counting the days of a Nazarite term, even during days of counting throughout leprosy, some say this applies only during a lengthy Nazarite period. Others debate this point. It's questioned by the application by short Nazarite terms in regard to the necessity of him having his hair be at least 30 days of growth long and similar. There's additional discussion on these points. New Mishnah. Some say any impurity of the corpse which causes a Nazir to need to cut his hair, that level of impurity causes you to be liable for entering the temple with it, and not less. Others say this level of corpse impurity should not be more lenient than impurity from a sheretz creature. The Gemara discusses particular instances of these concepts. New Mishnah. Some reason, if a barley grain-sized bone does not contaminate through a roof connection, and the Nazir still cuts its hair for touching and carrying it, then logically a quarter lug of blood, which does contaminate through roof connection, should also contaminate for touching or carrying. It was answered that although this is logical, it's not a viable comparison, as these laws are a tradition from Mount Sinai. The Gemara clarifies, the oral law is the stringency of a barley grain-sized piece of bone that it creates impurity contamination, as described. And that's the end of chapter 7. Chapter 8 of Tractate Nazir continues going through the laws of the Nazarite vow, more in regards to the laws of contamination through impurity. The first Mishnah says, if there are two Nazirim and somebody says that he saw one of them become impure from a corpse, but he's not sure which, they both need to cut their hair at the end of the term, and together they bring an offering for both purity and impurity. And they should say, if I'm impure, the impure offering should be for me. If I'm pure, the impure offering should be for you. They also count 30 more days, and then jointly bring an offering for purity, and say that whichever of the two of them was impure before, this second offering should be for them. The Gemara asks why this should be the case, as unlike the law this is learned from, which applies in a private domain, this case is taking place with 3 people, 2 Nazirim, and a witness. So the area they're in is a public domain, so how are the cases comparable? Some simply answer that the witness wasn't in the area directly there with him and saw from a distance. Some would say the shaving of the head of a Nazir includes an allowance of the typical prohibition against rounding the corners of the head, so therefore, as in this case of 2 Nazirim of questionable impurity, one of them is cutting his hair impermissibly, so the case must be referring to either a woman or minor who are allowed to cut their hair. Some say minors actually can't round the corners of their head. The sources are broad and discussed. Let's start the discussion on these laws. It generally goes through the remaining points on the prohibition for a man to round the corners of his head, which is basically a prohibition against shaving a beard. Broadly, it is permissible
permissible to shave your body, albeit for a man due to the prohibition of a man may not wear a woman's garments. It's a violation to shave his underarm or pubic region, although it can be cut. There's further discussion on this. It's held a Nazir can't remove his body here, and it mentions some incidents where these laws were ruled on and some additional qualifications. New Mishnah. In the above case of two Nazirs where one of them is said to have become impure, if one of the two of them dies, the remaining Nazir should find someone else to take a Nazarite vow, and then they redo the whole above listed sequence. Others disagree, although it'll be difficult for him to find someone to take a Nazarite vow along with him, so he should instead bring an offering for purity and for impurity and say whether he was pure or impure. It should go according to the offering he brought, and the other should either be voluntary or out of doubt. Then he counts 30 days and brings the offering for purity and says if he was impure, now he's bringing this offering. If he was pure, this one's voluntary and the remainder of the earlier one. So he's technically now bringing the offerings in separate parts, but this was still agreed with. The Gemara says the first opinion only said his opinion to test his students to see if they'd come up with the latter opinion, and there's issues with the first opinion, namely that if there's two people bringing offerings, there will be delay and it'll spoil. New Mishnah. A Nazir who wasn't sure if he was impure from the dead and also wasn't sure if he was confirmed to have tsaras, leprosy, he waits 60 days to be able to eat sacred foods, which was prohibited from the leprosy, and his Nazarite period ends after 120 days, as haircutting for tsaras overrides haircutting for a Nazir when it's certain, but not when it's doubtful. The Gemara goes through all of the haircuttings and all of the different offerings required to be brought by such an individual and additional points. These are further discussed along with instances of particular cases. It also asks, of the 4 haircuttings required, are they done as part of the haircutting ceremony or because the actual hair must be removed as it's impure? This is practically relevant as to if you can remove the hair with a depilatory. It's explained to be as a part of the actual haircutting ceremony requirement. And that's the end of chapter 8. Chapter 9, the final chapter of Tractate Nazir, finishes going through the laws of the Nazarite vow. The first Mishnah says, Kuthians are not subject to the laws of the Nazir. Women and slaves are. Women can be stricter in this, as you can force a slave to take a Nazarite vow, but you can't force your wife. The Gemara cites and discusses the verses which source these points. It also cites verses which teach that non-Jewish individuals are not subject to the laws of impurity, and which verses exactly imply that they cannot take a Nazarite vow. It also goes through some points on the permissibility of them taking the vows to donate their worth to the temple. New Mishnah. The Nazarite vow of a slave could be stricter than that of a woman, as somebody can revoke his wife's vows, and it's a permanent revocation, but he can't revoke a slave's vows, and if he does, once the slave goes free, he completes his Nazarite term. The Gemara cites sources for these principles and the difference between the case of a slave's typical vow and his Nazarite vow. New Mishnah. If a slave becomes a Nazir and then ran away from his master, it's debated if he's allowed to drink wine. The Gemara suggests the debate is whether the owner gave up ownership of the slave and whether this legally makes him a free man, or possibly they both agree with this principle, and they debate if the owner thinks the slave will return as to whether he'd permit him to continue drinking wine. New Mishnah. If a Nazir finishes his service and cuts his hair, and then finds out that he became impure, if it was from a known impurity, he must redo his term. If it was from an unknown impurity called impurity of the deep, he does not. For instance, if he swam in a cave and then found a corpse floating inside, he must restart his term. If the corpse was found sunken on the cave floor, if he went into the water to become cooled off, he's pure. If he had gone into the water to purify himself from a corpse impurity, he's now still impure, as it's an unknown source. So he's assumed to maintain whatever status he had when he entered the pool. The Gemara cites scriptural sources for these laws. It also further defines what exactly an unknown source of impurity is, and it says it's a tradition passed down from Mount Sinai. If further discusses these points. This is all explained further, additionally clarifying as to what exactly constitutes this unknown impurity. It's debated, and it's lengthily questioned if something impure is sitting on top of something floating in the water, if the impure entity is considered itself to be floating in the water, which is relevancy by many different laws, and it stands unresolved. It's also said that a Nazir, or somebody making the paschal offering, if they walked over an unknown grave on the 7th day of their purification, they're still considered to be pure, as this type of impurity is less powerful. The validity of this is debated. New Mishnah. If somebody finds a corpse in a place for the first time lying in a manner of a typical Jewish burial, he can remove it along with the dirt underneath it to relocate it. If he found 2 corpses, he can remove them with the dirt. If he found 3, if there's a separation between the first and third from 4 to 8 cubits, is considered to be a graveyard zone. So he must search from there outwards 20 cubits, and if he finds a grave at the end of the 20 cubits, he must search an additional 20 cubits. The further isolated cave can't be relocated, even though he would have been allowed to if he had found it first. The Gemara says the wording implies that excluded from these laws are a known grave, a sitting corpse, or if it's bent in half,
Some even say an incomplete corpse, and the reason why is because as they weren't buried according to the Jewish custom, they possibly aren't Jewish and shouldn't be reburied. It's such an incident of this occurring, and scriptural source for the point that you can take some of the underlying dirt along with approximate amounts as to how much. That's for the discussion. If no additional graves are found from the 20 cubit radius, it's considered to be a graveyard zone, as the land of Israel is considered to be pure. New Mishnah. If there's a doubt of somebody having tzara'as leprosy, if it's initially, he's pure, as long as he hasn't been confirmed to be impure. Once he's impure, if there's a doubt, he's considered to be impure still. The Gemara cites verses as sources for these points. New Mishnah. Ezav, somebody with a type of impure emission, if he hadn't been confirmed to be Ezava, he's checked through his food, drink, carrying loads, jumping, sickness, sight, and thought. If he is confirmed to be a Ziva, he's not examined, and his emissions are considered to be impure. If somebody hit somebody, and the doctor said the man would die, but the man got better, and then he died, it's debated if the striker is liable for the death penalty. The Gemara states scriptural verses as sources for these points. The remainder of these laws in regards to impurity from types of emissions are further qualified. New Mishnah. The prophet Shmuel was a Nazir, according to some, based on a verse that uses similar wording by the Nazir Shimshon as by Shmuel also. The Gemara says a point that somebody who told somebody to recite their after blessing over a cup of wine, it debates if saying amen is preferable to saying the blessing itself. A source saying that saying the actual blessing is preferable. It ends by saying a verse which says that Torah scholars increase peace in the world. And that's the end of chapter 9 and the entire Tractate Nazir. Alright, that was a lot of information, so here's a rough summary of a lot of the practical takeaways from this tractate. A Nazarite vow was a specific type of vow that used to be taken. Essentially, it was a vow to abstain from wine and any grape product, cutting hair, and coming in contact with impurity from a corpse. This status would last for whatever length of time the vower specified within the vow. There was a ceremony to end the Nazarite term, involving the cutting of the individual's hair and the bringing of several offerings to the temple. Tractate Sotah is the tractate which goes through the laws of the special Sotah ceremony in the temple. Essentially, adultery is forbidden. If it's confirmed that a woman was adulterous, she must divorce her husband and does not receive her marriage contract. However, in the event that she only suspected of adultery, for instance she was in seclusion with another man, she can prove her innocence by undergoing the Sotah ceremony. Assuming she's innocent, she can choose to go to the temple, where she takes an oath of her innocence and then drinks of prepared bitter waters, which is basically just water with a scroll containing relevant verses from the Torah dissolved into it, which, after a lengthy process, she's made to drink. If she's innocent, then nothing happens, and she actually receives several blessings of fertility. But if she was guilty of adultery, and for some reason still decided to go through with this ceremony, her body would miraculously, immediately physically degrade, she swells, and then dies, along with the man that she did adultery with, wherever he is. This is all described in these verses from the Torah. Chapter 1 will begin with discussion on these laws. The first Mishnah says, according to Rabbi Eliezer, a man can warn his wife against seclusion with another man before 2 witnesses, and can have her undergo the Sotah ceremony based on 1 witness or his own testimony. Rabbi Yeshua says both require 2 witnesses. For instance, if the husband warned the wife to not speak to an individual before 2 witnesses, and she did it anyways, that's still permissible, meaning they don't divorce. And if he's a Kohen, she can still eat teruma. If she entered a secluded place with the other man and remained there long enough for them to have been adulterous, they must divorce, and she can't eat teruma. And if her husband dies childless, she must do chalitza and can't do yibum, the Levirate marriage with his brother. The Gemara explains, in regards to the order of tractates, Nazir goes next to Sotah, as it said that if somebody sees the Sotah ceremony, he should stop drinking wine, as the Nazarite vow would forbid, as drinking wine leads to such transgressions. The order, however, is of Tractate Kesubos first, and chapter 7 of that discusses vows. So afterwards went Tractate Nedarim, which is all about vows, and afterwards went Tractate Nazir, which is about a specific type of vow, and now we're doing Sotah for that above-mentioned reason. Also, the wording of if the husband warned the wife is past tense, teaching that after the fact, the husband warning the wife to stay away from a certain person is valid, but it's not something that should ever really be done initially, as it could damage the relationship and cause issues. It also lists many teachings sages would say prior to teaching this whole topic, one said that women and men are paired in heaven for marriage in accordance with their deeds. Some said that marriages are determined at conception, but to determine a remarriage is as difficult as splitting the Red Sea. Further, it said that all opinions agree that a single witness is believed to testify about seeing an actual act of cohabitation, and to bring sources. This is debated based on if the Hebrew term for witness refers to two witnesses or a single one, and how that would necessitate additional teachings. The debate between Rabbi Eliezer and Rabbi Yeshua as to whether we require one or two witnesses is based on the interpretation of verses. Some say Rabbi Eliezer would actually hold that he only requires one witness to warn the woman, and two witnesses for her to do the Sotah ceremony, the inverse of his stated opinion. However, according to this and all similar opinions, this could cause issues of the husband claiming afterwards he had warned her when he actually hadn't warned her. Practically, it says, now that there's currently no temple, there's no concept of warning a woman to not seclude with somebody, out of concern that we follow this opinion that one witness is sufficient, as if she does seclude with that person, she was warned legally, so she can no longer be with her husband, and she can't resolve it by doing the Sotah ceremony, as there's no temple. The terminology for warning used is also a word which implies anger. Some say as after the husband's warning, the woman will seclude herself from the community, causing anger from the community. Some say it's because it causes anger between the husband and wife. According to these opinions, it's forbidden for a man to warn his wife against seclusion with another man. Related, it speaks on the negativity of sinning in private, and also says that a person does not sin unless a spirit of folly enters him. It further debates from a number of sources, as if it's permitted for a man to warn his wife about these matters. Some say it is allowed, some say it's actually required. This is discussed. It discusses some further debates. Some said in regards to Canaanite slaves, it's permitted to acquire them. Others held that it's a requirement that they can't be emancipated. This is debated from a number of sources and explanations on certain verses on the subject. In addition, it further speaks on how terrible adultery is and how terrible anger is. And it says that before people did adultery, the divine presence dwelled among all of them. It also speaks on how good deeds and sins go before a person in the world to come. It further debates sources for the amounts of witnesses. It also gives additional definition as to exactly how long a forbidden period of seclusion is, which is said to be at least the time it takes to do the beginning of cohabitation, which, among several other definitions, is defined to be the time it takes to walk around a palm tree. These different definitions are all qualified. It also speaks on the importance of washing before eating bread, citing verses and sources for its great necessity, and also how greatly negative it is to be haughty, and similar concepts. It also cites verses talking about how poor arrogance is and its consequences, along with the great importance of humility as seen by Mount Sinai, where the Torah was given on the smaller mountain, and also that God rested his presence on a thorn bush. There's further on the negativities of haughtiness. It also qualifies if the husband warns his wife to not talk to somebody, and she talked to him or secluded herself with him, or she was told to not seclude herself and she only spoke to him, they're still married. They only divorce if he warned her against seclusion with another man, and she then secluded herself with him for a period. It also cites verses that show such a woman can't do Yibum, the Levirate marriage, and she requires Chalitza, as if her husband would have been alive, they would have had to divorce anyways. There's variation on this. It also cites other additional sources for this concept. New Mishnah. The following woman cannot eat teruma: a woman who admits she committed adultery, a woman who had witnesses testify on her that she had committed adultery, a woman who refuses to undergo the Sotah ceremony, a husband who doesn't want the woman to undergo the Sotah ceremony, and a woman who cohabited with her husband while traveling to Jerusalem to do the Sotah ceremony. The Gemara debates based on this and verses that for a woman to undergo the actual Sotah ceremony, there would need to be no witnesses that she actually did the adultery. Some hold like this and explain their sources, others disagree with this principle and debate them. This is for the questions based off of several other conversations, and it also says some opinions as to whether other merits from the Sotah would push off her punishment to a later time based on some verses. New Mishnah. If the woman secluded herself with the man and became suspected of adultery, the husband takes her to court, who provide 2 Torah scholars to escort them to Jerusalem, so that way they don't cohabit along the way, which is forbidden. Others say we just trust the husband on his own. The Gemara explains that this case is not a proof that 3 men are allowed to be alone with a woman on the road, and not less, being 2 men, which is definitely not allowed in case one leaves to use the restroom and the remaining is in seclusion with the woman, and they would then impermissibly cohabit. As here, in this described case, the extra men are acting as witnesses. Torah scholars specifically are brought as they can warn the husband not to cohabit, as they know the laws, and it's not because of their proper character. It also explains the sources for the opinion that the husband is just trusted to not cohabit with his wife in this situation. New Mishnah. The husband and escort bring her to the high court, the Sanhedrin in Jerusalem, who attempt to get her to just admit her guilt, so that way they don't need to do this ceremony, similar to what they would do by capital punishment with listed words. If she admits she did adultery, she writes a receipt for her marriage contract and is divorced. If she does not, she's taken to the east gate, where they give the Sotah drink, purify women who had given birth, and people who had tsaras leprosy. A Kohen then holds her clothing, and it's permissible if they tear, and exposes her chest and unbraids her hair. This was done to be embarrassing, to discourage people from doing things that make them suspect of doing adultery, and also as a punishment of sort for her secluding herself improperly with another man. Others say they would not do this if she was pretty, to prevent anyone from thinking improper thoughts during this whole ceremony. If she was dressed in white, she would now wear black. If she was wearing gold ornaments, rings, chokers, or otherwise, they're removed so that way she doesn't look pretty. Her garments are then tied with palm fiber above her chest, covering herself. Anyone's allowed to watch the ceremony besides for her slaves or maidservants, as the Sotah woman might become emboldened seeing them and then falsely testify. Other women are allowed to watch this based on the verse so as to discourage this whole thing. The Gemara cites the scriptural source for these points. It says we discourage the woman from undergoing the ceremony, as cited before the scroll is dissolved into the water. Afterwards, she's encouraged to do the ceremony so as to prove her innocence. It also goes through the things the court explains to her. They teach her the portions of Tamar and Yehuda and of Reuven, who confessed their sins and things ended up good for them, and it cites these incidents. It also says they make her walk to the east gate, so that way she'll be tired and likely to just admit it if she had done adultery, and therefore not need to do the Sotah ceremony. It also says people of the Zavin and Zavos emissions, which are types of impurity, are also purified by this location. It also says we don't do two Sotah ceremonies at the same time, so that way they don't refuse to admit to committing adultery, because they'll see the other woman also doing the Sotah ceremony and become more confident. Some allow this by a woman who is actively visibly afraid, as long as it's done by a single Kohen, as mitzvahs shouldn't be done in bundles. The opinion which says we cover a woman during the Sotah ceremony says this would apply here, as there's a possibility she'll be innocent and the younger Kohanim will think improper thoughts and try to be improper with her. But by capital punishment, he would hold any convicted person who's not clothed, although others would disagree by a woman, but this opinion says there's no concern of people being improper with her, as she's receiving capital punishment, and the concern is only by her, as there's a tradition that the evil inclination prevails only over things you see yourself. Others say simply the intent is just degradation, which isn't super applicable by capital punishment, but some would say that degradation is considered to be worse than physical suffering. The remaining steps are qualified, and it says that some hold that women are actually obligated to watch the Sotah ceremony. New Mishnah. It said that how a person acts, that's how God deals with them. This is seen by the punishment of an adulteress. Through the Sotah ceremony, she dressed up to commit adultery, so now she's dressed down. She revealed herself to sin, so her sin is revealed to all. She sinned with her thigh and stomach, so she's punished through her thigh and stomach, which become physically deformed after the Sotah ceremony along with the rest of her body. The Gemara says, even though capital punishment doesn't exist any longer, as the Sanhedrin no longer exists, God still punishes people in that measure. If somebody deserved death by stoning, they'll fall from a roof or be trampled by wild animals. If somebody deserved burning, they'll fall into a fire or be bitten by a snake. If somebody deserved beheading, the country authorities will execute him or bandits will kill him, and if somebody deserved strangulation, they'll either drown in a river or get a choking disease. It further describes how each step of the adulterer's seduction and cohabitation are referenced throughout steps of the Sotah ceremony. It additionally cites verses on the topic of divine punishment and many related points. It also says that the tabernacle and its parts are hidden underneath the temple sanctuary. It also says how the serpent by Adam and Eve were punished in a similar manner. It was originally supposed to be the king of all the animals. It was supposed to walk on legs and eat the same food as people, but now it's a cursed creature that crawls on its stomach and eats dust. It goes through the remaining points on the measured punishment by the Sotah. New Mishnah. Similarly, Samson followed his eyes, so his eyes were gouged out. Avshalom gloried in his hair, so he was hung by his hair, and he cohabited with his father's 10 concubines, so he had 10 spears thrust into him, and he stole 3 things: the heart of his father, the court, and of Israel, so he had 3 other spears thrust into him. The inverse applies also for good. Miriam waited for her brother Moshe in the basket for an hour, so the entire Jewish people in the desert didn't travel, waiting for her for 7 days when she became impure. Joseph buried his father and was greatly honored, so his bones were brought up by Moshe, and God buried Moshe. And it's also said that God attends to all of the righteous after their passing. The Gemara cites many related verses and teachings in regards to Samson and the reason for his punishments, along with points on his wife, Delilah. There are many further points, and it goes through Samson's life, explaining many verses and teachings from Scripture on him. It also explains some points on Tamar and also on the forefather Abraham. It explains that Abraham was extremely hospitable and would explain to all of his guests that the food came from God and they should thank and bless God. There are further points on the incident of Tamar and Yehuda, going through all of the verses and their explanation. It also goes through the verses on the death of Avshalom And it says that after his hair was caught as he fled, he went to cut his hair with his sword, but he saw the depths of Gehenna open up beneath him. It also says that when David cried over his son's passing, he said, "My son," 8 times to remove him from the 7 chambers of Gehenna. And the last one, some say Avshalom's head was reunited with his body, some say it was to bring him to the world to come. There are further points, and it explains that Miriam waited for her brother for an hour and was repaid far greater with 7 days later. The verses are cited. In addition, at the beginning of the story of the Jewish people's slavery in Egypt, it says, "A new king arose over Egypt." Some take this to mean that this was a new king. Some say it means that he made new decrees based on the fact that it never said that the old king died. And when it says he did not know Joseph, it means he acted like he didn't. There are further explanations. It says the Pharaoh said, "Come, let us act wisely regarding it." It says it, not them, as he meant in regards to God, based on verses. The wisdom that they thought of was that it said that God will repay punishment through fire or the sword, but God promised to never again flood the world. So they thought to drown the babies in the Nile River, not realizing God hadn't promised to not flood a single nation. It also says Pharaoh had 3 counselors: Balaam, who gave the advice to drown the babies and who was eventually killed; Eov, Job, who was silent and suffered; and Yisroi, Jethro, who ran away in protest, so he greatly merited through his descendants. Based on further verses, it is explained that Pharaoh pretended to work to coerce all the Jewish people to partake in the labor to eventually become slaves, and they eventually built the cities of Pitom and Ramses, called that as the word means to fall apart, essentially, which the buildings that they were building constantly would fall apart, so that way the Jewish people would have to keep working. There are further verses. It says that the women were made to do men's work and the men were made to do women's work. It also says that it was the merit of the righteous woman that the Jewish people were freed from Egypt, that they would prepare water and food for their husbands and sneak over to them to be with them, based on verses. It also says the woman would go to give birth beneath the apple trees, and God would send angels to take care of the babies and would give them stones to nurse from, which contained oil and honey. And when the Egyptians went to grab the babies, they would be sucked underground, so the Egyptians would park their oxen and plows over the area, but when they left, they'd pop back out, and this is why these children recognized God first by the splitting of the sea. Pharaoh summoned Jewish midwives to advise him. It says, summoning women named Shifra and Pua, and some say the individuals were actually Yocheved and Miriam, who were called that because of how they took care of the newborns as midwives. There are further points on this. It's explaining that the midwives told Pharaoh that the Jewish people are compared to various wild animals: a lion, a serpent, an ox, a wolf, and others. They say that the Jewish women did not require midwives. They were rewarded with their descendants, being the Kohanim and Levium and David, who was the descendant of Miriam. It further expands on several other scriptural figures referenced by other names. It's also said that Pharaoh threw his own people's babies into the river. It's also said that Amram, Moshe's father, saw that all of their male children were being thrown into the Nile, so he stopped having children at all, and then all the other Jewish people followed suit, until Miriam said that that was wrong, as she was preventing even women from being born. So Amram remarried his wife with a whole ceremony, so that way all the Jewish people would follow. It also calculates the age of Yocheved, Moshe's mother, based on the fact that it said she was conceived en route to Egypt and born between the walls of Egypt. And the verse calls her young, in spite of the calculation making her therefore be extremely old. So it said that it's that she resembled a young woman. It also said that she gave birth without pain, as did all of the scriptural righteous women. It also says that Moshe's name given at birth was Tovia. Some say it shows that he was fit for prophecy, some say that he was born circumcised, and some say that their house was filled with light. It says Yocheved hid him for 3 months, as she had given birth very early and couldn't wait any longer, as the Egyptians would take their babies into the houses and then hurt their own babies, making them cry, so that way the hidden babies would cry, allowing them to be found. So she hid Moshe in a wicker basket, either wicker because the righteous are very particular with their property, or so it wouldn't break on a hard object. It had tar put on the outside and clay on the inside, so that way Moshe wouldn't need to smell the tar, and she put him in the river. It says Pharaoh's daughter went to wash in the river, which is explained that she wanted to spiritually wash after having been around her father's idols. She saw the basket, and it says that her maidservants criticized her for not following her father's decrees and trying to rescue this baby, so the angel Gabriel struck down all of the maidservants. Some say one was left to fetch the basket. Some say that she went to take it herself, and based on the wording, it shows that her arm miraculously stretched out to reach the basket. There are further points. It says she knew he was Jewish as he was circumcised, and it says that after this, the Egyptian astrologers saw that the savior of the Jewish people would be stricken by water, so they ended their decree, but they didn't realize that this was a reference to Moshe striking the rock of the well of Miriam, much later on. It goes further and it describes the dates that all this was occurring on. It also says that Miriam offered to fetch a Jewish wet nurse, as Moshe refused to nurse from any of the Egyptian ones, as that would have been of non-kosher food. There are additional points on Moshe's mother, Yocheved, being brought to nurse him instead. It also says in regards to Yosef, all of the descendants of Esav, Yishmael, and Keturah all came to his father Yaakov's burial and hung their crowns on his coffin. When Yaakov was then brought to Ma'aras HaMachpelah, the cave of doubles, where all the forefathers are buried, Esav showed up and said that he should be buried there, as it wasn't fair that Leah had taken his spot. So they said he had sold his firstborn rights to Yaakov, so they were arguing if that included the burial rights to the cave, so they sent Naphtali, who was very fast, to run to Egypt to fetch the document. In the meanwhile, the son of Dan, Choshim, who couldn't hear very well, saw that the burial was being delayed, so he stepped forward and smashed Esav's head with his staff, killing him, and Esav's eyes popped out and landed at Yaakov's feet, causing Yaakov to open his eyes and smile. Moshe buried Yosef, and he knew where he was buried, as only Serach, the daughter of Asher, was alive from his generation, so she said that Yosef had been encased in a metal coffin and placed in the Nile River to bless their water. So Moshe went there and told Yosef to either show himself or be absolved of his oath, and the coffin arose to the surface. Others say this happened, but in the royal catacombs. There are further points in the burial of Yosef. When he was initially sold as a slave to Egypt, he was purchased by Potiphar, who is later referenced in the verse as being called Potipharah in the female, as it says that he purchased Yosef for inappropriate reasons, but the angel Gabriel made him into a eunuch. There are further points on him and the passing and burial of Moshe, who it says was buried in the portion of Gad and carried there by the divine presence. Further, it said, in spite of all this, Moshe did not die, and in spite of the Torah containing many references to the places of his burial, the Roman Empire sent many people to find it, but no matter where they stood, it always seemed out of reach. There are further points on all this, and it's explained that Moshe desperately wanted to enter Israel so he could fulfill all the obligations specific to the land of Israel. And that's the end of chapter 1. Chapter 2 of Tractate Sotah continues going through the laws of the Sotah ceremony as described in the Torah. The first Mishnah continues midway through the description of the actual process continued from the prior chapter. The next step was that the husband would place her mincha offering on a basket of palm bast and put it in her outstretched hands, which she would need to hold so as to make her tired. The difference between the other mincha offerings and this one is that others start and end in a sacred vessel. This starts only in a palm basket, and the others require oil and frankincense. This requires neither. The others come from wheat or fine barley. This is from unfine barley. Some comment that the same way the adulterer behaved in the manner of an animal, her offering is the same food as animals. The Gemara explains that we make her tired so that if she actually had done adultery, she will just admit it and she won't be made to do the whole Sotah process. The woman in this case is being spared for her own sake, not for the dissolved scroll, which had already been dissolved. It goes through the remaining points as to the performance of mincha offerings and specifics as to how and where they're done. The remaining laws of the process of the mincha offerings are explained. It also additionally explains the opinion that the adulterer acted in the manner of an animal, so the offering is done with animal food, as mentioned. New Mishnah. The Kohen then takes an earthenware vial, puts half a lug of water from the kior into it, although some say a quarter lug, as we also use less writing, and then goes to the sanctuary, removes a marble stone that had a ring attached to it, and adds enough dirt from there to be visible in the water. The Gemara says some require this to be a new earthenware vial, and the source is debated. Others disagree, and there are additional points. According to some, it debates if there is no dirt, if it would be valid to use ash instead, which is questioned based on the logic of several other discussions. It said that you can use the dirt of decayed vegetables, which are also considered to be earth, but not ashes, which are not considered to be earth. Similar to the dirt being required to be visible in the water, the ashes of the para aduma, the red heifer, must also be, and the spittle during chalitza must also be visible. And some say the blood of the Metzoros bird must be visible. The validity of the last one is debated from a few verses. It also debates if it's valid to add the dirt before the water. Some say no, some say yes, based on verses. New Mishnah. It lists all the verses from the Torah describing the Sotah ceremony, which are written on the scroll to be dissolved, and there are a few opinions as to which particular of the verses are used. The Gemara explains the debate as to which verses to be used is based on a debate of the interpretation of the verses. There are further additional points on the extremely serious negativity of adultery. New Mishnah. The Sotah scroll is not written on wood, papyrus, or on unfinished parchment. It must be written on a finished parchment scroll, and the ink cannot be gum, ferrous sulfate, or otherwise. It has to be ink, and writing which is capable of being erased. The Gemara says, based on a related verse, it shows that the Sotah scroll must be written by day in sequence after she took the oath and with etched in parchment lines. It must also be written on only one page and dissolved all at once, not one letter at a time. It also asks several particular specific questions in regards to this process, which go unresolved. It additionally describes the oaths the Sotah must take along with their particular wording. New Mishnah. Afterwards, the woman says Amen twice, once for the curse and once for the oath, once for the warned man and once for other men, once that she wasn't an adulterer during the first stage of marriage and again during the second stage, once that she didn't do adultery before Yibum and for after the marriage, and once that she did not commit this sin, and if she had, the water should enter her. Some say the double amen is also that she had not committed adultery and will not in the future. The husband has no jurisdiction with what she did prior to betrothal or after her divorce, even if they remarry after her. Generally, if the circumstance is that if she had cohabited, she wouldn't be prohibited to the husband, he cannot stipulate anything regarding the Sotah ceremony by it. The Gemara says, if a woman pending Yibum cohabits with another man, she cannot do Yibum based on this discussion, although others disagree. It additionally debates the validity of the opinion if a husband can make his wife take this vow on the future, if this would still remain in effect after a divorce, and it's also said this is a valid stipulation. It also debates whether a woman can be made to redo the Sotah ceremony on several occasions for several acts of suspected adultery. This debate is explained to be in a situation of one husband and two different adulterers if they can be made to do several Sotah ceremonies, and that's the end of Chapter 2. Chapter 3 of Tractate Sotah continues on the laws of the Sotah ceremony. The first Mishnah says, the next step of the ceremony, continuing from the prior chapter, he would take the mincha offering out of the pawn basket and put it in a service vessel and put it in her hand, and the Kohen puts his hand underneath and waves it with her, brings it to the altar, scoops out a klimet's handful, and burns it on the altar, and the remainder is eaten by the Kohanim. It's debated if she's given the bitter waters to drink before or after the mincha offering, although it's agreed it's valid if it's done before. The Gemara cites verses to explain the source for the manner of the joint waving. It further lists the debate as to whether the Sotah water is drunk before or after the mincha offering. A related source says she only drinks the water after the mincha offering, after the scroll is dissolved, and after she accepts the oath in accordance with this related opinion. The specification of the water being drunk only after the scroll is dissolved is to say it's only done once the writing on the scroll is fully dissolved, without anything remaining. The point on this being after the oath is just unnecessary. The dispute as to when the Sotah drink is done is based on the interpretation of a number of verses, which are explained as to the specific teachings in regards to the sequence derived from each verse. There are further points, and it says the source that the actual water must be bitter. New Mishnah. If, prior to the erasure of the scroll, she refuses to undergo the Sotah process, the scroll is put away and can't be reused, and her unoffered mincha offering is scattered on the ashes. If this occurred after the scroll was erased, the Sotah admitting that she was an adulterer, the Sotah water is poured out and her mincha offering is also scattered. If she doesn't admit that she's a Sotah but still refuses to drink the water at this point, then she's forced to drink it. If she was guilty of adultery and for some reason decided to go through with this entire ceremony, the physical symptoms would miraculously be immediately visible and she would be taken outside so the courtyard wouldn't become impure. If the woman had merits of good deeds, the effects could be held in abeyance for several years. Some say it's very important to teach daughters Torah to understand the merit of learning Torah. Others disagree, saying you shouldn't. It's also said that a woman prefers 1 kav and physical intimacy over 9 kav and abstinence, which will be explained. It's also said a foolish pietist, a cunning, wicked person, an overly ascetic, abstinent woman, or a person who is injured from being excessively ascetic have an extremely negative impact on the world. The Gemara is a source which says that ferrous sulfate cannot be used in the Sotah scroll, and it's discussed. Some say it's valid to use in the writing of other scriptural verses, and it's debated if it's permitted in the passage of the Sotah, and that's written in the actual Torah scroll. This is relevant if somebody wants to erase the actual verses from a Torah scroll while doing the Sotah ceremony. It debates it from a few sources. It also explains the Mishnah is in accordance with the opinion that the Sotah drinks the water after the mincha offering, based on the mentioned sequence, although he would agree with the opinion that merit would hold the punishment in abeyance. The reason why she's rushed out, as mentioned, is to prevent impurity, which is said to be from menstruation. It also cites sources for the concept of her punishment being held in abeyance. It has related discussion on the concept of an individual's punishment being held in abeyance for the merits he's done generally. It also explains the debate as to whether you should teach your daughters Torah, and the point on preference of intimacy over several kav refers to amounts of food. An example of a foolish pietist is a man who refuses to help a drowning woman, as it's improper. A cunning evildoer is someone who explains his position to a judge before the other litigant comes, or somebody who gives advice to others in regards to their property ownership, or rules leniently by himself and strictly by other people, and other examples. It also speaks very negatively about an individual who studies scripture and Mishnah, but does not serve Torah scholars, which is explained to mean learning Gemara. It also defines an Am Haaretz, an ignoramus, as somebody who doesn't fulfill many essential commandments. It also speaks on other negative attributes, such as a student who hasn't reached a status where he can rule Torah law, who does so anyways, and on a Torah scholar who can do this and chooses not to. The time is said to be at the age of 40, or somebody of equivalent wisdom. It also lists many forms of extreme over-asceticism, of self-harm and similar, that should never be done, and the negativities of insincerity in regards to service. New Mishnah. Some say that merit does not hold the Sotah's punishment in abeyance, as then people would take this less seriously, and also anybody who was innocent and was unaffected by the Sotah waters would then be looked poorly upon. Others say that the punishment is held in abeyance, but she just slowly wastes away and dies at her time. If her mincha offering became impure before it was put in the service vessel, it's like all other impure mincha offerings and can be redeemed. If it became impure after it was put in the service vessel, it must be burned. It must be burned if the woman admits she was an adulteress, or witnesses testify she did, or if she refuses to drink the water, or if her husband doesn't want her to drink the water, or her husband cohabited with her on the way to the temple, or if she was married to a Kohen. This does not apply if she was a Kohen married to a Yisrael. The difference between a male and female Kohen are that only the mincha offering of a female Kohen is eaten, only a female Kohen can become permanently disqualified from a Kohen, only a female Kohen can become impure from the dead, and only a male Kohen can eat of kachei kachim offerings. There are some general legal differences between a man and a woman. A woman, if she contracts tsaras leprosy, does not need to grow out her hair and tear her garments. Only a man can impose a Nazarite vow onto his son. Only a man can cut his hair at the end of a Nazarite term imposed by his father. Only a man can betroth his daughter. Only a man can sell his daughter as a maidservant. Only a woman is stoned while clothed. Only a woman is not hanged when she receives capital punishment, and only a woman cannot be sold for theft. The Gemara discusses the remaining points on the sequence of the mincha offering as to when it's burnt. It cites verses for these points in regards to the listed legal differences between a female and male Kohen and between a general male and female. And that's the end of chapter 3. Chapter 4 of Tractate Sotah continues on the laws of the Sotah ceremony. The first Mishnah says, a woman in the first stage of marriage, erosin, or a woman pending Yibum, the Levirate marriage, do not do the Sotah ceremony, and they also don't collect a marriage contract, which is based on a verse. This would also apply to a widow married to a Kohen Gadol, a divorcee, or similar married to a Kohen, and an illegitimate individual or a Nazarite married to a Yisrael, which are all prohibited. Also included is a woman who admits to adultery if there are witnesses that testify to her adultery, or if she refuses to undergo the Sotah ceremony. If the husband said she won't do the Sotah ceremony, or if he cohabited with her on the way to the temple, she does not do the Sotah ceremony, but does collect her marriage contract. If the husband died before they could do the Sotah ceremony, Beis Shammai says they get the marriage contract and don't do the Sotah ceremony. Beis Hillel says they either do the Sotah ceremony or don't receive a marriage contract. Similarly, it's debated if a man's pregnant or nursing ex-wife can be made to do the Sotah ceremony or collect a marriage contract. Some say yes, as he can remarry her after a period. It's also debated if an Ilonis, a physically unique woman that exhibits male characteristics, an old woman, or some other woman who can't give birth, if they can do the Sotah ceremony or receive a marriage contract. Some say yes, as they can stay married. If the wife of a Kohen does the Sotah ceremony and is innocent, she can stay with her husband. If the husband is sterile, she can do the Sotah ceremony. A man can warn his wife to not be with any man, even a relative, but there's no validity to warning a wife against being secluded with a minor boy or with someone who's not a man. The court, instead of the husband, would warn the woman if the husband became a deaf-mute, insane, or imprisoned. This is not to make her do the Sotah ceremony, but only to make her not receive a marriage contract. Some say it could be done for the Sotah ceremony if the husband is in prison, as he could do it when he leaves. The Gemara cites sources for the point that a woman pending Yibum does not do the Sotah ceremony. There are further verses as sources for this topic debated on. It also debates based on this if a woman acts promiscuously, if she requires a warning or not to not receive her marriage contract, as to whether or not she sinned, or if she requires a warning prior. It's discussed from this conversation, and it said that she does need a prior warning.
It also asks, in such a situation, if the husband is allowed to stay married to her, which is debated. It also asks if a husband can cancel his warning against seclusion or not, also discussed based on this topic, and we cite a source that the husband may cancel the warning, which is further qualified, and it says that he cannot cancel the warning after the seclusion occurs. The debate between Beis Hillel and Beis Shammai over the marriage contract is on whether a debt in an uncollected document is viewed as collected or not. Some say everybody agrees an Ailonis does not do the Sotah ceremony or receive a marriage contract, as she can't have children. Others disagree. This point, along with the others, are further debated at length. It debates what it means that he can't warn his wife to not seclude with somebody who's not a man by these laws. It debates if this includes an impotent man, or possibly it refers to a non-Jewish person who obviously is considered to be a man, but it uses this as an expression by these laws, as his cohabitation doesn't forbid the wife to her husband here. Some say it simply means he can't warn his wife to not seclude herself with an animal. Some say it references simple physical contact, depending on your definition as to what constitutes an actual act of cohabitation. It gets into a general discussion as to what constitutes positive attributes in a wife, and similar, along with a few unresolved questions on these laws. It also says if either the husband or wife are blind, they don't do the Sotah ceremony, or if either of them are lame or with hands missing. This is based on verses, and it's also not done if the woman is mute. And that's the end of chapter 4. Chapter 5 of Tractate Sotah continues discussing the laws of the Sotah ceremony along with related points. The first Mishnah discusses an incident mentioned earlier in Tractate Brachos, page 27b and further, wherein the Nasi, the prince at the time, Rabban Gamliel, was temporarily replaced, and there was a large influx of students and legal resolutions to unresolved debates. So it goes through a number of those here, some of which involves the Sotah ceremony. It says, based on a few verses, that just as the water of the Sotah ceremony tests the woman, they also test the male adulterer. Further, she's prohibited to be with the husband and also to be with the guy she did adultery with. It was also taught in regards to the laws of purity that a loaf of bread with secondary contamination, such as that it was within an earthenware vessel, can contaminate another item to create a tertiary contamination. It also expounded on the verses teaching the boundaries of the cities portioned to the tribe of Levi, teaching that they received 1,000 cubits of open space and 2,000 further cubits of the Shabbos Tichum boundary. Some say the 2,000 cubits were in fields and vineyards. The verse of the Oz Yashir song by the splitting of the Red Sea, it redundantly says to say. Some say to teach that they repeated it verse after verse, like the way the Hallel prayer said. Some say they actually said it like how they say the Shema prayer. It's also taught, based on other verses, that Job, Eov, only ever acted out of love for God. The Gemara clarifies that both points as to the punishment and forbiddenness mentioned by the Sotah above refer to the adulterer. Based on this exposition, it's debated as to the interpretation of various verses between these opinions and as to the various necessity for specific wording used in scripture. The point is debated in regards to a comparison of the laws of Sotah to the laws of impurity in a Sheretz creature and potential laws derived from them. The remaining points on the logic of this debate are further clarified. It also goes through the points on secondary and tertiary impurity as mentioned in regards to its source. The source for this concept is further described from a comparison to related laws by the transmission of ritual impurity and related points as in regards to the source that Kodesh, holy offering food, can become impure from a fourth transmission. It also further describes if a secondary impurity can create a tertiary impurity by unconsecrated produce. It also explains the debate as to how the Jewish people sing the song as they left the Red Sea after it split. It additionally goes through the points on Eov and says that there were these two students sitting before the sage Rava. One said he had a verse read to him in a dream, "How abundant is your goodness that you have stored away for those who fear you." The other student said he had dreamed of the verse, "But all who take refuge in you will rejoice, they will sing joyously forever, and those who love your name will exult in you." Rava said that they were both completely righteous, as one serves God out of love and the other out of fear. And that's the end of chapter 5. Chapter 6 of Tractate Sotah continues on the laws of the Sotah ceremony and adultery. The first Mishnah says, if somebody warned their wife to not seclude herself with a man and she secluded herself with the man, no matter how the husband hears about this, he must divorce her and pay the marriage contract. Some say he must hear it when it's widespread gossip. If, after a single witness, even a Canaanite slave man or woman, say they saw her commit the adultery, she does not do the Sotah ceremony and does not receive her marriage contract. People who might not like the woman in question, be it her mother-in-law, sister-in-law, co-wife through Yibum, or stepdaughter, they're all believed if they testified she did adultery to make her do the Sotah ceremony, but not to lose her marriage contract. It explains the verse and its necessity to show that a single witness's testimony is uniquely valid here. If one witness, male or female, testifies she did adultery, and another witness, male or female, testifies that she did not do adultery, she would still do the Sotah ceremony. If one witness says she did adultery and two say she did not, she would still do the Sotah ceremony. If two witnesses say she did adultery and one said she did not, she would not do the Sotah ceremony. The Gemara discusses the scriptural sources and necessity for these laws. It debates the validity of secondary invalid witnesses coming after the testimony of a single valid witness. The repetitiveness in the final point of the Mishnah is to show that if there are invalid witnesses involved, it's to show we still follow the majority of opinions even if it ends up resulting in a leniency. And that's the end of chapter 6. Chapter 7 of Tractate Sotah continues going through the laws of the Sotah ceremony, now in regards to the oath taken during the Sotah ceremony. The first Mishnah says, the passage of the Sotah can be read in any language, as can the confession of tithes, the saying of the Shema, prayer, the after-meal blessing, oaths by testimony, and by deposit. The following must be said in Hebrew: the Bikurim first fruits declaration, the Chalitza declaration by the Levirate marriage, the blessings and curses on Mount Gerizim and Mount Avel, the priestly blessing, the blessing of the Kohen Gadol, the passage read by the king at the Hakel gathering, the passage read by the decapitation of a calf, a ceremony during the temple times if a murder victim was found, and the wartime addresses of the Kohen. The scriptural sources for every single one of these is brought, and it explains the sequence by the blessings by Mount Gerizim and Mount Avel. The Gemara further describes the sources for all these points in the manner of how several of these prayers or blessings were said. There are further points on this, and it explains that a congregation can pray in any language, although an individual should pray in Hebrew. It further goes through sources for the language said by the remaining various blessings and prayers. It also more precisely describes the sequence of the blessings and curses by the Jewish people done between the mountains before they entered Israel, and there's debate as to the particular location and placement of the mountains. It also describes points on the crossing of the Jordan and the carrying of the ark, as they did. The ark was placed in the Jordan River and the water split, although it debates as to how high the water split, along with other points such as when the spies carried the fruit back to the Jewish people from the land of Israel, how they carried it in regards to the placement of the men. It speaks further on the incident with the spies' incursion into Israel. It says that Kalev went and prayed at the graves of the forefathers to be able to do the right thing, and Yeshua didn't do this as Moshe had already given his blessing earlier. It explains the names of the giant inhabitants and on the fertility of the land of Israel. It explains how Yeshua spoke good of the land in spite of the negative reports of the other spies, starting off speaking as if he would give a negative report and then switching to a positive one. It also said is that the spies thought it was a poor land, as the Canaanite inhabitants would die as they traveled, but that was so that way they would be preoccupied and wouldn't notice them. Or possibly that it was the passing of Job that caused the inhabitants to be preoccupied. It also describes the punishment of the spies. It said that they died from their tongues extending down to their navel and maggots crawling back and forth between their mouth and navel. Some say that they just died of a throat inflammation. There are further points on the crossing of the Jordan. It goes through the remaining verses on this topic. There are further points on the miraculous events during this. It says how the enemies they fought were miraculously stricken with various afflictions, including by a flying venom-spitting insect that ate them. It also describes the stone placement on the breastplate of the Kohen Gadol. It debates on the order of the placement of the names of the stones and related points. It also describes the incident with Yosef and Potiphar's wife. It said that Potiphar left the house as there was an idolatrous holiday, and Potiphar's wife attempted to cohabit with Yosef, and Yosef almost conceded, but then he saw a vision of his father who spoke to him, so he stabbed his fingers against the ground, hurting himself and preventing an act of cohabitation. This is further described, and it says that when Pharaoh met Yosef, he spoke to him in every language, but only Yosef spoke Hebrew, and the Pharaoh made him swear to not tell anybody. There are related verses expounded on. It also speaks on the splitting of the Red Sea. There's a few opinions as to how that went down. Famously, it says that a man by the name of Nashim ben Aminadov, the prince of the tribe of Yehuda, while everybody else was arguing as to what to do, simply walked into the sea, and when it covered him, that's when the water split. It further describes the placement of the tribes by the mountains, and it also says that by Mount Sinai, the general principles of the Torah were taught to Moshe, and the details were taught in the tent of meeting. Others say that everything was taught on Sinai, and it was reiterated later. It also goes through the curses said by Mount Gerizim and Mount Avel and their meanings. New Mishnah. In the temple, the priestly blessing is said all at once, with God's name fully pronounced as written. Outside, it's said in 3 parts, with the other pronunciation of God's name. Outside the temple, the Kohanim raise their hands to shoulder length. In the temple, they raise their hands above their heads, besides for the Kohen Gadol, who doesn't raise his hands higher than the tzitz.
Others say that he would actually raise his hands higher. The Gemara goes to a number of various sources for the above points on the priestly blessings in regard to the language it's said in, the name of God used while reciting it, and where they hold their hands as they do so, and they do it for all Jewish people, facing them in a loud voice. It's also said that prior to their start, the prayer leader calls out Kohanim, or Kohen, if there's just one giving the blessing. If others speaks on the importance of the Kohanim giving this blessing, that if they do so, they themselves are blessed, that it's done during the avoda portion of prayer and not after. Also that the cup of blessing, a cup of wine with a blessing said on it during the after meal blessings, should be done by a generous individual. It further speaks on the great negativity of misery. It's also said if a synagogue is entirely comprised of Kohanim, they should still give the priestly blessing to the other Jewish people out working in the fields. People shouldn't stand behind the Kohanim as they give the blessing, and it's said that to the sides is still considered to be in front of them. It is also said that once the Torah scroll has been opened, no one should talk at all, even about halacha. The Kohanim must also wash their hands prior to giving the priestly blessing, and they also say blessings prior, which are listed. It gives additional points as to the proper manner of giving the priestly blessings, and on the congregation saying amen afterwards, and after other blessings, for instance, that they must wait until the reader fully finishes his blessing before they say amen. It's also said that the one who reads the Haftorah from the Book of Prophets must initially also read from the Torah, and they wait to read the Haftorah until the Torah scroll has been rolled. It's also said that the congregation shouldn't leave the synagogue until the Torah scroll has been removed, and other points. It also lists the blessings the congregation says as they receive the priestly blessing. This is further discussed along with the placement of various other blessings that are said in prayer. Additionally, it's also said that the Kohanim giving the blessing have the Shekhinah, the divine presence, at their backs. The reason the priestly blessing in the temple was said in one period without the pauses is because they didn't say amen in the temple, which is sourced from a few places. New Mishnah. On Yom Kippur, the Kohen Gadol would read several blessings from the Torah. A Torah scroll would be handed to the head of the synagogue, who would hand it to the deputy Kohen Gadol, who would hand it to the Kohen Gadol, who would read particular Torah portions from it, the portion of Achrei Mos, but on the 10th, he rolls it up and holds it to his chest, declares, "More than what I have read before you is written here." Then he reads another portion by heart, and on the 10th, that is in the book of Numbers, and then says 8 blessings on the Torah, on the sacrificial service, for thanksgiving, for forgiveness, for the temple, for the Jewish people, for the Kohanim, for Jerusalem, and for the rest of prayer. The Gemara says the sequence of passing the Torah scroll doesn't prove that honor can be given to a student before his teacher, as all of that was done for the Kohen Gadol's honor. Prior, the Kohen Gadol was sitting in the women's courtyard. It further qualifies the remaining points on the reading of the Torah and on the method of saying the blessings after. New Mishnah. Every 7-year cycle, on the year following the final Shemitah year, on that year's Sukkot, the entire Jewish people, men, women, and children, would gather in the temple to hear the Torah be read by the king, called the Hakel, the gathering. On this day, they would make a wooden platform for the king in the temple. He sits there, a Torah scroll is handed to the head of the synagogue, who hands it to the deputy Kohen Gadol, who hands it to the king, who stands and takes the scroll, but reads from it while sitting. Once the King Agrippa read from the Torah and chose to do so while standing, and he was praised by the sages for this. When he reached the verse, "You may not place over you a foreigner," in reference to the king, he began to cry, as his father was not Jewish, but the Jewish people told him, "Do not fear, Agrippa, you are our brother." The portion the king reads from is, "These are the words until the Shema." He reads the Shema and the verse, "And it will come to pass, and you shall surely tithe, and when you have finished tithing," then he reads the verses regarding the king on the blessings and curses until he concludes, and then he says the same 8 blessings the Kohen Gadol said at the end of his service in the prior Mishnah, although he switches the blessing for forgiveness with a blessing for holidays. The Gemara qualifies the precise date and timings that this would be done on. Again, all this procedure was done for the king's honor. It also says that King Agrippa and the other kings who weren't from King David's dynasty would sit in the women's courtyard. King Agrippa's renouncement of his honor was proper, as it was for a mitzvah. It also says that them trying to flatter Agrippa was not proper, and it caused many later issues. Further on flattery, some say it actually is permissible to flatter the wicked in this world, which is explained to mean that it could be done for your safety, but not to try and gain benefit. It quotes many verses on this, and it speaks on the great negativity of flattery in general and the punishments for it. It further speaks on how terrible flattery and flatterers are, as are scoffers, liars, and people who gossip, which is based on verses. And that's the end of chapter 7. Chapter 8 of Tractate Sotah begins on a bit of a new topic, the laws of the priestly speech given before battle, as discussed in these verses. The first Mishnah says, during wartime, the Kohen, the priest who was anointed for war, would address the nation in Hebrew. It quotes the verses that would be said, that they should not expect the mercy from their enemies and to not be afraid in battle, and that God is with them, as God was against the Philistines and Goliath, and against the Ammonites and Shavach, so too God will be with them now. The Gemara explains the logic of these cited verses, how they reference Moshe speaking Hebrew, so too this was all done in Hebrew. There are additional points on the Kohen who provides this function, and he starts by saying the Shema prayer, so as to say, even if they have only done the basic obligation of saying the Shema prayer in the mornings and evenings, they will be kept safe. There are additional points, and it goes through many verses speaking about Goliath, his size, his parentage, and that his mother was an extremely immoral woman who cohabited with many individuals based on some verses. Goliath's mother actually was said to be Orpha, whose mother-in-law was Naomi, along with further related points. It also speaks further on the Ammonites and Shavach. It also explains how the ark would accompany the Jewish people to war, and some points on Pinchas, who it says was a descendant of both Yisrael and Joseph. New Mishnah. There are some exemptions to people who were supposed to go to war. Somebody who had just built a straw or cattle barn, or a woodshed or storehouse, or built, bought, inherited, or was gifted a house, or if he planted a vineyard or 5 fruit-bearing trees, even if there are 5 species, or if the trees were planted, layered, grafted, purchased, inherited, or gifted to him. He's also exempt if he just betrothed the woman, whether she's a virgin or a widow, or if it's a Levirate marriage. In fact, if he just finds out that his brother passed away, he can return from the war. All of these prior people need to hear the Kohen speak, but return from the war, and are still required to assist with supplying water and food to the troops, or to repair roads. They're not exempted from fighting if they had built a gatehouse, portico, or a gallery, or planted 4 fruit-bearing trees, or 5 non-fruit-bearing trees, or remarried their divorcee. If it was a forbidden marriage, a widow to a Kohen Gadol, a divorcee, or similar to a Kohen, a marriage to an illegitimate individual, or to a Nazarite, the husband is not exempted from the war. Some add that if he rebuilt a house where it once stood, he does not get to return. Some say if the house is made of poor quality temporary materials, he does not return. If somebody built a house and inaugurated it, planted a vineyard and redeemed it, or fully married a woman, or did Yibum, he does not even need to do anything with the military then at all, not even to supply for the troops or repair the roads. The scriptural sources are all listed. The Gemara further discusses verse sources for these points. This is all spoken on further, including lengthy discourse as to which kinds of planted trees would make valid exemptions from fighting in battle, according to these laws. It also qualifies the points on valid marriage exemptions along with the remaining points. It's also said that this order teaches proper conduct, that a man should build a house, plant a vineyard, get a livelihood, and then marry. The remaining points are spoken on. New Mishnah. The remaining verses are listed. It says anybody who is afraid should return home. Some say this means somebody who is afraid of battle. Others say it means somebody who's afraid due to his sins. They can leave under the guise of the other exemptions. Some say it's for the sin of an improper marriage. It also says that stronger men were put at the front lines to inspire the troops, and also men were stationed behind the army with axes to prevent anybody from trying to run away from the battle and causing even more people to be killed. All of these exemptions apply by voluntary wars. By wars of a mitzvah, like Yehoshua's conquering of Israel, nobody's exempt. Others say it's that the exemptions are by a war of mitzvah, and there are no exemptions by a war of obligation. The Gemara explains the difference in opinions in regards to exemptions for sin. It's if somebody does a rabbinic violation. Sources are brought, and it's said that even according to these, if the man's actually afraid of battle, he'd be exempt. The dispute in regards to fought wars is clarified. Everybody agrees that the wars of Yehoshua were obligatory, and the wars of King David are debated. Some say it was a mitzvah, as it was done for preemptive protection. Others say it was voluntary. This was practically relevant in regards to whether the individuals were considered to be engaged in doing a mitzvah and therefore exempt from doing other mitzvahs. And that's the end of chapter 8. Chapter 9, the final chapter of Tractate Sotah, discusses the laws of the found murdered body and the repentance ceremony involving it as discussed in these verses. The first Mishnah says, in regards to the scriptural laws of if a murdered body is found, the Egla Arufa ceremony was done, involving slaughtering a calf and prayers for atonement. It is done in Hebrew. 3 judges of the Sanhedrin would go to the corpse's location, although some say it was 5. This would not be done if the body was found under a pile of rocks or hanging from a tree or floating in the water, based on verses. This would also not be done if the body was found near the borders of Israel, or near a mostly non-Jewish town, or near a town where there is no court. The body is measured from a town only where there is a court, which will be explained. The Gemara explains the source for this being done in Hebrew, along with the debate on the amount of judges. It further argues as to exactly which members of the court must be present during the ceremony. Based on a source, it would imply that the entire Sanhedrin was required to go out for this. It also defines which opinion would hold that the scriptural source would imply this is not done if the corpse was found covered
murdered or similar, it discusses related points in the laws of field charity. The further points in these laws are clarified. New Mishnah. If the corpse in question was found precisely between two towns, each one of them must offer one calf, and the city of Jerusalem does not do the service. If the head and body are found separately, it's debated as to which it's measured from. It's additionally debated where precisely on the corpse the measurement to the cities begins. Some say from the navel, some say from the nose, some say from the neck. The Gemara says it discusses the corpse being precisely between two cities, as his opinion holds that precision by measuring is possible. By Jerusalem, these laws don't apply, as it wasn't given to one tribe, it was given to the whole nation. The dispute in regards to if the body goes according to where the head or the body were found is a debate as to whether the head or body would move further during a decapitation. The debate as to the location on the body of measurement is that some say it's the nose, as that's the source of breathing, others say the navel, as that's where your stomach is, others say it's debated based on the development of a fetus. The remaining opinions are discussed. New Mishnah. The judges of the Sanhedrin then left, and the town's judges would bring a female calf of cattle that had not been pulled with a yoke, and it's permissible if the calf has a blemish and it's brought down to the hard valley and it's decapitated from the back, and that location can no longer be used to plant or work, although it can be used to comb flax or chisel stones. They wash their hands there and say, "Our hands have not spilled this blood and our eyes did not see." This is to say that they had no part in the murder or assisting the murder. The Kohanim say the verse, "Atone for your people Israel that you have redeemed, O God, and do not place innocent blood in the midst of your people Israel." The remaining parts of this verse say that the blood of the murdered individual will hereby be atoned. The Gemara asks as to why a blemished calf can be used here, and it can't be learned from other offerings, like the red heifer, which can't be blemished, that the same applies here. It debates this comparison from several verses and sources. The remaining points on these laws are qualified, and it also speaks of the importance of escorting people to safety, and if you have nobody with you, you should learn Torah as you walk, and that somebody will be safe even if they're only escorted the first few steps of their journey. It discusses various other points on the importance of escorting individuals as they walk for safety. It speaks on some related verses on the prophet Elisha, who it says was punished with illness, as he caused those bears to attack those children who mocked him, as he pushed away Gehazi, who took gifts from an Aramite general, and he suffered a third illness, which he passed away from. It expounds on these verses and speaks of an additional incident of a sage pushing somebody away, and it having negative consequences. Specifically, the incident involving the sage Yehoshua ben Parachia and Yeshu HaNitzri. Now, some quick background. Yeshu HaNitzri is often translated as Jesus of Nazareth, but that's not a very accurate literal translation. The word Yeshu, in spite of its similarities, does not translate to Jesus. It's a very commonly used acronym, which stands for Yamach Shemai V'Zichroi, literally may his name and memory be erased. Further, this figure is referenced a few times throughout the Gemara, and particularly here in this source, actually it provides some background as to who this character is and what he did. Specifically, he studied beneath the sage Yehoshua ben Parachia at the time of the sage Shimon ben Sotah, and under the difficult rule of the heretical Hashmona'i king Yanai Janius, and all of these individuals lived around 200 to 150 BCE, so objectively this referenced character of Yeshu must refer to somebody living around 150 to 50 BCE, and because of this, most commentaries explain that this Yeshu figure, as referenced in the Gemara here and in several other sources, does not refer to the historical Jesus of the Christian faith. Anyways, with that aside, it says the story as to how he became a heretic. He had studied beneath the tutelage of Rabbi Yeshua ben Parachia for a while, and together they were traveling back to Jerusalem, and they stopped by an inn, at which point the sage praised the hostess in reference to her deeds, but his student criticized the compliment, thinking it was on the looks of the hostess, and saying she actually wasn't beautiful. So because of this, the sage got upset that his student was thinking about such things and had him excommunicated. The student came begging back to him many times, but Rabbi Yeshua ben Parachia always ignored him. Once, the student again came to beg forgiveness, and the sage happened to be finally willing to forgive him and take him back, but he was in the middle of prayer, so he gestured to the student to wait, and the student thought he was motioning him to leave, pushing him away, so he decided to become a heretic, stood a brick on one end, and worshipped it as an idol. Further, he began to practice forbidden sorcery, and caused many others to sin. So when he later re-met his teacher, he refused to repent, saying that it was too late for him, as he'd caused others to sin in addition. So by this and others, we see the negativity of pushing people away with both hands. New Mishnah. If the murderer is found before the calf is offered, the calf is no longer slaughtered. If he was found after, the calf must be buried there, as it had atoned for an uncertainty, and the murderer still receives capital punishment. punishment. If one witness says he saw the murder and another witness says the other witness did not, the calf is not slaughtered. If one witness says he saw it and two say he did not, the cow is offered. If two witnesses say they saw the murder and one says they did not, they do not slaughter the cow. At one point in time, there was a lot of murders, particularly from a man named Eliezer ben Dinai, also known as Techino ben Perisha, who killed a lot of people, so this whole ceremony was discontinued. Further, at some point, there were many adulterers, so the Sotah ceremony was also discontinued based on a verse. Similarly, when the sages Yossi ben Yoezer and Yossi ben Yehuda passed, the comprehensive knowledge of Torah ceased. Other abolished practices, the Ma'aser confession and the waters and strikers, which will be defined along with the banging of the hammer, and they also instituted the mandatory tithing of questionable tithed produce. The Gemara cites sources for many of these points. It also discusses the point on the witnesses of the murder regarding the atonement calf offering. This was abolished when there were too many murders, as those weren't uncertain murders. Everybody knew who was doing them. In regards to the abolishing of the Sotah ceremony, it cites verses as sources for this principle, and it discusses remaining points on how as time passed, the Jewish people have regressed greatly and increased in wrongdoing and similar. The other abolished practices are described the Ma'aser tithes, the awareness, which were the Levium singing the verse, "Awaken, light you sleep, Hashem," which is a reference to God's seeming disregard for our suffering, and was not applicable during a time of peace. The striking that was abolished was that people would make a cut on the forehead of their offerings, so its blood would cover their eyes and make the slaughtering process easier, and it was abolished so it didn't look like a disqualifying blemish. Others say it refers to them striking the animal on the head to slaughter it, which is impermissible according to the laws of slaughtering animals. The banging of the hammers is in reference to the blacksmiths working on the intermediate holidays, which was abolished. New Mishnah. Ever since the Sanhedrin ceased, song and wine feasts were abolished. When the early prophets passed, the Urim V'Tumim ceased. When the temple was destroyed, the Shamir worm and the Neifes Tzufim, which will be defined, were lost, as was the people of faith in Israel. Others add, since the destruction of the temple, every day has a curse. The dew does not fall in blessing. Flavor has been removed from fruit, and some add their richness. Some say this was due to the cessation of purity and of tithing, ended the richness of grain. Others say this was caused by harlotry and sorcery. The Gemara cites sources for these points and the prohibition to listen to music, with some exceptions, and the negative effects of doing so. It further defines which constituted the earlier prophets, essentially being King David, the prophet Shmuel, and King Shlomo, and after the Urim V'Tumim ceased. It further speaks on the greatness of various sages. It defines the Shamir worm, a worm used to carve rock by King Shlomo during the building of the first temple, as will be discussed later in Tractate Gittin, as iron tools could not be used. Also, other things that ceased by the destruction of the temple, it says paranda, silk, white glass, the nofes tzufim, which was a honey bread of a sort, and others. There are related teachings on the importance of studying Torah together, even in poverty, and further. New Mishnah. During Vespasian's siege of Jerusalem, there was a ban by the sages made on grooms' wreaths and on a particular musical instrument. During Titus's siege, they banned bridal wreaths and teaching the Greek language. During the final parts of the campaign, they banned bridal canopies within the city, although it was later re-permitted. When the sage or the mayor passed, there ceased to be composers of parables. When Ben Azai passed, there ceased to be diligent scholars. When Ben Zoma passed, there ceased to be experts in exegesis. When Rabbi Akiva passed, the glory of Torah ceased. When Rabbi Hanina ben Dosa passed, there ceased to be people of deeds. When Rav Yosef Kantonta passed, there ceased to be pious men, even as he was the last of them. When Rabbi Yochanan ben Zakkai passed, the splendor of wisdom ceased. When Rabban Gamliel, the elder, passed, the glory of Torah ceased, along with purity and abstinence. When Rabbi Yishmael ben Pavi passed, the splendor of the kahuna, the priesthood, ceased. When Rebbe passed, humility ceased, along with fear of sin. Further, since the temple was destroyed, scholars and highborn have been ashamed and covered their heads, and meritorious men have been impoverished, while the strong and slanderous have triumphed, and there are none who seek, search, or inquire. The only one on whom we can rely is our Father in heaven. Others add, since the temple is destroyed, the scholars become like school teachers, the school teachers became like synagogue attendants, and the synagogue attendants became like commoners, and the commoners became lesser in their wisdom, and there are none who inquire and search. The only one on whom we can rely is our Father in heaven. During the years of Mashiach's coming, insolence will increase, prices will rise, the vine will give fruit, but wine will be scarce, the government will turn to heresy, and there shall be no rebuke. The meeting place of the sages will be used for harlotry, Galilee will be destroyed, and Gavlan desolate, and the people on the borders will wander from town to town unassisted. The wisdom of scholars will decay, and those who fear sin will be hated, and truth will be absent. Youth will shame the elders, and elders will stand before the young. This is all based on verses. The face of the generation will be the face of a dog, and a son is not ashamed before his father. The only one on whom we can rely is our Father in heaven. The Gemara discusses some opinions on which types of bridal wreaths were forbidden, along with the musical instruments and the bridegroom's canopies. In regards to the ban on the Greek language, there's a story when the Hashmonite kings besieged each other, Hyrcanus outside Jerusalem and Aristobulus inside. Some would sneakily pay to have land snuck over the walls so that way they could keep having the daily temple offerings inside, but one man told those facilitating this in Greek that they couldn't take the city as they were maintaining the temple offerings. So they swapped the animal for a pig the next time, and it stuck its foot in the wall as they were carrying it up, and the whole city shook. So they banned teaching Greek. Some say this isn't a reference to the actual language, but rather to the concept of Greek wisdom. Some in Rabban Gamliel's household still had this, as they were close with the government. It further speaks on the great losses as many sages pass from this world, and it says that in spite of that, humility and fear of sin still do exist. And that's the end of chapter 9 and the entire Tractate Sotah. Alright, that was a lot of information, so here's a rough summary of a lot of the practical takeaways from this tractate. There are various particular practices that used to be done in the times of the temple, particularly the Sotah ceremony as described in scripture. Essentially, adultery is forbidden. In the event that there was a serious concern that a woman had committed adultery, and she denies it, if she agrees, she could be brought to the temple, bring a few offerings, and be made to drink these specially prepared bitter waters. If she had not committed adultery, she would receive blessings of fertility and health. If she had, she would swell and burst, as would the other adulterer. During the times of the conquering of Israel and later battles, there was an obligation for a Kohen to speak before the battle, giving blessings and words of preparation. In some instances, if a person had recently married or acquired a house or similar, he'd be exempt from fighting. In the temple, in the year after the sabbatical year, the entire Jewish people, men, women, and children, would gather in Jerusalem for a pilgrimage called the Hakel Gathering to hear the king read from the Torah. In the temple, the priests would recite the priestly blessing. This is still done, albeit with very slight variation. In the times of the temple, if a body was found murdered and the culprit was not found, as atonement, a calf would be beheaded in the area, along with prayers of atonement called the Egla Arufa, as said within scripture. Tractate Gittin discusses the laws of divorce, and particularly the divorce document, the get, which is given from husband to wife at the time that he wants to end their marriage. The exact method of giving this document, how it must be written, and the witnesses that must view this transfer will all be described throughout. Chapter 1 begins the discussion of these laws. The first Mishnah says, if an agent brings a divorce document to Israel from abroad, he must declare that it was written in his presence and signed in his presence. Rabban Gamliel says this must also be done if it was brought from the towns of Rechem and Cheger. Rabbi Eliezer says this must even be done if it's brought from Kefar Ludim to Lud. But the rabbis say it must only be said if it's being brought to or from abroad. It must also be said by the agent that it was written and signed in his presence if he's bringing it between two different provinces abroad, while Rabbi Shimon ben Gamliel says even between two specific jurisdictions. In regards to the definitions of the borders of Israel, anything east of and including Rechem is considered abroad, anything south of and including Ashkelon is abroad, and anything north of Akko is considered abroad, and it's debated if Akko is considered a part of Israel by these laws. If somebody brings a divorce document within Israel, he's not required to clarify that it was written and signed in his presence, and if people debate the validity of the document, it should be confirmed by the signers of the document. The Gemara explains there are two reasons why such a declaration would be necessary. Either because people abroad don't really know these laws so well, so we're clarifying that the agent must be able to say that the document was written and signed properly with the correct intent. Secondly, it's done because it's difficult to get witnesses in such a situation to confirm the document signatures, so we simply have the agent confirm that he saw it signed when he delivers it. There's a practical difference between these explanations. Either if two agents are delivering the document, the second explanation wouldn't require them to make this declaration. If the document was delivered between provinces within Israel, the first explanation would not require the declaration, and if it was delivered within the same province abroad, the second explanation wouldn't require the declaration. According to the first explanation, that the people abroad don't really know these laws so well, it debates how a single witness is sufficient to testify that the document was written properly, so rather it's explained that those abroad do actually know how to properly write the divorce document, or at least their court scribes know how to. The reason one witness is permitted here is as a leniency to prevent the woman from having to remain in stasis, not with her husband, but also undivorced, unable to remarry. So we want to make it easier for her to be able to get this document. When she receives it, she'll do so before several witnesses, so the husband won't be able to later challenge the document's validity, and also the agent will be careful to make sure that everything is valid himself. In accordance with the second explanation, that the witness's declaration is necessary as it's difficult to get witnesses to confirm the signatures, the reason one witness is allowed is also debated, and the reason is given that the signatures on the document are considered as if they were examined by the court and accepted, and the single witness can confirm it, for the same reason as before, because we want to make it easier for the woman to receive her document and just not be stuck without a divorce. It explains why the second opinion disagrees with the first one, who says he must confirm the document was written with correct intents. He says he disagrees as the requirement of the declaration warrant to say that he saw it written with the correct intent. He just needs to say he saw it written. The answer to this would be that they didn't make it too long, as otherwise the agent might not say the whole quote and it'll then be ineffective. The first explanation debates the second, that it's done as it's difficult to testify the signatures of the document, as then he should only really need to testify that he saw it signed, not that he also saw it written. The answer to that would be that they have to clarify that also, so that we don't think this is permitted by other cases of document confirmation to confirm it with one witness. Based on these explanations, it debates who the author of the Mishnah was in accordance with the opinions held by these laws, if they line up with the cited opinions by the Mishnah. In regards to the cities of Rechem and Cheger, those are explained to be border towns of Israel, and Kfar Ludim is said to be surrounded by the border, like this. Seemingly, the dispute from the Mishnah in regards to the permissibility of documents from these towns is the same dispute as to whether they're not quite far enough abroad that they won't know how to make this document so they would be permitted, or that the witnesses on the signatures are too far so they won't be allowed. The same debate as described here. Alternatively, this dispute can be interpreted entirely like both opinions. If the issue is of improper intent from an abroad divorce document, you can say that the border towns may not be so knowledgeable, or surrounding towns must do it so that way they'll be like all the other abroad towns. The other opinion would apply by this too, only the issue would be he'd hold that border towns are actually too far away to go and get a signature confirmed. We bring similar instances of such a debate and challenge these opinions from particular instances that imply like the other. There are a few additional various cases brought which imply like the other opinion to try and disprove the other, but they're individually qualified to work like both. It's even brought that actually both opinions would agree that in actuality a declaration is needed to confirm the signatures. It also cites which other opinions hold like these two explanations and as to whether they require the additional agent to come with this messenger to certify the validity of the document. Some would even say that if somebody deviates at all from the established procedure of giving a divorce document, the divorce is unsuccessful, meaning if she remarries, they must divorce and their children are illegitimate, as seen in a different case. It also said by the witness watching the writing of the document, he only needs to watch one line be written, as if we started being more stringent, that would cast doubts on many prior written and certified divorce documents. Some even say it's sufficient for the agent to have just heard the sound of the quill writing on the parchment. This would apply even if the scribe was going in and out of the house, and there's no concern that somebody else asked him to write a divorce document for the wife with the same name as the one the agent was certifying, meaning the scribe would now have written it for a different woman, which is not allowed. So that's said to not be a cause for concern. There's a debate if Babylonia is considered to be a part of Israel by these laws of sending an agent to deliver a divorce document. The debate in question is as there were schools all over Babylonia, so they'll be able to certify the signatures with witnesses, while others hold that the students will be busy and unable to certify them. Further, when the Mishnah said everywhere north of Akko is considered like outside of Israel by these laws, that's everywhere excluding Babylonia. By these laws, the border of Babylonia is said to extend until the second willow swamp past the bridge. There are other cities mentioned that said that when delivering a divorce document, they must make the declaration when going from Aktisphon to Bay Ardashir, but not vice versa, as there were markets in Aktisphon that people traveled to, so the merchants recognized the signatures, but the shop goers would not. There was this one city, Mechuzah, whose people were always traveling, so their witnesses were required to make a declaration even within the same neighborhood. The declaration is effective to invalidate a husband's challenge, even if the declaration wasn't really necessary in its case. It's also said that a declaration isn't necessary if the document is being brought from Babylon to Israel, as people to certify the signatures will be found, as people frequently traveled between Babylonia and Israel. It expounds on some related verses, and it speaks on the importance of not having excessive fear in a person's household, as that'll lead to many negative consequences. There's further discussion on this point and on the virtues of being silent in the face of enemies and simply praying to God or learning Torah or similar, which will have God answer instead. It also speaks on the prohibition for bridegrooms to wear a wedding crown after the destruction of the temple, although some hold it was only prohibited for men to wear. It also speaks on the importance of giving charity. It debates the exact placement of the city of Akko in regards to these laws. It's also debated if a divorce document written on a boat in a river is considered to be like in Israel, as to whether the rivers are considered to be like Israel. This is debated from discussion of other laws. It further debates the definition of the borders of Israel and how this extends over the Mediterranean Sea. It also explains how the land of Syria is similar and different to Israel in various ways by multiple laws, as it was conquered by King David. These laws are discussed further. It gets into a related point on if a slave brings his emancipation document from abroad, and it says, "Your person and my possessions are acquired by you." The slave goes free, but he does not acquire the possessions. If the document just wrote, "All my possessions are acquired by you," it's debated if this is valid. Some say no, as it's a single statement, so he doesn't get his freedom or the possessions. Others say yes, as it's like a divorce document that the woman herself can confirm and free themselves, but not get any extra possessions. The points are further disputed. The ending of the Mishnah was that if people contest the divorce document, it should be confirmed through its signers. The disputant in question would refer to the husband. New Mishnah. If somebody brings a divorce document from abroad to Israel and cannot declare that it was written and signed in his presence, if there are witnesses who signed it, the signers must confirm it. These laws of divorce documents and slave emancipation documents are similar by taking the document to and from Israel, among other laws. The Gemara explains the case in question, where he cannot declare that it was written and signed in his presence, is where he saw it written and signed properly, but then he later became a deaf mute. It lists other similarities between a divorce document and a slave emancipation document. These similarities are further discussed. There are additional points. New Mishnah. Any document with the signature of a Kuthian witness is invalid, besides for a divorce document and a slave emancipation document. It cites an incident where this occurred. The Gemara debates the author of this Mishnah as to who holds like these laws in regard to the Kuthians. And it says the case is like the opinion that doesn't typically allow Kuthian signatures, but here there's a signature from a valid witness underneath, so everything's certified. This case is for the debated. New Mishnah. All documents processed by non-Jewish courts, even if the witnesses who signed them are non-Jewish, are still valid documents besides for divorce or slave emancipation documents. Some say even those are still valid, they're just invalid if it was made by somebody who's not a judge in such a case. The Gemara asks, based on this, why a gift document signed by a non-Jewish court is still valid, and explains, as has been established, that the law of whatever country you're in is legally binding according to Jewish law also, so they would still hold validity. The opinion that it does allow such divorce documents is where the signatures all have clearly non-Jewish names, but if they aren't typically non-Jewish names, then that's where they would be treated like private documents. Alternatively, is that the ending part is just in regards to financial documents, which are only invalid if written privately. It brings sources for this view, and it brings instances of the validity of other such documents. This is discussed further. New Mishnah. If somebody tells their agent to give a divorce document to their wife, or to give an emancipation document to their slave, according to Rabbi Meir, if he wants to retract this before it reaches them, he can. The rabbis say he can only do it for the divorce document, as they hold you can only benefit a person in their absence, not disadvantage them. Here, a slave's support is voluntary, while a wife's support is mandatory. Rabbi Meir argues that by emancipation of the slave, he can no longer eat teruma, so it should be disadvantageous to him also, but the rabbis say the slave is his property, so it's not really their loss. The Gemara says, based on this, according to the rabbis, if somebody takes property from a debtor on behalf of a creditor, the creditor can viably acquire it as it was only advantageous to him. Others disagree with this point, and it's debated. It argues these opinions based on several related verses and topics. It further debates based on this discussion in the event that somebody owned a slave, whether he's legally required to sustain him, and as to the point that he cannot take his earnings without feeding him, and similar. This topic is further debated. There's additional debate as to whether somebody can make their slave work without being obligated to feed them. Many bring proofs from several discussions that this is not permissible. Others disagree. There are additional points on this. New Mishnah. If somebody tells his agent to give a divorce document to his wife or an emancipation document to his slave, this is no longer done if the husband died in the meanwhile. If the husband told the agent to give somebody an amount of money and then died in the meanwhile, the agent would still deliver the money. The Gemara says the money case is specifically where the husband pointed to the actual physical coins he wanted given, and some say the husband in question is healthy and he gave the coins in the presence of the agent and the recipient to automatically transfer it to them. Others say it's a sick man giving the coins and he's allowed to send an agent to give specifically specified coins, out of concern that if it was unspecified, he may have been referring to some hidden coins somewhere. although it is ruled that that's not a concern. These two answers disagree with each other, as the second doesn't hold with the principle of automatic acquisition between all three parties, whether it's a loan or a deposit, and the first opinion disagrees with the second, as they hold that the wording of the Mishnah implies that the case uniquely cannot be referring to a sick individual based on the sending of the divorce document portion. These opinions further debate this. Some clarify that the principle of the three present party acquisition was tradition passed down from Mount Sinai among a few listed others. It brings some instances and examples of this principle's occurrence. It's additionally debated as to whether somebody in debt who gives money to an agent to be given to the creditor, whether or not he's allowed to retract that payment prior to it reaching the creditor, meaning it's questioned if it's been fully acquired on behalf of the creditor or not. They cite sources in accordance with their opinions along with a few related incidents. The point on whether telling an agent to take something is considered an acquisition, if that's the case, is debated further based on other sources. There's additional points on this in regards to a particular case. And that's the end of chapter 1. Chapter 2 of Tractate Gittin continues going through the laws of divorce and the divorce document. The first mission says, if somebody brings a divorce document to Israel from abroad, and he only said the document was written in his presence, or he only said that the document was signed in his presence, or he said that it was written in his presence and half was signed in his presence, or he said that it was signed in his presence and half was written in his presence, in all those cases the document is invalid. If one person says it was written in his presence and a different person says it was signed in his presence, it's invalid. If two people say it was written in their presence and one person says it was signed in his presence, it's debated if this is valid. If one person says it was written in his presence and two people say it was signed in their presence, it's a valid divorce document. The Gemara says this is necessary in addition to the first Mishnah of the Tractate to show that the document is valid specifically if the agent says he saw it written and signed in his presence. In regards to the agent seeing half the document written, it refers to the last half. If somebody saw the document written and half of it signed, we said it's invalid. Some say even if there are two additional people who come and certify the signatures, the document is still invalid as the document can only be confirmed through the standard signature confirmation, or through the instituted agent confirmation, and not through a combination of both. Others disagree with this and say it'd only be impermissible if there was one other person certifying the signature, as we don't want people to draw a false comparison that one witness is sufficient by other monetary document certification. Others say that this would still be invalid for the above stated reason that it can't be a combination of certification methods. This argument is further disputed from additional sources, and it brings other similar arguments as to the validity of combining different factors to create a single status, like by different wall measurements, different combining hand washings, and similar, which are all disputed points. These laws are debated, and there's some unresolved questions about the validity of immersing half of somebody in a mikveh and then pouring water on their other half. It was held that if one person says the document was written in their presence and another person says the document was signed in their presence, it's invalid, but it said it would be valid if both of these individuals were appointed as agents to deliver the document. There are other versions of this dispute which are additionally qualified. It was said, if one person says the document was written in his presence and another two say it was signed in their presence, it's valid. This is said to apply if the document was produced by the witnesses to the writing, as that individual has additional credibility, so it's as if two of each certify the document. This would imply that if two agents bring the divorce document from abroad, they'd still need to certify that it was written and signed in their presence. Others debate this point, and it's discussed. New Mishnah. If a divorce document was written and signed on the same day, or written and signed on the same night, or written at night and signed on the following day, it's valid. If it was written by day and signed that night, it's debated if it's valid, some permitting a predated divorce document only as opposed to other types of documents. The Gemara gives explanation as to why a divorce document must have a date recorded on it. Some say that if the woman in question was married to her uncle and then committed adultery, the husband would want to protect her, so would predate a divorce document to make it look like they had gotten divorced beforehand. Others say it's to prevent a husband from benefiting off of his ex-wife's property after the divorce. The reason the second explanation disagrees with the first is that they hold that unchastity is uncommon, and the first explanation disagrees with the second, as he holds that the husband can use his wife's property up until the time of the actual giving of the divorce document. Accordingly, these opinions would dispute in accordance with the opinions from the Mishnah as to whether a predated divorce document is actually permitted, as the second explanation's issue doesn't really involve predated divorce documents, it's more involving post-dated ones. This means they'd all hold differently as to when the husband can't benefit from his wife's produce property, either from when the divorce document is given or written, depending on the Mishnah's dispute according to explanation 1, or from when it's signed or written, depending on the Mishnah's dispute according to explanation 2. There are additional points on this. It says, we're not really concerned about the husband cutting the date part out of the document to steal his wife's produce. We say, if on the document the date is written as just the 7-year sabbatical year cycle,
or just the year, or just the month, or just the week, it said the document is still valid as it prevents the husband or wife from doing any of the listed wrongdoings within that time frame. It also says that's not really a concern of a case where a husband writes a divorce document and then hold on to it just in case. As it said, a person really doesn't do that because he doesn't want to bring misfortune upon himself in such a situation. Additionally, there's not really a worry of predating in a divorce document brought in from abroad and it taking a very long time to reach Israel to be given, as people would hear about it and then report the timings. A woman typically needs to wait around 3 months before remarrying to prevent issues of pregnancies from being possibly from either husband. There's a debate if we start counting this period from the time of the giving or the time of the writing of the divorce documents. These opinions debate this and cite sources for their respective opinions. The law, however, is that it's decided to be that the counting starts from the time of the writing of the document. There's a similar dispute between these opinions as to when a marriage contract becomes considered like a normal debt contract, which can get cancelled by the sabbatical year. Some say when the wife accepts partial payment from the contract and establishes the balance on her ex-husband as a loan. The opinion says only the first part is necessary. They cite sources, but we find one that implies more like the second opinion. There's additional argument if a marriage contract can be predated, like other documents, which is argued between these opinions. The opinion which permits a predated divorce document would hold that once the husband decides to divorce his wife, he can no longer eat the produce of her property. Additionally, he'd only permit this predated divorce document if it was written and signed immediately. If it was signed from then until 10 days after, it would be invalid, as there's a concern the couple would reconcile and then cohabit, thereby invalidating the document. Others disagree, saying if such a thing occurred, it would then be public knowledge. There is a case brought if a man went to 10 men and told all of them to write and sign a divorce document. Some say this means that 2 of them are acting as witnesses and the remaining are just as a stipulation on the document. Others say that all 10 must act as witnesses. There's a practical difference if 2 of the 10 men sign it on that day and the remaining men sign it on later days. The first opinion would hold that this is valid, and the second would say this is not valid as they were all witnesses. Another difference would be if one of the 10 was a relative. If one of the first 2 men that signed were ineligible or a relative, some say it's valid as he's just fulfilling the stipulation. Others say it's invalid as it could get confused with a case of regular documentation. A case like this did occur with only 2 signers doing so on the day of, and it was ruled leniently by an emergency. This is qualified. New Mishnah. A divorce document can be written with anything, with ink, paint, red pigment, copper sulfate, or anything lasting. You can't use liquids, fruit juice, or anything impermanent. A divorce document can be written on anything, on a detached olive tree leaf, on a cow's horn, although the husband must give the woman the cow, on the hand of a slave, but he must give the slave, and others hold that you actually can't write a divorce document on the hand of a living creature or food. The Gemara further defines all of these different types of pigments. Some Shabbos laws, by types of ink, writing is forbidden on Shabbos, and it's said that if somebody traces over black ink on Shabbos with red ink, he's liable for both writing and erasing. If he traced black ink over black ink or red ink over red ink, he's not liable. If he traced red ink over with black ink, some say he's liable only for erasing, others say he's not even liable for erasing, as he destroyed the letters beneath. This is a stricter opinion by Shabbos laws. For instance, this opinion would say, in spite of this logic, by a divorce document, you can't have somebody write the signer's name in red ink and have the signer himself trace it over in black ink. For an illiterate signer, some suggest etching their name into black paper and having them fill it in with black ink. Others say we can write their name in lead and then have them trace over it with ink. This is assuming the lead isn't water steeped in lead, which actually can be used to write the document itself. Some suggest having them trace over their name writing in gallnut juice, assuming the paper was pre-treated with gallnut juice so that way it won't show. Some say they should trace over their names written in saliva. All of these methods work only with divorce documents, not with other variants. Sources are brought and it debates the necessity of the witnesses actually reading the document. If the document was written in a foreign language, some would have people who spoke that language read it to them separately, informally, and use their translation to facilitate the document. Some say if the document was written in a foreign language but Jewish witnesses signed it, it's nevertheless still valid, although this is debated in regards to the assurances necessary that it's not a forgery. If a husband gave his wife a blank document and said it was the divorce document, some say this is valid, as it could have been written with gallnut juice, which got absorbed into the paper, although they clarified that at the time of the giving, it wasn't fully absorbed, therefore making her a doubtful divorcee. This is qualified, and it brings additional cases of unique divorce document deliveries. If the husband says, "This is your divorce document," and then throws it between some jars, and the woman goes to find it and instead finds a mezuzah scroll, assuming it's the only of such scrolls found, we assume that's the document the husband threw, as mezuzah scrolls aren't typically left among jugs. There's a case mentioned where a husband took a Torah scroll and gave it to his wife, saying it was her divorce document. And it's explained this is invalid as the Torah scroll was treated with walnut juice, so the new writing wouldn't show against it. In the event that the person writing the document didn't do so with the intent that it should be for the woman, so then retraced over everything with the proper intent, it's debated if this is allowed based on a dispute, if it's allowed to retrace over such a document. There are additional points on all of this, along with points as to whether engraving is a permissible manner of writing a divorce document, which is debated based on the definition on the manner of engraving and indentation. There's additional lengthy discussion on all of these points. It also goes through some further unique manners of document transfer, including a case where a husband gives his slave a divorce document for his wife and then gives his wife a gift document for the slave, thus allowing her to acquire the slave and be divorced through the document that he's holding. This would function validly so long as the slave is bound, therefore giving him a similar legal status to a courtyard, which a woman is allowed to acquire a divorce document from. Both of these points are specified to show that either the bound slave or the courtyard individually function to allow transfer of a divorce document through them. Others dispute this, saying the woman needs to be actually handed the document, meaning an acquisition with her consent, but this is refuted. In regards to writing the document on the horn of a cow, it said you must give the cow, as severing the horn after the writing would intervene between that and the giving and invalidate the document. It gives sources for the opinions which hold the divorce documents cannot be written on living creatures or food, based on verses, although the other opinions interpret them differently. New Mishnah. It's an invalid divorce document if it's written on something attached to the ground, although if it's written and then detached and then completed and then given to the woman, it is valid. Others say the writing and completion must be both done after it's detached. Some hold we don't write a divorce document on previously erased paper or on unfinished parchment, as that could be forged, but others disagree. The Gemara explains the divorce document that would, in theory, be valid if attached to the ground. That's if the entire first portion of the document containing the names and are all not yet filled in and will be written only after it's detached. Some say this portion, that's the part that can't be written while it's attached to the ground. Others say it's the signatures that are the main concern. It's agreed that if a person wrote the document on an earthenware perforated pot, it's valid, as he could give the pot. If he wrote it on a leaf in such a pot, it's debated if this is valid. Some say it's allowed, as, again, he could just give the entire pot. Others say no, as this is concerned, he'll pull off the leaf and give it to her, which would not be allowed. It brings some additional laws of acquisition in regards to the perforated pot, as to if the acquirer also gets the seeds, and similar, along with some laws on tithing, which are discussed further. In regards to not writing the divorce document on unfinished parchment, it gives definition as to the different levels of high treatment, which has practical differences in regards to the minimum amount of liability for carrying by the laws of Shabbos. In regards to the opinion that you can write the divorce document on erased paper or unfinished parchment, this is as he holds that it's the witnesses of the document's delivery who have the power to sever the marriage, and there's debate if there's still concern for forgery as to whether such a document must be used immediately or not. It's also disputed if this leniency applies only to divorce documents, according to this opinion. New Mishnah. Everybody is qualified to write a divorce document, including a deaf mute, an insane person, and a minor. A woman can write her own divorce document, and a man can write his own receipt for a marriage contract payment, as their validation is through the signers of the documents. The Gemara says, some hold by those first three, who are legally considered mentally incompetent. It only works if an adult stands over them and instructs them. This would not apply by an idol worshipper who's writing this document, as he has his own logic and intents. This opinion is disputed. Some even say if a divorce document is found just lying in a pile of garbage, it can be used so long as the wording and names all line up, and if it hasn't been signed yet. There are further such points, and it's a dispute as to whether just the signing or even the actual writing of the text of the document needs to be done with the correct intentions for all of these cases. Some interpret our Mishnah, where the mentally incompetent individuals write the document, to be specifically referring to where they left the first half of the document blank, which is disputed based on if you hold it's necessary. New Mishnah. Everybody is qualified to deliver the divorce document to the wife, besides for a deaf mute, an insane person, a minor, a blind person, and a non-Jewish person. If the minor received the document and then became of age, or the deaf mute received it and was cured, or similar with all of the other examples, he's still not allowed to deliver the document. If a regular person was given the document and then became a deaf mute or insane or blind or similar, and then was healed and went back to normal, he can bring the document. As a general rule, if somebody is mentally competent at the beginning and end, he's qualified to bring the document. The Gemara explains why a non-Jewish person can't deliver the marriage contract. He is considered to be mentally competent, it's just that the laws of marriage by him are different than by a Jewish person, so he can't legally bring a divorce document on somebody's behalf. The issue with the blind person bringing it is debated. Some say it's because he doesn't know who he's giving it to. Others say he could use voice recognition, so the issue is that the document is that it's being brought from abroad, meaning the agent must testify that it was written and signed in his presence, which a blind person cannot do. And people clarify that it would be valid if he wasn't blind and he saw it signed and sealed, even if he's still blind when he brings the actual document, unlike by all the other cases. It disputes if a Canaanite slave can bring such a document based on a similar logic as to why a non-Jewish person can't bring it, and that these laws don't apply to them. Some say it does to an extent, so it's disputed. New Mishnah. Women who are not believed to testify that a wife's husband died, as described towards the end of Tractate Yevamos, being a mother-in-law's daughter, a co-wife, her husband's brother's wife, and her husband's stepdaughter, are nevertheless still trusted to bring the divorce document, as there is a written document which proves legitimacy here. The wife herself can bring the document, but must testify that it was written and signed in her presence. The Gemara brings a source which seems to say that these women are not actually trusted to bring the divorce document. Some say the difference is if this occurred inside or outside of Israel. It's disputed which way. There are disputes for it not being allowed if it was written inside of Israel. This is further discussed, and it goes through how a wife can bring her own divorce document. Some say it's as the husband tells the wife to be an agent until she arrives to the court in Israel, at which point she should give it to a second agent who she would receive it from. Others say she should testify to the court that it was written and signed in her presence, and then the court should give it to a second agent who then gives her the document. And that's the end of chapter 2. Chapter 3 of Tractate Gittin continues going through the different laws of divorce and on the writing and delivery of the divorce document. The first Mishnah says, a divorce document that's written for the sake of a different woman is invalid. For instance, if a man was walking through the marketplace and heard a scribe writing a divorce document specifying coincidentally him and his wife's name, he can't use that document. Or if a man wrote a divorce document for his wife and he then changed his mind, somebody else with the same name and wife's name cannot use that divorce document. Or if a man had two wives with the same names and he wrote a divorce document for one, he can't go and use it for the other wife. Or if a man told a scribe to write a divorce document for one of his two wives that had the same name and he decided which one to give it to, that's invalid. Like I want to explain, the first case, based on particular use of wording, is where student scribes were practicing writing the divorce document. This means that the document wasn't even a divorce document at all, and the second case is more extreme as it was an actual divorce document, and the third case is more extreme as it was written for the man to divorce with, and the fourth is more extreme as it was technically also written to divorce the correct wife with. It says scriptural sources for the disallowance of all these cases that it must be a valid divorce document written specifically for the correct women alone with no retroactive clarification to make it for the women. In the third case, where it was written for one woman and he wants to switch it, he is still allowed to use it on the first original woman. Based on this, some derive that if two people with the same name who live in the same town, they both may produce a loan document against each other. This is debated. In spite of the lack of validity to the above cases of unspecified divorce documents, they still do work to make it that the woman can no longer marry a Cohen, although it's a debate if the first case works in spite of its invalidity. Some say only the last case disqualifies her from marrying a Cohen, some say none of them do, and there are related points on these opinions. According to this, it further asks if retroactive clarification would function in regards to the writing of this divorce document. Some say no, and it's questioned based on a discussion by the bringing of the Paschal offering being retroactively clarified to be for one of somebody's sons, as discussed in Tractate Pesachim, depending on who gets there first, although that's said to not be really the principle of retroactive clarification so much as it is a father encouraging his sons to run and do a mitzvah. This was all discussed on page 89a of Tractate Pesachim. In regards to the validity of retroactive clarification, berera, as it's called, by the divorce document, it also debates if this only applies if the decision being made, which the clarification hinges on, is being made by the individual himself or somebody else. It brings some instances to try and prove that seemingly many hold that retroactive clarification does not function if you yourself make the decision, but they would hold its permissibility if others are making the decision. Others debate this and still accept the validity of retroactive clarification if it's made by others or himself. New Mishnah. A divorce document has two parts. The first half, the toiref, which contains particularities of the divorce document, the specific names, the date, etc., and the toifes, which is the universal wording that's in basically all divorce documents. If a scribe is just filling in the lower toifes parts on a bunch of documents, he must leave the spaces of the names and date blank. If a similar thing is being done by a loan document, the space for the names, price, field designation, and date must also be left blank. This was done to fix a difficult situation, which will be explained. It's actually debated, however. Some say none of this is allowed, some say it's only not allowed by a divorce document, as the woman says it must be written for the woman's sake. The Gemara says that some add that the words "you are hereby permitted to every man," which is the main part of the divorce document, should also be left blank to be filled in with the intent for the correct woman when it's actually written, even as the witnesses of the delivery are the ones actually severing the marriage. The necessity for this statement is explained. The notion of fixing a difficult situation, as mentioned, was for the scribe to make things easier for him. The opinions that disallow writing the divorce document in such a manner do so, as they hold that writing the bottom part of the document will lead a person to accidentally also write the top part. The opinion which additionally forbids doing this with any document is as he holds that will lead to a person also doing this by a divorce document. Some say the issue is that the whole document must be written for the sake of the woman. Some say the issue is the scribe's wife might overhear him writing the divorce document and think it's for her, and it could cause a fight. Some say the notion of fixing a difficult situation, as mentioned, allowing this practice, was to prevent the woman from going undivorced, for instance, to allow the husband to find somebody who can write the document in this easier method. In regards to marking the date on the document, the reason for this was described earlier, but by the divorce from a betrothal, where those explanations just don't apply, it's done so that people will know the divorce was after the conception of a child. We rule like the opinion that the main bulk of documents can be written beforehand to be filled in with the specific names and dates later, besides for the divorce document where that's not allowed, although others do still disagree. New Mishnah. If a man's agent was bringing a divorce document to his wife and he lost it, if he immediately found it, it's still valid. If not, and it takes a while, it's invalid, as it could be that it's somebody else's document with the same name. If, however, it was stored in a specific type of container that the agent recognized, it would be valid. The Gemara quotes a different discussion that seems to imply we are not concerned about finding an identical divorce document during travel, but that's explained to be where there's no caravan. Unlike here, where we're discussing where it's within a caravan, so the odds of somebody having a similar divorce document are a bit higher. Related points are discussed. There's further debate on these cases and particularities between unique cases. Some say the difference between cases is the one which said you can reclaim a lost divorce document is where he's able to identify it based on a little hole specifically next to a particular letter. Whether or not a broader identifying mark, like a hole anywhere on the page, is sufficient, whether under biblical or rabbinic law, is debated from particular cases. We said the lost divorce document can be used if it was found immediately. There's debate as to how much time approximately this is. Some say less than the time for a caravan to have passed by a pitched camp. Some say so long as nobody else has passed by yet. Some say so long as nobody has stayed there. Some say it's the time necessary to write a divorce document, some say it's the time necessary to read a divorce document, and some say it's the time necessary to write and read a divorce document. It's held that even if it's lost for a while, but it can be identified with specific identifying marks, such as mentioned, a hole next to a specific letter, it can still be used once it's found. In regards to the ruling as to what's held to be considered to be immediate in regards to finding the divorce document, some say it's so long as nobody's stayed there, some say it's so long as nobody's passed by there. It also gives definition to the containers that the document can be found inside of in the cited case by the Mishnah. New Mishnah. If an agent was bringing a divorce document and the husband, when he gave it, was old or sick, the agent can still deliver the document to the woman with the valid presumption that the husband was still alive. This has a similar application by other laws. For instance, if a non-Kohen woman married a Kohen and the husband was abroad, she can assume her husband is still alive and eat terumah tithes. Or if a person sends his chatas offering to the temple from abroad, the Kohanim in the temple can still offer it, assuming the sender is still alive. The Gemara says an opinion that, however, we do not assume a person will still be alive if when the agent left, the man was over 80 or in his death throes. There are sources which say that we do still assume the husband's still alive, even if he's way over 80, but that's possibly where the man was particularly noted for his longevity. It cites a different case where it implies that there is actually a concern of a husband dying by giving his wife terumah, but that's said to not be comparable to the delivery of a divorce document through an agent, where such a thing cannot always inherently be a concern, or else the whole concept just wouldn't be possible. There's further points on this. There's additional discussions mentioned by the case of the delivery of a chatas offering, as the person bringing it must lean on it. It's either where he sent it with a woman who could do that for him, or it's a bird chatas offering which is not leaned on. It mentioned this principle of not assuming the sender is dead by a divorce document, and then also by terumah, where the woman can just choose to not partake in it. And it also taught the chatas offering case to show that by a bird offering it can still be brought inside, even though there's a doubt if the sender is alive, which makes the animal now unconsecrated and not allowed to be brought into the temple courtyard. So it says there is no such concern. New Mishnah. It was held regarding a town besieged by an army, a ship in a storm, and somebody being tried for capital punishment. They are still nevertheless presumed to be alive. If the town was captured by the army, the ship was lost at sea, or the person is going out to be executed, they have the stringencies of somebody that's alive and the stringencies of somebody that's dead apply to them. For instance, a non-Kohen woman married to a Kohen, or a Kohen woman married to a non-Kohen, they cannot eat truma in this situation. The Gemara clarifies the case of being tried for capital punishment is specifically by a Jewish court. If it was a non-Jewish court and he's been sentenced to death, you can just assume that they'll follow through with that and treat him like a dead person. This is assuming the verdict has been signed, so that way there's no concern of them taking a bribe. It cites some related cases discussing whether or not somebody died or was executed by a court, and it's held that we would believe non-Jewish people if they casually mention that somebody died. However, there is a concern by if they're involved with the court function of the actual execution, as they're not automatically believed if they say they executed somebody, as they were involved with the matter, so therefore their testimony is somewhat biased. There's further discussion on this. New Mishnah. If an agent was bringing a divorce document within Israel and he got sick, he can give it to a second agent to deliver it. If the husband told the first agent that he should collect a specific object from his wife, the agent can't have somebody else deliver the document, as the husband wanted specifically this agent to collect the object from his wife. The Gemara says this principle applies only if the first agent becomes sick, not in other cases. It also said cannot apply if the husband specifically told the agent that he should deliver it, according to some, the wording of which is debated. It also brings a different case where the husband informs agents to write the divorce document, and it learns in that case that they can't give the documents to secondary agents, which seemingly contradicts our case, but that's explained to be unique, where clearly the husband, as he's having others write it, is embarrassed, and he wouldn't want other people getting involved in this whole situation. Alternatively, it's different here, as the agent was given an actual document, and by the other case, he was only told something to write a document, which he then delivers. There's practical variation by a gift document, which is debated if it's considered to be similar to a divorce document. In regards to the last ruling, that if the husband told his agent to pick something up from his wife, only he can do it. Some derive from this that a borrower or renter cannot lend or rent the objects to other people. Others disagree that this is the source for this ruling, although it's debated. New Mishnah. If an agent was bringing a divorce document from abroad, this time not within Israel, and he got sick, he can give the document to a second agent, and the first declares before a court that it was written and signed in his presence, although the second agent doesn't need to do this when he actually delivers it. He just needs to say that he's an agent of the court. The Gemara says it implies that the second agent can then go and appoint a third agent, but it said that this must be done before a court. It also says if the agent is delivering the divorce document within Israel, he can appoint an agent who can appoint an agent, etc. Although if the first agent dies, the remaining agent lose their authorization. Others disagree and say they would only lose authorization once the husband dies. It provides a few cases of these instances occurring. It also explains how there is no concern of the husband fixing his relationship with the wife in the meanwhile, and invalidating the agent's need to bring the divorce document. This is qualified. New Mishnah. People need to give tithes to Kohanim, Leviim, and the poor. So, if somebody lends money to a Kohen, a Levi, or a poor man, he can hold that the necessary tithes, which they'd be getting from his crops, will instead just be kept by him as repayment for the loan. Anyways, he can make these designations assuming the debtors are still alive, with no concern that the Kohen or Levi died in the meanwhile, or that the poor man just became wealthy. If they did wind up dying, the lender must get permission from their heirs to take their tithe portion as payment. This does not need to be done if the initial deal was made before a court. The Gemara suggests that this deal, that the lender can retain the tithes as repayment, is permissible even though the tithes haven't yet been designated to go towards the specific Kohen or Levi, either as the lender here is good friends with the Kohen or Levi, so it was definitely going to go to that guy anyways, or the ownership of the portions was given to the borrowers through somebody else, so they have legally acquired it, or it's a rabbinic institution that this is a valid acquisition. It explains why these opinions disagree with each other, along with some related points in this case, such as that he can fix the price of the tithes of the produce at a cheaper option, which can be done even once the price drops, and there's no principal of interest applying to any of this. It's also said that he cannot retract from this agreement, although the Kohen can retract on his end. There are additional points. It discusses this further, and also in regards to collecting his payment from the heirs if the man dies, as mentioned in the end of the Mishnah. There's additional points on giving tithes, such as specific cases of concern about a lack of tithes taken from an amount of given produce, which are further qualified. New Mishnah. If somebody sets aside fruits or coins to separate necessary tithes from them, and they're not right before him, he can separate the tithes, assuming the fruits or coins still exist. If afterwards he finds that they were lost, he must be concerned that they were lost within the time of his tithe designation within a 24-hour period. A related topic, there are 3 points that wine must be examined to make sure it's not turned to vinegar by the blowing of the east wind after the holiday of Sukkot, at the time of the budding of berries, and at the time that liquid enters unripe grapes. In regards to the designated period of 24 hours, some say this means there is concern by his tithing 24 hours before he found that the produce went missing. Some say it's 24 hours after, although it's disputed based on the wording, and there's debate on these times. In regards to checking when the grapes go bad, some add specific times when grain and wine can be sold 3 times a year by particular seasons and holidays, which is explained to refer to times when a partner can sell those produce without consulting the other partner. It also cites many verses and discussions on the east wind and upon the other winds and their importance, the harshest of which is said to be the south wind, which is blocked by the angel Ben Nates to protect the world. It also goes through the negative effects of the east wind, which causes decay in many things, and it cites verses on this topic. There are further instances of this given, and that's the end of chapter 3. Chapter 4 of Tractate Gittin goes through additional laws on the bringing of the divorce document and points on its nullification when it's being brought by an agent. The first Mishnah says, if somebody sends a divorce document to his wife through an agent and he bumps into the agent before he delivers it, or he sends another agent to run and catch up to the first, he can tell him to make the divorce document void and it's been nullified. If the husband or his second agent reaches the wife first and tells her the divorce document that's going to arrive soon is void, it's nullified so long as it hasn't arrived yet. If it had, it's too late. Additionally, as the agent is traveling, the husband could convene a court elsewhere and nullify the divorce document where he is, although it was later decreed that this was not allowed as it could cause many issues. The Gemara says the wording implies that even if the husband bumps into the first agent by chance, he could nullify the divorce document without concern that he's just trying to annoy his wife throughout this whole process. The fact that he's allowed to send a second agent shows that his orders to the first agent do not override the orders of the second. Additionally, it taught the case where the husband reached his wife first to show, again, by here too, there's no concern that he did this to mess with his wife. It also shows that this is not a concern by him sending the second agent to his wife, even though he only did it through an agent. Further, it specified the husband can't nullify the document once it's actually reached the woman, to show that even if the husband is clearly rushing to try and annul it, but just doesn't get there in time, it nevertheless still would go through. It also discusses specific wording the husband should use to nullify the document. It works to say things like, the divorce document is void, or I do not want it, but to say things like the divorce document is invalid or it is not a divorce document, that does not work. These phrases are additionally qualified. Additional particular phraseology are discussed. If the husband cancelled the divorce document, it's debated if he can then later go and reactivate it. It's held that he can, although it is discussed. Prior to the annulment of the principle that the husband can just bring together a court to annul the document right where he is, it's debated if this court must consist of 2 or 3 people, as to if that's considered to be a legal court for this. They argue over sources as to the number of judges required in various circumstances. In regards to the prohibition of this practice, of no longer allowing the annulment of a divorce document from far away with a personal court, this was done to prevent possible illegitimate children, as the wife wouldn't know that the divorce document she received was cancelled, and then she might impermissibly remarry. Others say the concern is the inverse, that wives who were divorced via agent won't remarry out of concern that their husband undid the divorce with his own court. The debate between these is as to whether the woman will find out about this via the information spreading, depending on whether this occurs if the annulment was done before 2 or 3 witnesses. After the institution of this, that it wasn't allowed. If the husband did nullify the document with his court anyways, it's debated if this now has any validity. Some say no, as the betrothal and divorce function through the sages, which means they can retroactively nullify the divorce, as even if the betrothal was done through cohabitation, they could just retroactively make it that their act of cohabitation was just a form of illicit relations, meaning they were never legally married in the first place. If a husband told 10 people to write a divorce document for his wife, some say he can nullify this before only one of them, others say that all 10 must be present. This disagreement is based on whether partially invalidated testimony is considered to be totally invalidated or not. Or possibly both opinions agree that partially invalidated testimony is not invalidated, and the disagreement is over whether something done before 10 people must be undone before all of them. There is a further question depending on which of these 2 issues you hold exists, as to if the husband said all of them should write the divorce document. It discusses this while comparing it to a number of related cases which are qualified. There are additional points. There's a quoted case where a man sent a divorce document to his wife, so the agent took it and brought it, but the wife said to give it to her the next day, so the agent went back, and the man said, "Thank God," essentially as he was happy it wasn't delivered. However, it's debated if him saying "thank God" was sufficient to nullify the document in regards to whether disclosure of intent is sufficient to nullify the document. They debate this from further sources. It brings a few particular cases to illustrate this principle. In conclusion, it says that we hold that a divorce document can be nullified before 2 people, along with this opinion's statements by the other arguments, and additionally that we hold with the opinion that disclosure of intent by a divorce document is just disregarded. New Mishnah. It was originally done that on the divorce document the husband would write the names which they were known by in the place that the document is written, along with their cities, but it was then instituted that they should write their names and any other names they're referred to by also to resolve any potential issues. The Gemara further describes this opinion with some instances, and that he writes all of the names that he's known by with the name that they're primarily known by first. New Mishnah. A woman collects payment of her marriage contract through an oath if it's from orphan's property. Some courts wouldn't administer this oath, so it was said the woman should just accept any vow the orphans want her to take in regards to this and then collect the marriage contract. Anyways, the witnesses sign their names on the divorce document, even though it's not strictly necessary to prevent any issues. There was also a document established that prevented the sabbatical Shemitah year from repealing any outstanding debts to resolve potential issues. The Gemara says, the first point applies by general collection from orphans, but it specifically mentioned the widow to show we're not more lenient here to help her get remarried easier from these new assets. It cites cases which show why the courts don't force widows to take these oaths, one of which was a situation where a woman accidentally swore falsely during testimony about not having benefited from a gold coin when, unbeknownst to her, she actually had by mistakenly baking the coin into a loaf of bread. So because of the repercussions of this incident, they no longer required specifically widows to take oaths, not even when taking property from orphans who she takes care of. Some hold that you can nevertheless have her take an oath outside of court. It mentions related incidents. Some simply ruled to allow the widow, when collecting this property, to take a vow in court as the orphans require, as specified in the Mishnah, or to just take an oath outside of court. This all applies by a widow. By a divorcee, she can be made to swear. The point is debated. In regards to the opinion that the widow should take a vow as dictated by the orphan to collect their property, some hold this cannot be done if she already remarried. Others say she can, and the husband won't be able to revoke the vow as it will be made in public. This is discussed and there's a debate if, when annulling a vow, if the person needs to give the details of the circumstances around the taking of the vow. Some say no, as he might not give all the details. Some say yes, as the vow could have been taken in a forbidden manner, and the annuller should be informed of that if that was the case. This is further debated. It was said that witnesses sign their names on the document to prevent any issues. This is like the opinion that it's not typically required to have them sign the document, as the witnesses of the delivery are the ones who sever the marriage, and the other witnesses of the actual signing were just rabbinically instituted. Some sages would sign their names in such instances using a mark or symbol, like a fish or a sail, but that was publicly known about, so it was accepted. The points on the Shemitah sabbatical year not overriding lending documents is a principle known as Prozbul, which was instituted. Essentially, as the Shemitah year annulled any of such documents, people wouldn't lend each other money as the year approached out of concern that they wouldn't be repaid. So the Prozbul declaration essentially submits the debt to the court instead, which is not annulled within the coming of the Shemitah year, which is signed by witnesses, and they can then collect their money afterwards. This was instituted after the Shemitah year principle became one of rabbinic law only, which is why it was allowed. Alternatively, it functioned as the court is permitted to just declare property ownerless, which is sourced from some verses. There's further discussion on the point of Prozbul, along with points on etymology. There are further points. It said that Prozbul is only declared if the borrower has land to back his debt, and if he doesn't have any at all, the lender can give him ownership of a tiny piece of his land, which he doesn't even need to physically give over. Details of this principle are discussed, along with additional discussion on the notion that the Shemitah sabbatical year cancels all withstanding debts. There are additional points on these laws. New Mishnah. If a Jewish person's Canaanite slave was taken captive and other Jewish people ransomed him, if they ransomed him as a slave, then he's a slave. If they ransomed him as a free man, then he's free. Others say he's always ransomed as a slave. The Gemara explains that this is prior to where the owner abandoned the slave. And if he was ransomed as a free man, he would still not be enslaved according to the first opinion, as they hold that the first man's ownership was revoked. So that way people will be more likely to ransom slaves. The other opinion disagrees, saying there's a mitzvah to ransom slaves. Others hold the opposite, saying this case was after the first owner abandoned him, so he's either enslaved again by the second man or not, and the other opinion disagrees to prevent the potential likelihood of slaves giving themselves up to bandits to be able to escape. These opinions are debated on further. There's further discussion. Some hold that if such a slave is captured and he then escapes on his own, he's considered to be emancipated, and the master must write him a emancipation document. There are additional points along with a few particular cases brought. There's more of this. Some say it's actually a transgression to free a Canaanite slave. Others disagree. It's debated. It said if a slave is consecrated to the temple, he goes free, as it can't be the man himself, and it wasn't the value of the man either. So it's interpreted to mean that he's saying he should become like a person who's consecrated, like a free Jew. It's also said if you declare the slave ownerless, he's free. There's additional points on these laws. The points and principles of the consecration of a slave and its legal validity is debated further, along with declaring a slave to be ownerless as to whether he additionally requires a document of emancipation. There's further points, and it describes which laws by this we hold. Like, there's additional discussion on certain actions a slave can do that, if done, causes us to presume he was freed. For instance, borrowing money from the owner, being the administrator of his property, wearing tefillin, and others, along with debate if a person can make his heirs emancipate his slaves after his death. There are additional points, along with a few particular instances. There are further laws on the emancipation of a slave. New Mishnah. If somebody designated a slave as collateral and then emancipated him to resolve potential issues, the owner must have the slave go free, and it's debated who writes the note of indebtedness, either the slave or the emancipator. The Gemara goes through this case and clarifies points. It's the first owner who's emancipating the man, and the slave is not obligated at all to work for the second, but to prevent issues, the second man frees him anyways. The remaining points in the case are discussed along the points on using property as collateral, such as if the designated property is flooded. There's debate if the creditor can collect from other properties, along with additional points. New Mishnah. Somebody who's half slave and half free. Beis Hillel says he works one day for his owner and one day for himself. Beis Shammai says there's an issue as to how he can marry, so he says that the owner must free him in exchange for half the slave's value, and Beis Hillel changed his ruling to agree with Beis Shammai. The Gemara says additional discussion on these principles. There are additional laws and points about the concept of half-freed slaves. There's more, and then how he or his half-owner are repaid if he's killed by somebody's ox or otherwise injured, and if a freed slave's owner is a Kohen, if he hasn't yet been emancipated with a document as to whether he can still eat truma. There are further additional points on all these laws, and additionally regarding betrothal of a half-slave and similar. There are additional points. New Mishnah. If a person sells a slave to a non-Jewish person or to somebody who lives outside of Israel, the slave is automatically freed. The Gemara says an opinion that by the first case, he should write a document which says he does not retain ownership if the slave escapes. This goes further. There's additional discussion and debate if selling a slave to a Kuthian or apostate has a similar status to selling it to a non-Jewish person. If non-Jewish bandits captured a person's slave, it's argued if he can be paid for the slave by the bandits, as this would typically not be a permitted sale. Additionally, if a person does sell a slave to a non-Jewish person, which is ruled to not be allowed, as the slave won't be then keeping Torah and mitzvahs in such a situation, so he must buy him back for whatever the price. Some say there's a less severe penalty here, as this is uncommon. There's additional points on this and on the prohibition to sell a slave to a person who lives outside of Israel. It's explained that in such a situation, the purchaser is penalized, along with some related incidents and expansion on some particular verses. New Mishnah. Captives cannot be ransomed for more than their value to prevent any further potential issues. Additionally, it's forbidden to help captives escape, which is explained to be to prevent any future or remaining captives from being mistreated further. The Gemara further describes these points along with a few particular incidents. There's a story where a sage saw that the daughters of another sage would stir a boiling pot with their hands without being harmed, so he assumed that they were very righteous. Once all three of them were captured, and a raven and then a dove spoke to the sage telling him to flee. So he went to check on the other daughters, and he overheard them saying that they were marrying their captors, so he escaped on his own, and when the two daughters eventually returned, he found out that they had been stirring the pot with sorcery. New Mishnah. You cannot buy Torah scrolls, tefillin, or mezuzahs from non-Jewish people for more than their value to prevent any potential issues of theft and ransoming of such scrolls. The Gemara discusses these points and mentions that a Torah scroll written by an idol-worshipping priest should be burnt, and if by a non-Jewish person, it should just be stored away. And if it was found in the possession of an idolatrous priest, it should be put away. And if it was by a non-Jewish person, some say it couldn't be read from. It cites related points on this topic and says you can pay up to a Tractate coin above their value, but also not to undervalue them either, as the sage did this once. And the seller who was selling a pair of tefillin got upset and angrily threw the tefillin into a river. New Mishnah. If somebody divorces his wife due to her poor reputation or due to a vow, he can't remarry her. Some say he can if it was a private vow. Some say it's allowed if it was a vow that does not require asking a sage. Some disagree. And there's a case where a man vowed against benefiting from anything unless he divorced her, and he was allowed to remarry her to prevent potential issues. The Gemara further describes these cases and the different methods and principles of these vows. It debates if a public vow is before 3 or 10 people, which is based on verses along with the remaining points. The last case is also qualified. It debates if the point on preventing potential issues applies to the first case or to the last. New Mishnah. If somebody divorces his wife because he found out that she was an Ilonis, a physically unique woman with male characteristics, it's debated if he's allowed to remarry her. If she remarries and has children and demands her Kesubos marriage contract payment from the first husband, he can tell her it would be better to not require this, as he can retroactive cancel his divorce based on this new information and therefore make her children illegitimate. The Gemara discusses these points. New Mishnah. If somebody sells himself and his children as slaves to a non-Jewish person, they're not redeemed, but we do redeem the children after the father passes. The Gemara says an opinion that this rule only applies if he's done this multiple times. Related incidents are cited. There is a related story where the sage Reish Lakish, who was a bandit chief when he was younger, allowed himself to be captured by a cannibal tribe and brought a bag and a hard stone ball. On the day he was to be killed, they told him that they had a tradition that he would be granted one final request to the man that they'd be eating to gain forgiveness. So he said that he wanted to tie them all to chairs and hit them with his bag. So they agreed, and then he put the stone in the bag, and then he beat them all to death with it. Anyways, he eventually became a great sage from a later story and lived a very simple lifestyle. New Mishnah. If somebody sells his field to a non-Jewish person, he must purchase and bring the first fruit tithes of the field from him to prevent potential issues. The Gemara explains the sale of such land does not reduce the sanctity of the land, and the non-Jewish person acquires it fully. Others disagree with this point, and it's and debated based on the interpretation of a verse. It discusses how there's no reduction in sanctity after such a sale in regards to collecting tithes. There's further discussion on this and variation in regards to the property that's in Surya, which has a slightly different status. Further, the requirement to bring the first fruit tithes from such a sale is said by some to be to prevent potential issues, not as a biblical requirement. If a person sells the rice to the produce of his field, but retains the field itself, it debates if the buyer needs to separate the first fruits with a blessing or not, as he doesn't actually own the field. This debate is based on whether a person who purchases an item for its produce, whether that's considered to be an acquisition of the item itself or not. It debates this principle from several sources. There's additional discussion on this, the Shemitah sabbatical year, and on the Yovel year, and this goes further. And that's the end of chapter 4. Chapter 5 of Tractate Gittin covers some additional laws of divorce, some further rabbinic institutions to resolve financial-related issues, and a lengthy portion which goes through many stories and anecdotes relating to the destruction of the Second Temple. The first mission says there are general types of people that are owed money. Somebody who they or their property was damaged, somebody who lent another person money, and a woman who receives her marriage contract. It was instituted that the damaged party collects payment from superior quality land, a lender collects payment from average quality land, and a woman collects her marriage contract from inferior land, although others hold that she also collects from average quality land. Another institution, a creditor cannot collect payment from encumbered properties if the man owns unencumbered property, even if the unencumbered ones are of inferior value. Another institution, creditors can't collect payment of their owed debts from orphans unless it's inferior quality land. Another institution, to prevent potential issues, we don't collect from encumbered properties to give food for land improvement or to provide food for a man's wife or daughters. Another institution, somebody who finds a lost object, he's not required to take an oath that he's returning everything he found so as to prevent issues. The Gemara says the point that damages are collected from superior quality, this opinion holds that the definition of superior quality land is assessed according to the damager's properties. Others disagree, saying it's a biblical law that it's assessed according to the damaged individual's properties, which is described. It discusses exactly which case this latter opinion is referring to, and it said that the cases where the superior quality land of the damaged property is comparable to the inferior land of the damager, so this opinion would hold is paid according to the damaged individual's property. Others would say it's assessed from the damager's property. This dispute is based on the explanation of particular words from a verse. These opinions are further described also in regards to the value level of property collected by the temple treasury when compensating from damages. This is further described. There was also the debate if a woman's Kesubos marriage contract is collected from inferior or average property. The logic of inferior land is that a woman wants to marry, so she's not going to refuse to get married if her contract payment will be through inferior land. Additionally, a man can divorce his wife only voluntarily, which can prevent situations of the wife antagonizing him while waiting for divorce. Further, the opinion that said that the contract is collected from inferior land, they hold that's only if the land is being collected from orphans. If it's from the husband itself, they would still hold it's taken from his average quality land. This point is further argued on. It's additionally proven that a divorcee collects her marriage contract from her husband's inferior land. By the point that a creditor collecting land from orphans only gets from inferior land, some hold this even applies if the document specifies he could collect from the superior quality land, although others disagree. The point is further argued on. In the end, it's held that a creditor can only collect from inferior land from orphans, even if they're adults, and he must take an oath while doing so. It was also stated that creditors can collect from encumbered properties if the man owns unencumbered properties. It debates if this would also apply if the debtor was given a gift of land, if that also can't be collected from first. This is argued on further along with the remaining points. There's additional discussion on particularities of these laws. There's further points on the laws of collection of creditors. New Mishnah. If orphans rely on a householder to take care of their affairs, or their father had appointed an administrator over them, that man is responsible to tithe their produce. If this administrator was appointed by the father, he needs to swear to the orphans that he hasn't kept any of their property. This is not necessary if he was appointed by the court. Others say it's the exact inverse. The Gemara says this is where the tithes produce is to feed the orphans. The administrator wouldn't be able to tithe it if it was to be stored until the orphans grow up. It cites sources for this. It further qualifies what an administrator is allowed to do with the orphans' property, whether he can litigate cases with them, whether he can sell or redeem the property, and similar. It cites a number of related instances along with some general issues of purchasing property from orphans, such as that if such a purchase is made and the property goes up or down in value and the orphans decide to cancel the sale, the orphans will either get the increased value or will have to be paid to make up for the decreased value. There are related similar laws. This goes further. It mentions some particular instances along with some additional remaining laws and clarifications. It holds with the opinion of the inverse, that the administrator is only required to take an oath if he was appointed by the court, not by the father. New Mishnah. Another institution, if somebody made somebody's produce impure, or mixed teruma tithes into somebody's produce, or made somebody's wine into nesach, using it
for an idolatrous libation, which makes those foods inedible. If this was done accidentally, he's not liable to repay them. If it was done intentionally, he would be liable. The Gemara debates if the wine here is being used for an idolatrous libation or is being mixed with such nesach wine, which has variation in the monetary compensation. This and the sources for the principles of the Mishnah are discussed. It debates by these principles as to whether unrecognizable damage is legally considered to be the same as actual damage, which is argued on further based on some related discussions. There's additional points on all this. This is all for the qualified. New Mishnah. If a Kohen made an offering with the improper intents, messing it up, essentially, if this was done intentionally, they're liable. The Gemara debates when a Kohen in this situation is believed if he did this. Some say not, if the object is not in his control when he informs somebody. Others disagree, and it's argued on. It also brings a few particular instances of this concept actually occurring. New Mishnah. Some hold, if a father signs a betrothal on his minor deaf-mute daughter so that way she'll get married when she eventually gets older, she can be divorced with a divorce document. Similarly, if the family of an orphaned minor girl wants to have her marry a Kohen, as discussed in earlier tractates, essentially a legal contract which makes her wait until she becomes an adult, at which point she can refuse to go through with this marriage or agree to it. She can eat truma here at this point, and if she dies, the husband inherits her estate. Additionally, regarding a stolen crossbeam that was built into a house, he instituted that the beam is repaid in value to encourage people more to repent and to not have to tear down their house to return what they had stolen. Additionally, regarding a stolen chatas offering, that status is unknown. It atones for the benefit of the altar. The Gemara additionally qualifies these rulings. These are explained further. New Mishnah. After the destruction of the Second Temple and the following diaspora, many non-Jewish people started living in the abandoned portions of the land. The following laws apply outside of Judea and also within Judea after the period where people were being killed during the war. Anyways, if a person acquired land from a person who had taken land during the war and then legally additionally acquired it from the original Jewish owner, that's not valid. He has to return it. If he acquired it from the original owner first and then the second person who took the property, that would be a valid acquisition. Similarly, if somebody acquired land that was used as a mortgage for a mortgage contract from a husband and then from his wife, that's not valid. If he acquired it from the wife and then the husband, that is valid. It was later instituted that if somebody purchased land from somebody who acquired the property during the war, he should give a quarter of it to the original owner, so long as the original owner does not have the means to actually acquire the land for himself. Additionally, if the new owner of the land had it for 12 months, the purchaser gets it and gives a quarter of it to the original owner. The Gemara explains why this principle didn't apply in Judea during the actual war. Titus, the Roman emperor who had led the siege and destruction of Jerusalem, had instituted a few laws. First, that whoever doesn't kill a Jewish person should be executed, then whoever kills a Jewish person would be fined, and then whoever kills a Jewish person would be executed. So during the periods of the first two rulings, if somebody was attacked for their land, they would fully and sincerely give the land over, meaning it would no longer have this particular legal status where he didn't fully give it up mentally by the later situations. Further, in regards to the actual destruction of Jerusalem, it said this occurred due to the incident with Kamsa and Bar Kamsa. The region of Har HaMelech was destroyed due to the incident with the rooster and the hen, and the city of Beitar was eventually destroyed due to the incident involving a carriage, all of which will be recorded. First, the incident of Kamsa and Bar Kamsa. There was a very wealthy man who was good friends with a man named Kamsa and enemies with a man with a very similar name, Bar Kamsa. So he tried to invite his friend to a banquet and accidentally invited his enemy, Bar Kamsa. So Bar Kamsa arrived and the rich man became furious and immediately tried to kick him out. Bar Kamsa, embarrassed, begged to stay, offering to pay for his meal, then half the banquet, and then the entire banquet. The rich man refused and forcibly ejected him. Bar Kamsa left ashamed and angry at the sages who were at the meal and did nothing. So he went to the Roman officials and spread slander that the Jewish people had begun a rebellion and offered to prove it by having the Romans send a delegation to bring an offering in the temple. So they sent a fine calf, and along the way, Bar Kamsa made a blemish on the calf's lip, making it unfit for offering. When it was brought to the temple, they debated if they should offer it anyways due to the unique circumstances, but they decided against it. Some suggested just killing Bar Kamsa, others rejected this, and it was said that this rejection resulted in the destruction of the temple, Jerusalem, and the exile. Nero, the Caesar, was sent to attack Jerusalem. There's some debate as to if this refers to the actual Caesar Nero, or if this was some general who was also named Nero, but anyways, he arrived and shot an arrow in all four directions, and they all landed by Jerusalem. A child walked by, and he asked what verse the boy was reading, and the boy said, "I will take my revenge against Edom through the agency of my people Israel." So Nero realized that God wanted Jerusalem destroyed, but he would also destroy whoever did so. So he ran away and converted to Judaism, and the sage Rabbi Meir was his descendant. So instead, Vespasian was sent, and he laid siege for 3 years. Now, Jerusalem had three wealthy men, Nakdiman ben Gurion, ben Ben Kalbasavoa, and Ben Tzitzisakesses. These are all actually nicknames referencing their great wealth. Collectively, they sustained the city throughout the siege with wheat and barley, wine, salt, and oil, and wood. Together, there was enough food and supplies to keep the people of Jerusalem safe for 21 years. However, of the many factions within Jerusalem, there was one group called the Beryonim, and they refused to make peace with the Romans or to hold out with their supplies for the siege. They wanted to fight, and they wanted everybody in the city to join them. So they went and burned down all of the storehouses, resulting in there being no food in Jerusalem at all, and a severe famine. It gives an instance of a wealthy woman who went to buy food from the market, and each time she went, there was less and less until she walked the city herself, stepped in waste, and died. Although before she did so, she threw out all her gold and silver into the streets as they were of no more use. One of the sages, Rav Tzadok, fasted for 40 years to try to prevent the destruction of the temple, and ended up being extremely delicate to the point where he could only eat fig juice. Anyways, the sage Rabbi Yochanan ben Zakkai secretly met with his nephew, a man named Abba Sikra, who was the head of the Beryoni group. Apparently things were pretty out of hand, because he said if he tried to get them to stop, they'd just kill him. So they worked together to try and sneak Rabbi Yochanan out of the city. Rabbi Yochanan pretended to be sick for a while, and then kept an animal carcass in his room to spread the rumor that he had passed. His students then carried him alive in a coffin outside of the city. The Baryonim, who were guarding the exits so that way nobody could escape, wanted to stick spears, or at least hit the coffin to make sure Rabbi Yochanan was actually dead, but they argued against it as it would be disrespectful. Anyways, once he was outside, Rabbi Yochanan ben Zakkai entered the Roman camp and greeted Vespasian, calling him a king. Vespasian reprimanded him, saying he wasn't a king, and if he was, then why are you only coming now? Rabbi Yochanan responded, saying that Vespasian was destined to become a king, as all the verses referenced Jerusalem falling only to a king, and he had only come now due to all of the issues with the Beryonim. Vespasian asked, via metaphor, of a keg of honey and a snake, essentially why they didn't destroy the walls of Jerusalem to get rid of the Beryonim, and as they were discussing this, a messenger arrived informing Vespasian that Rome had just appointed him as the new Caesar. This, by the way, lines up with the historical accounting. This whole siege occurred during the year of the 4 emperors, the last of which was Vespasian, who was summoned away from his siege at Jerusalem and sent his son Titus in his place. Anyways, after further discussion, Vespasian offered one thing to Rabbi Yochanan ben Zakkai, and knowing that asking to spare Jerusalem would be rejected, he requested that the city of Yavne, containing the Torah sages, that it should be spared, and that the family of Rabban Gamliel should be spared, and that he should also provide doctors to care for the sage Rav Tzadok, which was granted. So Titus was sent and eventually broke the siege, and as the war was fought in the temple, and within the streets of Jerusalem, it said that Titus took a harlot into the innermost part of the temple, spread out a Torah scroll, and cohabited with her on it. He also slashed the pareches, the curtain, with a sword, and blood poured out of it, and Titus thought he had killed God. In the meanwhile, the war was lost, and basically every remaining person within Jerusalem was either killed by the Roman forces or enslaved. He then wrapped all the utensils of the temple into the paruchas and brought them on a ship back to Rome. It said that a hurricane threatened Titus's ship, and Titus claimed that the Jewish god is of water, as he had killed the Egyptians with water and the armies of Sisera. So it says a heavenly voice declared, "O evil man, the son of an evil man, a descendant of the evil Esav, I have a puny creature in my world, and it is called a gnat. Go up on dry land and fight it." Anyways, Titus arrived off his ship, and a gnat flew up his nose and sat there picking at his brain for the next 7 years. At first, it would be silenced during the banging of a smith's hammer, but eventually it got used to it, and then never stopped its incessant chewing. One surviving sage was among the nobles of Rome, and he reported that when Titus died, they split his skull open and found a gnat inside, swollen to the size of a swallow, and some add that the gnat had a copper mouth and iron nails. Another incident, Onkelos, the sage who would eventually write the Aramaic translation of the Torah, was Titus's nephew, and before he converted, he decided to do some necromancy to see if it would be a good decision. He summoned his uncle, Titus, and asked him who is prominent in the world to come, and Titus said Israel. He asked if he should join them, and Titus said that they have too many laws and you won't be able to fulfill them, but he should attack them, as it said whoever does so will become a leader. Onkelos asked Titus what his punishment is, and he said that every day his ashes are regathered and judged, and then reburnt and rescattered across the 7 seas. Onkelos then raised the wicked prophet Balaam and asked similar questions, got similar answers, and was told that Balaam was punished by being boiled in semen. Lastly, he brought up Yeshu HaNitzri via necromancy to ask him these same questions. Now, there's actually a lot of debate as to who this Yeshu HaNitzri refers to. I explained this further back in Tractate Sotah on page 47a, but briefly, Yeshu HaNitzri is often translated as Jesus of Nazareth, as you'll see in some editions. This is not a very accurate translation, as on top of the word Yeshu just not translating to Jesus, it's a completely different word despite sounding similar. The The reference figure also has dates recorded as to when he lived within the actual Gemara, which is around 100 BCE, along with points on his story being mentioned throughout the Gemara, and it being one completely different than the historical Jesus of Nazareth. So, as mentioned, it's actually a subject of much debate as to who this refers to, with no conclusive answer, although whoever it was, we do know that he had to live under the rule of the king Janneus, as mentioned in some other stories from the Gemara. Anyways, with that aside, he asked him who is prominent in the world to come. He said Israel. Uncle asked if he should convert, and he was told to seek their benefit and not their harm, as touching them is like touching the people of God's eye. And lastly, for his actions of mocking the words of the sages, he was punished in boiling feces. However, it does say admiringly about him how even as a sinner, as a Jew, he still gave good advice and sought to help others. Anyways, the other referenced incident was of the rooster and the hen, which caused further destruction. A region had the custom to bring a rooster and hen before a bride and groom as a blessing to be fruitful. Some Roman soldiers were passing by and they stole the birds, so they attacked the soldiers. The Roman armies came, and it says one prayed with the verse, "Do not go forth, O God, with our legions," and was then bitten by a snake in a restroom and died. The Caesar decided to spare the Jewish people here, so they all celebrated, so the Caesar got upset and decided to attack them anyways and sent 300,000 men and killed everyone on the mountain for 3 days and 3 nights, and those on the other side of the mountain didn't realize what was going on as they were busy celebrating. It gets some details on this region, and it debates if people from the town of Sachania who were destroyed were righteous, and it says that they just hadn't mourned for the destruction of the temple. Anyways, the third incident was the one involving a carriage. One town had the custom to plant a cedar tree by the birth of a boy, and a cedar tree by the birth of a girl, and when they married, the trees would be cut down to build a wedding canopy. Once the Caesar's daughter was riding her carriage through the town, and her carriage broke, so they cut down a cedar tree and fixed the carriage, so the people of the town got upset and attacked them, so the Caesar then destroyed Beitar, which it describes, and on top of marking the end of the historical Bar Kokhba revolt and the death of Bar Kokhba himself, it says all the residents within were executed until their blood flowed to the Mediterranean Sea, and vineyards of the area were fertilized with all this blood. It cites related verses by the death of Zechariah, whose blood lay boiling on the floor of the temple, and Nebuzaradan, one of the offers of Nebuchadnezzar, slew many over it to try to get it to rest. Members of the Sanhedrin, young men and women, and school children. Eventually it rested, and Nebuzaradan ran away and converted to Judaism. It mentions a few wicked people did such, including the descendants of Sancheriv, who became the sages Shemaiah and Avtolion, the descendants of Haman, and others. It cites many verses which reference aspects of the destruction of the temple. There's a recorded incident where 400 boys and girls were enslaved and being shipped to Rome to become concubines, so they all decided to jump off the boat rather than do such. There's also an incident where a woman with 7 sons was brought before the Caesar, and each was told to bow to an idol. Each refused and was executed until the youngest, where the Caesar even offered to drop his ring on the floor to make it look like the boy had bowed, but he still refused, so the mother told her son before he was executed to inform Abraham when they met that while he had put 1 son on the altar, she had put 7, and then went and took her own life. It expounds on additional verses. It goes through some further points on the destruction of the first temple, on the mass executions, how the Jewish children were enslaved and tied to bedposts to be looked at while the Babylonians had relations, and additionally by the later destruction of Beitar, all the children planned to attack the Roman soldiers with sticks, and in the end they were wrapped in Torah scrolls and set on fire. There's a story of a rumor being told to a sage of an exceptionally beautiful child in a Roman prison, so he traveled to him and asked him about some verses from the Torah to confirm that he was Jewish, and then paid a massive sum to free him, and the boy became a great sage. There's also a story of 2 slave owners that each said that they had a beautiful slave, a man and a woman, so they set them in the same room so that way they'd reproduce, but they were both Jewish captives and Kohanim at that, so they just sat on opposite sides of the room, and when day came, they saw each other and they recognized that they were brother and sister, so they hugged and they both died. Another story, it speaks of an enslaved, beautiful Jewish woman who was the daughter of the Kohen Gadol, who was used for illicit services by her captor and sold, and it speaks of her lamenting this to God. It also speaks of some instances of adultery and how it resulted in the destruction of the Second Temple. After that, it goes back and discusses additional points on the reclamation of property in the region after all these events and the resulting laws. It also says that these principles don't apply in Babylonia. There are additional points on these laws. Additionally, it states that from Moshe until the sage Rebbe, there was not Torah and authority in one person, and it goes through many biblical and historical figures and explains how this wouldn't apply either as there were other great men also in those times or otherwise.
New Mishnah. In regards to legal matters, a deaf mute can make hand signals and others can make hand signals to him. Others say they can even just mouth words in regards to the transfer of movable property. In regards to children, they can vow the purchase or sell movable property. The Gemara says that the deaf mute would still need to use hand signals by divorce, and it discusses the remaining points. New Mishnah. Some additional institutions which create harmony. The order of reading of the Torah is of a Kohen, Levi, and Yisrael. Additionally, the Erovei Chatzeris should be placed in the house that it typically is. The cistern closest to the irrigation channel should be filled first. Prey caught in traps, or animals, birds, or fish, it's considered theft to steal them. An item found by a deaf mute, insane person, or child are also protected by the laws of theft. If a poor man is collecting field charity of olives on top of a tree, the olives that fell below him are protected by the laws of theft. If poor non-Jewish people want to partake of field charity of any sort, they're allowed to take whatever they want, again, to promote peace. The Gemara additionally qualifies the point on the order of the Torah readings. These principles are discussed further. There are additional points on these laws, on the point of the Erev boundary, on the cistern laws, and the others. It also describes the traps and how all these additional principles of theft apply as listed. Additionally, it says to promote peace, we give charity to non-Jewish poor people, right along with Jewish poor people. We visit the non-Jewish sick right along with the Jewish sick, and we bury the non-Jewish dead the same way we bury the Jewish dead. New Mishnah. A woman can lend a person she suspects of violating principles of retaining produce by the sabbatical year her sifter, sieve, hand mill, or oven, although she can't sort or grind with her. Similarly, a person can lend the wife of an ignoramus a sifter and sieve, and can sort and grind and sift along with her up until the point where she adds water to the flour, as this could involve some transgressions. These are all principles to promote peace. Additionally, you're allowed to lend support to non-Jewish people who work the land by the sabbatical year, but not to a Jewish person who has those laws actually applied to him. Additionally, it's allowed to greet everybody, including non-Jewish people, with the traditional greeting of Shalom, which is considered a form of God's name based on some verses, and to ask after their welfare to promote peace. The Gemara additionally qualified these principles. The points on the sabbatical year are additionally discussed along with the issues of preparing bread alongside the wife of an ignoramus. This is further discussed, and it says that it's still forbidden to work the land on a sabbatical year. So during that period, a Jewish person cannot work alongside a non-Jewish person who is allowed to work the land then. Additionally, some hold that it was nevertheless improper to give the double greeting of saying Shalom twice, although others would frequently wish success to their non-Jewish neighbors, wishing them strength in their work. Additionally, it said that it's permissible to ask after their welfare, obviously, but it's even allowed on their holidays and has no negative connotation, unlike a source which it cites that seemingly disagrees with this. It cites a related incident on these topics, and that's the end of chapter 5. Chapter 6 of Tractate Gittin goes back to discussing the laws of the divorce document and its delivery. The first Mishnah says, if the husband tells somebody to accept the divorce document on behalf of his wife, or to be an agent to deliver it to her, he's allowed to retract it up until the point that it reaches his wife. If the wife sent somebody to accept the document for her, the husband can no longer retract it once it's given to the agent. Therefore, it's possible for the husband to just tell his wife's agent that he's not having him accept it. He should just take it and bring it to her, and then he can retract it up until the point that it reaches his wife. Others hold that even if the wife told her agent to just take the document once the husband hands it to the agent, he's no longer allowed to retract it. The Gemara argues based on the wording, if when the husband told his agent to take the document to his wife, the expression of having him take it, if that's the equivalent to having the agent acquire it legally for her. But this is rejected, and when the agent is told to accept it by the husband, he's authorizing him to deliver the document. It tries to imply from the wording of the remaining parts of the Mishnah that telling the agent to take the document is the legal equivalent of having him acquire it, but it cannot. Additionally, in regards to people who can legally be agents to bring or accept a divorce document, it's known that a man can be an agent to bring a divorce document, and a woman can be an agent to accept one. Additionally, the last suggested case of the Mishnah was where the husband told the wife's agent to essentially become his agent. So this shows that a man can additionally be an agent to accept a divorce document, as additionally seen from other scenarios. It cites additional cases which show a woman can also act as an agent for acceptance and also for delivery. There's an additional ruling if a woman told her agent to bring the document to her, and the agent told the husband that she, the agent, will be the one accepting the document, which is not what the wife had told her to do, and the husband gives the agent the document, but says the document goes to you as the wife said. The divorce document is invalid.
This is explained by some to be because the agent is essentially refusing to be an agent to deliver the document back, so it's not being appointed even for this by the husband. If further debate the validity of this concept, there's additional discussion on the phrase telling the agent to take the document, if that's the same legal equivalent of telling her to accept the document. This goes further, and it does conclusively prove, according to one opinion, that saying this divorce document is for you is the same legal equivalent of saying they should acquire it. It debates further the phrase take it has the same legal equivalence. It's also argued between opinions as to whether a woman can appoint an agent to accept the divorce document from the husband's agent. The potential issues with such a situation are the husband will take offense and invalidate it, or that it could be confused with the case wherein the husband placed a document into a courtyard and then that courtyard was given to the wife, including the document, and that's definitely not a legally valid form of divorce. The practical difference between these logics are if the woman appointed her agent first, so that's not comparable to the courtyard situation. There's an additionally cited case wherein a husband sent a divorce document to his wife via agent, and the woman was preoccupied, so she told the agent that he should be her agent to accept the document, and it was debated by many if this was valid. In an additional case, the witnesses of the husband mistakenly wrote the wrong name on the document, obviously invalidating it, and it was eventually ruled that the agents are nevertheless allowed to rewrite the document as many times as they want. The other points are qualified. New Mishnah. If a woman told an agent to accept her divorce document, she needs 2 sets of witnesses to confirm that this occurred. 2 to confirm that she told the agent to accept the document, and 2 to say that they saw the agent then go and accept the document and also tear it. Additionally, it's allowed to be the same 2 witnesses by both, or one of the same witnesses by both. The Gemara says there's a debate if the husband gave the divorce document to a third party, and the husband says it was just for safekeeping, and the third party says it was for divorce, as to who we believe in this situation. Some say we believe the husband, as if he wanted her divorced, he could have just given her the divorce document. Some say the third party, as evidently they were trusted by the husband. Others will say that we do always believe the third party, but those are explained to be talking about monetary disputes or commercial documents. If further debates if the third party in this instance is believed, and the reason the document had to be torn was that during this period there was governmental decrees against religious observance, so they had to get rid of the documents after use. Additionally, it is agreed that if the wife confirms that the third party gave the divorce document to divorce her with, she's believed, so long as she confirms it was given by the husband to the agent while she was actually there. This is because this claim has more believability, as if she wanted to lie, she could have just claimed the husband gave it directly to her. In additional instance, if the husband confirms he had given the document to a third party to divorce, and the third party also confirms that it was given to divorce, and the woman says she was given the document but it was lost, some claim they still require witnesses to prove this, as the document is lost, the third party doesn't have it, and the husband himself didn't directly divorce her. Additionally, there is a principle that we presume an agent has fulfilled his assignment, but that's only if it results in a stringency. Additionally, here we have a greater concern that the woman would lie straight to the husband that he divorced her, as she has a third party to back her claim up. New Mishnah. Regarding a betrothed Na'ara, a woman in a middle stage of adulthood, she or her father can accept her divorce document. Others disagree, saying it's just her father, as there can only be one person with this authority. Additionally, any girl who is not able to take care of her divorce document cannot be divorced. The Gemara explains the logic of these points, and in regards to the situation described from earlier tractates, that if there is an orphaned minor who is legally given by her family to an individual to officially be married so long as she consents once she becomes an adult, this could be cancelled via a divorce document. But if the girl was mentally incompetent, she cannot do this, which is if she cannot tell the difference between her divorce document and another object. Generally, a child who has the mental competency to pick a stone over a nut is considered to be competent enough to legally acquire objects, and a child who is competent enough to borrow an object and return it when asked, he can legally acquire objects on behalf of others. Others say both of these statuses can only acquire for themselves, and it's additionally debated. There's further discussion, and it clarifies some laws of marriage. The minimum age for marriage is adulthood. There was that unique case mentioned where an orphan minor girl can be legally given by her family to an individual to be kept in his care until she becomes an adult, at which point they're properly married if she consents through miyun. The initial age of the situation, way prior to the actual marriage, is where she's mentally competent enough to tell the difference between a stone and nut. Children who are competent enough to buy and sell movable items, if their father contracted them to eventually marry a certain individual, they're allowed to receive their own divorce document in the year prior to adulthood. When they're legally allowed to take vows or consecrate items, they're legally allowed to reject a Levirate marriage through the process of chalitza, and all actual proper marriages only become legal when once both parties are adults. Additionally, an orphan can only sell his father's property once he's 20. New Mishnah. If a minor girl in the above situation, waiting for adulthood to have her agreed upon marriage go through, she has to accept a divorce document herself, as she can't legally appoint an agent, so the husband can cancel the document until it reaches her. The father can appoint an agent to get and accept the document, so the husband can't retract it once it reaches the agent. Although this isn't really practically relevant, as it says in a later tractate, Kiddushin 41a, that a father shouldn't betroth his daughter while she's a minor ever. Another rule, if the husband told the agent to give the divorce document in a specific location and the agent gives it to her somewhere else, it's not valid. If the husband just told the agent the woman's location, he can give it to her wherever he wants. If the woman told her agent to only accept the divorce document in a specific location and the agent gets it somewhere else, it debates if this is valid. If she told the agent to bring the document to her from a specific location and he brings it from a different location, it's valid. The Gemara explains the opinion, which says a divorced wife can't clarify where she wants her divorce to be accepted, unlike by the husband, is as the woman can be divorced involuntarily, as she's just informing the agent as to the location of the husband. New Mishnah. If a Kohen's wife told an agent to bring her divorce document, she can eat truma until she gets it. If she told the agent to accept it for her, she can't eat truma immediately. If she told the agent to accept the document for her, but in a specific location, she can eat truma until the document reaches that location, and others say she can't eat it immediately. The Gemara clarifies the later case to be where she told the agent where the husband was, but that it would be activated once the agents reached a designated location. Additionally, the opinion which held the woman can't eat truma immediately after sending her agent would apply even if she told the agent to go east and she sees the agent heading west, as there's a possible concern that the husband bumped into the agent in that area immediately anyways, so she can't eat truma immediately. It explains how similar opinions exist by the laws of the Eruv boundary. New Mishnah. If a woman told people to write a divorce document and give it to his wife, or to divorce her, or to write a letter and give it to her, they can validly write and give a divorce document to his wife. If he told them to release her, or to provide for her, or to do for her as is customary, or to do for her as is fitting, he's not considered to have said anything, and they don't write a divorce document. The Gemara clarifies additional wording along these lines as to what is and is not considered to be a valid request to have a divorce document written and given. New Mishnah. If somebody was going out to be executed and he tells people to write a divorce document on his behalf for his wife, they may do so. Later, they also permitted people going to travel by sea or in a caravan to travel to a desert to do this, and some also added a dangerously sick individual can do this. The Gemara says an incident where somebody going to be executed said that some of his finances should be given as a gift to a sage, so it debates if the laws of a divorce document are similar to a gift by these laws. This case is unique, as it was a clear instruction as he was about to die, unlike by a very sick individual who can only give away parts of their property via oral transfer through an act of acquisition. It was debated, however, in this particular case, as the man used a very odd expression, saying to take 400 zuz from his wine, but it was explained and ruled to mean that he was strengthening his pledge to have them even take the money from the value of his wine if necessary. New Mishnah. If somebody was thrown into a pit and he said, whoever hears his voice should write a divorce document for my wife, they can write a divorce document based on this. The Gemara clarifies due to the issue of demons taking the forms of humans and tricking people, this case must be where they at least saw the man's shadow of a shadow, which a demon cannot mimic. Additionally, it's considered to be a time of danger, so you can write it even if you can't precisely identify who this is. New Mishnah. If a healthy man told people to write a divorce document for his wife, but he meant to annoy her, and then he fell off a roof and died, it was ruled if he intentionally fell off the roof, this is a valid divorce document. If it was accidental, like the wind blew him off, it's ruled to be invalid. The Gemara clarifies this case, saying it meant the conclusion of the incident clarifies the husband's intent. A related incident, a man entered a synagogue, saw a teacher, his son, and another man, said, two of you should write a divorce document for my wife, and then the teacher died. It was ruled that as people would appoint a son as an agent for this in front of the father, so the son would be allowed to do so with the third guy. New Mishnah. If somebody told 2 or 3 people to write and give a divorce document to my wife, they can do it themselves. If he told 3 to give a divorce document to his wife, they can have others write, sign, and deliver it, as he's considered to have designated them as a court. It cites a source for this, and others disagree, saying those men specifically must take care of it themselves. And also, if he told 10 people to write and give a divorce document to his wife, 1 of them can write it and 2 can sign it. If he said all of you write, 1 writes it and all of them sign it. So if even one of them died, the document would then be nullified. The Gemara debates the validity of if a husband telling 2 people to write and deliver a divorce document and they had a scribe write it, but they signed it, if this is valid. Some held that they should separate, but it should be further studied. The questions exactly as to what they were unsure about in this ruling, and it discusses a few potential issues. The opposing opinions on this are additionally explained. Further, if a husband told 2 men to ask a scribe to write it and 2 others to sign it, it's valid, but this should not be done, as the wife might have hired those witnesses and it would result in a false statement. If the husband wanted those 2 original witnesses to sign it in such a case, it's agreed it's valid, but it's now debated if it should be done between a large number of different opinions. Regarding the case of a large group of people, there's a debate if 2 or all must sign, but that's explained that one is talking about where he's enumerating everybody in the group, and the other one was talking about where he only enumerated some of them. It was enacted if a husband told a large group that all of you should write a divorce document, the scribe should clarify within the document that the husband said to write and deliver the document through any one of you, and it should be signed by any 2 of you. And that's the end of chapter 6. Chapter 7 of Tractate Gittin continues discussing the laws of the divorce document, and additionally it covers many related discussions on illnesses, cures, and similar. The first Mishnah says, if somebody contracts cardiacus, a delirium caused by drinking a lot of fresh wine, which some explain to be the name of the demon that causes this phenomenon, and then says that somebody should write a divorce document for his wife, it's not valid. If he said to write a divorce document, then drank wine and contracted this cardiacus, and said to not write the divorce document, we ignore him. If somebody became mute and he's asked if they should write a divorce document for him and he nods yes, he's tested 3 times to make sure he's communicating properly, and then they write it. The Gemara defines cardiacus as the demon which causes delirium from drinking fresh wine, and the name is relevant if you plan on writing a amulet of protection. It additionally lists ancient medicinal cures for this, and for heat stroke, which is water, and then for 2 days of heat stroke it's bloodletting, and then other ancient medical practices and whatnot for more, along with particular foods which cure frostbite. It also mentions some incidents where some servants of the sage of the Reish Galusa tried to kill the sage Rav Sheshas after he exposed that they were feeding people non-kosher food, first by putting a bone in his food, which he found, and then digging a hole and putting a mat over it, as Rav Sheshas was blind and he would walk over it and die. So he was warned right beforehand as he asked a nearby boy to recite a verse, and the boy said, turn to your right or to your left, and he avoided the trap. Another topic, there's the verse as said by King Shlomo, King Solomon, I provided myself with masculine and feminine orchestration with delights of mankind, and Shida and Shidois. Some translated those last 2 as male or female demons. Some said it meant chariots. The reason King Shlomo needed demons was, as famously, he wanted to build the first temple in Jerusalem, but it was forbidden to build it out of metal tools, which made cutting stone pretty difficult, and he was told to use the shamir worm, a special worm that can cut stones it's placed on, which Moshe had used to engrave the stones of the ephod. He didn't know where the worm was, though, so he took a male and female demon and pressured them to tell him, but they said that only Ashmedai, the king of the demons, knows where it is. By the way, some write that Ashmedai is a title for king. It's not his actual name. Anyways, they told him Ashmedai could be found on a particular mountain where he had a pit dug filled with water, which was covered with a stone and sealed with his signet, and every day Ashmedai would ascend to heaven to learn Torah in the Heavenly Academy, and then come down to earth to learn down here, and then he goes to his pit, checks the seal, drinks some water, and then leaves. So King Shlomo sent his commander, Benaiah, son of Yehoiada, who took a chain with God's name engraved on it, wool, and wineskins, and then went to Ashmedai's lair. He dug from beneath the pit, funneled out all of the water, and then funneled in the wine, and plugged it with the wool, leaving the seal untampered, and hid in a tree to wait. Ashmedai returned, uncovered his hole, saw the wine, and he didn't want to drink it, as verses discouraged drinking wine, but eventually he became thirsty enough that he drank it anyways, he became intoxicated, and fell asleep. Benaiah then jumped down and wrapped him up in the chains, and when Ashmedai woke up, he couldn't break them as God's name was carved into them. So then Benaiah traveled with Ashmedai back to Jerusalem. Along the way, Ashmedai kept knocking down houses and trees, until a widow begged him to not knock down her house, so Ashmedai jumped so hard out of the way that he broke a bone. Ashmedai mentioned the verse, and a soft expression can break a bone. Anyways, Ashmedai saw a lost blind man and helped him on his way. He saw a drunk man and helped him on his way. He saw a joyous wedding and began to cry, and he saw a man asking a shoemaker for shoes which would last 7 years, and he laughed. He also saw a sorcerer doing sorcery, and this also made him laugh. Eventually he was brought before King Shlomo. Ashmedai informed him that when Shlomo dies, all he'll have is the cubits of his burial plot, in spite of him conquering the entire world and capturing him, and King Shlomo told him to tell him the location of the shamir worm so that way he could build the temple. Ashmedai informed him that the worm was in the care of the angel, the master of the sea, which lent the worm to a certain bird so it could build its nests. Anyways, Shlomo sent others to find this bird. They did. They put a glass box over its nest. The bird returned, saw the box, flew off, grabbed the shamir worm, and placed it on the box, causing it to split in 2. So they scared off the bird, grabbed the shamir worm, and brought it to King Shlomo. In the meanwhile, the bird swallowed a rock to choke itself for breaking its oath to the Master of the Sea. So the first temple of Jerusalem was thereby built. Anyways, Benaiah went to Ashmedai and asked him about all the things that had occurred while they traveled together. He was told he'd helped the blind man as he knew he was totally righteous, and whoever helped him would be rewarded. He had helped the drunk man as he knew the individual was wicked, and he wanted to use up any of the man's potential reward. He had cried over the wedding as he knew the husband would die in 30 days, and the bride would have to wait 13 years to do Yibum, the Levirate marriage, to remarry his brother, who was a minor at the time, until he became an adult. He'd laughed at the man who asked a shoemaker to make him shoes that would last 7 years, as he was going to die in 7 days, and he laughed at the sorcerer as he didn't realize that there was a king's treasury buried directly beneath him. Anyways, Ashmedai remained with King Shlomo until they completed the building of the temple. Once Shlomo approached him and they conversed, Shlomo asked him about the verse that references demons being superior to humans. Ashmedai said he'd need to take off the chains and Shlomo's ring, which had God's name carved into it, to be able to show him, so King Shlomo complied with this. Ashmedai immediately swallowed the ring and regained his power, placing one wing in heaven and one in earth, and throwing Shlomo a distance of 400 parseos. Shlomo eventually recovered and spent a long while journeying back to Israel. Nobody believed that he was the king along the way. Eventually he made his way back to Jerusalem and claimed that he was the King Shlomo, but they said that's not possible, as the king's been sitting on the throne this whole time. Shlomo managed to convince them of his legitimacy, and he confirmed that the impostor Shlomo had never shown his feet, as demons have rooster feet, and additionally that the impostor Shlomo was trying to engage in intimacy with people forbidden to him. Anyways, Shlomo was given the ring and the chain, marched into the throne room, and Ashmedai flew off, but nevertheless, Shlomo lived the rest of his life in fear of Ashmedai, as the verse says, "Behold, Solomon's bed, 60 mighty warriors of the mightiest of Israel encircle it, all handle the sword and are skilled in warfare. Each man has a sword at his thigh because of terrors in the night." It's debated if Shlomo ever fully regained his status as king. It additionally gives some unique ancient medicinal practices and customs to cure types of headaches. There are cures for eye issues, types of blindness, nosebleeds, mouth bleeding, toothaches, heart conditions, intestinal pains, and others, types of leaves, types of foods or fluids or animals or customs and whatnot that are described. It has more of these for abdominal issues, fevers, and others. There are additional of these along with a number of general health advice. Back to the divorce document delivery. If the husband said to give the divorce document, then contracted cardiacus, becoming temporarily mentally incompetent, and during this said to not give the divorce document, it's debated if during this state they can give it anyways, or if they should just wait until afterwards. The debate is based on if this state is compared to the man being asleep, or if it's compared to the man being insane. Additionally, unlike by an insane person, this illness can actually be cured as described earlier. We try to dispute the opinions that say you can't bring a document in such a state, as this opinion held elsewhere that if somebody's throat was cut through both pipes, the trachea and esophagus, and he motioned to have his divorce document written, he is believed and it's written. However, this is different than cardiacus, as there his mind is compromised, unlike here where he is not strictly unable to think clearly. During such a state with his throat cut, you can have the divorce document brought, and you can also testify that he died from just seeing this, as he's definitely going to die. There are additional points on this. In regards to questioning somebody who became mute, there's a concern that he just has an illness where he just repeatedly nods, so it's explained that he asked a question that should be answered no, then one that should be answered yes, then no, etc. It gives other additional methods. It additionally debates the levels of mental competency attributed to an ordinary mute or a deaf mute, which is typically stricter. There are additional points on this. From a different discussion that's more in Tractate Yevamos, it mentions that a deaf mute brother can't divorce from the Levirate marriage if his brother was mentally competent, but if the mentally competent brother did the Levirate marriage with his mentally incompetent brother's wife, he can validly divorce her. Others did dispute this and would additionally hold that an insane woman can never be divorced out of concern that people will try to be immoral with her afterwards. New Mishnah, if somebody went to a man and asked if they should write a divorce document for his wife, and the man said to write it, and they have a scribe write it, and other witnesses sign it, even if the husband gives it, it's not valid, as the husband needs to tell the scribe to write it and to tell the witnesses to sign it. The Gemara says the issue is that the husband said they should write the document. If he said to give it, it would have been valid, according to the opinion that words can be transferred to an agent. The ending of the Mishnah then would either be according to the opposing opinion, or alternatively the whole Mishnah is like the opposing opinion and the ending bit is just where he said to give the document. Some would hold in the described case, the scribe is allowed to be one of the signers, and this could be problematic as the scribe could end up signing the document when he wasn't requested to, so it additionally debates who this Mishnah goes in accordance with. New Mishnah, if a husband told his wife, "This is your divorce document if I die," or "This is your divorce document after this illness that he has," it's invalid, and it's like he said nothing. If he said, "This is your divorce document from today if I die," or "from now if I die," this is valid. If he said it's from today and after death, its validity is in doubt. So if he dies, she must do chalitza and can't do yibum. If he said this is your divorce document from today, if I die from this illness, and he got better and was walking around the market, and then he got sick again and died, he's checked. If it was from the first illness, she's divorced, and if not, they're not divorced. The Gemara explains the term if I die can either mean from now, as in this point here, or it can refer to after he dies at a future point. If he said from today, if I die, that's the first instance. It's retroactive from that point. If he didn't say from today, it refers to after his actual death. It debates the validity of the remaining terminology. Essentially, if the husband said he wanted the document to take effect after he died, it's debated if this should take effect literally after he died, or if it means it should apply retroactively in the event that he later dies. It's disputed between a few opinions as to who we hold like. In regards to where the document being given is reliant on him dying of the illness and he recovered in between before dying later, it said it's similar to a gift, where if somebody offers one while sick and then gets better, we assume he retracted it and it would be nullified. Others debate this comparison. Based on the discussion it's held, if a person has an illness, offers a gift, and then transfers to a second illness and dies, his gift transfer would remain in effect. Additionally, others dispute the opinion that if somebody sick offers a divorce document and then recovers, it's nullified. They would instead hold the document ends the marriage, so people won't come to think the document can take effect after the husband's death. This can technically exist, as has been described. The whole betrothal to begin with is verified rabbinically, so it can therefore be retroactively undone rabbinically through whatever means. It says in related incidents by monetary laws to other people can be held responsible for unusually occurring accidents. New Mishnah: if the husband gave a divorce document to take effect retroactively when he died, she should no longer be alone with him unless there are witnesses, even a slave, unless it's her female slave who she's on familiar terms with. Additionally, it's debated as to what her marital status is. Some say it applies, others say it's in doubt. The Gemara says, in such a situation, if the witnesses saw them cohabit, he can assume it was done with intent to remarry, but if he saw him pay her after, we assume it was done impermissibly. Others say that even if he paid her, we assume it was to marry and the money was just a gift or something. Others disagree with this whole explanation and instead simply say if they're seen cohabiting, it's a dispute if they're assumed to be doing this to remarry or not. This is additionally qualified. In regards to if they're considered to be married, it debates if the husband is responsible during this period to provide for her. New Mishnah: if a husband told his wife that she's divorced on condition she gives him a sum of money, she's divorced, and she must give the sum. If he said it has to be given from now until 30 days, she is divorced only if she gave it within 30 days. There's a recorded incident where a husband had made the divorce conditional on the return of his cloak, and she had lost the cloak, so it was ruled that she could have just given the value of the cloak instead. The Gemara debates based on the particular wording if the document still needs to exist when she gives the money, which is additionally debated elsewhere by the laws of betrothal. It repeats both, as there's a difference between divorce and betrothal as to the willingness of the husband to make such a conditional request. It additionally debates these opinions. This is further discussed. It also clarifies the point on the payment within a time frame to say that this is an actual part of the conditional requirement, not just a request to have her pay it faster. Further, the broad case with the cloak is to establish that the value of an object can be given in such a described situation. There are additional points, and it brings a case where the custom in a region was for a sharecropper to water crops 3 times a year and take a fourth of the produce, and the deal was made to water 4 times per year and take a third, but it rained, so he only ended up watering 3 times, and it was debated if he'd still get the full produce payment. This is said to make the sharecroppers entitled to the extra portion, as it's comparable to the case of the value of the cloak being repaid instead of the actual cloak itself. It goes through some related monetary principles and additional instances of a conditional divorce document. These are further qualified. New Mishnah: if a husband told his wife that this is a divorce document on condition that you serve his father or nurse his son, she's then obligated to nurse for 2 years, although some say 18 months. If the father or son died before that, the divorce document is still valid. If the husband said the document is conditional on you serving my father or nursing my son for 2 years, and the son died or the father refused her service, not out of anger, it's not a valid divorce. Others disagree and say it is, and would hold that so long as the wife didn't cause the condition to be unable to be fulfilled, the divorce would still go through. The Gemara explains that some others would actually require her to only nurse or serve for a single day, although that could possibly be an instance where the husband had specified that it should be for a single day, and others disagree, and it's debated. There's further discussion on this. New Mishnah: if a husband told his wife, this is your divorce document if I do not return within 30 days, and he traveled from Judea to Galilee, reached Antipras, and returned, it's nullified. If he traveled from Galilee to Judea and he reached Kfar Osnai, it's nullified. If he was traveling abroad and he reached Akko,
and then returned on time, it's nullified. If the condition was that the divorce takes place if he's absent for 30 days and he was going back and forth, it's still a valid divorce as he wasn't alone with her during this period. The Gemara explains the particularly mentioned regions is it's where he said that's where he's going, which is conditional for the document to take effect along with him returning within 30 days. The remaining points are qualified. New Mishnah, if a man gave a divorce document on condition that he doesn't return within 12 months and he died during that period, it's not a valid divorce document. If he said this is your divorce document from now, if I don't come back within 12 months and he died during that period, it would be a valid divorce document. If he said if I don't return within 12 months, write a divorce document for my wife, or write a divorce document if I don't return within 12 months, and they wrote it during 12 months and gave it after, it's invalid. Others say by the second instance it would be valid. If it was written and given after 12 months, but the husband had died, if it was given after he died, it's not valid. If they're not sure if it was before or after, her marital status is in doubt. The Gemara additionally qualifies these points with particular discussion on the differing opinions along with some particular date stipulations. And that's the end of chapter 7. Chapter 8 of Tractate Gittin covers some additional further laws of divorce and the delivery of the divorce document. The first Mishnah says, if a man throws a divorce document at his wife in her house or courtyard, she's divorced, as it's in her property. If he threw it into his own property while she's there, she's not divorced. If he threw it into her lap or sewing basket, she is divorced. The Gemara cites verses which source these laws of particular domains. Additionally, in regards to putting the document in her property, this is where the husband doesn't share it, as he had relinquished his rights to the property. Typically, such relinquishment of property is not allowed, so this must be where it was done during the initial stage of marriage or similar. Additionally, some add that there is no issue of this whatsoever, as technically they're married, so her hand would also be shared in ownership by the husband, which would be equally problematic. Therefore, this opinion would say that the divorce document and her independent ownerships occurs simultaneously. This is additionally qualified. It cites some particular incidents of these laws occurring. In regards to him tossing the document into her property, some clarify this to mean she actually must be there, at least beside her house or courtyard. Others say that she can be far away, and the dispute is like if her courtyard or house have a category of her hand or of her agent. Others say both agree it has the status of her hand, but they disagree if she needs to physically be there, attached to it, for it to be valid. There are related incidents mentioned. Additionally, in the husband's house, if the woman owns a bed inside, he can validly put the document on her bed. The particularities of this are discussed. In regards to tossing it into her sewing basket, some require it to be hanging off her, and similar. This would also apply to things similar to a sewing basket. New Mishnah. If the husband hands his wife a divorce document and says, this is a note of indebtedness, or if the wife just finds the divorce document lying around by him, it's not valid. The document must specify that it's given as a divorce document. Similarly, if he hands it to her while she was sleeping, it's not valid until he says that he's given her a divorce document. The Gemara suggests a clarification where she grabbed the document that was by him as to be where it was on his person, and he turned to her, essentially handing it towards her, and she took it from him. It brings sources for the validity of this logic. Also, if a man wrote a divorce document and gave it to his wife's slave who was sleeping while she guards him, it's valid. But not if he's awake, as then he's legally regarded in a similar status as a courtyard that's not under her control. Where it does work is clarified to be where he's bound, so he's classified similar to a stationary courtyard, which can acquire a divorce document for its owner. New Mishnah. If a woman was in a public domain and the husband throws the divorce document at her, if it's near her, she's divorced. If it's near him, she's not. And if it's right in the middle, she has a doubtful status. This would also apply by marriage and with debt, by tossing the money towards the individual, if he acquires it or not. And if it's right in the middle, they split it. The Gemara defines these amounts as being within 4 cubits of either of them, and where it's half and half is where there's 8 cubits between them, and the document extends into both of their 4 cubits. Some say it just means that whoever's closer. Some say it goes by who's able to guard it, and if both or neither can, it's half and half. There are additional points on these principles by marriage. An additional rule, if a husband hands his wife a divorce document, but there's a string attached in his hand, if it's strong enough that he could pull it back to himself without breaking the string, she's not legally considered to have been divorced, as he still partially controls the divorce document. Additionally, if her hand was open and positioned downwards and he threw it into her hand and it falls out, she's not divorced. If it then is destroyed before it hits the ground because there's a stream beneath her. New Mishnah. If the wife is on her roof and he's in his courtyard and he throws the divorce document up to her, she's divorced once it enters the airspace of her roof. If he was on his roof and she was in her courtyard and he threw it down to her, she's divorced once it leaves the roof's domain, even if it's destroyed before it hits the courtyard. The Gemara explains by the wife's roof, the roof is guarded, either as there's a fence around it or it's within 3 handbreadths, so it's considered to be a part of the roof, as it's within its airspace. By her courtyard, it's considered to be guarded, as the courtyard walls here extend above the roof. The remaining points are additionally qualified. It also describes some points as to how these laws differ from those of the Shabbos domains. Further, if there's a double courtyard, one inside another, with the inner one belonging to the wife and the outer one to the husband, and the outer walls are higher than the inner walls, and the husband tosses her divorce document to her, as the outer walls guard the inner walls, once the document reaches the airspace of the outer wall, she's divorced. This is additionally qualified. New Mishnah. There's a dispute if a man can divorce his wife with an old divorce document. An old divorce document is if the husband secluded himself with her after he wrote the document, but before he gave it to her. The Gemara says this dispute between Beis Hillel and Beis Shammai is on whether we're concerned the divorce will precede the conception of a child. Nevertheless, some hold that if the woman was given an old divorce document and remarried, she can stay remarried, and some allowed the remarriage to begin with anyways. New Mishnah. If somebody was in Babylonia and they wrote the date of the divorce document according to the reign of the Roman Empire, here referred to as the unworthy kingdom, or according to the kingdom of Media or Greece, or since the construction or destruction of the temple, or if he wrote it in the east and wrote it that it was in the west, or vice versa. If the woman had remarried on the basis of such a document, she must leave both her prior husband and her new husband and receive a divorce document from both, and does not pay her marriage contract or any of the forms of sustenance from either. And if she took sustenance from either, she must return it, and any new children born to her are considered to be illegitimate, a mamzer. If the husbands were kohanim, neither can become impure to bury her if she dies. Neither husband is permitted to her findings or earnings property. Neither can revoke her vows, and if she was not a Kohen, she can no longer marry one. If she was a Levi, she can no longer eat Meiser. If she was a Kohen, she can no longer eat Teruma. Neither heirs from either inherit her marriage contract, and each of her brother-in-laws will do Chalitza and cannot do Yibam. Similarly, all of this would apply if the scribe wrote either of their names or cities wrong. Additionally, this list of penalties apply if there was a woman whose brother-in-law passed, but they were one of the mentioned relatives, so they don't do Yibam or Chalitza, so her co-wife went and remarried without needing to do chalitza, but they then found out the widow was an Ilonis, so their co-wife needed to have done Yibam or chalitza, so their new marriage is void, and as mentioned, the listed penalties apply. Additionally, this would all apply if the widow married the brother-in-law through Yibam, and the co-wife married someone else, and then found out that the widow was an Ilonis. In an additional case, if the scribe accidentally gave the divorce document to the wife and the receipt to the husband, which they then exchange, so they now both have the wrong document, and they found out what happened later on, all of the above penalties apply. Others say if they found out what happened immediately, there's no divorce, but if they found out later, the divorce is valid because the original husband shouldn't be able to invalidate the marriage of the second. The Gemara clarifies, the unworthy kingdom, as mentioned, refers to the Roman Empire, and they're called this because they didn't develop their own language or alphabet. The dates of the local monarchy are used in divorce documents so as to have peaceful relations with the monarchy. The remaining points are additionally clarified. This goes further and it also defines what classifies as immediately after the divorce or a while after, along with the remaining points. New Mishnah. If the husband wrote a divorce document for his wife but then changed his mind, Beis Shammai says he's disqualified her from marrying a Kohen. Beis Hillel says she's not disqualified even if he actually gave her the document, but conditionally, and the condition wasn't yet fulfilled. The Gemara cites some related incidents along with some points on tithes to show the descent of the greatness of later generations. New Mishnah. If a man divorces his wife and then stays in an inn with her, Beis Shammai says they don't need a second divorce document. Beis Hillel says they do if they divorced from the final stage of marriage. If it was from the earlier stage of marriage, they wouldn't be so comfortable and they wouldn't require a second divorce. The Gemara says some hold this dispute is where the witnesses actually saw them cohabit, and the debate is if this act was to remarry or if it was just done impermissibly. It debates this from other sources. Others say it's where the witnesses saw them seclude as to if this creates a presumption of cohabitation. The remaining points are qualified. New Mishnah. A divorce document is written and signed very uniquely. A few lines are written, it's folded over and sewn shut, and the outside is signed by a witness. Then further is written, it's folded, sewn, and signed on the outside, etc. It needs 3 folds and 3 signatures. If one of such signatures is missing, the husband must divorce her new husband, and all of the earlier mentioned penalties apply. Some say anybody can sign the extra fold to fix it. Others say nobody disqualified except for relatives. This invalidation applies so long as there are more folds than witnesses' signatures. The Gemara says these issues apply in case the husband said all of you signed the document. It further explains the debate as to who can make the additional necessary signatures, and some say it doesn't apply if there is or are more than 4 folds and 3 signatures, in which case they would agree that disqualified witnesses, besides for relatives, cannot sign it. The remaining points are additionally qualified. There are additional points, and some even allowed a random slave from the street to sign this document to fix it. And that's the end of Chapter 8. Chapter 9, the final chapter of Tractate Gittin, goes through some additional final laws of the divorce document. The first Mishnah says, if a husband divorces his wife and informs her that there's a stipulation that she can marry whoever she wants besides for one particular individual, some say she can marry anyone besides for that one guy, others say she can't marry anybody, so the husband should instead retract the divorce document and give it back, now saying that she's allowed to marry anybody. If the restriction was written into the actual divorce document, even if he erased it later, the document is invalid. The Gemara explains the Mishnah used some odd wording of that she can marry anyone but a specific individual. It debates if this means except for him or on condition that she doesn't marry him. Based on a related discussion of tsaras, leprosy impurity, where it uses similar wording, it shows that it means except for this person. Others do still disagree. It further explains this debate as to whether specific qualifications within a divorce document is valid or not. It also debates if this concept is permissible by betrothal. There is an additional unresolved point as to what if the husband had told the woman she can remarry anybody besides for some particular people, and then handed her the divorce document saying she's allowed to marry those people. It's debated if she can now marry anybody or if he meant she can now only marry those particular individuals. In regards to the opinion that the husband can make restrictions within the divorce as mentioned later, many sages wanted to refute this, so they posited many potential issues that could arise from this situation, but it was said it couldn't be refuted. It gives additional instances of this concept. The attempted refutations are additionally discussed. Further, any potential condition on a divorce cannot prevent complete marital severance. For instance, if the document is conditional that she no longer drinks wine, it's valid. If it's conditional that she no longer drinks wine so long as the wife is still alive, it's invalid. If it's conditional that she no longer drinks wine as long as another particular person is still alive, this is valid. Additionally, it's debated as for what to do if the man gave his wife a divorce document saying, "You are not my wife today, but you are tomorrow." It said once she's divorced for that first day, she's permanently divorced. If the husband told his wife she's divorced on condition she goes and marries a certain person, it said she cannot now marry that person, so that way people don't think that you're allowed to trade your wife as a gift. But if she did end up marrying him, they don't need to divorce due to this rabbinic issue. Others disagree and say she actually can't marry anybody, as she has to marry him as stipulated, but she also can't marry him due to the mentioned issue. So he would hold that she must divorce anybody she marries, besides for the particular individual as was stipulated. If there is an impossible to fulfill condition in the divorce document, like that she flies up to the sky or something similar, it's debated if it's valid. We hold it is. It's debated if the condition that she does something impermissible, like eat a pig, if that's similar to this, or as it's a physically possible thing, if it's considered to be a binding condition. If further debated validity of such a stipulation, the remaining points from the Mishnah are additionally qualified. These are discussed further along with some particular incidents. New Mishnah. If a husband gives a woman a divorce document on condition that she doesn't marry somebody that she can't marry anyways, such as his father, her brother, a non-Jewish person, or otherwise, it's a valid divorce. If she was a widow and he said she can marry anybody besides for a Kohen Gadol, or now that she's a divorcee, a Kohen, or an illegitimate individual, or anybody else, that you are permitted to make a betrothal with, albeit through a transgression, the divorce is invalid. The Gemara clarifies what additional cases these parameters include. If the husband stipulated that his wife can marry anybody besides for a particular minor, it's debated if this is a valid stipulation, as a minor is not allowed to be betrothed until he's an adult, or perhaps it would be valid as he'll become an adult eventually, undoing that factor. It debates this from a few similar cases. This first point, it said the divorce is invalid, and the remaining points are unresolved. New Mishnah. The main part of the text of the divorce document is, "You are hereby permitted to any man." Some add that the document must have the words, "And this is what shall be to you from me, a document of banishment, and a letter of abandonment, and a bill of release, to go and wed any man that you will want." The main parts of an emancipation document are the words, "You are hereby a free woman or man," or "You are hereby unto yourself." The Gemara discusses other particular phraseology that could function within these documents. It also explains particularities in regards to the method of writing the divorce document, the way certain letters should be marked, spacings between certain letters and words, and similar. There are additional points on this. It generally looks like this. New Mishnah. 3 types of divorce documents are invalid, but if the woman remarries after receiving one, her children are still legitimate. A document written in the handwriting of her husband, but wasn't signed by witnesses, a document that was signed by witnesses but has no date, a document with a date, but only one signed witness. Some say if it wasn't signed by witnesses, but it was given before witnesses, it's valid. And also an unsigned document given before witnesses can be used to collect encumbered properties, as this opinion holds witnesses' signatures aren't essential, they're just to prevent issues. The Gemara says this is unlike an old divorce document, as described earlier, where the remarriage is permitted initially, unlike here. It also doesn't discuss an unsigned folded divorce document, also mentioned earlier, although it's similar. It
Also explains why it didn't bring the mentioned case of the document being dated unlike the region. This is further qualified. There are additional points on this and several opinions as to who exactly we follow by these laws. New Mishnah. If two men sent two identical divorce documents to their wives through an agent and they got mixed up, both documents should be given to both women. So if one got lost, the other can't be used. If 5 men all write within the same divorce document that they're divorcing their wives, with all the signatures below, it's valid and should be given to each of their wives. If a separate basic formatting was written for each of them, with the witnesses signed at the bottom, only the bottom one is valid. The Gemara additionally qualifies specifics on these points. New Mishnah. If there were 2 divorce documents written on one paper beside each other, and there are 2 Hebrew witnesses from one going beneath both, and 2 Greek witnesses from the other extending beneath both, only the first Hebrew document is valid. If one is Hebrew and Greek, and one is Hebrew and Greek extending beneath both, then both are invalid. The Gemara explains the particular issues with these cases in regards to the specific formatting of the signatures on a divorce document. These are discussed further. New Mishnah. If the remainder of a divorce document is written in a second column with the signatures beneath that one, it's valid. If the signatures are at the top, to the side, or on the back of an unsealed divorce document, it's invalid. If 2 divorce documents are attached vertically by the tops and the signatures are in between, both are invalid. If both are attached by the bottoms with the signatures in between, only the document facing the same way as the signatures is valid. If the bottom of the first is attached to the top of the other with the witnesses between, only the top document is valid. If a regular document writing was in Hebrew and it was signed in Greek, or written in Greek and signed in Hebrew, or one witness's signature was Hebrew and the other was Greek, or it was written by a scribe and signed by one witness, it's valid. If the witness signed name witness, it's valid. If he signed the son of his parents' name witness, that's valid. If he wrote name the son of his parents' name, but he didn't write witness, it's valid. And this was how some particularly righteous individuals would sign their documents. Additionally, if in the actual document the husband and wife's last names were written instead of the parents' names, it's still valid. The Gemara discusses the issues in regards to the formatting with illicit cases. It debates the specifics as to what's being referenced in the described cases, with the witnesses being signed in between, along with a few particular incidents, and it also expounds on a number of related verses. New Mishnah. Only a Jewish court is allowed to force a man to give a divorce document. You're allowed to hire non-Jewish people to beat up the husband until he's willing to give the divorce document. The Gemara further discusses this, along with the validity of certain courts from those times doing this. New Mishnah. If a woman was rumored to be betrothed, she's treated like she's betrothed. If a woman is rumored to be divorced, she's treated like she's divorced. There are mitigating factors which remove the effects of such a rumor, such as if the woman was divorced conditionally, or if the betrothal was thrown to the woman, so it's questionable. The Gemara discusses this along with the believability of other types of rumors of impermissible relations, particular variants of betrothal, like in a different town, and similar. These are additionally discussed along with particular incidents. These are all further discussed. New Mishnah. Beis Shammai says a man is not allowed to divorce his wife unless he found her being adulterous, which is based off of a verse. Beis Hillel says a man can even divorce his wife if she did something offensive to him, like burn his food. Rabbi Akiva said a man can even divorce his wife if he found someone he'd prefer to marry, which is also based on a verse. The Gemara additionally debates the wording of these verses as to their implication. Additionally, if a husband divorces his wife for no reason, he does not need to remarry her. It's also said to be improper to plan on divorcing a wife without letting them know. There are additional verses spoken on in regards to grounds for divorce on the topic of wives acting publicly improperly, and to be careful of such things. There's more on this, and it says that God despises a man who divorces his wife in regards to a second marriage. And further, it's said that when a man divorces his first wife, even the altar in the temple cries, which is based on a number of verses. And that's the end of chapter 9 and the entire Tractate Gittin. Alright, that was a lot of information, so here's a rough summary of a lot of the practical takeaways from this tractate. A man can divorce his wife through a divorce document called a get. There are particularities on the writing and signing of such a document. It must be done specifically with intent towards the divorced woman in question, and signed and certified by witnesses. Generally, divorce is very much frowned upon and should only be done if absolutely necessary. The Second Temple was destroyed due to causeless hatred, and will, God willing, be rebuilt through causeless love.
Tractate Kiddushin discusses the laws of betrothal, along with points on the different stages of marriage during the betrothal and related laws. The first chapter begins with the general laws of betrothal and acquisition. The first Mishnah says, a woman can be acquired in marriage through 3 methods, referring to betrothal: through being given a sum of money, through a document of betrothal, or through an act of cohabitation done specifically to create a betrothal. It is worth noting, however, that betrothal through cohabitation was later made impermissible and outlawed, as it could cause way too many issues. So it's really only the first 2 that apply. If it's done with the amount of money or an item worth a set value, Beis Shammai says the minimum amount should be the value of a dinar or something of its worth. Beis Hillel says it's the minimum of a pruta, which is a different form of coin. The woman ends the marriage, acquiring herself back through either a divorce document or through her husband's passing. Additionally, a woman doing yibum, the Levirate marriage, can have this accomplished through cohabitation, and this marriage could be ended either through the chalitza ceremony or through her brother-in-law passing. The Gemara explains it uses the word acquire here as opposed to the typical terminology of betrothal, as is a term that references the form of betrothal through the payment of a sum. The source for the validity of this concept is defined from a verse. Later, it'll go back to using the terminology of Kiddushin, betrothal, and this specific word is used as the word Kiddushin is related to the word hektish, to consecrate, essentially. As similar to consecrating something to the temple, the woman is also forbidden to be with anybody else besides for her husband. Additionally, the Mishnah speaks from the point of view of the woman, unlike later, as here it also speaks of her acquiring herself back, and additionally, it's to show that a woman can only be betrothed if she consents to it. It also additionally defines why it used certain words in either their masculine or feminine forms during the initial quote, and why other particular words were used. Particularly on the wording derech, which means way, in reference to the way, or manner of things, and it goes through many other quotes where similar wording is used. It alternatively suggests it's used to show there's differentiation within laws on the topic. Additionally, the specification of particularly 3 methods of betrothal comes to exclude chuppah, a part of the final stage of marriage, from functioning as betrothal in the initial stage of marriage. Others hold that chuppah actually is allowed, and they say it's to exclude chalifin, a legal exchange form of acquisition, which according to him cannot be done to give a betrothal, as it can be done with an item worth less than the value of a pruta coin, which a woman would not accept for betrothal. The specification of specifically 2 methods of ending a marriage comes to exclude chalitza by a typical marriage from functioning. It cites further sources from verses and scripture that a woman can be betrothed through money. It further goes through verses and explains the necessity of particular words and letters along with other sources for principles and the laws of emancipation. It additionally quotes the verse, "When a man shall take a woman." The specific terminology for take used in the verse is one frequently used to reference monetary sale, which is a source that betrothal can be effected through a sum. The source betrothal can be done through cohabitation is the end of this verse, and he cohabits with her, referencing the fact that betrothal can be done through a cohabitation. It also explains the necessity of these verses as to how these principles can't be learned from other verses. Finally, the source that betrothal can be done through a document is discussed. It cites a few potential sources, and it quotes the verse, "And she will leave and she will be," referencing both divorce and then betrothal. And it's known that divorce is accomplished through a document, so the inference is that betrothal can be accomplished in a similar method. It says many sources that the inverse does not apply to show that divorce cannot be done through giving a sum of money. It additionally explains why none of these 3 methods of betrothal could be learnt out from the other 2, due to additional issues with the comparison, along with the ruling out of additional attempted comparisons. It further explains how the process of chuppah cannot be learnt to be permissible by betrothal, along with the other allowed points. Anyways, in regards to the actual process of betrothal, via money in this case, essentially if a man gives the woman a sum of money, or an item worth a sum of money, and says the words, "Behold, you are betrothed to me," or with similar terminology, they're then legally betrothed. This can only be done with the man betrothing the woman. Additionally, it's explained that if the man gave the sum of money, but the woman said the words of betrothal, it's not valid. Some say actually if she gives the money and says the words, it's invalid, but if he gives the money and she says the words, it's uncertain. It also lists a few terminologies that don't legally function to create a betrothal, along with phrases that wouldn't work as divorce, along with explanations. It goes through a number of other potential terminology, variation of the words, "You are betrothed to me," as to which ones are permissible to use and which ones are not. Particularly, for instance, if the man said, "You are my charofa," which essentially means designated. It's said to be a valid terminology, but only specifically in Judea, where such a terminology was commonly used in reference to betrothal. Additionally, other unique phrases like "you are singled out for me," or a different variation of "you are designated for me," it said these are valid, but some clarify these only function as long as the discussion between the man and woman occurring prior was specifically on the topic of betrothal, and we bring sources that this concept does exist, although it does remain unresolved. Broadly, some would hold that if there's just a general discussion on the topic of divorce or betrothal between a man and a woman, and then the man just hands the woman a divorce document or an item for betrothal, some hold this prior conversation was sufficient, others hold that they need to give a precise statement of intent after. It's debated, but it is held that in such a case, just the prior conversation would have been sufficient. It further goes through additional phrases of divorce on emancipation and similar. Further, some state betrothing a woman through a loan does not take effect, but betrothing through the benefit of a loan does, but should still not be done to prevent issues of interest. The benefit of a loan here references betrothal on condition that he'll extend the time of his loan to her. So the financial benefit she gets from that deal is what's acting as the betrothal in this case. Additionally, if a man gives a woman a coin on condition it is returned to him, this cannot be done to create a sale, or to betroth a woman, or to redeem a firstborn son. It can be done to give teruma tithes, but it shouldn't, as it resembles a Kohen who works on a threshing floor to receive teruma as payment, which is a wrong thing to do. This is based on a debate as to if a gift given on condition that it will be returned, as to whether that's legally considered to be a gift. Anyways, an additional method of doing betrothal, through giving a sum of money, the woman can tell the man to give the money to another individual on condition that she'll be betrothed, as she's acting as a guarantor, essentially, in this case. Additionally, if a man tells an agent to betroth a woman to him, but the agent spends the money, and then gives his own money to the woman to betroth the initial husband, this is valid, as a Canaanite slave can be emancipated through a similar principle. Also, if a woman tells a man to give money to an individual, so that she'll be betrothed to him, the second man, this works, based on both of the above established principles, which are additionally explained. If a woman gives a man a sum of money, and says she'll be betrothed to him if he takes it, some hold this is valid, as in this case, the referenced husband is a very distinguished individual, and is benefiting the woman by accepting her gift, and basically honoring her, thereby making it a valid form of betrothal. It additionally explains the application of these principles by related laws. Another rule, some hold if a man tells a woman to become betrothed to half of him and she accepts, this is a full betrothal. If he says half of you should become betrothed to him, it's not a valid betrothal. The logic is that a man was allowed to marry multiple women, but not vice versa. Others just disagree with this principle. Additionally, it asks, what if a man tries to betroth half a woman with half a coin, and then the other half of the woman with another half of a coin? It debates if this is permissible. Additionally, it asks, what if both halves were given at different times, or on separate days, or both halves were of a single coin? These all remain unresolved. It's also unresolved if a man said to another that his 2 sons will betroth the other's 2 daughters through a single coin. There are additional posed questions which remain unresolved. There was a case where a man gave a woman an amount of silk as a betrothal. Specifically, he said she should be betrothed for 50 coins, and the silk was worth that amount. However, its value was not appraised when it was given. It's debated if the appraisal was necessary. Some say no, as it was worth the correct amount. Others say yes, as the woman wasn't sure of the worth of the cloth. Others say the dispute is simply where the husband offered the silk as is for a betrothal, and the debate is if the worth of the item has the same status as money, as to whether or not it must be appraised to clearly define the worth. They argue over sources for this. Others rule simply, if a man promises a woman 100 coins for a betrothal, and then gives 1, this is a valid betrothal, but he must pay her the full amount later, as it's like he created a conditional betrothal on him paying the remainder later. Others disagree with this notion, and they debate its permissibility from sources. Others hold if a man promises 100 coins as betrothal and then gives her an item as collateral, this is not a valid betrothal, as that's not even a valid collateral. This is additionally qualified, and it cites some related incidents. There are a number of unresolved points in regards to unique methods of giving the betrothal item, like placing it on a rock that's owned by both of them, or if he gives it to a dog that's chasing after her to save her, thereby benefiting her, and similar. It also goes through some other means of betrothal. If a woman requests the purchase of an item, like beads or a drink, or some dates, and the man offers to give her them in exchange for her accepting his betrothal, and the woman says, do give them, it's ruled that that would not be a valid betrothal. Finally, in regards to the earlier mentioned silk case, it said that it does not need to be appraised, and we follow the opinion which says if a man offers a betrothal of 100 coins and gives 1, he is betrothed and can give the rest later. And we follow the opinion which says in that case, if he instead gave her something as collateral, that is not a valid betrothal. Anyways, non-betrothal through a document. It's described, it can be written on paper or earthenware of any value, specifying the woman is betrothed to the man. This is the opposite of a bill of sale, where the owner of the item writes the sale, while here the husband is writing the betrothal. This is based on verses which are described. Others say it's just a tradition from Mount Sinai that it's done this way. In addition to the above described points on the betrothal document, a father must consent to the betrothal of a daughter, unless it's an adult woman with legal independence, in which case she can betroth by herself. It asks, what if the document of the initial stage of betrothal was not written specifically for the sake of the woman? Is this still valid, or does it need to be like a divorce document, which is specifically written with the intent for a specific woman? It says this is a valid comparison based on a cited verse, meaning the betrothal document must be written with the intent and for the sake of the specific woman. It debates whether the woman needs to be aware of the writing of this document based on similar comparison of verses. Finally, a woman can be betrothed through a specific act of cohabitation, based on a verse here. A woman who has cohabited with a husband. This is a different verse than was brought earlier to show that both verses are necessary, that betrothal through cohabitation is sufficient on its own without any of the other methods being necessary. Others disagree with this logic, saying such necessity of double verses don't exist by other topics. They further debate the necessity of these verses. There are additional points on this. Further, it asks if it's the beginning or ending of the act of cohabitation that would create betrothal. This would be relevant if a man started cohabiting with a woman for a betrothal, and then the woman accepts a betrothal from somebody else. It's also practically relevant to know if a Kohen Gadol, who is obligated to marry a virgin, if he can betroth through cohabitation. It's held the betrothal takes place upon the ending of the act of cohabitation. It similarly debates if cohabitation for betrothal can also be done to affect the final stage of marriage, nisuin, and it brings sources that it's only relevant for betrothal. It also brings proofs for the opposite, but those are disputed. It also debates related laws from these concepts in regard to the consumption of teruma tithes. As to the opinion of Beis Shammai, that the minimum a woman can receive for a betrothal is a dinner, some say this is as a woman would presumably only be willing to accept that as a minimum amount. Others say it's based on a verse which uses an expression which references silver Tyrian currency. It gives a few instances of similar uses of this word throughout and how they refer to the usage of this specific variant of silver coin. This notion is debated referring to several other verses. A third reason for Beis Shammai's minimum is that there's a verse from Chizkiah which states that a maidservant can deduct the value of the years she's worked from the price of her emancipation, pay the remainder, and then go free. Based on the fact that there's a deduction of value occurring from a set amount, the initial sum must refer to a dinner which can be divided into a smaller sum, and not a pruta which is the smallest possible sum and can't be divided further. Anyways, he would derive laws of betrothal from here, and imply that both must evidently be done with a minimum of a dinner, a coin of substantial value. A final explanation as to why he'd require a dinner was so that the daughters of Israel would not be viewed as insignificant due to a low betrothal sum. Beis Hillel, on the other hand, says the minimum can be a pruta. Some say this is a fixed sum, an eighth of an Italian issar. Others say it goes by the current value. It is debated as to which we hold like from a few sources in regards to a debate as to the different values of several types of ancient coins in relation to each other. Some hold simply if a man betrothed a woman by giving her a date, even if it looks like it's worth less than a pruta in its location, it's still valid as it could be worth more in different locations. It gives some instances of this principle. There are more of these, and it cites a case where a man gave a woman a mat of myrtle, and people said it wasn't worth a pruta, so he said she'd be betrothed through the coins which were held within the mat, which the woman took without saying anything. It was held that she was silent after she received the money, which is not legally considered to be consent, which means it wasn't a valid betrothal, and it brings sources. Others disagree with this principle, and it's debated. There's another case of a woman selling silk ribbons, and a man went and grabbed one from her, and she demanded it back, and the man said he'd only return it on condition that she would be betrothed to him, so she took the ribbon and said nothing. It was held this was not a valid betrothal, as she was taking back something she owned, and it discusses some related instances. There's a comparison between betrothal and a land sale, saying neither can be done at a value of less than a pruta. Additionally, it stated that anybody without knowledge of the laws of divorce or betrothal should not be involved with them by being a judge and whatnot, and doing it anyways is considered to be worse for the world than the generation that brought about the flood, which is based on verses. There's related discussion on laws of debt and loans. There are a few sources discussed, and additionally brings sources for the fact that a woman after her husband's passing may remarry, along with sources that Yibum, the Levirate marriage, is accomplished through cohabitation and similar. It also cites the verses for the notion of chalitza. The fact that a woman coming from a Levirate marriage has her marriage ended upon the death of her husband is learned from a logical comparison to a typical marriage, which is treated stricter here, and by there, she is allowed to remarry upon the passing of her husband, so too here. It additionally discusses this comparison and disputes other similar ones. It also goes through sources from scripture that a woman who did Yibum, the Levirate marriage, cannot remarry based on a divorce document. New Mishnah. A Hebrew slave can be acquired through money or a document, and he acquires himself through fulfilling 6 years of service, the coming of the Yeval year, which is every 50 years, or through the repayment of his value, minus the amount he served. A Hebrew maidservant can reacquire her freedom through this, or by coming of age and having physical signs of adulthood. If a slave completed his service, he can choose to stay in his owner's employ, but must undergo a process described in these verses, wherein he gets a small hole bored through his ear against a doorpost, or through the coming of the Yovel year, or through his owner passing away. The Gemara cites sources for this principle that Hebrew maidservants can reacquire herself through money. These are discussed further. Based on other verses, some would hold if a slave has chosen to sell himself, he can choose to be sold for over 6 years, and also he cannot choose to have his ear bored to maintain his servitude. Further, it said, according to this, in such a case, when he's emancipated, he's not given a severance gift, and additionally, his owner can't give him a Canaanite slave woman to have children with. Sources for these principles are cited, and it's all additionally discussed. It further goes through the different opinions on the implication of particular words throughout the verses on this topic, on the laws of emancipation. Particularly, there's a debate if slaves are emancipated from a non-Jewish person through non-relatives or relatives. So, one would hold if somebody is redeemed by non-relatives, they go into this new individual servitude, as otherwise they wouldn't redeem him in the first place. Others hold that if he's redeemed by his relatives, he would go into their service to prevent himself from repeatedly selling himself and having to be emancipated repeatedly. Others say simply both types of people make him become totally free. It also brings a source that a slave can be emancipated through a document, which is debated as to who it holds writes the sales document. This is additionally discussed along with the sources for the freedom from the Yovel year, every 50 years, through earning his value, and the other remaining methods. It additionally debates if a maidservant goes free upon the death of her father. This is argued from a number of discussions. This is all qualified further along with points in the laws, in particular sums of severance gifts, along with other versions of it. gifting flocks, grain, or wine instead of a sum. Additional sources for these points are brought. It also cites sources to show that non-Jewish people too have the laws of inheritance applied to them, and they inherit from their parents. It speaks further on various laws of emancipation, and it also states that a female slave can't be sold by her father repeatedly. This is unlike a male who can specifically enter servitude multiple times to repay separate people that he'd stolen from. On that topic, it said if a person's value is 500 coins and he stole 1,000 coins worth of goods, he can repay this by selling himself as a slave for 2 terms. If he was worth 1,000 and he stole an item worth 500, he can't sell himself for this at all. Others say he can only repay through his servitude if he and the item he stole have the same value. It's also said that a maidservant can be redeemed even against their father's will to prevent disgrace, and as explained earlier, she's not legally allowed to be resold. There's further debate on this, and it asks if yield, essentially a man offering a betrothal to his maidservant through the money he spent on her, as to which stage of the marriage process this would create, whether the initial or the final stage, which is practically relevant in regards to him being allowed to bury her if he's a Cohen, or if he's allowed to annul her vows. It debates this from several sources as to which stage of marriage this would create. It also debates whether a minor boy, the son of the owner, if in this case he's legally allowed to enter this stage of betrothal through this process. It said, according to one opinion, that a minor boy just before the stage of adulthood is uniquely allowed to do the Levirate marriage, Yevamos, marrying the dead brother's wife, as they have a legal bond already, unlike by typical cases of marriage, where both parties need to be adults for this to be valid. However, it's not really considered to be a full proper stage of marriage, and many laws wouldn't apply. For instance, the woman wouldn't be held liable for adultery during this period. Anyways, by the maidservant, it said that betrothal can only be done by an adult and with intent, which is said to mean that it's done with her intent, meaning so long as she also consents to this. Others debate the validity of this entire principle it's discussed. Some do try to imply from this that a father can tell his minor daughter to accept her own betrothal on her own to get married once she becomes an adult, along with additional points. There are further principles of these laws discussed. It also debates if a girl can be sold to her own relatives, along with additional points. Additionally, in regards to a Hebrew slave, the verse says, if he comes with his body, he shall leave with his body. Some take this to mean his physical body should leave as it was taken in, meaning intact. Others say it means if he enters alone, he leaves alone. According to the first opinion, this would imply, unlike by a Canaanite slave who must leave servitude upon particular injury, this wouldn't apply here. Some saying this means he's given additional financial payment along with his freedom. According to the second opinion, this would mean if he's married when he becomes a slave, he can also be given to a Canaanite maidservant. If he was unmarried, he cannot. There are further points on the calculation of the slave freeing himself based on his value, which is said to go by his purchase price, so it remains there even if he goes up in value, along with sources. Additionally, in regards to the treatment of slaves, it's said that they should have food, drink, and beds of at least equal quality and value to their owners, which shows that they're generally treated leniently and kindly, which is brought to suggest this would also apply to their emancipation payment. It's debated. There is further discussion, and it also debates if a Hebrew slave working for a non-Jewish person, if he can repay his servitude in half payments, or if it must be done all at once. This is discussed. It also goes through some points on sale and redemption of fields in regards to the Yovel year. In regards to the principle that a slave can choose to retain his servitude, but must have a hole bored through his ear, as the verse says, and the master shall bore his ear with an awl, and he'd additionally become free during the Yovel year, the source for which is also brought. It lists the necessary type of hammer, awl, and whatnot that are used in this process, and the hole is placed in the upper cartilage portion, along with debate if all the tools must be metal or not, based on principles of derivation from verses. It also says it must be an awl specifically, and not a corrosive liquid or something. Some disagree and say it actually must be the ear lobe that's pierced, which is discussed. Additionally, in regards to the laws specified within these verses of a captive of war being allowed to be married after a month-long mourning process and conversion, it argues if a Cohen is allowed to do this, and it said that the initial act of cohabitation is permitted, as the law is actually viewed as a deeply wrong thing. It's just that these unique laws were given, as the verses list, as it says, in recognition of the evil inclination, so as to only allow the theoretical cohabitation with the captive after the listed sequence, after a month-long wait, to try to mitigate what would have been a much greater issue back in those days. Others say there's actually debate if the Cohen is allowed to do this even the first time. The logic of the principle of marrying a battlefield captive is further explained. Essentially, as referenced in verses of the Torah and explained here, such a notion is considered to be deeply immoral and abhorrent. However, in those days, soldiers on the battlefield basically did whatever they wanted, and it says it knew that if it was just outright prohibited, everybody would just violate the principle in a far worse manner. So instead, it was ruled that it was forbidden to cohabit with a woman right there, and instead she can be taken home, wait a month, have her cut her hair and let her nails grow out to try to make her be generally more physically unattractive. And generally, after this whole month-long process, people would become typically disinterested, and it would prevent what would have potentially been a severely problematic issue. Further, on the slave requesting to maintain his service, it said that he must request this twice, once at the beginning of his service and once at the end. This is discussed along with the other principles as to when this concept is impermissible, such as if the slave has a wife and children, and the owner does not, and others. It also speaks on several verses, and it says that a man is also obligated to sustain his slaves' families. It goes through additional particularities as to how the doorpost and owl sequence was performed. New Mishnah. A Canaanite slave can be acquired through money, a document, or a proprietary act. He becomes free through others paying a sum for his emancipation or through an emancipation document. Others hold he can also free himself by paying his own value, or through somebody else's emancipation document, so long as the sum belongs to them. The Gemara cites verses for sources for these points. Some say a Canaanite slave can also be acquired through chalifin, an exchange of articles. Others say it should be done with a physical acquiring, meaning holding him and bringing him over to you as opposed to calling him over. It also gives some definition as to a proprietary act, such as carrying his shoes, his clothes, washing him, dressing him, or otherwise. Additionally, it's held that a female Canaanite slave cannot legally be acquired through an act of cohabitation of any manner. It cites some related incidents illustrating the laws of proprietary acts to acquire a slave. The remaining points on the different forms of emancipation are additionally discussed. This is all qualified further. Additionally, it's said that a slave is redeemed upon particular injury, like the loss of a tooth or the end of a limb that won't regrow. Sources are cited. These are discussed further, and it's also debated between several opinions as to whether a slave who goes free due to an injury, if they should additionally receive an emancipation document. It's also said a slave who is made disabled by being hit, such as being deafened or blinded, he automatically gets to go free, but only if he was struck on that organ, meaning the individual who hit him was directly responsible for his injury. Additionally, for instance, if the slave was struck and was injured, but not fully, for instance his eyesight worsened or a tooth loosened, he goes free anyways, if they're not usable. If they were weak or loose beforehand and were then knocked out fully, the slave would go free, assuming they still functioned prior. If the owner was a doctor and was trying to assist his slave and during the operation accidentally injured him by blinding him or removing a tooth, the slave gets to go free anyways. It's additionally held if the slave was blind and the owner knocked the eye out of his eye socket, even though it wasn't usable, the slave goes free as he's missing an organ now. If the slave had an extra finger in a row with the others and the owner cuts it off, the slave goes free. It cites a related incident, and it also lists all the limbs which are considered to be the ends of the body, which was relevant by the laws of impurity, which are the ends of the 10 fingers and toes, the ear tips, the nose tip, the end of the male genitalia, and the ends of a woman's chest, and some say also a male's. Castration of a slave makes them go free automatically, although it debates as to which parts. A tongue cannot be cut by a slave, not without having them go free automatically, although it's considered to be a hidden organ by the laws of impurity, meaning it does not need to be exposed to water by immersion. There are additional laws of immersion qualified. It further debates which parts of the male genitalia, when injured or cut, would make a slave automatically go free. New Mishnah. A large animal is legally acquired by its owner through handing it over via the reins or mane. A small animal is legally acquired by lifting it up. Others say the small animal is legally acquired by drawing it near, taking it into the buyer's domain or particular public areas. The Gemara says, some hold that large animals are also acquired through drawing them near. Others say large animals must be lifted, so the acquisition of an elephant, for instance, would be done either through chalifin, a representative exchange of an item, or by renting the space where the elephant stands, or by placing 4 vessels beneath the feet of the animal, assuming it's in a public domain. Or you could have the elephant step on bundles of vines. New Mishnah. Real property, land, and houses are acquired only through money, a document, or a proprietary act. Movable property can be acquired by drawing it near you. Movable property can be acquired along with real property via money, a document, or a proprietary act, and movable property can make real property subject to an oath regarding it. The Gemara cites sources for these principles. Additionally, if the custom of a locale is to buy property only via a document, you must use a document unless otherwise specified. There are further sources cited for all this. It debates if movable property must be actually piled on top of the land that it's being acquired with. It has some particular incidents on this. It's further discussed and held that movable property does not need to actually be piled onto the land it's being sold with, but the seller must specify that it's by dint of the land, and he must tell the buyer to acquire the movable property in addition. The sales can also be combined if the field is being sold and the movables are being given as a gift. If the field is being transferred to one person and the movable property to another, it debates as to what to do here. There's further discussion on these principles. Based on a source, it's additionally implied, like the opinion, that if a person sells 10 fields in 10 different countries to a man, when the buyer performs an act of acquisition on one of them, he acquires all of them. Some say there are attempted refutations of this concept. It's discussed, others disagree, saying the purchase of land is distinctly different than animal sales, as technically the whole earth is one entity anyways. The remaining points from the Mishnah are sourced along with further points. There are additional points on the laws of oaths. New Mishnah. With anything used as payment for something else, once one party has possession of the payment, the other party is responsible for the item. For instance, if an ox is exchanged for a cow or a donkey for an ox, once one party has taken possession of the other animal, the other party is then responsible for the other animal. The Gemara debates if the item being used for this exchange, called chalifin, is a coin. It said no, as chalifin can be with anything used as a substitute for payment, meaning anything but a coin, essentially. The remaining points on acquisition through exchange are additionally qualified. New Mishnah. The temple treasury can acquire through money, while a typical person's domain acquires through a proprietary act. Additionally, verbally declaring an item as consecrated to the temple is sufficient to the same degree as handing over a typical item. The Gemara explains the temple treasury can purchase an item for money, even if it's nowhere near them, unlike by a typical sale. It also defines some principles on consecration. New Mishnah. Bit of a new topic. All obligations a father has to his son, men are obligated in, and women are exempt. Regarding the obligations that a son has to his father, both men and women are obligated in. Broadly, as a very important general rule, men are obligated in all commandments of the Torah, while women are obligated in all besides for any time-bound positive commandments to do something, which they are exempt from. Both men and women are obligated in all negative commandments to not do something, besides for not cutting your beard, which applies only to men, and to not become impure from the dead, which applies only to Kohanim. The Gemara defines the principles of obligations a father has to his son, which are to circumcise him, to redeem him if he's a firstborn, to teach him Torah, to get him married, to teach him a trade, and according to some, to teach him how to swim. Some add, if a father doesn't teach his son a trade, it's as if he's taught him banditry. The sources for the fact that a father is obligated for each of these are brought from verses, and particularly how these apply to a father to his son. Additionally, it's debated if a father or his son has priority in regards to them being redeemed from a Kohen. There's more on this. It's also debated if the redemption of somebody's son or the going to the temple for a holiday pilgrimage, which is time-sensitive, which of the two have priority. And based on verses, it's also said that a man is obligated to redeem all of his firstborn sons, even from several wives. We bring verses to show a mother is exempt from the obligations to teach her son Torah, as she wasn't commanded to be taught herself, which is itself sourced here from the verse, and you shall teach them to your sons. Some say a father takes precedence over his son to study Torah. Some say the son, if he's smarter or more diligent, will take precedence. It gives a related incident. There's also an incident mentioned here where there was a very powerful demon in the study hall of the sage Abaya, so strong that it could even harm people walking in pairs. So they heard the sage Rav Acha was traveling over and said that all of the guest houses were full, so that way he'd have to stay in the study hall and hopefully take care of the demon. Rav Acha stayed there, and the demon appeared to him in the form of a 7-headed serpent. So Rav Acha prayed to God and bowed to God 7 times, and each time he bowed, one of the demon's heads fell off. Anyways, Rav Acha then reprimanded everybody, saying he was only not harmed due to a miracle. It's also said a person should study Torah and only then marry, although this was said to apply in Israel, and outside in Babylon you should get married first. It cites incidents expressing the importance of marrying, and it said if a man is 20 without a wife, his days will be filled with thoughts of sin, and it said that God reprimands him. One sage even expressed how happy he was that he had married at 16, and he said he would have been able to combat the Sotah even better had he married even earlier. Additionally, it said you should advise and guide your son when he's in his youth, which is defined as either 16 to 22 or 18 to 24, depending on the opinion. It further expresses the necessity to teach your son Torah of all forms, including Mishnah, Gemara, Halacha, law, and otherwise. And it brings sources which show a grandfather should also teach his grandson, and if he does, it's as if he personally received the Torah from Mount Sinai, along with further points on this importance. It's also said a third of your day should be spent studying scripture, a third Mishnah, and a third Gemara. It also speaks of how the sages would count all the letters of Torah and point out the exact halfway point within it in other texts, and it clarifies how it was counted. It says there are 5,888 verses in Torah. Tehillim has 8 more, and the Book of Chronicles has 8 less. Although, as is said, our knowledge as to the precise beginnings and endings of scriptural verses is flawed, so we can't exactly qualify such things anymore. It's also said that a person should be so well versed in Torah that he could answer any question he's asked without stuttering. There are further points on the great importance of studying Torah. It's compared to the antidote as a cure to the evil inclination, which is said to be particularly terrible, as even God refers to it as evil in verses. It's also said that a person's evil inclination renews itself every day and tries to overpower and kill him, and without God's help, nobody would be able to withstand it. To defeat it, it says to shatter it within the study hall. Anyways, it cites further sources to get a son married and to teach him a craft along with how to swim for safety reasons. Obligations of the son and daughter to the father are things like honoring your parents and similar, and it speaks on the importance of this concept along with the great sin of cursing them, which is compared to blasphemy against God, as the mother, father, and God are all equal in the creation of a child. It also says a son should focus more on honoring his father, as a son naturally loves his mother more, so the obligation to honor the father is put first and then the mother. It also says the inverse applies, that a son loves his father more as he teaches him Torah, so verses also have the mother mentioned prior. It's also said that when a child distresses his parents, God thinks that he did the right thing by not living among them, as otherwise he would have been distressed too. It also speaks on the great negativity of sinning in secret, along with not walking 4 cubits with an upright, haughty posture, or with your head uncovered. In regards to honoring your parents, it was asked, what if your father and mother both asked that you should get them water at the same time? Who should you answer? And it was said that you should give it to the father, as the mother is also obligated to honor her husband. There's further points on this. To further express the great importance of honoring parents, it cites the famous story of Dama ben Nisina, a non-Jewish man from Ashkelon, who was renowned by the sages for his righteousness in this. As the sages went to purchase a new stone for the ephod in the breastplate of the Kohen Gadol, then they offered him 800,000 golden dinarim for it, and he accepted. However, the key to the chest was underneath his father's pillow, and he refused to wake his father during his nap, as he had so much respect and honor for him, and therefore lost out on the deal. As reward, God made a para aduma, a unique red heifer, born into his flock, so the sages went to purchase that, and the non-Jewish man, Dama ben Nisina, said he knew he could charge any price for the cow and they'd pay it, but he'd only ask for the sum he'd lost out on from the initial sale. It expresses the sages' great admiration for this and says, we can learn from this, if a non-Jewish man who has no obligation in these laws can honor his parents to this extent and be rewarded, how much more so we, who have an actual obligation, should do so, and will additionally be rewarded. There's more on this, and it also cites another incident of Dama ben Nisina respecting his parents as he was sitting in fancy silk clothes among the nobles of Rome. His mother came and tore his clothes and hit him and spat at him, but he nevertheless did not shame his mother. Further on honoring your parents, it said a man can feed his father delicacies, but if done with resentment, it will drive him from the world, and a son can make his father work a millstone, but if done only because absolutely necessary, and if done with love and encouragement, it could bring him to the world to come. It also mentions several sages who had great love and respect and honor for their parents, one even bending down to let his mother climb onto him to reach her bed and similar. It also says the sage Abayo as an orphan, however, he very frequently referenced teachings, particularly medicinal ones, from his mother all throughout the Gemara as he was raised by his nurse. There are additional incidents and further on the great importance of honoring one's parents and teachers. It also says to not sit in your father's seat or to contradict him or to interject with your opinion before him, and you must give him food and drink, dress him if necessary, and similar. It's held in regards to honoring and assisting your parents, for instance, giving them food, it should be purchased from the father's funds. You can also use ma'aser, charity tithes, although it says it's improper. There's more on all this, and it also says the honor of one's father should take priority over other mitzvahs if they can be done by others. It's said a father can renounce his honor, but it's debated if a teacher can renounce his. This point is discussed along with a few related verses. There's more on standing before the elderly and one's teacher and similar. There's more on this. It also says to stand before a Torah scholar, and therefore, for sure, a Torah scroll itself. It discusses additional verses. Anyways, in regards to the principle that women are exempt from all time-bound positive commandments, this would mean they're exempt from having to dwell in a sukkah or shake lulav and etzrog on sukkahs. They're exempt from having to hear the shofar blown on Rosh Hashanah, they don't need to wear tzitzis, and they do not need to wear tefillin. They would, on the other hand, be obligated to have a mezuzah on their door, build a fence on the roof, return a lost object, and many others, all positive commandments which are not time-sensitive. There are a few unique exceptions to this principle, such as the obligation to eat matzah on Passover, to rejoice on holidays, and to partake of the Hakel gathering, even though those were actually time-sensitive, and they're exempt from having to learn Torah, propagating and redeeming their firstborn sons, even though those are not time-bound. The principle is derived from tefillin, a time-bound positive commandment, which women are specified to be exempt from, along with Torah study, both of which contain the first and second portion of the Shema prayer, unlike a comparison to the mezuzah, which only has the first portion of the Shema prayer. Others debate these principles. These individual obligations are additionally discussed. The specifics of the exceptions are also qualified as to why they specifically apply. It cites several verses which show a man and a woman are equated by laws of punishment, laws of monetary payments, and laws of killings. All of these must be specified, as punishments could be unique as they were for atonement, payments is unique as without it women wouldn't be able to live normal lives, and killings is unique as there's a loss of life. It qualifies the principle that only a man is obligated to not cut his facial hair, along with sources. Some also add a woman is not exempt from the commandment to not make a bald spot on her head out of mourning for somebody, and it brings a source which is discussed. These sources are further spoken on, along with some additional verses. New Mishnah. In regards to services within the temple, the leaning of hands upon an animal, the waving offerings, and the bringing of the mincha offerings over to the altar, and kamisa, scooping a handful of a flour offering, and burning of sacrifices on the altar, and milika, the unique slaughter of a bird offering, and the receival of the animal offering's blood, and the sprinkling of the blood, all of these apply only to men, besides for the mincha offerings of the Sotah or the female Nazir, which apply to women. The Gemara cites sources for all of these individual principles as to how the verses each imply who precisely they refer to. These are further listed. New Mishnah. Every commandment dependent on the land, which will be defined, applies only within Israel. Anything not dependent on the land applies everywhere, besides for Orla, the prohibition to harvest fruit during the first 3 years of a tree's growth, and Kilayim, the prohibition to plant different plant mixtures together, which apply even outside of Israel. Some also say the commandment of Chadash, the prohibition against eating of the new grain crop until the Omer offering is brought on, or until the 16th of the month of Nisan. The Gemara defines a commandment dependent on the land to be commandments which apply to land obligations, and it cites sources for this principle. The sources that Orla and Kilayim apply outside of Israel is a tradition from Mount Sinai, and it debates the verses on the principle of Chadash. This is further argued on. It additionally discusses other verses on other obligations like Shabbos, Matzah, and others as to how the wording relates to these principles. It further goes through verses along with points on the passing of Moshe and the dates of his birth and passing, both of which occurred on the 7th of Adar. Additionally, it said that upon entering Israel, the Jewish people were given 3 commandments, Orla, Kilayim, and Chadash, as mentioned, which would apply also outside, although others disagree with this logic. There's more on these 3 principles, with additional points on the application of the Yovel year. Some actually held that the principles of Orla, that you shouldn't harvest fruit from a tree until it's over 3 years old, do not apply outside of Israel, but others disagree, saying it's a tradition from Mount Sinai, that they apply everywhere, although specifically to definite Orla. Questionable Orla would be allowed, according to this. It also goes through the punishment of lashes that were applicable for violating the laws of Kilayim, along with verses as sources and some particularly relevant incidents. New Mishnah. Somebody who does a mitzvah, he's rewarded for good, his life is lengthened, and he inherits the world to come. If you do not, you do not receive these. The Gemara says a different source implies that it's particularly the mitzvahs of honoring your parents, being kind, receiving guests, making peace between others, and especially studying Torah that grants you the reward in both worlds. So it says, this source says, if one does a mitzvah, that can tip the balance between your merits and sins if they're equal to grant these things. Others say the reward for the performance of mitzvahs is only within the world to come. There is a recorded incident where a boy was performing the mitzvah to shoo away a mother's bird while collecting eggs, along with honoring his parents at the same time, as he was asked to do this, both of which promise long life, and he fell and died while doing this, so perhaps the reward is not received in this world. Additionally, there's a principle that somebody on the way to do a mitzvah is not harmed, not even on their return, but this was unique as there was particular danger due to the unsafety of the latter. The heretic Acher, once the sage Elisha ben Avuya saw something like this and he became a heretic due to it, although some say it was when he saw the tongue of Chutzpis, the Metorgamon, which was ripped out by the Romans, being dragged about by a pig, and he was so upset by this that he became a heretic. It also says one who is given an opportunity to sin but chooses not to is given a great reward, as seen by a time a sage was propositioned by a Roman noblewoman to do illicit acts. So to escape, he said the name of God and caused his body to start rotting away. So she said some witchcraft and it cured him. So he ran into a demon-infested bathhouse and was unharmed due to his merit as armor-bearers of the Caesar guarded him. There was a different similar incident where a noblewoman propositioned the sage Rev Tzaddik and also offered him non-kosher meat, so he climbed into the oven to show how severely wrong he considered this to be, and the woman left him alone. There was also a time the sage Rav Kahano was selling baskets, and a Roman noblewoman tried to be improper with him. So he said he'd go to the roof to prepare, and then he jumped off the roof. So Elijah the prophet, Eliyahu Hanavi, ran over and caught him, saying he had been bothered to run 400 parsios to catch him. So the sage argued that he was in this whole situation to begin with due to his poverty, so Eliyahu gave him a chest of coins. It also cites sources for all of the earlier points on those unique mitzvahs which have reward in both worlds. There's more on this in some related verses. It also says once a person sins once, he starts to feel as if it's permitted to him. And it's also said if a person's evil inclination, God forbid, overcomes him and he's going to do something wrong, he should at the very least go far away and hide himself so that way he doesn't desecrate God's name. There's more on these points. New Mishnah. Anybody involved in studying scripture or Mishnah and ethical behavior will not readily sin. Based on a verse, the three-ply cord is not easily severed. If a person is not involved in these, he's not a member of society. The Gemara says, the righteous are compared to a tree in a clean place, whose branches that extend outwards are trimmed off, as the righteous suffer to inherit the world to come, while the wicked are like a tree in an unclean place, with the branches extending out, which are cut off, as the wicked have good in this world, so they have nothing in the world to come. It's also said Torah study is the most important, as it brings to doing the other mitzvahs, along with further on the importance of studying Torah and learning the three things listed above. It also says to not eat in the street, as a dog does. It says an angry man has nothing but anger, while a good man has the fruits of his actions, and it says to not benefit off of a man who doesn't study scripture or Mishnah or ethical behavior, and it says their company is the company of scoffers. And that's the end of chapter 1. Chapter 2 of Tractate Kiddushin continues going through the laws of betrothal. The Mishnah says, a man can betroth a woman in person or through an agent. A woman can accept a betrothal in person or through an agent. A father can give his daughter to be betrothed during the middle stage of adulthood, either in person or through an agent. The Gemara says it specifies betrothal in person to teach that it's a far greater thing to do mitzvahs personally, as we see many sages took personal involvement in the preparation of food for Shabbos, for instance. Some actually hold a man is forbidden to betroth a woman through an agent if he'd never seen her, in case he ends up not being attracted to her. So this would say the part where it says a woman can accept betrothal in person shows that's preferable, and it's permitted to use an agent, as typically they prefer to be married to anybody over not being married at all. Additionally, the specification that a father can betroth his daughter during the middle stages of adulthood, right at the beginning of stages of physical development, is specified to show that a father should not betroth his daughter when she's a minor, and in fact, in accordance with the opinion that holds, it's outright forbidden to do so. It cites scriptural source for the concept that a man can use an agent in his place to deliver particular documents by divorce and also by betrothal and by other areas. It goes through the sources for the permissibility of the appointment of an agent for bringing teruma, for the bringing of the paschal offering and other sacrifices, and it also tries to find additional logical sources besides for scriptural ones to learn these out from the others based on their similarities. These are discussed. These sources are spoken on further and additionally on principles of the court's division of a minor orphan's land. These are for the qualified. It also questions the established principle that a person's agent is legally considered to be like his sender by everything, as it says in a later tractate, Bova Kama, that if somebody sent an agent who is mentally competent with fire and he burned something down, the agent alone is liable. So shouldn't the sender also be? So it's explained that the man was sent to commit a transgression, and there's no legal principle of sending somebody to commit a transgression. There is a particular exception to this mentioned by the laws of Me'ilah, benefiting off of consecrated property, but that's uniquely based on verse. It also brings sources for the liability of a man and his agent by the stealing of an animal to slaughter and sell it, making there be two exceptions to this rule, that there's no legal principle of an agent by a transgression. The validity of the sources for this are discussed. There's a debate as to if an agent was sent to carry out a transaction, if he can additionally act as a witness to the transaction. The logic of why not is because the agent acts as the sender himself, and the sender cannot be a witness to his own transaction. It's debated, but it's held that an agent can still also act as an agent. Based on this principle, it said a man can send two agents to betroth a woman for him, both as agents and witnesses, and he can also do this for divorce and monetary cases. All three of these were necessary to list, as betrothal limits the woman, and both agents wouldn't be able to marry her, so there's no worry of false testimony of divorce. And this is unlike by monetary law, where there's a concern they might try to keep the item in question. It's such discussion which questioned the allowance of using agents as witnesses for monetary matters. In regards to a betrothed Na'ara from her father, as we mentioned in Tractate Gittin, both she and her father can accept her divorce document. Others disagreed, saying you can't have two people doing this, so it's only her father that can accept it, and if the girl cannot take care of her divorce document, she can't become divorced. Some say these principles don't just apply to divorce, they also apply to betrothal. Others disagree. The difference is that betrothal would remove herself from her father's jurisdiction, unlike by divorce. This logic is debated at length, although based on a recorded incident, divorce and betrothal are not strictly comparable by these laws, and only a father can accept his daughter's betrothal. Additionally, it's held that a Na'ara cannot appoint an agent to accept her divorce document, and only a father can do this. It had said, if a minor had been betrothed to be married once she becomes an adult and she asks somebody at the stage to get her divorce document, she can't appoint an agent, so she's only divorced, cancelling her betrothal once she herself received the document. It tries to learn from this that a Na'ara would be able to appoint an agent herself. Additionally, if a minor somehow accepted a betrothal without her father's knowledge, which is not permissible or legally valid, some held she must get a divorce document and also do miyun to legally refuse the marriage. The divorce document is in case the father decides to permit the betrothal, and miyun is in case he does not, and it's to prevent people from seeing this and thinking that such a thing is legally valid. This all only applies if the betrother and the father had been discussing betrothal prior. If there wasn't even such a notion, there's no validity whatsoever and it's completely null and void. Others simply hold either way it was completely forbidden, so miyun isn't even necessary as there's no legal permissibility to this betrothal. It debates these opinions. In the event that an individual impermissibly betrothed a minor without the father's knowledge, and then the betrother died, meaning the principle of the Levirate marriage would theoretically apply, the girl can circumvent this by doing miyun, refusing this marriage, although she can just do nothing, as this really wasn't legally allowed in the first place. If she does want to legally separate fully from the brother-in-law, she'd need a bill of divorce in case the father decided to allow the second betrothal, and she'd need chalitza in case the father allowed the first betrothal, and she'd need miyun in case the father allowed neither, so in this way she won't be married to anybody and nobody will think this was permissible. If the brother-in-law did not try to betroth her also, she'd only require chalitza, and she would not need miyun, as nobody will think that brother-in-law can marry her sisters, which is a rabbinic principle, and the source is cited. There's also a cited incident where two parents decided to betroth their children to each other, but it was ruled to be invalid as the son hadn't been asked, and we don't assume he would have consented to this, as this opinion holds that we also don't assume a parent would consent to the betrothal of their child without being informed of it either. It additionally says, if somebody tries to betroth a minor, it's impermissible for all of the above listed reasons, but additionally, there's not even a principle of concern of the father agreeing to it if the betrothal was done in a demeaning manner like handing her some vegetables. So there wouldn't even need to be a necessity for divorce or similar. It goes through similar cases, and what if after such a betrothal later on, the husband additionally tries to do nisuin, the final stage of marriage, without the father's approval? The validity of this is debated between several opinions. Additionally, if a minor was impermissibly betrothed to a man, some say the girl or her father are allowed to reject it, some say only the father can, it's debated. New Mishnah. If a man asks a woman to become betrothed to him through a date, and then hands her another one asking her to be betrothed through it, if one of the dates is worth the minimum value of a pruta, she's betrothed. If not, then she's not. If he hands her a number of dates and says she should be betrothed with this, and with this, referencing the dates, she's betrothed if the value of all of them is at least a pruta. If, as he was giving them, the woman was eating each one, he's only betrothed if one of them had the value of a pruta. The Gemara discusses particularities on these cases. It's argued as to which case the wife eating the date is referring to. Some say it's actually in the first clause, some say it refers to the second one, meaning she'd only be betrothed if the last date she eats was worth a pruta. It's argued on. Additionally, if a man betrothed his sister by giving her money, obviously this is not allowed. Some say she must return the money as it was given as a deposit, some say she keeps it as it was given as a gift, and he did it like this because he didn't want to embarrass her. It argues some principles in the laws of challah tithes. The case of giving food to a woman as betrothal, as she eats it, is discussed, and it said, if the man said, become betrothed to me with these, even if the woman eats them as he gives them, it already all belongs to her, so they're accumulated to form her betrothal. Some would suggest it's the last item that must be worth the parota, as previously mentioned. Others disagree based on the author. Additionally, it's held that if a betrothal is done with a loan, it's invalid as those are meant to be spent. It also brings a related instance where a man offered to betroth a woman with 100 coins and gives it to her, and they then realize it was only 99, meaning he's now in debt. Some say it's embarrassing for her to demand it, so it's an invalid betrothal. Others disagree. This is unlike the earlier mentioned case where he only gave 1 coin, as it's a lot less embarrassing to demand the full 99 coin remaining sum there. Additionally, in regards to betrothal through a loan, if a man offered to betroth somebody through an item of his, which is in her deposit, and she finds that it was lost or stolen, it's still allowed if there's a pruta of the item left. However, this would hold if a man lent a woman money and is now allowing her to keep it for betrothal. Even if the woman spent it all and there's none left, the betrothal would still be valid. Others disagree, saying it's the same as a deposit and there must be a pruta left. The principles of this debate are additionally discussed. If it debates the validity of betrothal through a loan, either with a debt document or with an oral loan, these principles are discussed. New Mishnah. If a man betrothed a woman by giving her a cup of wine, and then afterwards finds out it was a cup of honey, or vice versa, or if he betrothed her with a silver coin and then finds out it was a gold coin, or vice versa, or she betrothed him on condition that he's rich and then it turns out he's poor, or vice versa, in all these cases she's not betrothed. Others say if the husband misled her, but in a way that it turns out it is actually better for her, it would still be valid. The Gemara explains, if a man betrothed a woman with a cup, some say she gets the cup and what's inside of it, others say she just gets the cup, and other sources say she only gets what's inside of the cup. This is because the first case is where it's filled with water, the second is where it's filled with wine, and the third is where it's filled with brine. In regards to the opinion that the betrothal works if the woman was misled to her advantage, this is a difficult principle to establish, as some people prefer different things. Some would rather vinegar over wine, some would prefer silver over gold, etc. Some suggest that actually what he holds is that the case is where the woman told an agent to accept her betrothal, saying she was told she was promised a silver coin, and the agent was then given a wrapped up gold coin. Some say the woman meant she'd only accept the silver coin, while this other opinion is establishing she was just giving an example and would be fine with this also. This is further qualified. There are additional points on this, and it said regarding the woman gaining an advantage due to the man actually having a more distinguished lineage, for instance. It's agreed that the betrothal is nevertheless invalid, as the woman might not want to marry a husband who will act haughty, so it's not necessarily to her benefit. We bring sources for this principle which are discussed. It also cites other particular conditions on a betrothal. For instance, if the man said she should betroth him on condition that he read scripture, some say he must read a minimum of 3 verses in a synagogue, some say he must be able to read and translate. If he gives the condition that he's a scriptural expert, he must prove he can read all of Chumash, Nevi'im, prophets, and Kesubos writings. If he says it's conditional that he studies, some say he must study laws, some say he must study Torah, particularly Midrash. There are other stipulations mentioned. If he says he's a student, he must be able to answer at least a single question from the Tractate he's studying, even if it's an easier one. If he said it's conditional that he's wise, he must be able to at least respond to a question in something that requires skill of reasoning. If the betrothal condition was that he's strong, he must be at least at the level of strength enough that his peers fear his strength. If they agree that the betrothal is conditional on the fact that he's wealthy, he must at least be honored by his town due to his wealth. If the condition was that he's righteous, she can betroth herself to him even if he's completely wicked, as there's a possibility he had a thought of repentance. If he betrothed on condition that he's a wicked man, she can be betrothed to him even if he's righteous, as it's a possibility that he had a thought to commit idolatry. Additionally, it said that 10 measures of wisdom were given to the world, 9 of which went to the land of Israel, and the rest to the world. 10 measures of beauty went to the world, 9 of which went to Jerusalem, and the rest to the world. 10 measures of wealth went to the world, the early Romans took 9, and the rest went to the world. 10 measures of poverty went to the world, 9 of which went to Babylonia, and it says 10 measures of arrogance were given to the world, which sourced in Babylon, but eventually the 9 portions wound up in Elam. The verse sources for these principles are discussed. Additionally, 10 measures of might were given to the world, 9 of which were given to the Persians. 10 measures of lice were given to the world, 9 of which went to Media. 10 measures of witchcraft went to the world, 9 of which went to Egypt. 10 measures of disease went to the world, 9 of which went to pigs. 10 measures of promiscuity went to the world, 9 of which went to Arabia. 10 measures of brazenness went to the world, 9 of which went to Meshan. 10 measures of conversation went to the world, 9 of which went to women. 10 measures of drunkenness went to the world, 9 of which went to Ethiopians. And 10 measures of sleep were given to the world, 9 of which went to slaves. New Mishnah. If a man betrothed a woman on condition that he was a Cohen, but then she found out he was a Levi, or vice versa, or that he was one of the Nazarites, a descendant of the biblical Gibeonites, and it turns out that he was illegitimate, or vice versa, or on condition that he lived in a town and then she found out he lived in a city, or vice versa, or on condition that his house was near a bathhouse and it turns out it was far, or vice versa, or on condition that he has an adult daughter or maidservant and he does not, or vice versa, or on condition that he has no children and he does, or vice versa. In all these instances, even if the woman afterwards says she was fine with the betrothal anyways after finding out, it's still an invalid betrothal, and this all applies also if the woman was the one misleading the man. The Gemara sets a case. If a man sold his possessions specifically to move to Israel, but he didn't say so, and was then unable to move to Israel, it said the sale still retains its validity, as unspecified intentions are not legally recognized. It debates at length as to what the source for this is. Alternatively, if the man sold his possessions with the expressed intent to go to Israel, but then changed his mind, some say the sale stands, as he could have gone if he wanted to, others say the same, with slightly different wording, the difference being that if he heard about a danger and decided not to go, according to the second opinion, it would annul the sale. New Mishnah. If a man tells his agent to betroth a specific woman in a specific location, and he betrothed her somewhere else, this is not a valid betrothal. If he only told the agent that she happens to be in a specific place, the agent can betroth her wherever he wants. The Gemara says the same principle essentially was established within the laws of the divorce document delivery in the prior tractate. This is repeated here, as betrothal could be viewed differently, as people in different specific regions might dislike or like the husband, and he could want specific people near the woman when he offers the betrothal. It needs to be mentioned by divorce, as perhaps this is unique, as the husband is fine being embarrassed in a specific location, but not in another. New Mishnah. If a man betrothed a woman on condition that she has no standing vows, and he finds out afterwards that she did, there is no betrothal. If he married her without this stipulation, and then found out that she had standing vows, he can divorce her without paying the marriage contract. If a man betrothed a woman on condition that she has no bodily defects, and then finds that she has them, there is no betrothal. If he married her without this stipulation, and finds that she has physical defects, if the defect is bad enough that it would disqualify a Kohen from service in the temple, he can divorce without needing to pay the marriage contract. The Gemara says this was additionally stated within the laws of Kesubos of the marriage contract, but it was said there as it related additionally to the marriage contract, and it was stated here as it relates additionally to betrothal. New Mishnah. If a man betrothed two women with an item worth a pruta, giving half to each, or to one woman with an item worth less than a pruta, even if he sends bridal gifts after, there was no betrothal, as we don't assume the gifts are part of a new betrothal. This would even apply if a minor boy was betrothed, and then sent the secondary betrothal gift upon becoming an adult. The Gemara explains the necessity of these cases, saying it needed the point on bridal gifts, where unlike the half coins, he's sending an entirely new item, possibly for betrothal, and by the minor, everybody knows, and it has been well established that a minor cannot be betrothed, so it also needs to establish the latter gift as non-functioning. Some say generally there is actually a concern that a bridal gift is considered to be a part of betrothal. It debates this, and it said, if the custom of the locale is to give a betrothal before gifts, a gift brought first could act as a betrothal. Otherwise, if gifts are typically brought first, it would just be viewed as a gift, even if a minority do otherwise. Another point, if a marriage contract is just found in a market, it said if the custom is to betroth before receiving a marriage contract, we assume the woman on the document is betrothed. Otherwise, no. Even if a scribe is not available in the location, we don't assume the husband found one. New Mishnah. If a man betrothed a woman and her daughter, or a woman and her sister at the same time, neither of them are betrothed. Once there were 5 women together, 2 of which were sisters. A man took a basket of figs that belonged to the woman and said they should all be betrothed to him through it, and one woman accepted it on behalf of all of them, and it was ruled that everybody in the group was betrothed besides for the 2 sisters. The Gemara cites sources for these principles from verses. It also qualifies points on tithes by this discussion. Additionally, it's debated if betrothal that does not facilitate legal cohabitation, whether that's still a valid betrothal, which is relevant by this discussion of betrothing relatives. The remaining particularities of these debates are qualified in regards to this debate if betrothal is valid even if cohabitation in the situation is not permitted, which is debated from a number of sources. There's a case where 2 unrelated men betrothed 2 sisters and neither knew which she betrothed. So it says that each man must divorce both. However, this is not comparable here, as the men knew who the sisters were at the time of betrothal, and the case was only brought to say in the event that both men died, leaving a brother, that they must do chalitza with each. If one left 1 brother and one left 2 brothers, the single brother does chalitza with both, and one of the other brothers does chalitza, and the other can do yibum. If both brothers married a sister, they don't need a divorce. This is to specify the order, that the single brother does chalitza before any of the others do yibum. It tries to bring other instances to debate if betrothal is allowed when cohabitation is not, and it holds that it would still be a valid betrothal if done when cohabitation in the situation was forbidden. Based on the cited incident with the betrothal of 5 women, it can learn that betrothal with produce from the Shavuos sabbatical year is valid, as was described in that particular case. It learns that betrothal with stolen goods is not valid, and this applies even if the stolen goods belong to the woman. How this is sourced is described. Additionally, it can be learned that a woman can become an agent for another woman for betrothal, even though by doing so they become co-wives who are considered to be rivals and can't testify about each other for a number of things. These principles are additionally debated. It gives some instances on the impermissibility of betrothal via stolen document. New Mishnah. If a person, a Kohen, betrothed a woman using his portion of a sacrificial offering, whether with kache kachim, most holy portions, or kache kalim, of lesser holiness, this is not a valid betrothal. If he betrothed the woman using ma'is or sheni tithes on purpose or on accident, This is not a valid betrothal. Some say it's only allowed if it was intentional. If a man betrothed a woman using consecrated property, it's valid if done on purpose, but not if done on accident. Others say it's valid if done on accident, but not if done on purpose. The Gemara discusses the principles of these points along with some related incidents. The points on particular offerings are additionally qualify. These points are discussed further. It also qualifies the impermissibility of benefiting from consecrated produce in regards to the prohibitions of me'ila. Additionally, regarding the dispute over betrothal through consecrated produce, it's debated which opinion we hold like, if it's valid if done unknowingly or knowingly. There's further discussion on the points on consecrated property related to this, and there are a few opinions as to who we hold like. There's further opinions on the laws of consecration of produce as to whether it has validity in either way. It also discusses some laws regarding animals found near Jerusalem, if they're presumed to be consecrated, and towards which offering, and if so, what needs to be brought along with them. In regards to attempting betrothal via ma'aser sheni tithes, it clarifies this is dealing with a learned woman who is aware of the fact that these funds will remain consecrated even if she accepts them as betrothal. There are related points. New Mishnah. If a man betrothed a woman using urla, the forbidden fruits of the first 3 years of a tree, with kilayim, forbidden mixtures from a vineyard, with an ox that had been condemned to be stoned, using an egla arufa, a calf that was to be decapitated, with birds from the mitzorah, someone who has leprosy impurity, from his offering, from hair of a Nazir, from a firstborn male donkey, with a mixture of milk cooked with meat, or with unconsecrated animals slaughtered in the temple courtyard, all things that a person is forbidden to benefit from, the betrothal is invalid. If the man transgressed and sold one of these items, and then betrothed the woman using the funds from the sale, that is a valid betrothal. The Gemara cites scriptural sources for all of these principles, that each of them is forbidden to be benefited from. This goes further, and it disputes regarding the birds of the mitzorah offering as to when they become forbidden to be used. Some say at the time of slaughter, as that's when they become forbidden. Others say at the time the birds were designated for this, as it's the same as the mitzorah himself. Both are forbidden while they're still alive. Some say the egla arufa becomes forbidden to be used at the point where it's brought down into the valley. It debates these opinions from related discussions. It also argues if particular verses imply as to when the birds become forbidden or remain permitted, which is discussed further. The point on the firstborn male donkey, it's actually an argument if you can't benefit from it, so this is clarified to be talking about after the animal was killed, where everybody agrees it can't be benefited from. It brings sources for the prohibition against benefiting from a mixture of meat and milk. Of course, as the verse says, you can't cook a kid in its mother's milk, which is stated 3 separate times throughout the Torah, once to prohibit eating, once to prohibit benefiting, and once to prohibit cooking them together. The sources for the prohibitions of using unconsecrated animals slaughtered in the temple courtyard are brought and discussed. It brings proofs that eating of such meat is forbidden, and then additional ones that even benefiting from them is additionally prohibited. It also quotes sources for the fact that if they're sold, that's not allowed. But if somebody did, the funds can be used for betrothal, and it specifies that by idolatry, an idol's payment is specifically treated like the idol, implying other things don't have this stringency. New Mishnah. If somebody betrothed a woman with terumos or ma'aser tithes, with the gift portions of an offering, with chatas offering water or ashes, this is a valid betrothal, even if the man is Yisrael and not a Kohen. The Gemara says, in opinion, that the right to choose which Kohen you give your tithes to is not of sufficient value to create a betrothal. Our case in the Mishnah is where the Yisrael man has actual untithed produce inherited from his maternal grandfather, who was a Kohen, and this portion here is considered to be as if it was already tithed. It debates if the right to choose the Kohen to give tithes to, if that's considered to be valid as equity. This is debated. Additionally, a separate source implies that ash water of offerings would not be permissible, so it's explained that our source refers to payment for working to transport ash water, while that referenced payment for sprinkling ash water, which isn't really work. This is implied from the wording, and that's the end of chapter 2. Chapter 3 of Tractate Kiddushin discusses some additional unique laws of betrothal. The first Mishnah says, if somebody asks another to betroth a woman for him, and then the agent goes and betroths the woman to himself instead, this is valid. If a man tells a woman that she'll be betrothed to him after 30 days, and then before that another man comes and betrothed her, she's betrothed to the second man, and if the second man was a Kohen, she can eat truma tithes. If a man tells a woman that she'll be betrothed to him from now and after 30 days, and then in the meanwhile another man betrothed her, she is both betrothed and not betrothed to both of them. So if she was being betrothed to a Kohen, or she was a Kohen being betrothed to a Yisrael, she can no longer eat truma. The Gemara says in the first case, where the agent betrothed the woman himself, it was permissible, but it's said to be a deceitful thing and wrong. In our Mishnah, it refers to the man as his fellow, not as an agent, to show that even if he's not specified as an agent, this is permissible. And another source says this case, but refers to the second man as an agent to show that this applies wherever she's betrothed, as an agent will actually go around trying to find her. It cites some incidents relating to this occurring. A sage once went to betroth the woman for his son, and then betrothed himself to her instead, but this was fine, as the woman had actually rejected the proposal to the son, and he betrothed her without speaking to the son in case somebody else betrothed her first. There was a similar case brought regarding land purchases, along with further instances. Additionally, if a man tells a woman that they'll be betrothed after 30 days and nobody intercepts her in the meanwhile, they would validly be betrothed after that time. If before the 30 days are up, she decides to retract this betrothal, some say she can, as it was only a verbal agreement, others disagree, saying words cannot negate other words. It cites a number of cases to debate whether or not a statement can annul a prior statement. There's lengthy further discussion on this, but in the end it holds with the opinion that words can actually negate prior words. By the betrothal after 30 days, and a man comes in the middle and betroths her, we said the second betrothal was valid. Some say it's a valid betrothal forever, others say she's betrothed by the second man until the 30 days are up, at which point the second betrothal is nullified, and she's back to being betrothed with the first man. The logic of these disputes are qualified in regards to the necessity of the remaining cases of the Mishnah. According to the opinion that she's betrothed to the second man forever, if she betrothed a man from now and after 30 days, and then a second man from now and after 20 days, and then a third man from now and after 10 days, she'd need a divorce document from the first and last man only, as a stipulation of the amount of days can either be a stipulation of an amount or a retraction of the prior statement. The other opinion holds that she needs to divorce every one of them, no matter how many men there are, as each one's betrothal essentially takes up a small slot, leaving room for all of them. These principles are further debated. New Mishnah. If a man betrothed a woman on condition that he gives her 200 coins, she's betrothed immediately, and he gives the coins after. If he betrothed her on condition that he has 200 coins, she is betrothed if he has it. If he betrothed her on condition that he'll show her 200 coins, she's betrothed once he shows it to her. If he was a money changer and just showed some coins he had on his table that didn't belong to him, she's not betrothed. The Gemara says there's a debate in the first case where the betrothal is conditional on him giving 200 coins, if she's retroactively betrothed once he gives the coins, or if he's only betrothed at the later point when he gives the coins. The practical difference is if the woman betrothed another man after the betrothal but before he gives the coins, if this is valid. This is additionally debated elsewhere by laws of divorce. It says both, as betrothal brings a woman close to a person, so it's more likely it'd take effect retroactively, and also it says this by divorce, as the man would not be embarrassed to be divorced for money, so that's more likely to take effect retroactively. It debates the opinions from several other discussions. In the case where the betrothal is conditional that he has 200 coins, this requires him to prove that he has it, as this is to create a definitive betrothal, unlike a different case where it's not necessary, as that was to create a doubtful betrothal. The remaining points are qualified, saying the moneylender can't show the coins on his table as valid, even though he is holding on to them for business. New Mishnah. If a man betrothed a woman on condition that he owned a very large particular amount of land, she's betrothed if he has it. If the betrothal was on condition that he has this land, but it's also that the land is in a particular location, she's betrothed only if it's in that location. If the condition is that he shows the land, she's betrothed if he shows the land that he owns, not just land in general in a plain or something. The Gemara says again the requirement for him to actually prove that he has this land is unlike by a different case. Here it's to create a definitive betrothal. This is all said in addition to the prior Mishnah on money, as money tends more to be concealed, so it repeats it here also with land. The remaining points are additionally qualified. It discusses some further principles and the laws of land sales. New Mishnah. All legal stipulations must be doubled, meaning stating both what occurs if the stipulation is fulfilled, and also if it's not fulfilled, as was done by the deal with the descendants of Reuven and Gad in verses to clarify the full extent of the deal. The Gemara discusses these verses on this situation, along with the logic of this principle and further sources. These are all qualified. New Mishnah. If a man betroths a woman and then finds out she was actually a Cohen, or actually a Levi, actually rich, or actually poor, when he had thought otherwise, the betrothal is still valid, as it's not her fault he thought incorrectly. If a man betrothed the woman to take effect after he converts, or after she converts, or after he or she are emancipated, after her husband passes, after her sister passes, or after she's had chalitza done with her brother-in-law, this is not a valid betrothal. If a man tells somebody, if your child is a girl, she should be betrothed to me, this is not allowed. If the fetus was discernible, then the betrothal would be valid to take effect once she becomes an adult. The Gemara explains, the forbidden instances of betrothal were on things outside his control. Conversion was included within this, as it requires it to be done before a panel of 3 judges, and he might not be able to find them to be able to convert. Additionally, explains that this can't be done preemptively with a Canaanite maidservant, even though he can choose to free her, as during the betrothal, she's a slave, and slaves have a legal status that's similar to animals, so the betrothal wouldn't be allowed. Also, a man can't decide to betroth his wife right before he divorces her, even though divorce is within his control, but her acceptance of the betrothal is not. The remaining principles are discussed. It additionally debates the validity of purchasing or consecrating things that don't yet exist. New Mishnah. If a man betrothed a woman on condition that he speaks to a local ruler on her behalf or works for her as a laborer, if he fulfills this condition, she's betrothed. The Gemara clarifies this would only apply so long as he also gave her an item of the minimum value to allow betrothal, a Betrothal. Other sources imply a woman can actually be betrothed simply by the fulfillment of his service, but that's explained to be like the opinion that a worker is paid after he completes his labor, while this is like the opinion that a worker's earnings are earned at the beginning of a labor, so it would technically be a debt, and that can't be used as a betrothal. This is based on the particular use of wording. New Mishnah. If a man betrothed a woman on condition that his father consents, he's betrothed if the father does, otherwise no. If the father died first, the woman would still be betrothed. If the son died first, the father is told to not consent to the betrothal, so that way the woman won't need to do Yibum, the Levirate marriage. The Gemara asks as to what exactly the father consenting means, if it means saying yes or just not saying no. It's explained that there's a bit of a split in the Mishnah. The first case is actually so long as the father doesn't protest at the time he hears about the betrothal. The ending part refers to that the father can't protest ever, so he can invalidate it after the son passes. Alternatively, both cases refer to the condition being that his father won't protest within 30 days. New Mishnah. If a father says he gave his daughter for betrothal, but he's not sure to who, and a man walks over and says it was to him, we believe him. If after the first man said it was him, a second man came over and said he was the betrother, both must divorce the woman, or only one can divorce her and the other can marry her. The Gemara says an argument by the first case where the man is said to be believed. Some say he's believed only to divorce her, as there's a concern people will lie to marry only. Others say he's believed to be allowed to betroth her, although concedes that if a woman herself is unsure who she betrothed and somebody else confirms it was him, we don't believe him. The reason the first opinion would say the betrothal is invalid and allows it by the second case is there's a second person, so he's less likely to lie. They cite sources. It also debates as to how valid a father's testimony that his daughter was betrothed would be, for instance, if she cohabited with somebody, as to whether we consider this to be adultery. If this betrothal was believed from the father, meaning the punishment would either be stoning or not. Some say no, as the father is not believed to create capital punishment. Others disagree and say she would receive capital punishment. However, he does clarify if the woman herself alone testified that she was betrothed, she still wouldn't be stoned, as only her father would be believed to make her liable here for capital punishment. There are a number of opinions on this and related laws. New Mishnah. If a father said that he had given his minor daughter for betrothal, or betrothed and then divorced her, and she's still a minor while he's giving the testimony, we believe him. If she was an adult at the time, he's not believed. If the father testified that his daughter was abducted and he had ransomed her, he's not believed either way. The Gemara explains the difference by the second case is that the father is testifying about something he has no control over. It further debates the validity of the father, in this case, betrothing his daughter by a number of particularly problematic cases, like to a mamzer, a widow, to a Kohen Gadol, and similar. It said that this is possibly like the opinion that betrothal while cohabitation is impermissible is invalid, meaning this wouldn't be allowed. It's debated as to which opinions we hold like. In the end, it's explained that it's based on a verse that a father can testify on the betrothal of his daughter, but not on her being a captive. New Mishnah. If a man says, when he passes, that he has no children, he is believed, in regards to the laws of the Levirate marriage. If he says he has brothers, he is not believed. The Gemara cites a source which seems to disagree with this, and it tries some explanations. It suggested that our case is where the dying man is presumed to not have brothers or sisters, so saying he has no children wouldn't change anything, but saying he has brothers would, while the other case is where the man was presumed to have brothers, but not to have children, and he's believed as the only reason the husband would be lying would be to make his wife not responsible to do Yibum, which he could simply do by divorcing her. Others debate this. New Mishnah. If a man betrothed one of his daughters, but didn't specify which, his adult independent daughters are excluded. If he had two groups of daughters from two wives, and said he gave his oldest daughter for betrothal, but he's not sure if it's the oldest of either group, or the youngest of the older group, or the oldest of the younger group. The rule is, none of them are ever allowed to marry the man besides the youngest daughter of the youngest group, as it's definitely not her. Others say only the oldest daughter of the older group can't marry him. It essentially recites this entire case, but if it was the youngest daughter. Some saying he can only marry the oldest of the older group, the other saying he can only not marry the youngest of the younger group. The Gemara says, based on the initial point that the adult daughters are excluded from the possibility of the betrothal, this perhaps could mean that, as it must have been a minor that was betrothed, that based on this betrothal to a person that it's forbidden to cohabit with is allowed, as obviously it's completely forbidden to cohabit with a minor, so perhaps that's a viable implication, but we say no, as possibly it's where the man only had an adult or minor daughter, and it said daughters, plural, just as in general. Additionally, him betrothing his adult daughter is theoretically possible here, as it's where she appointed him as an agent. The presumption that he's betrothing the younger daughter is as that's an obligation for him. It debates the remaining cases as to what the oldest or youngest in regards to the groups are possibly referring to. These are further discussed. New Mishnah. If a man tells a woman that he betrothed her, and she says, no, you didn't, he is not allowed to marry her relatives, and she can marry his. If she said, you betrothed me, and he says, no, I didn't, he can marry her relatives, and she cannot marry his. If he said, I betrothed you, and he says, no, you betrothed my daughter, he can't marry the relatives of the mother and daughter can marry his relatives. If he says, I betrothed your daughter, and she says, no, you betrothed me, he can't marry the daughter's relatives, and the daughter can marry his relatives, and the mother can't marry his relatives. The Gemara explains the necessity of all these cases, and it said if a woman claims to be betrothed to a man and he denies it, he's requested to give a divorce, and if he did it himself, he's essentially admitting he had married her, and therefore must also give a marriage contract. If somebody betrothed a woman in front of only a single witness, it said that this is not valid, even if they confirm the witness's testimony. It argues further on particular cases. It cites a number of opinions agreeing that betrothal before a single witness is invalid. Others debate this, but it's ruled that it's not allowed. It mentions some additional points on loss of witnesses by monetary matters, and similar in regards to the validity of believing a single testimony in unique circumstances. For instance, if a single man tells a person that he ate prohibited animal fats, and he doesn't deny it, he's liable. If a single witness testified that somebody's pure food becomes impure, and he doesn't deny it, he's believed. If a single witness testified that a man's ox was sodomized and can therefore no longer be brought as an offering, and he doesn't deny it, he's believed. All of these were necessary to mention, as impure foods can be eaten when a person is impure, and the sodomized ox just might not be brought to be offered, so he might be silent in all those cases for those reasons. If a single witness tells a husband that his wife did adultery and the husband says nothing, it debates if we believe the witnesses or not. They cite sources. Related to this, it cites the incident where the wicked King Yanai had all the sages of the time executed. Essentially, King Yanai had just won a great victory over some cities he had conquered, and he invited all the sages over for a big feast. One particular wicked individual suggested to the king that he should test the sages by wearing parts of the Kohen Gadol's garb to see if they supported him, which he did. However, the sages doubted the validity of his position, as there was some significant questions as to the validity of his ancestry, so the sages were all expelled. Then the man said that those opinions were likewise held by all the people in Israel, and that there was no great concern if all the sages were executed, as if anybody wanted to study Torah, the book still existed. So he went and had all the sages executed, besides for the sage Shimon ben Sotah, who escaped and eventually managed to rebuild. This was brought as it debates the validity of the witness's testimony in regards to King Yanai's ancestry. These principles are all further debated along with sources. New Mishnah. Whenever there is a valid betrothal and marriage, the status of the children goes after the father, meaning if the father is a Kohen, Levi, or Yisrael, that's what the child will be. If there was an invalid betrothal and marriage, a Kohen Gadol to a widow, a Kohen to a divorcee, a Mamzer to an ordinary person, the status of the child follows the blemished individual. If the betrothal with this man was invalid but allowed with others, meaning a marriage forbidden by the Torah, the child would be a Mamzer. If the woman isn't allowed to be betrothed to anybody Jewish, meaning a Canaanite slave woman or a non-Jewish person, the status follows the mother. The Gemara debates if there are any exceptions to the initial general principle, and it said some particular situations. This for the discussion, it said, by other nations the status goes after the male, and if they convert to Judaism, it goes after the more blemished in regards to prohibited nations like the Ammonites or Egyptians and similar. It cites sources for the remaining principles. These are all discussed further, and the remaining scriptural sources for these laws are quoted. New Mishnah. Mamzerim, illegitimate children, can end their line of illegitimacy by marrying a Canaanite slave woman, thereby making their son have the status of a slave, and then having the son be emancipated. Others say this wouldn't work as their child status is also of a mamzer. The Gemara debates if the suggested method is fully allowed and recommended, or it's just something that legally works if done. It debates this and it decides it's fully permissible and actually recommended. The opinion that says this is totally not allowed as their child is a mamzer is based off a verse, the logic of which is debated. And that's the end of chapter 3. Chapter 4 of Tractate Kiddushin finishes the discussion on the laws of betrothal and various forms of forbidden marriage and some points on genealogy. The first Mishnah says, there were 10 genealogical classes that went from Babylon up to Israel. Kohanim, Leviim, Yisraelim, Chalolim, disqualified Kohanim, converts, freed Canaanite slaves, Mamzerim, illegitimate individuals, Nesanim, descendants of the Gibeonites, and Shetukim and Asufim, which will be defined. Kohanim, Levinim, and Yisraelim can all marry each other. Leviim, Yisraelim, Chalalim, converts, and freed slaves can all marry each other. Converts, freed slaves, Mamzerim, Nesinim, Shetukim, and Asufim can all marry each other. Shetukim, also known as Bedukim, are somebody who knows the identity of only their mother. Asufim are orphans off the street who don't know the identity of either of their parents. The Gemara says that they went from Babylon up to Israel to show that Israel is higher than all other lands. It says a number of verses referencing this topic. Some say there's a debate if these groups traveled to Israel willingly or if they were forced. Some say that actually the genealogically unfit were separated, and there's a debate if that group went up willingly or not. It additionally cites verses from Scripture to show how all 10 of these groups went up to Israel by the beginning of the Second Temple era. Scripture referencing all of them individually. It also debates based on verses which of the groups were allowed to eat teruma. It continues citing verses referencing these groups going up to Israel, and additionally cites a number of verses and teachings on the great importance of only marrying permissibly and how terribly it's viewed if a person marries somebody forbidden to them. There are related incidents. There are also incidents discussed about arguments on genealogy and further in only marrying people permitted. This goes further, and it cites some principles on the teachings of God's 12-letter name, how and when it was taught, along with God's 42-letter name. There's further incidents of genealogical unfitness, and it also says related teachings such as if you see people or families in conflict, you can assume there's a genealogical flaw in one of them. It also discusses the genealogical fitness of the residents of various locations. It says Babylonia is good, while Maishan, Media, and Elam are all problematic to different degrees. It also gives definition as to the parameters and borders of the land of Babylonia, which is disputed. It also discusses various districts within Babylonia, which had high levels of genealogical fitness, along with the status of various other particular areas in the region. There's further discussion on these points, and it says there's a debate by Mashiach's coming if Mamzerim and Nesinim will become pure or not. They cite verses, it's held that they will become pure. It also debates as to who converts are allowed to marry, and it said that they can both even marry a Kohen woman and also a Mamzer woman. Some say a Shetuki, somebody who only knew his mother, should be allowed to marry any Jewish person, as he can marry most of them, but it was still forbidden out of concern that he'd accidentally marry his paternal sister. Some say that's also very uncommon, so it was ruled because we're just being strict by genealogical matters. Asufim are forbidden for the same reasons. Additionally, if the child was found circumcised, with his limbs straightened, powdered, or spread with oil, with an amulet or similar, he's not considered to be an Asufi, as he's assumed to be Jewish. If he was found suspended from a palm tree, or where an animal can reach him, or near a sorb tree or similar, he is considered to be an Asufi. There are additionally listed particularities, and it says during years of famine, a child is not considered to be an Asufi, as he would hold then, even if he was left on the street and removed from there by others, the parents can still identify themselves as the parents. Such people would be believed immediately, as would a midwife testifying as to which of two twins were born first. If she had left, some say she's not believed, some say she is, only if she maintains her position. The difference between opinions is if she had just looked away. Additionally, a woman is automatically believed if she was in the same bed as other women and blood was found. One of them can say it was her and is believed to making the others not be a Nida. Additionally, it said that a midwife is believed to say the child is a Kohen or a Levi or a Mamzer or similar, so long as she's not challenged. Some say by 2 people, some say even by 1. Further, it said that 3 are established to believe the status of their firstborn son. The midwife, who's believed immediately, the mother, who's believed through the first 7 days, and the father, who's always believed. Sources are brought, and it qualifies the remaining points. It's held by a Shetuki or a Beduki that if the mother is questioned and says she had been with somebody permitted, she's believed, even if the majority of the population would not have been permitted to her. New Mishnah. Anybody forbidden to enter the congregation, for instance, Mamzerim and Shetukim, they can't marry into each other. Others say they can, only if their prohibition to enter the congregation is certain. Uncertain statuses here are Shetukim, Asufim, and a Kuthian. The Gemara says this is all pretty redundant from the first Mishnah, and debates what exactly the initial prohibition is referring to. These principles are further debated, and there are some additional qualifications. There are additional points on unique levels of genealogical statuses in regards to marriage, and points on believability by testimony here, and similar along with the permissibility of various particular nations, such as the Kuthians. These are discussed further. New Mishnah. If somebody wants to marry a female Kohen, he must examine back 8 ancestors: her mother, her mother's mother, her mother's father's mother, and her mother. Her father's mother, and her mother, and her father's father's mother, and her mother. If he wants to marry a female Levi or Yisrael, he must check all of the above along with the maternal grandmother. You don't need to check the ancestry of somebody whose ancestors were a Kohen who actually served on the altar, or a Levi who served in the temple, or a member of the Sanhedrin. If somebody's ancestors were public officials or charity collectors, his daughters can marry a Kohen, and they don't need to be checked. Some even say it's sufficient to have been a witness on a document in the court of a Yeshana by Tzipori. Some even say it's sufficient to have been a soldier in a king's army. The Gemara says women need their genealogical status checked as opposed to men, as women used to frequently make fun of each other by accusing the other of being immoral, while men make fun of each other by their pedigree. So if there was something wrong with their status, it would have been known about. Additionally, it was ruled scripturally that genealogically fit Cohen women can marry men unfit to be a Cohen. Some say simply, as opposed to all this, all families are simply presumed to be genealogically fit. Some say our Mishnah was specifically discussing cases where the individual's genealogy was contested. The exceptions, if the Cohen or Levi served in the temple or similar, exist because those positions require having a level of genealogical fitness. The other point to discuss along with scriptural sources, it says men who had served in the king's army refers to troops of the house of David who were required to be genealogically fit. It quotes verses on this. New Mishnah. The daughter of a male chalal, somebody who was born to a Cohen and a woman forbidden to him, she's unfit to marry a Cohen forever. If a Yisrael married her, his daughter can marry a Cohen. If a chalal married the daughter of Yisrael, their daughter cannot marry a Cohen. There's a dispute. Some say the daughter of a male convert cannot marry a Cohen, the same as the daughter of a male chalal. Others say if a Yisrael married a female convert, his daughter can marry a Cohen. If a male convert married Yisrael, his daughter can marry a Cohen. If a male convert married a female convert, his daughter cannot marry a Cohen. It's the same between converts and freed Canaanite slaves, even if there's a 10-generation gap. They retain the status unless the mother or father is a regular Jewish person. Others say simply, if a male convert married a female convert, the daughter can marry a Cohen. The Gemara discusses the scriptural sources for all these points, and it qualifies these further. These principles are additionally discussed. It also goes through the lashes received for a prohibited betrothal between a Cohen and others, as described. Many related verses on this topic are discussed. New Mishnah. If a man says his son is a mamzer, he is not believed. Even if the father and mother agree the fetus is a mamzer, some say they're not believed, some say they are. The Gemara says the first case is somewhat redundant in the formatting. They debate as to if the parents are believed and have their sources quoted. New Mishnah. If somebody told his agent to betroth his daughter and then the father went and betrothed her, whoever's betrothal is first counts. If they're not sure, they both must divorce her, or one can and the other can continue the marriage. Similarly, if a woman had her agent betroth her to somebody and also betrothed herself, she's betrothed to the first betrothal. If they don't know who was first, they both divorce, or again just one and she can marry the other. The Gemara says both cases are necessary to show both apply, as you might have thought that as men are typically more knowledgeable in genealogy, and a woman herself would typically investigate an individual before marrying them. A related case, if a father betrothed his daughter at the same time that she betrothed herself, and then it was found out that she was an independent adult, some say it's only her betrothal that's valid, others say there's a concern both are. This must be on the final date that she had become an adult, so there's a debate if she would be considered as a part of that status there. They argue this from other cases. It's disputed further, and it's held like the opinion that she is considered to be an independent adult and betrothed only by herself. New Mishnah. If a man went overseas with his wife and came back later with his wife and children and says this is the same wife he left with along with these being her children, he's believed without needing proof. If he came back with only children and said his wife had passed and these are our children, he must bring proof that they're his kids, and he does not need proof that his wife had passed. If he came back with a new wife and her children, he must prove that it's his wife, but he doesn't need to prove the children. If he came back with just children and said it was from a second wife, he must bring proof about the wife and the children. The Gemara clarifies all the cases where the proof for children was not required, or where the children specifically tag along with the mother. There are related instances by this discussed. New Mishnah. On the laws of seclusion, a man cannot be secluded with one or even two women, but one woman can be secluded with two men. Some say even one man can be secluded with two women if his wife is there, and he can sleep by them in an inn as his wife is watching him. A man can be secluded with his mother or daughter, and he can even sleep physically touching them, but not when they grow up, as they must wear clothes if they're going to be sleeping in the same bed. The Gemara says, a man cannot be alone with two women, as a woman would be more easily convinced to partake in such a thing. It gives scriptural sources for all this. There are particular instances, and it mentions a woman can be secluded with two men, but only if they're of good character. If they're not, a woman cannot be with any number of them, and it cites some incidents to show the cause for this concern. Additionally, some say being with two men is only allowed if it's in a city. If it's on a road, they would need three, in case one leaves to use the restroom. It cites sources. There was a punishment of lashes for violating these laws, and some say it wouldn't apply to married women, so people wouldn't think that their children are then illegitimate. Additionally, there's no concern by seclusion if the husband is in the city, or the seclusion is open to a public thoroughfare. It also says there's no worry if men are in the outer room and women are in the inner, but there is such a concern by vice versa. Some say it's actually the opposite. It cites some incidents showing the strength of the evil inclination by this topic. There was this one incident where there were several captured women who had been rescued and were being kept on the second floor of a sage's home, and the sage saw one of the women and became so desiring of her that he picked up a ladder that would have taken 10 men to lift and started going up. But as he was climbing up, he quickly realized what he was about to do and yelled there was a fire in the house. So many people came to help out and stopped him from doing that transgression. It also mentions some occasions where the Sotah decided to mess with sages by pretending to be a beautiful woman, tempting them, and then revealing who he was right before they did anything wrong. One sage used to frequently curse the Sotah, so the Sotah came to him disguised as a poor man and asked to be invited in, and then started acting disgustingly and making his skin start rotting off and doing very impolite things. So the sage scolded the man for behaving like this, and the Sotah made it look like he had died. So everybody started yelling that the sage had killed somebody, so the sage hid it in an outhouse, and eventually Sotah revealed himself, saying he shouldn't be cursing him. There's another incident of a sage whose wife decided to test him, so pretended to be a harlot and convinced the sage to cohabit with her, and then later revealed it was actually his wife later, but he still felt so bad at it that he fasted until he died. It qualifies the remaining points on seclusion, along with a few exceptions, like a child can sleep with their parents and similar. New Mishnah. An unmarried man or woman should not be the teacher of children, and there's a dispute if unmarried men should herd cattle or sheep together. The Gemara says the issue with teaching the children is because their parents will be there, and the teacher might be improper with the kids' parents. The other points are debated if that's actually a cause for concern. New Mishnah. Somebody in business with women should not be alone with them, and a man should not teach his son a trade that involves women. A man should teach his son a trade that's clean and easy, and it cites many teachings as to what's considered to be a good and proper trade, such as not a donkey, camel, or wagon driver, a sailor, shepherd, storekeeper, or otherwise for various reasons. And a father should take care to teach his son Torah, with many related verses. The Gemara expounds on these points, saying for many problematic jobs, kings and Kohen Gadol were not appointed from them, as they could have been problematic individuals. It gives instances of good jobs, like stitching, and the importance of various other jobs. It further qualifies the points on the immense importance and value of teaching children Torah. And that's the end of chapter 4 and the entire Tractate Kiddushin. Alright, that was a lot of information, so here's a rough summary of a lot of the practical takeaways from this tractate. To marry someone, there's an initial stage of betrothal called Kiddushin. Betrothal can be done through giving a sum of money or an item of value, through a written document, or through an act of cohabitation, all done while specifying it's done to betroth the woman, although the last one was later made to be impermissible. Nowadays, betrothal is typically done through giving a woman a ring worth a large sum right before the chuppah ceremony of the marriage. There is an obligation to honor one's parents. As a general principle, men are obligated in all commandments from the Torah, and women are obligated in all besides for time-bound positive commandments. There are two types of mitzvahs in the Torah: commandments to do something, called positive commandments, and commandments to not do something, called negative commandments. Women are exempt from all positive commandments that are time-bound, meaning the obligation only has application within certain time frames. This includes obligations like wearing tefillin and tzitzis, along with a few holiday obligations, like eating in a sukkah, hearing shofar, and many others. There are many exceptions to this rule. An unmarried man and a woman should not be in seclusion with one another to prevent any potential issues.